All right, well, I'm going to instil all my character and excitement into reading this opening statement, everyone, so get ready. Okay. I declare open this meeting of the Senate Economics Legislation Committee. The Senate has referred to the committee the particulars of proposed expenditure for 2021-22 and related documents for the Treasury portfolio, the Industry, Science, Energy and Resources portfolio, and elements of the Infrastructure, Transport, Regional Development and Communications portfolio. The committee may also examine the annual reports of the departments and agencies appearing before it. The committee has set 25 February 2022 as the date by which senators are to submit written questions on notice, and 25 March 2022 as the date for the return of answers to questions taken on notice. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. The Senate, by resolution in 1999, endorsed the following test of relevance of questions at estimates hearings. Any questions going to the operations or financial positions of the departments and agencies which are seeking funds in the estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has resolved also that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. In particular, I draw the attention of witnesses to an order of the Senate of 13 May 2009 specifying the process by which a claim of public interest immunity should be raised, and which I now incorporate in answer. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement that meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to the public interest that could result from the disclosure of the information or the document. An officer called upon for the first time to answer a question should state their full name and position for the Hansard record, and witnesses should speak clearly into the microphone, as should the chair. Please make sure all mobile phones are switched off or turned to silent. I remind senators and witnesses in the hearing room that microphones remain live unless I instruct otherwise, for example at suspension or adjournment. For witnesses participating via video conference, please mute your microphone as the default and unmute your microphone when speaking. I ask members of the media to follow the established media guidelines and the instructions of the committee secretariat as set out in the guidelines. Senators and witnesses' laptops, mobile phones, other devices and personal papers are not to be filmed or photographed. I remind everyone in the gallery that they are not permitted to speak or interfere with the proceedings or with witnesses. At any point during the hearing, security is present and they will be asked to remove anyone who does not follow these instructions. Witnesses and senators who are seeking to table documents during the committee's hearing were requested to provide an electronic copy of those documents. And the day prior to the hearing, so documents could be circulated electronically during the hearing. Please liaise with the Secretariat if you need assistance. Senators, departments and agencies have been provided with advice on the arrangements in place to ensure the additional budget estimates 2021-22 hearings are conducted in a safe environment. This guidance is also available from the Secretariat. I draw your attention to the QR codes available at all wait times. Witnesses, observers and staff are encouraged to use the codes before entering rooms to allow a full record of attendance to be kept. The committee appreciates the cooperation of all attendees in adhering to these arrangements. The committee's proceedings today will commence with the Treasury portfolio, beginning with the Australian Securities and Investments Commission. The hearing will then follow the order as set out in the circulated program. I now welcome Senator the Honourable Jane Hume, Minister for Superannuation, Financial Services and the Digital Economy. I also welcome the Chair, the other Chair, Mr Joe Longo. Hello, Chair. and officers from the Australian Securities and Investments Commission. Minister, Chair or officers, would you like to make an opening statement? And I note, Chair Longo, you've circulated an opening statement, so would you like to speak to that?
Thank you, sir. I
think, Chair, your audio's just a bit scratchy, Chair Longo. So, do you want to try without the video and just see how that goes?
Can you hear me now?
We can hear you. It's a little bit scratchy. Do you want to keep going? We'll see how it goes.
I was going. Say that.
It hasn't improved, Chair Longo, unfortunately.
I'll try.
We've got the ACCC. I'd like to send that.
Your
colleague's got an electronic PDF for that. So
Fantastic.
can you ask her to send it to the ACCC and circulate it?
Yeah, we'll do.
Okay. Chair Longo, just before, just as you're trying to work out your audio, we might just take the opening statement as read and move to questions. And I'm very familiar with the capacity and quality of all the members from the Australian Securities and Investments Commission, so I'm sure they'll be able to do a very good job of answering questions. Okay, we're trying to get him on chorus call. Okay, so I'll just give a few minutes, perhaps. Can I just say to colleagues, before we go to the ACCC, I've just given the Secretariat a copy of an article which I'm going to be tabling with the ACCC, and I'll be asking them some questions in relation to the article, but I wanted to give it to them now so they've got a chance to have a read of it and reflect on it. But I've got copies here which I'll pass around to you all if you like.
That's already in the public domain.
Yeah, it's already in the public domain.
Senator McKim has quite a few questions for us.
Oh, okay. Senator McKim, are you with us there?
I am with you, Chair.
Do you want to kick off, just whilst we're trying to get Chair Longo, I understand you've got a few questions, so would you like to ask some of your questions, and it might well be that Chair Longo's colleagues will be able to answer them?
Sure, thanks, Chair. I appreciate that, and good morning, everyone. I just want to start by asking if someone could step me through the process of what happens when ASIC forms a view that a search warrant needs to be obtained in order to assist an investigation.
Thank you, Senator McKim. Sarah Court, Deputy Chair, ASIC. I might hand over to our General Counsel, Chris Savandra, to answer the detail of that question. Mr Savandra, are you able to answer that for Senator McKim?
Thanks, Senator, for the question. It's for the Hansard, it's Chris Savandra, General Counsel of ASIC. Senator, we assess the matter. We have power both under the Crimes Act and under the ASIC Act to access search warrant powers. it's very much an assessment undertaken by the team as to the need for a search warrant. There are a number of factors that feed into that decision. Some could be such as the need to ensure that there is not any destruction of evidence. A key aspect of a search warrant is the element of surprise, as opposed to other powers, which we have coercive powers to obtain documents through notices, or coercive powers to examine people also. So it's generally used where the matter is criminal, not always, but generally where the matter involves us investigating criminal misconduct, serious misconduct, where we have made an assessment that there is a need for a search warrant, to obtain evidence through a search warrant, generally to preserve that evidence. The search warrant we apply to a magistrate on an ex parte basis, and the search warrant needs to be approved by a magistrate or a judicial officer. We then work generally with the Australian Federal Police, not always, sometimes state police, who are the warrant holder, so they execute the warrant, and ASIC officers attend the search warrant, generally as constable assisting, so they're authorised by the relevant police force to be present at the search warrant.
All right, thanks, Mr. Savundra. Can I ask how many search warrants ASIC has applied for and obtained over, say, the last 12 months? Do you keep figures on that? And perhaps, if possible, you could go back a couple of years so we could see whether the trend is going up or down?
We do. Sorry, Chair. Did
Sorry
you
to interrupt, Senator Scarr. It's Joe Longo. I'm back online via audio.
Oh, okay. Thank you, Chair Longo. Senator McKim has just been asking some questions before you came online, Chair Longo. So, Senator McKim, does it make sense for us to finish your line of questions, and then I'll go to the Chair? How long do you think it will take?
Oh, I've got a few questions, Chair. So if you were going to give the ASIC Chair an opportunity to speak to his opening statement, perhaps we could do that now and then come back to.
Yeah. Okay. I'll do that. I'll do that. I just didn't want to interrupt your flow.
No, thank you.
Okay, Chair Longo, we have your opening statement. So, are there any particular comments you'd like to make on that opening statement?
No, Senator Scarr. Through the Secretariat, I simply wanted to table it,
Yep.
and I don't propose to speak to it in any more detail. Of course, myself and the other commissioners are quite happy to answer any questions coming out of it.
Okay.
Thank you.
Thank you. And it was a very useful opening statement, so thank you very much. Okay, back to you, Senator Kim. If I can give you till 20 past 9, and then we'll be going to Senator Walsh and or Senator McAllister. So over to you.
Sure, Chair. I'll just indicate probably I don't think another 5 minutes is going to allow me to finish, but I'm happy for you to come back to me once.
Okay, we'll see how we go. Thank you, Senator McKim.
Yeah, thanks. So can someone answer that question about the amount of times that ASIC has applied for and been granted a search warrant, perhaps every 12 months, going back for 3 years?
Senator, unless any of my colleagues can assist, as in we do report on those numbers in our annual report.
Okay.
Just within the time you've given me, I can articulate the number of notices in the financial year 2021 and 1920, because that's in our most recent annual report. I just need to go back one more year to get you that third year. But in 2021, there were 30 search warrants executed, and in 1920 financial year, there were 10.
Okay, thanks, Mr. Savundra. That's a relatively significant increase. Able to answer the same question in terms of the use of your Section 19 powers, that how many Section 19 notices that ASIC has issued each year back for 3 years?
Again, Senator, I only, because our annual report only has the 2 years, I do have that data. So Section 19 examinations, and we do have powers to summons witnesses, and also under the ASIC Act, but also under the Credit Act. But if I just focus on Section 19 examinations, there were 975 Section 19 examination notices. This is notices that the examination may not have proceeded. Notices were issued in 2021. In the prior year, 1920, there were 857.
All right, thank you. And do you have data on how many of those notices did proceed to interview?
Not to hand, Senator. If I could take that on notice, please.
Sure, thanks. I appreciate that. And off the back of either or both of the number of Section 19 notices issued or the number of search warrants that you applied for earlier, do you have information about how many, in how many of those cases charges were actually laid?
Not to hand, Senator, and I anticipate that we would need to that would be a manual exercise to undertake. So it's not, to my knowledge, a measure. I would note that many of our investigations, or a number of our investigations, our investigations are fact-finding exercises, and it may well be that we speak to people through examinations, whether that be the person of interest or a relevant witness. They provide us with useful information, which might mean that the investigation ends without any action very quickly because of the information that's been obtained through those examinations.
Sure, thanks. If you're able to just take that on notice and provide that you're able, that would be appreciated.
And sorry, Senator, it's Warren Day, Chief Operating Officer at ASIC. We answered a series of questions at our Parliamentary Joint Committee hearing last week of a similar nature. And one of the things we pointed out then, which I think is worthwhile pointing out now, is that just because ASIC issues a, say, Section 19 examination, doesn't necessarily mean, in fact, probably doesn't mean that that person may be a person of interest or may, in fact, be the person who ultimately ASIC's investigations are aimed at. In fact, more often than not, those powers are used sometimes because, in fact, the relevant person wants to be compelled to give evidence to protect them from criticism, potentially from employers or third parties. It may be that it's also a way to ensure that we get the full cooperation and answers from other witnesses who are not, again, persons of interest, or the target of those investigations. So I don't think it can be assumed that any person who receives a Section 19 examination is automatically someone we are considering prosecuting ultimately, or is the target of the investigation. So I think it's a difficult approximation to ask a question that thinks that, how many of those Section 19 examinations led to that person being prosecuted. If it is, how many of those were used, and it might be, say, 5 or 6 that relate to the one matter, and the one person who or entity that we were looking at then gets prosecuted, that's an appropriate sort of consideration. But I just want to caution you to say it's not necessarily the case that everybody who receives the Section 19 examination is a person of interest.
Thanks, Mr. Day. Would you make the same assertion in regards to people who have had search warrants executed against them?
It's probably less so, but there is still a chance of that, because a search warrant may be executed at premises that may have nothing to do potentially directly with the person who might be the subject of the investigation. It might be a related third party. It may, in fact, even be an unrelated third party. It may be, though, that we need to be able to collect evidence from that premises because we have a suspicion that there is, required evidence that might be found at that premises. So again, I don't think that it's easily said that the search warrant against a particular premises, and a person at that premises is automatically the case that they are the person of interest.
Senator McKim,
Right,
do you
thanks for
have,
that.
sorry to interrupt, do you have one final question before I share the call as I foreshadowed?
I've actually got a number of further questions, Chair. So, I mean, as I indicated, I'm very happy for you to share the call, but I just want to place on record that I would like another block of questions, please.
Noted, Senator McKim. Thank you.
Thank you.
Senator McAllister.
Thanks very much, Chair. I wanted to just get an update on the investigations into the allegations against Nuix. I'm not actually sure how to pronounce the name of this company. I've read about it a lot.
You did very well. Nuix.
It is Nuix. So I understand ASIC may be constrained in how much you can say, but if you are able to just provide an update, I'd appreciate it.
Thank you, Senator. It's Joe Longo. I'll ask Deputy Chair Sarah Court to answer that question. We might ask you to elaborate a little bit. We announced, I think last week, that one of our investigations, the one into the financial forecast and the prospectus, is not continuing. We've concluded that investigation. There's another investigation that is continuing. Would you like a quick overview of what we're doing and not doing, and then take it from there? Would that be helpful?
I think that sounds good. I think I'm interested to understand which issues are a continuing source of interest to ASIC.
Okay. Well, I'll ask Deputy Chair Court to elaborate on that. I'll hand over to her.
Thanks.
Good morning, Senator. Just to set the broad scene, the committee may recall from the last occasion that ASIC is looking at 3 elements of the issues concerning Nuix. The first relates to the issue of the prospectus on 18 November 2020 and the financial forecasts that were included in the prospectus. The second is an investigation in relation to potential insider trading. And the third is continuous disclosure concerns that we are investigating that relate to downward revisions of the forecast in April and May of 2021. In relation to the first of those matters, the issue of the prospectus, as Chair Longo indicated, we have concluded our investigation in relation to that set of issues and the revenue forecasts that were included in the prospectus. We've looked at the issues very intensively and have examined all of the material that was available to the board and senior executives of Nuix at the time that the prospectus was issued, and we have concluded that we do not have any reasonable basis on which to take any further action in relation to that part of the investigation. So we have concluded that aspect, and that our conclusion on that issue is in the public domain now, and Nuix have been advised to that effect. Our investigation in relation to the insider trading allegations and continuous disclosure issues are continuing, and we are hoping to be able to conclude those by the end of June of this year, so in the next couple of months.
Right. I'm interested in the way that this might interact with any of the class actions that I understand are also on foot. How does ASIC commonly manage circumstances where you're undertaking an investigation of a breach under your legislation, but there is a parallel action coming from shareholders?
Senator, I might answer that broadly, but then defer again to Mr. Savandra, our General Counsel, on any particular issues. But in my experience, there are often class actions at or around the same time as a regulator is conducting an investigation. We conduct our investigation independent of the class action, if you like. We see that I see that the public interest of the regulatory outcome is what ASIC focuses in on. There is, of course, often a request from class action participants for information or material that a regulator has gathered, and it very much depends on the circumstances and where we are at a particular investigation as to how we deal with those requests. But we will very much focus on just proceeding our investigation and getting that matter into court. That's where it ends up as soon as we can, and the class actions often follow in behind that. But I don't know, Mr. Savundra, if there's anything else you wanted to add to that answer.
No, Senator, class actions can request information under legislative provisions that we've obtained through our investigation. But it is discretionary, and one of the discretionary factors is whether the release of that information may have the potential to interfere with or prejudice ASIC's investigation. So it's often the case that we tend to release information to class actions later on in investigations or after they've concluded rather than during because of that potential.
Yes, so I mean, essentially, I think the structural point that both of you have alluded to in your answers is that an ASIC investigation or potential prosecution doesn't really provide any remedy for affected shareholders if they seek remedy for any financial loss that they've experienced because of behaviour. They need to do that through a class action or some other means. Your actions don't really support their interests in that sense directly.
That's correct, Senator. As in ours is a public action. The class action is about private rights, generally compensatory rights. ASIC, by and large, or almost always, through public law enforcement, is seeking to deter or punish misconduct. So we are looking at addressing misconduct rather than compensation. We do have powers where it is in the public interest to pursue compensation, but by and large, those are used in limited cases where there's a strong public interest, and it generally is to be in furtherance of ASIC's statutory mandate, which is to promote good conduct and compliance with the law.
One of your lines of investigation relates to continuous disclosure. You provided advice to Treasury back in 2020 that the previous regime around continuous disclosure was a fundamental tenet of our markets and is particularly important during times of market uncertainty and volatility. ASIC stands by that advice?
I'm not sure if I'm the right person to be answering that, Senator, only because I wasn't here at the time of the advice, but Mr. Savundra.
Commissioner Armour, I think, might be able to speak to that topic.
Senator, we provided input into Treasury on our view of the importance of the continuous disclosure regime as it was then operating in the context of the markets at the time.
Yes. Obviously, the government has changed the rules in relation to continuous disclosure in the Corporations Act. Would you accept that those changes diminish the prospect of class action succeeding? They raise the threshold for claimants, don't they?
They do make a change to aspects of the threshold. Yes. Whether or not there will be significant change is something we will need to see in the cases that we can take or the cases that third parties can take relying on those provisions is going to be something we'll have to see through sort of practical application.
Yeah, I mean, it's a matter for the courts, of course, but on the face of it, the test that needs to be met by the claimants is higher. They have to demonstrate that it was an intentional failure to disclose the information now, don't they?
Yes, there has been a change in the test. That's correct.
And it makes it a tougher test, doesn't it, for claimants to meet?
Yes, that was the, as I understand, the policy thinking.
At the time, the changes were explained by saying that the old rules exposed company directors to the threat of opportunistic litigation. How many class action suits against company directors have been successful in recent years?
Oh, I can't. I'm sorry. I don't have the figures in front of me to give you an answer to that. And I would mention that class actions cover a range of laws, not just the continuous disclosure laws that have been referred to. And I think some of the policy discussion wasn't necessarily focusing on success in the courts, but class actions that had commenced and then been settled. So it would be a difficult exercise. There is some empirical work that's been done, and I think was produced too. Was it a parliamentary joint committee that reviewed the proposed laws on the number of cases? And I'd be happy to refer the Secretariat of this committee to that material if that would be of assistance.
You made a submission to the Australian Law Reform Commission saying that the economic significance of fair and efficient capital markets dwarfs any exposure to class action damages. Does ASIC stand by that assessment? In that submission, we pointed out the size of the Australian equity markets, the value of the daily trading in those markets. Those markets are based on a system of continuous disclosure, and we were talking about the value of those transactions. Yes, indeed, and it is essential that participants in those markets, as far as is possible, have equitable access to information about the performance of the companies that are trading in those markets. That's not the Nuix shareholders don't feel that they had access to adequate information, do they? That's the basis on which they've launched their class action.
So, Senator, I'm actually going to not answer any queries, I hope you don't mind, in relation to Nuix, because I've recused myself from that matter, but I will hand over to one of my colleagues.
Joe Longo, Senator, I think maybe Deputy Chair Court could have a go at answering that, and I might amplify if I think necessary, but Deputy Chair Court, did you want to answer that?
Thank you. I don't feel qualified to comment on the nature of the shareholder class action, Senator. As I say, we are continuing our inquiries into the continuous disclosure issues and the financial forecast downgrades, or the downgrades that were announced to the market in April and May of 2021. No doubt where we end up on that may be relevant for the class action, but I don't prefer to comment on the nature of the class action. I should add that class actions don't always mirror regulatory actions, in the sense that there may be other provisions or other allegations that those class action plaintiffs choose to file.
But at the end of the day, if the Nuix shareholders want any remedy at all, it's the class action pathway that's going to deliver it for them, isn't
Well, it depends, Senator, where our investigation ends up, but I certainly think in terms of seeking any financial redress or compensation for a decrease in share price, I'm assuming that's what the class action is seeking, some form of redress for those shareholders.
Thanks. Thank you, Chair.
Thank you. I just have some follow-up questions in relation to the issues raised by Senator McAllister. In the first point, I just want to clarify, Commissioner Armour, we've had previous discussions in relation to this issue. It's not correct to say, is it, that the changes in the law mean that there has to be an intention to mislead the market before there's liability under the continuous disclosure laws. The liability can also be triggered if the relevant enhanced disclosure entity, the ASX entity, was negligent or was willful or reckless. So it's not just intentional misleading that's captured and could be the subject of class action litigation under the law as amended. It also includes situations where there's recklessness or negligence. That's correct, isn't it?
I believe so, Senator. I haven't got the section in front of me. I just would have to check on the negligent point, just to be clear, but I think that's
Well,
what you've said is largely correct.
I just read an update from Minda Ellison on my phone to double check, but it was my recollection. So maybe we'll, I'll give them a plug. I'm sure they're correct. And when we talk about class action litigation being successful, you made the point that one of the issues is that there are very few class action continuous disclosure cases that actually end up going to court to final judgment. Many of them are actually settled before they go to court, and it becomes almost a pro forma procedure of the class action funder, the civil litigation lawyers, and the insurer providing the D&O insurance, the Class C cover, coming to some agreement as to what the settlement amount is. Isn't that a fair observation?
That was one of the concerns that was raised in the discussions about changing the provisions. Of course, the settlement is a court-approved settlement, but you're right. There haven't been many, particularly in recent years, liability hearings on class action based on continuous disclosure. I think the Myer case is a notable exception.
Yeah, and it's also correct to say that ASIC still has powers with respect to prosecuting breaches of listing rule 3.1, which is the continuous disclosure listing rule. Is that correct?
So the ASIC's powers have been amended in line with the amendments that apply to third-party litigants. When we talk about civil penalty, ASIC does still have a power to issue an infringement notice that hasn't been amended, so we have that separate power, if you like.
Okay. And in the final point, and I think Senator McAllister raises legitimate concerns, as she diligently does. There is a review, isn't there, with respect to the changes that's going to occur in 2 years' time, where the concerns presumably can be soberly assessed by an independent expert who can look back over the last 2 years and see if the concerns that have been raised have actually occurred in practice, or whether or not companies haven't changed their behaviour, which is my expectation.
Senator Scarr, I have a recollection that there was a discussion that there would be a review of these laws. I'd have to go and check the exact details of that proposal.
And Chair Longo, just my final question on this. Senator McAllister made the important point by referring to ASIC submissions in relation to the continuous disclosure regime, that it is a very important part of our regulatory regime in Australia, and it can have it does have a positive impact in terms of the cost of capital that companies need to pay because investors are given added comfort by the rigour of the continuous disclosure regime. But by the same token, those seeking to raise capital, companies and directors, are also incentivised to comply with the continuous disclosure regime, because if a company doesn't comply with the continuous disclosure regime, that will in fact raise their own cost of capital in terms of future capital raisings. Is that a fair comment?
Yes, I think that they're all clearly pertinent observations to make. I suppose from my perspective, and I think I've made this observation before, although I can't remember before which committee, I think Australia's had high standards of disclosure for many years now. We've had quite rigorous standards under the corporations legislation since the 90s in this area. So clearly there's been some changes in the law as the exchange between Senator McAllister and Commissioner Armour shows. But I don't expect standards of disclosure to drop as a result of those changes. And I think your observations, the way I would put it, is to say I think listed corporates in particular, I think remain committed to higher standards of compliance in that area because it's in everybody's interest to do so, and it's the right thing to do. So at this stage, I think we need to see how these reforms play out in the coming period of time, and do a look back.
Okay. So I'm aware of time. Senator Small is joining us remotely and had a few questions. Can I give you just a few minutes, Senator Small? There are other senators seeking the call.
Yep, thanks. Thanks very much, Chair, and I'll be nice and brief. The first issue I'd like to turn to this morning was design and distribution obligations.
Yeah, I'm trying to. They've got questions.
Can you hear me, Chair? Can you hear me, Chair?
Yes, we can hear you. Go on.
Okay, sorry. Yeah, thanks. So I'll just address my questions broadly. Design and distribution obligations, only in 31st of January this year, the ANZ Bank announced that with DDO in any future full notes offers, they'll be limited to wholesale investors only and those investors receiving financial advice. Is there anything that's gone wrong in the implementation of DDO where retail investors might be prevented from having access to those hybrid securities? Noting, I guess, that they have intrinsic risk, but is it going too far to suggest that retail investors should be unable to do their own assessment of that risk?
It's Karen.
I'll ask Deputy Chair Chester to answer that in the broad, and she might also have a go at the more specific question.
Thank you, Chair Longo. And Chair Senator Scarr, I couldn't quite catch the questions that Senator Small put to us on design and distribution obligations. Apologies. So if he could please repeat them.
So the thrust of it, Ms Chester, is this. The ANZ Bank has recently announced that future DDO will only be available to wholesale investors and those investors receiving advice, not available to retail investors. So has something gone wrong in rolling out DDO where hybrid securities are not available to retail investors, making their own assessment of the risks inherent?
So, Senator Small, you're right to say that, so thank you for the question, and I wasn't aware of that specific example, and I didn't quite capture the name of the hybrid security that you were talking about.
So,
ANZ Bank.
No, ANZ Bank.
Oh, sorry, yes, yeah. No, it was an ANZ capital note.
Oh, capital note, thank you very much. So you're right in saying that the design and distribution obligations do have some exclusions. They don't apply to wholesale investments, wholesale investor products when they're targeted at them solely, nor do they. sorry, I just lost train of thought. There's some background noise here. So you're right, as the design and distribution obligations took effect from October last year, product providers and distributors would begin to think about how they wanted to go through the process of target market determinations. In doing that, they may have decided that it would be appropriate for the distribution mechanism to involve only personal advice, personal financial advice. And we know that some product issuers have decided that in terms of their distribution channels, but also that the product may no longer be appropriate for retail investors. It might be something that's only appropriate for wholesale investors. And without knowing the particulars of the ANZ case, it could well be that they have made that decision themselves. These are commercial decisions that are made by the financial institutions involved, Senator. So, and to some extent, it's unsurprising. We would expect that a more robust look at the product, its risk return profile, its complexity, the target market would mean that some of these products might be simplified or some of them might be retargeted to different client cohorts. And it sounds like that's what's the case here. I wouldn't intuitively jump to the conclusion that something's gone wrong with the implementation of the design and distribution obligations. From our standpoint, we are seeing changes to product design, good changes to product design, and better targeting of products to consumers and investors that are best placed to understand those products.
Senator Small, we really are running out of time. I need to give the call to Senator Walsh, who's told me she has, the Senator has 7 minutes of questions. And then once that's exhausted, there's three other senators wanting questions, and I'll give them the benefit of whatever time remains. But I want to make sure you've got an opportunity, Senator Walsh.
Okay.
So you have
Do
the
I have
call.
the call? Okay. Thank you, Chair. My questions are about the financial services and credit panel. So hoping to get the right official to answer those questions. So I understand that the Minister has set out the list of eligible people for convening the panel. And just first of all, I just want to get my terminology right. So I understand that there's a broader panel, and then when there are disciplinary matters, that a single specific panel will be constituted from that to hear those matters. What are we calling those single panels that are convened?
Well, Senator Joe Longo, I'll ask Commissioner Press to speak in more detail, but essentially we're talking about the Financial Services and Credit Panel. As you've noted, the government has just appointed a number of people to that panel.
Yep.
And it's from that group of people that particular panels are appointed to deal with particular matters.
Yep.
Each panel is made up of 3 people. 2 of those people are allocated from the pool of external advisor persons with appropriate background and experience that the Minister has appointed, and each panel is then allocated an ASIC officer to chair the particular panel meeting where referrals from ASIC are dealt with. The only other thing I would say, just for today's purposes, is that ASIC is very close to publishing some information and guidance to the market as to how these panels will work and what sort of matters will be sent to them. So that's where we are at the moment.
Okay.
Whether Commissioner Press can answer any further.
Okay. Thank you. So can you give us more of an indication of when that guidance will be available? Because I did have those sorts of questions, like how are you going to go about appointing the 2 people that you appoint to each individual panel, and have you figured out how to sort of manage, I guess, the caseload of work in terms of, you know, the number of matters that will come to you and how you're expecting to need to resource that by setting up these individual panels?
Yeah, the guidance is about to be published for consultation imminently, but I'll ask Commissioner Press to give a few more details. But
okay, thanks.
All those questions are very much on our mind as well, and we'll be doing our best in the material that's about to be published to answer them. Commissioner Press.
Thank you, Chair Longo. For Hansard Daniel Press, Commissioner of ASIC. That Chair Longo had explained is correct. We are very close to putting consultation out. I would expect it to be out in the next 3 to 4 weeks, so at the end of the first quarter. I think that will outline some of the way we're thinking about thinking about selecting a panel, and also what the panel will need to consider potentially, we will be working with the panel to ensure they are well educated around the facts that they need to be considering when they look at each case. We're also be thinking about ensuring, sorry, someone's just sent me a text to correct me, the consultation paper will be out by the
Who
end
was
of
it, Commissioner
February.
Press?
I'm not prepared to put that in writing.
I won't press the
So
question. I won't press the question.
So
I won't
I don't
even
need to-
I
no, I
won't
don't
even
need to
ask you to
include-
take public interest immunity, Minister. Sorry, Senator Wash, I couldn't
No,
resist.
it was one of my very capable executives at ASIC. The consultation paper will be out by the end of February. The actual guidance will be completed by May. I think it's important, that timing is probably important to note, that the panels will only look at referrals from the 1st of January this year. So May is actually a timing that will work, given that we will need to go through the investigative process before referring anything to that panel.
Okay, thanks for that information. For the Minister, you've put out a list of people. You've made the appointments to the panel, and you've got people on the panel with a range of experience, including people who are past Financial Planning Association representatives, financial advisor representatives, as well as from the broader
stockbroking, timeshare, from all the different aspects of advice.
Yeah. Do you have members of the panel who are expert in some of the subsectors of the broader sector, like, for example, representatives who are expert in the specialised nature of self-managed super fund advice?
Well, I'd imagine that most financial advisors have some experience with self-managed superannuation, so that's a pretty broad skill set.
Yeah.
But yes, we have tried to get a full cross-section of people from the industry. The way we went about that was Treasury requested nominations from the peak bodies via emails that were sent out to people that had submitted to the consultation process on the Better Advice Bill. And then we prioritised candidates that were registered on the Financial Advice Register or the Tax Practitioners Board.
Yep.
And then ASIC vetted those candidates for past misconduct. Treasury collected their CVs, checked out their private interest disclosures, and then obviously we made sure that the people that we were picking were members from a range of specialisation within advice to ensure that the disciplinary body is a proper peer review process.
Thank you. And in that process, you didn't think it was necessary to look at representation from the specific self-managed super fund association?
Well, from the peak bodies, we asked them to nominate members, and if there was
people.
somebody there that they nominated that was qualified and ready to go, well, then they would have been included. The panel isn't just limited to these people. Obviously, this is the first tranche, and if we feel that there is a skill set that is missing or an expertise that's missing, there's no reason why we couldn't appoint another person.
And in relation to financial advice around stockbroking, was consideration given to the need to have representation from the stockbrokers and financial advisors sort of area?
And there is, yes.
Right, but not from the peak body, as I understand it?
I'm pretty sure that peak body did nominate some people that are on that.
Okay.
On the panel.
Okay, thank you. And I, for my sins, remember Minister doing the legislation hearings for this bill, and I also remember getting representations from the consumer law sector, given that this panel comes from the Financial Services Royal Commission and, is a response to significant misconduct, much of which was advocated around by consumer law groups. There doesn't appear from the list, as far as I can tell, to be any representation of consumers on the panel. What was the thinking
That's because
around
it's a peer review panel. It's not a representative body.
So it's a peer panel, and so you didn't think it was appropriate to have people
They're not peers.
from
They're consumer representatives.
Right. They may be sort of qualified to understand the world of financial advice and what consumers' challenges are.
And that's why they're on places like AFCA. Yes, but this is a peer review body.
You think that they weren't appropriate for
Well, not
this
for a
panel?
peer review body because they're not peers.
Okay. You just mentioned before, you've obviously just constituted the panel. What would you understand the process would be sort of going forward for sort of additional appointments or replacement appointments?
Well, I'd imagine we would take advice from ASIC and from Treasury once the panel is up and running, and we see how the peer review process is working, what the demand is. Well, then we would make decisions accordingly.
Okay.
So, Senator Walsh, your 7 minutes are about to go into double
Does that
digits.
include the minute that you've taken up with your introduction?
I knew you would say that.
I am concluded.
Well, fine.
Thank you very much.
Sorry, can I just clarify? I just had a message that, in fact, 12 of the 31 members on that currently listed on the board are members of the Tax Practitioners Board, so they would be experts in the areas of self-managed super funds.
Thank you. Thank you, Senator Walsh, and apologies for my interjection. Senator McDonald.
Thank you very much, Chair. I will be brief with my questions and put the rest on notice. But I did want to ask you, at the Senate estimates hearing, last hearing, I asked a question about ASIC's decision to allocate 60% of the cost of the High Court action against Westpac relating to the call centre activities of their super funds to the predominantly small business financial advisor section. It seems strange that the super fund sector didn't pay the full 100% of this cost, given that it related to the actions of super funds owned by a major bank that had never positioned themselves as providing personal financial advice. I want to know if there were other cases like this where there has been an unfair allocation of costs to financial advisors.
Thanks for that question, Senator. The system of allocation of costs for the industry funding model, a lot of it is prescriptive, some of it is in our discretion as to exactly how we allocate those costs. But I'll ask Warren Day, our Chief Operating Officer, to respond to that question, although we may need to take elements of it on time.
Yeah, thank you, Senator. As Chair Longo said, it's an ex post model, but in terms of the specific nature of the question about other matters, you're asking for us to identify other matters in line with what you've said. I'm more than happy to take that on notice and give you an answer about that.
All right, thank you, because the law doesn't stipulate the split of costs. That is your discretion. Is that right?
There's a formula there in industry funding that is based on certain metrics about volumes of work, but it's also resulting in terms of where our activity has been. So in relation to certain matters, it would depend on what the nature of those matters are. And you'd appreciate that certainly in relation to certain superannuation matters, financial advice becomes part of that. Depending on the nature of the matter we're talking about and the issues being considered, there are sometimes elements of that are financial advice, and vice versa. There are sometimes financial advice matters that have elements of superannuation. So we endeavour to make the appropriate allocation between that. But I'll go and take it on notice what you've asked.
Thank you. Can I just flag, I will put some other questions on notice, but of the two questions I asked at the last estimates, one you came back to me on Tuesday and the other one remains outstanding. So I hope you'll be more prompt in your responses this time, please.
Thank you, Senator.
Thank you.
Okay, thank you. Senator Rennick, quickly. We've got literally 2 minutes.
Very quick one, guys. Does ASIC require gold dealers and custodians of gold to comply with financial disclosure laws such as product disclosure statements, etc., when investors, put their gold bars with gold dealers?
I might ask Commissioner Armour to have a go at that question. I'm not quite sure of the extent of ASIC's jurisdiction over gold bars at this point in time. I know whether Commissioner Armour.
Yeah, look, my initial reaction is that I believe that a gold bar is likely to be a commodity and not necessarily a financial product, so may not be in our jurisdiction, but I'd be happy to go back and double check that for you.
Yeah, it's just that a lot of super funds now investing in gold bars, so I would have thought it should come under, be classified as a financial instrument, but I'll leave it at that. Thank you.
Okay.
Thanks, Chair.
Senator Bragg, did you have one question?
I just have one question, which is just to Commissioner Chester. Just following up from the discussion we had last Friday at the Corporations Committee, I just wanted to ensure that I understood your answer correctly, that you had not received any warnings about the prospect of insider trading or any sort of front running that might be done by super fund trustees or executives during that period of 2020 that was covered in the question on notice you supplied.
Sorry, Senator, I seem to have problems coming off mute when I get questions from you. So, Senator, the question last week was with respect to whether or not I'd received any communications over a 3 or 4 month period of time in 2020 regarding any complaints around insider trading. We've since received a broader question from you, or one of your colleagues, as I understand it, and we're going through a process of checking the electronic communications within ASIC at the moment to respond to that, but I stand by the answer to the question that was put to me last week.
Thank you.
Okay. Senator McKim, I'm acutely aware we haven't had the time to come back to you. Do you have one quick question and ability to put the others on notice?
No, I've got a few more than one. I have gone through, I will put some on notice, but I just appreciate the opportunity to ask a small block of questions, Chair. It'll only be a few minutes.
All right, just a few minutes, please, Senator McKim.
Yeah, thanks. And if witnesses could do their best to keep their answers brief, that would be helpful. Look, I want to ask about the short selling information sheet that you released in June last year. You said in that information sheet that short sellers reports should be released outside of trading hours and not immediately when markets open. Is there a legal requirement for short sellers to follow that recommendation?
No, Senator, it's Cathy Armour here. No, there isn't a legal requirement, but it is definitely our preference.
Okay. And again, you said that short sellers should fact check with the target entity. I presume there's no legal requirement there, just a preference?
Yes, again, practice.
Thank you. And you say short sellers should avoid overly emotive language. Again, no legal requirement, but just a preference?
Yes, Senator.
Thank you. Do you have a preference that companies should avoid overly emotive language in their annual reports?
The idea of annual reports is to provide information to investors that is useful. So we like it to be, I think the language we encourage is generally with reporting to investors is be clear and concise and effective as possible.
But you haven't put out an information sheet asking companies to avoid overly emotive language in their annual reports, have you?
Not mirroring the the information sheet on our short selling, but we do have quite a lot of guidance about the sort of material that companies should be putting out. And
Would it be fair to say that the information part is shot across the bows of short sellers, and that in recent times ASIC has had an increased focus on the activities of short sellers?
it's actually designed for both short sellers and issuers, Senator. We wanted it to be clear what our expectations are with short sellers, how we expect issuers to handle short selling issues, the sorts of discussions we have in those situations with market operators as well. We just thought it was appropriate that everybody was aware of our expectations.
All right. Well, one of the objects of the ASIC Act is for you to promote confident and informed participation of investors. Doesn't that mean supporting the flow of accurate information to the market, irrespective of whether that information is good news or bad news for a particular company? Would you agree with that statement?
Yes, Senator.
You would? Yep. But nevertheless, you've put out an information sheet targeting short sellers, but you haven't put out a similar communication issuing guidance around companies avoiding. I'll just finish my question, Ms. Zamora, if that's all right. Just you haven't put out an information sheet requiring or guiding companies to avoid overly language in their annual reports. So why the different approach for good news versus bad news?
So, Senator, it's not intended to be a different approach. We have a plethora of regulatory guides for companies on our expectations in the documents they provide for investors. So it wasn't intended to be that. We have a track record of cases where we have focused on companies who have had overly positive information to the markets. In many situations, that's what a lot of our continuous disclosure cases have been about. So it wasn't intended to focus, if you like, just on one part of that.
All right, and last question, Chair. Thank you.
Okay, thank you.
Thank you. Look, I just wanted to put this, and perhaps this is a fairer question to put to the Chair. But look, in recent times, we've seen the government watering down continuous disclosure obligations. We've seen the government try to hamstring proxy advisors. It looks on the face of it like ASIC are going after short sellers. I'm aware a number of short sellers have been raided by the AFP on the basis of warrants applied for by ASIC in recent times, and in many cases charges have not been laid. Trend here, and that trend is to go after short sellers and clamp down on any bad news about the market. Is that a fair observation, Chair Longo?
Chair, just before you answer that question, and thank you, Senator McKim, there's a lot in that question I appreciate, but if you could try and deal with it as briefly as possible so we can move on to our next witnesses. Thank you.
Yeah. Well, I think the key points are, I think we will try to elaborate on the response I'm about to give in writing. But as its commitment to upholding high standards of transparency in the markets remains undiminished, we have a number of ongoing matters of insider trading, continuous disclosure. I'm not going to comment on proxy advisors. That's a matter for the government. Insofar as the reforms on continuous disclosure, I think it's well to understand that the standards and legal obligations have not changed. We still have very high standards of disclosure in Australian markets, and I don't expect compliance with them to go down, and if they do, we'll be taking action. So I think they're the key points for now. I think the short selling phenomenon, as previous statements have indicated, can cause a lot of harm, and we are keeping a watchful eye on that conduct. So I might leave it at that, unless Kathy Armour wanted to have the final word.
Yeah, Senator McKim, I don't think we have a view that short selling is necessarily a negative. The short selling reports can provide a positive set of opinions, and information flows into the market, and it's just the reason for the report is to set out standards where we think that can happen in the most effective way.
Okay, thank you, Commissioner Armour, and thank you to...
Senator Scutch, sorry, just to come back to you on two points so that I avoid giving you answers on notice. You were right, continuous disclosure, it is a negligence test, and yes, the law does require a review within 6 months of the second anniversary of the changes.
Thank you, Commissioner Armour. Thank you for that. So thank you to all of our witnesses from ASIC. Thank you for joining us today, and we'll now move on to the ACCC.
Thank you.
Thank you.
I was expecting you online. No, I'm sorry. I've been spreading out my books.
Hello, Chair Sims. We're going to try and make this as eventful for you as possible, given it's your last one, I believe.
That's very kind of you.
Okay. So welcome to our friends from the ACCC. Chair, do you have an opening statement?
Oh, I don't really. I just did want to, rather than do it at the end, just say this is my last committee appearance of all the committees after nearly 11 years, and just to thank this and other committee members. It's always been a great, very wide-ranging interest in ACCC matters, and always appreciated the courtesy of the exchanges. That's not to say there's not going to be hard questioning. I have a sneaking suspicion there'll be some hard questioning today, but always appreciate the spirit, and thank the committee very much.
Well, and thank you for your service over such a long, extended period of time, and for your cooperation during these important processes on behalf of the committee. It's truly appreciated. Thank you very much.
Thank you.
Now, first questions.
Got to go first if you want.
Yeah?
Yep.
Senator Chisholm.
Thanks, Mr. Sims. I just had some questions following on a speech you made from August last year about a new formal merger regime, which I'm sure you remember.
Yes, I do.
So in your speech from 27th of August last year, which you set out some possible ways to keep our markets competitive and open, you proposed that all acquisitions above specified thresholds would be subject to mandatory notification to the ACCC before proceeding. Notified acquisitions would be prohibited from being completed unless clearance has been granted. My understanding is that recommendation would take us closer to the way most other countries operate in this area by moving away from voluntary notification process the Commission currently has in place. Is that correct?
That's correct.
Okay. Why did the ACCC make this recommendation that we change our merger rules to require large firms to make a mandatory notification to the ACCC about proposed acquisitions?
We did it for a range of reasons. First point to note is we get probably 300 merger applications a year. That's gone up now recently, a lot of activity. There's probably only about 30 we look at closely. The others would get approved within 2 weeks, and that won't change. The process won't change that at all. There'll still be a very quick process for 90% of mergers. So we're really talking about that, well, probably 5% of mergers. And the reason is we have had, firstly, mergers being completed without coming to us, not many, but some. We had a recent one in the IVF sector. We've also had merger parties, apropos your previous question, it sounds a bit emotive, but almost like having a gun at our head in the sense that, you know, give us an answer now or we're going to proceed and we'll fight you in court. And, you know, so dribbling information, we don't get very good information. Now, I'm not saying this happens all the time, but given the merger control is the most important thing the ACCC does, because that's the only thing that prevents market power rather than trying to deal with it when you've got it, which is a lot harder. We felt that it would put us in a much better position for those 5, maybe 10%, but 5% of cases, if we got upfront information, if they couldn't just threaten to proceed. They had to notify they can't proceed until our processes are completed, and also that they would need to, if they want to appeal the decision we make, it would largely be on the papers in front of us, so they can't withhold information. So it just makes for a better process, and a process that, as you say, Senator, does resemble what happens overseas in most jurisdictions.
Okay. And you mentioned a merger in the IVF space. What are the consequences? Like, what prompted you to raise this?
Well, I can't remember the exact shares, and we've got a cast of many on screen, but I don't think they'll be needed for this. But you had a dominant IVF player buying out a fairly sizable but low-cost player. And so we were concerned about the consolidation and the impact on prices for IVF. But they just went and, they gave us what's called a courtesy notification, which is, we know you're not going to be interested, but we thought we'd tell you as a courtesy. And then after a very short period of time, they proceeded. We sought an injunction in the court. We got the injunction. And before the court case to hear the matter substantively, they dropped the matter. So in that sense, that was okay. But
so the merger didn't go ahead?
The merger did not go ahead. But if I could just add, Senator, had there been 2 or 3 of those going at once, that would have been our entire merger resources tied up. So it's just a very clumsy way to do things, okay, and resource intensive.
And in terms of, like, when you say resource intensive, can you give us a sense of how many staff would be dedicated to something like that?
I don't know whether Mr. Gregson or Tom, sorry, I didn't know where to look. Tom, you're over there. Any idea on how many resources? Mr. Loyne is the EGM mergers.
Tom Loyne, Executive General Manager of Mergers, Exemptions and Digital Division. We would have had, I'd have to check the exact figures, but we would have had approximately 7 to 8 staff on that during the injunction phase and then the subsequent preparation for trial.
Okay.
Thanks, Tom.
So you don't necessarily think it would result in more mergers going ahead or less mergers going ahead? It would more be a smoother function for the ACCC?
I think it would be that, but look, my guess is it could change the result in 2 or 3 mergers a year. Just, depends on the mergers, of course,
sure.
So can't but I think it would put us in a better place to deal with 2 or 3 mergers a year, and usually those 2 or 3 mergers a year, they matter.
We've got some other questions, but...
why don't we deal with your other questions first?
Okay.
Just to help me manage time, we'll probably assist. So who's next?
I'll just keep going.
Yeah.
We just had some questions around scams targeting senior Australians, which I know you've been concerned about and we've asked questions about previously. We discussed the threat at scams at additional estimates last year. You'd set a record for reported scams through the ScamWatch website. What's changed since we last talked about it?
I'm going to pass to my colleague on my left, who's the person best placed to answer that. But I just mentioned we do spend a lot of time on scams. It is, and I always like to mention Delia Rickard, my deputy chair, who's doing media every second day, trying to send the messages out. So, but over to you, Richard.
Thanks, Senator. Richard Fleming, Acting Executive General Manager, Consumer and Fair Trading Division. So, Senator, we prioritise action against scam activity in relation to people experiencing vulnerability. So we have a whole lot of programs designed to prioritise that work. We have obviously our ScamWatch website that receives over 4 million views a year. We have an annual event we had in November, which was the Scams Awareness Week, where we really focused on distinguishing or trying to dispel some of the stigma around scams, and that's often a big thing for a range of communities, and that was themed about Let's Talk About Scams. So we have a range of activities throughout the year designed to engage with different groups, call groups, and other specific demographics.
And has there been any recent trends that have evolved in recent months?
So in 2021, we had around 288,000 scam reports, and that's an increase of 32% on 2020. So that also had around $320 million of reported losses, which is up 84% on 2020. And our estimates, loosely based on some of the work we've done, is that around $2 billion a year is lost on scams.
I guess there's been a recent, sorry, just to jump in, there has been, lockdowns have probably increased the numbers. There's been a bit more cryptocurrency scams as well, which we're trying to deal with both through the scams area, but it's also a digital platform issue there as well. So we've certainly seen an increase there, and it's extremely worrying.
Okay. And what about anything in particular targeting senior Australians?
I don't have any specific information on that, Senator, but we could take questions if you like.
Okay. Many Australians are concerned that their parents or elderly grandparents are being targeted by a range of aggressive marketing tactics, including door-to-door sales and phone-based telemarketing. What limitations are there on door-to-door sales in Australia? They're more likely to target retired or older Australians who are home during the workday. Is there any evidence that suggests that products or services sold through door-to-door marketing are likely to be less beneficial to customers?
Just before, we did a lot of work on door-to-door selling of electricity. I know it's not scams, but some of the behaviour almost bordered on it, and we, as a result of that, door-to-door selling of electricity virtually stopped. I wasn't aware there was that much scam activity for door-to-door, but Richard?
Yeah, so I think we put door-to-door sales or unsolicited selling in a different category to some of the scam work I was just talking about. So we have taken action previously in relation to a fair degree of unsolicited selling work. It's not something that's particularly changed in recent times, but it's something that we're always interested in for the reasons you mentioned, Senator.
Okay.
I think, Senator, the elderly perhaps not being as proficient with some of the technology and perhaps being not as questioning as other people might be, are often targeted by scams. Whether that's an increase or not, I don't know, but it's a common feature of scams.
Okay. But in terms of the data that you've identified of an increase, there's sort of no way of telling if that's been a demographic factor in terms of the...
We can take it on notice.
We haven't looked, Senator, but we could take that on notice.
Yeah. We've got a lot of data, Senator. Sorry.
Sometimes we don't have the demographics, like the age, but we certainly have the conduct. We can get back to you on that, Senator.
And what about telemarketing scams? Is that something that's also on the rise? And are there any limitations on telemarketing?
So there's a whole lot of arrangements about unsolicited selling I mentioned before. Obviously, the ACMA has a role as well for scam calls. Is there any particular example you have, Senator, in mind?
No, not particularly. Just see if it's something that you're aware of, that there's been a rise in the...
Look, a lot of scams happen by telemarketing, surprisingly, because you'd think they'd be done online, but a lot are done by telemarketing. We have talked to all the communication companies to see what can be done with some of those, because of course a lot of the scams are coming from outside the country, and there are things they can do to affect that call coming through. They're tricky because of course you don't want to stop someone's overseas relative calling, but we have had active discussions with the telcos on that. They're trying to do what they can. It's a tricky area, but there's a lot of telephone scams out there, Senator, more than you would think, so I understand your line of questioning.
Okay.
But Senator Chisholm, I think it's important to recall that the government did introduce some, in response to the Hayne Rock Commission, one of the recommendations there, some anti-hawking or anti-unsolicited selling legislation which cover financial products. So I think that falls into this purview.
Yeah, I think it's probably fallen a bit sort of more lowbrow than that in recent times as well. Like I've radio reports about people targeting older people saying, "Oh, we'll repaint your roof," and charging astronomical. So I think it's sort of gone a bit
beyond financial products.
Yeah, I think so. Like it's sort of just become really opportunistic and low rent, and targeting people. Obviously, a lot more elderly people at home, not wanting to go out at the moment as well.
Yeah, we'll come back to you. We have got a lot of information, perhaps not as handy it should be.
Senator, I might just add, Scott Gregson's my name, Chief Executive Officer. Many of those service-based direct dealing issues are quite localised, and we share responsibility for the consumer law with state and territory fair trading agencies. We'll see if we can get you some further information from them as well, but just to put in mind that we very much focus on those national trends. We try and educate and make awareness more broadly. But when it comes to dealing with localised traders, such as the roof painting or the driveway providers, we do work closely with fair trading agencies.
Yep. Mr. Sims, what advice would you give to someone who is concerned about a particular marketing tactic or aggressive door-to-door sales? What would you recommend they do? What steps can they take?
Well, I'll let my colleagues add to this, Senator, but my usual advice is if somebody's proactively contacted you, I would turn them away, would be my advice generally, because usually when someone's proactively contacting you, they're not selling you something that's to your benefit, otherwise they'll let you find out about it. So I know that could be an excessive, you could be turning down some good opportunities, but there's so much contact these days online or by phone or by SMS. I get these all the time. Of course, being home more, I get all the phone calls as well that I never got in the office. So I think you'd be much advised just to not listen to anyone who's proactively contacting you, but maybe there's more sophisticated advice.
In many circumstances, there's a cooling off period that applies, Senator. So even if people sign up in their home, there's an opportunity to cancel that contract for up to a period. So it's worth understanding those rights. So the local fair trading agency has that detail, as do we on our website.
Thanks.
Senator, I think if you're going to give that advice, there's even preliminary advice. The law is quite clear that if you're not interested and you ask someone to leave, they need to leave. Some of our cases have been quite on that point, including down to the effectiveness of stickers on your door saying that you're not open to people knocking. So, that real clear message, if you're not interested, tell them to leave, and the law requires them to leave.
That doesn't apply to politicians, though.
I was going to say, the exception is Labor Party campaigners over the next couple of months.
Of course.
Thanks for that. I think it would be interested on notice just to whatever data you've got around sort of the increase and if there is a demographic trend in that, if that's identifiable as well.
We'll get them to say that.
Thanks, Chair.
Thanks, Senator Chisholm. Chair Sims, I just want to I have a few follow-up questions in relation to your the proposals in relation to merger and acquisition reform. And I just wanted to ask you these questions just to get on the record. There are other views that were expressed after you gave that speech, including by a previous chair of the ACCC, who wrote an article that I lost the opportunity to go through the article with you, but I don't want to go through that article again.
I did say I was going to enjoy that.
That's right, but I've got another article we'll go through today. But I just wanted to get on the record just your acknowledgement. There is another view that the law as it is at the moment is working, that it's a well-trodden path, and a number of the practitioners, legal practitioners who specialise in this area say, we know the path we're on, it works well, why change it? Why create more uncertainty and delay? Do you recognise there are alternative views?
Oh yeah, look, I do, and that's why we started a debate, which will take some time. And of course, there is no doubt, Senator, let's be really clear, that the large businesses and their advisors, which is mainly the Law Council people you're talking about, do not want stronger merger laws, but I would guess most consumer groups, most small business and most medium-sized business probably do want. So I think there is a wide range of views, but the larger companies and their advisors certainly do not want merger law change.
Do you recognise, though, Chair Sims, that it's not necessarily that they don't want stronger merger laws, to use your words, it's that they don't consider that there's a problem in the area that needs to be fixed, and they're concerned that we might exacerbate an issue when we don't need to. Do you recognise that that's a legitimate... it's not necessarily as if they're against strong merger laws. It's a process issue they're concerned about. Do you recognise that?
I do have to make two comments. Yes, unambiguously, I recognise there are alternative views. That's why we started a debate.
Sure.
So I absolutely recognise that. I think that has to be said, though, that just as we can be accused of bringing a certain perspective to the issue, those representing whose life is spent in merger parties and trying to get their mergers through us also come with a perspective, Senator. So
yeah.
I completely accept, though, that there is a debate and there are legitimate views on both sides. I accept that.
Okay. I'm now going to ask some questions about the ANZ Bank criminal cartel case. And I just want to say at the outset that my interest in this is to attempt to see what we can learn from this.
Absolutely.
And work out the pathway forward.
Yep.
A lot has been written about the case.
That's a joint interest, Senator.
So in the first instance, can you appreciate, Chair Sims, that when someone looks now with the benefit of hindsight, albeit objectively, at what occurred in that case, where there was a 2-year investigation, charges were laid, proceedings commenced, and then over a number of years, a number of the charges were dropped. Charges against particular defendants was dropped, so the pool of defendants became smaller and smaller.
Yep.
At one stage during the proceedings, the judge referred to, and I'll be very particular in this, referred to the indictment as a complete schmozzle, and there are a number of attempts by the Commonwealth Director of Public Prosecutions to redraft the indictment in acceptable form.
Yep.
And then we get to the stage where, before the matter's gone to trial, the Commonwealth Director of Public Prosecutions, exercising their power, independent from the ACCC, and you've made that point very well, has decided not to proceed because there are no reasonable prospects of success. And that occurred a week or so ago. And then in the aftermath of that, we've heard from a number of the individual defendants, not corporate defendants, individual defendants who've talked about the human toll this case has taken on them personally, on their families, on their ability to progress their careers, and they are left now pondering, what was that all about? Can you reflect that looking at this objectively, it raises questions in our mind as to what happened and how did it go this wrong?
Senator, a few points if I could. Firstly, I mean, we run a whole lot of cases. We have a 80-85% success rate. I just want to get on the record that we rarely spend time in this or any other forum talking about the ones that go as expected. We've had, I think, 8 criminal matters now, and 5 have gone our way and 3 have not. The 3 are ANZ, Country Care and the case against the CFMMEU, but the other 5 went our way, including in both pharmaceutical and money remittance. We've got guilty pleas under the criminal laws. So, but absolutely, when you get that chain of events you describe, there have to be lessons learnt. I mean, we did have an immunity applicant who came to us, so they had concerns or felt there was issues there. You're right, we looked at it in detail. The CDPP looked at it in detail and decisions were made. I think it's fair to say the full range of evidence that we based our decision on obviously didn't get aired in court. So there's information we had when we made up our mind to pursue this criminally.
Mr Sims, can I just interrupt you just on that point, because I just wanted to tease out this point. Do you think you need to be quite reflective when you make comments like that? Because there had been individuals who have gone through a criminal process.
Yes.
They never got their day, the ultimate trial. The charges never went to a jury, right?
Yep.
People in this country are considered innocent until proven guilty. Do you think perhaps it isn't necessarily constructive to talk about evidence that didn't get its day in court because that raises questions, whereas it might be best just to say, The prosecution did not proceed. We'll reflect on the lessons learned, but that's the end of the matter, and actually let them get on with their lives.
Absolutely, Senator. I completely agree with what you've just said, and I apologise if it came out differently. I thought the question was about going back and looking at what we've done. But
it is, Chair. It's the human element to this, I guess.
Sure. I understand. Look, these cases, whether they're criminal sometimes or civil, they're very difficult. And there's no doubt that this case went on for too long. I think we have to, we had 2 years in the magistrates' court, which you'd have to question what that achieved. I think there's an issue there. But look, certainly there will be lessons to be learned. There's been a lot of talk in the press about perhaps it should have been taken civilly, not criminally. We need to reflect on that. And so, look, yes, the case is over and those people can get on with their lives, Senator, and they should, as you say, the case did not proceed. So that should be absolutely what happens. But we need to sit with the CDPP and get as many lessons out of this as we can, and we most certainly will.
Now, I want to refer to an article, and I don't know if you've been provided a copy.
I think I probably have.
Yeah, so it's an article entitled, and these aren't my words, this is the article.
Sure.
The ACCC has failed on consultation, say ANZ cartel case lawyers. It's written by Nigel Hunt, Will Heath and David Friedlander, who are partners at King & Wood Mallesons, and who acted for one of the bank defendants in the case.
Been a lot of articles written.
I note as a previous member of the profession that it's, just as an observation, it's probably a big thing for lawyers to come out and put words as strongly as they are in this article, to be frank. That's one of my observations. You might have a different view on that, but maybe you're used to more robust debate.
Look, the lawyers involved in matters get very heavily invested.
Okay.
So, no, this is not uncommon.
So I just want to talk firstly about the threshold issues, because when this case was initiated, and I used to be a company secretary, I've been involved in capital raisings, a lot of people in the market queried, what is this all about? Because it was considered that there was long-standing, sophisticated commercial practices around capital raisings, being underwritten by a number of different underwriters, and that there's cooperation amongst those underwriters. I just want to put a quote to you from the article and just get your response. I quote, "Companies benefit from engaging multiple banks to pull together large complex capital raisings. Once mandated, it is expected that the banks act cohesively and with a single combined purpose. Those banks need to be true to the investors who participate. This includes ensuring that the aftermarket is unaffected by their conduct, like gun jumping each other to sell down residual shares not taken up by investors who participate in the raisings. In this circumstance, the banks are not competing in building a book of demand for equity, so why would it make sense that they should be constrained in dealing with any residual shares in an orderly way? Question mark, end quote. Do you have a response to that?
I just look at the case in a completely different way, Senator. And look, given your earlier comments, I'm loath to mention evidence, but we did have a lot of things in front of us. We did consult widely with a range of market players to get a view, and we came up with a very different view to the one put there. That was certainly an argument raised by the parties.
Okay, all right, I'll take that. So you did. So this isn't a case. So one of the observations people have made is, why is ACCC doing this? Why wasn't ASIC doing this? Sure. ASIC will understand capital raisings better than the ACCC. Yeah. From your perspective, you did consult widely with people with deep understanding of capital markets?
We did consult widely, Senator, and separately. I think there's an issue, Senator, about the financial markets do operate in a way different to other markets, and there is a lot more sense of acting together in ways that just would not happen in other markets. So I think there's a range of issues to come out of this matter.
Okay. The other issue raised in the article, and I did give it to you before you came so you could have a quick...
No,
but I'm sure you'd read it before.
I had read it, but it was nice of you to do that.
The question was posed, and this is a general philosophical question, I think, and again, looking forward, why wasn't there consultation first in relation to the general practice of how these capital raisings could occur to put market players on notice that this was something the ACCC was looking at, so everyone could take a step back and reflect on, well, gee, we saw it in a different way than how the ACCC sees it, and you just gave evidence that you see it in a different way to what these senior legal practitioners saw it. Was that considered, or should it be considered in the future in these sorts of cases?
Senator, it comes up all the time. I've had more chief executives and chairs in my office saying, look, understand that, but don't proceed to court. We've learnt our lesson. I think the sense we had is that this was a very unusual situation and a different situation to what you normally find as the outcome of these sorts of capital raisings. So, and I think, it's been reflected in much of the commentary. The question has been, what was the right answer to this, rather than was there any concerning behaviour? So, I think there's just different views on what can happen and what should happen. But when you've got competitors, now I accept the article doesn't accept the premise that they were competitors.
Or that they're acting in that particular context as competitors. They're actually combined on a single enterprise to try and deal with the shortfall in a capital raising. That's the other perspective.
No, look, I get that. There was a contract in place that didn't cover this period, but I mean, there's also, so look, we do need to enter into a lot of reflection on this one, Senator, I agree, and learn lessons, and we most certainly will. We do always when cases don't go as we expect, but this one I accept is very much up there.
Okay, so I've just got two more questions just on this. So how do you engage in that reflection? Do you actually, and I know, and I put this question to the Commonwealth Director of Public Prosecutions, do you get someone external who hasn't been involved in the process, who hasn't been invested? Because I'm sure so many members of your team have invested so much time in this matter. Do you try and get someone to come in and look at it independently? And how do you engage in that process with the CDPP, which is also an independent body?
Oh, well, so what we'll do, Senator, is get someone who wasn't directly involved in it, and I've asked Scott Gregson, the Chief Executive, to be closely involved in this. He was not involved in the original decision-making.
Okay.
So, but if we want to really get the lessons, I strongly believe it's better done internally. So someone who knows the organisation but was not involved in the original decision. I agree, that wouldn't be a good idea. So it'll be done by people, say Mr Gregson will lead it, and he was not involved in the original decision, and he will involve other people who weren't involved. Obviously they'll talk to those who were, otherwise you're not getting the lessons. Look, with the CDPP, we'll talk to the CDPP. We have a meeting lined up to do that, but we have if I could just add, we've got an excellent working relationship with the CDPP. There's been many successful cases run with them. We totally respect that the way the situation is set up is that they are independent from us. They don't want us in the room when they make their decisions. And so how we go about that consultation will very much be driven by them. We'll do our own work because we've got our own work to do, and we'll talk to them and see how best to work together to draw the lessons. But they'll very much be calling those shots because they're a very independent organisation.
Okay. So my last question, and again, I'll look forward. Is in relation to criminal cartel offence provisions themselves.
Yes.
So there was another article, I haven't tabled it, but it's on the public record.
I've got it memorised, Senator.
Unfit for purpose criminal cartel laws need a radical rewrite? Does that ring a bell?
Oh, no, the one was the cryptic crosswords.
Oh, no,
draft
well, that's
of the
exactly,
laws.
no,
Yes.
and that's actually referred to in this article. I'll just quote from it. In the Banks cartel prosecution, the CDPP struggled to formulate a satisfactory indictment. It took multiple attempts and 2 decisions from the court. Justice Michael Wigney noted that the criminal cartel offence provisions are devilishly complex and labyrinthine, adding that it was difficult to think of any offence more complex and difficult. Wigney pointed out that by the time the maze of provisions is worked through, it is very easy to lose sight of exactly what conduct the offence provisions are intended to bring to account and punish. Even more bluntly, he suggested that those responsible for drafting the cartel offence provisions could not have set foot in a criminal trial court before and had approached the drafting task, this is your quote, as if it were akin to producing a cryptic crossword, end quote. So is this something which, and I'm going to ask a question of the Minister in this regard, is this something where not only do the regulators need to reflect, but we as members of the legislature and the government also need to reflect on whether or not these laws are just so complicated. We've got a judge in a superior court making those sorts of comments. CDPP, with all the talent they have and all the talent in your organisation, they can't get an indictment to get past muster. Isn't this a red flag to all of us that we need to have careful examination of these laws and see if they can be simplified and made more fit for purpose?
Every judge I've heard, and it's probably only 3 or 4 of them, and every lawyer I've heard talk about the laws has made the point about their complexity. What I don't know, honestly, not being a lawyer, just how much simpler you could make them. But this is the one bit of our laws where all commentary suggests they're too complex. So having a shot at simplifying would be, I suspect, a good idea. Where that ends up, where that leaves us, I don't know. I mean, simplification of laws is not a switch on a wall. It's simplifying laws is complex. Sorry, that didn't make sense. But
no, it does make sense.
But this Justice Wigney's comments were not, were amongst many that suggest how complex these laws are. So look, we will. What I think it'd be a good idea for us to do with the CDPP is have a look at that and see whether we should be thinking about approaching government.
Okay. Minister?
I think that that's a very reasonable comment and that your position is made very clear, Senator Scarr.
Okay, thank you. All right, well, thank you very much, Chair, for answering those questions.
Matter, Senator. I totally understand
Thank
the
you.
concerns.
Senator McKim, you have the call.
Thanks, Chair. Good morning to you, Mr Sims, and your colleagues. I wanted to refer you to the speech that was asking you questions about, which is one that you gave in August last year, but just on a slightly different focus to Senator Chisholm. You spoke in that speech about the negative effect that market concentration can have on productivity, on wages, and on macroeconomic policy, and you in that speech provided a starting point for a debate on the reform of merger laws to stop further uncompetitive market concentration. But I want to ask you about existing uncompetitive market concentration and whether you have any suggested starting points for a debate on policy reform to deal with issues arising from existing market concentration.
It's tricky, Senator, because that's why we need strong merger laws, because once you've got the concentration, it's hard to deal with it. I mean, one big change that we welcomed was the changes to Section 46, which obviously helped deal with misuse of market power. So that's probably an important start. So subject to any comments from Scott Gregson, I think the key focus is trying to prevent those perhaps 2 or 3 mergers that may get through that shouldn't. Once you've got the concentration, look, I suppose once you've got the concentration, we've fixed up the competition laws now. I think there is still a bit of an argument for an unfair practices provision in the consumer law because it's often companies with a fair bit of market power that engage in that behaviour. So I think having got a fit for purpose Section 46, having an unfair practices provision would also help us deal with that unfortunate behaviour. Anything else you'd like to add?
Mr Sims has certainly covered the issues that the ACCC's raised. I would note on a side issue that we have also floated concerns and issues with monopoly infrastructure and the type of things that might be raised there, but that's slightly different from the merger provisions at large.
All right, thanks. And I do have a question for you, Mr Sims, shortly about the effects test. So you'll get I will ask you about that. But you've said, you've argued, obviously, the need for strong merger laws and made the comment that, once mergers happen, it's hard to deal with. Would it be fair to suggest that that's an argument for divestiture laws?
Oh, Senator, I have a number of minor disagreements with my predecessors, and the chair has mentioned one with my immediate predecessor. I don't quite agree with my predecessor, but one, Professor Fells, who has argued for divestiture. I just think that it's firstly something that would be called for on many occasions, cause uncertainty, yet very rarely used. Secondly, if you do use it, it's it is a fairly blunt instrument. It takes a long time. You don't quite know what you're going to end up with. So, frankly, we're inevitably got limited resources, which everyone does, the whole world does. I'd rather we were focused on other provisions than trying to deal with queries for divestiture. But look, Alan Fells has a very different view, and that's
he certainly does. So just to be clear, Mr Sims, you don't believe that the creation of a divestiture law regime in Australia would be of assistance in dealing with uncompetitive market concentration. Is that your position? Is that fair?
That is my view. There may be other different views inside the Commission. It is an issue worthy of debate, and I certainly take your point, Senator. If I'm complaining about too much concentration, your question about divestment is an extremely logical one. But I just think it's going to cause us more problems than it's worth. You're going to get, once you've got that law, people are going to call on you to use it all the time in numerous sectors, and it's such a big stick. I just have a general philosophical concern about really, really big sticks and what that opens up. But look, different people have different views, Senator, and that's just a personal view. Others might, so I almost put it as a personal view as distinct from an ACCC one, because there may be different views inside the ACCC.
Sure, thanks. Thanks, Mr Sims. Well, perhaps a slightly smaller stick, if I could ask you about that. Do you believe that a company tax system that in some part would target excess profits would help with issues associated with uncompetitive market concentration?
Oh, Senator, I'm preceding my time at the ACCC. I am a long-standing fan of a excess profits tax, which Ross Garnaut and Clooney's Ross, I've forgotten his Christian name now, came up with about 35 years ago. So I've always been in favour of that. I think it's a good, sensible way to deal with the resource industry. But, when you move away from the resource industry, and I know Professor Garnaut has a probably different view, well, I don't know actually, but it again is a tricky matter to put in place. It's a lot easier in the resource industry because you've got a different philosophical approach to the limited resources in the ground. Once you do it for companies that just have worked their way to success, it is a fairly big stick again. What I would say, if I could just finish on this before, I may not be answering your question well enough, but what I do believe, and what the ACCC does believe, I think, is that in relation to the digital platforms, which have innovated and then acquired their way to a period of extreme concentration, that we probably need upfront rules to deal with some of that. Just like we have upfront rules in telecommunications, we have it in energy. As I understand it, well, it's not my sector, we have a bit in the financial markets. But I think the level of concentration there is so strong that you won't be able to deal with it via existing laws. You'll be chasing your tail forever. So a bit of thinking, which we will be putting out a discussion paper on that on the 28th of February, and we'll be putting proposals to the government in September. That's been much flagged, and that's where that issue will, again, starting another debate on what should happen there. Now, so I think I'd prefer, rather than divestiture and rather than excess profits, if you've got issues in a particular sector, I'd rather think about, is there an upfront behavioural rule or something like that that can deal with it. To me, that's a more manageable way of dealing with it, and I think we should be open to that in various sectors. So various sectors may need more regulation, but the two you've mentioned wouldn't be the first ones that jump into my mind.
All right, thanks, Mr. Sims. How effective do you think the effects test changes have been? And I wanted to specifically ask whether you thought that the introduction of the effects test in some respects too late to deal with concentration in some markets, in particular whether those in the food and grocery sector were already kind of baked in by the time the effects test was introduced.
Yeah, look, 2 points there. I think the effects test has been very useful because prior to introducing it, and I know it's called the effects test, but from our point of view, the biggest change was getting rid of take advantage, because take advantage was interpreted by the courts and advised to companies that provided you're doing something that a little company could do, then that's not a problem. Now, we firmly believe that bigger companies have to play by slightly different rules than smaller companies, but the old law allowed you to get away with doing whatever you liked, provided what you did was the same as what a small company could do, but of course the effect is vastly different. Now, the advice that lawyers now give is very different advice, and that has changed behaviour in the corporate sector. So I think that's a plus. The second part of your question, how can it deal with already concentrated sectors? Sorry, was that the second half, Senator? My apologies.
Yeah, whether some of the concentration, specifically in the food and grocery sector, kind of baked in before the effects was introduced, and therefore it hasn't been so efficacious.
Yeah, I think with supermarkets, frankly, one of the biggest concerns we've had, because you have had Aldi come in, you've still got Metcash, you've got online, you've got your local grocer, and the local stores have probably done a little better during COVID. But we've had a lot of concern about the impact on suppliers. That's where a fair bit of our focus has been. And again, but there are consumer issues as well. Again, I think an unfair practices provision, I think an unfair practices provision can actually bring more benefits when big businesses are dealing with small businesses, and we can actually stop a range of practices that do take advantage of that market power. And I think that's another debate we need to have about whether that could deal with many of the adverse effects from people having that market power.
All right, thanks, Mr. Simpson. Thanks for your service, and thanks for the open way that you've engaged with various committees that I've been on over the years. I thought the effects test is a great reform, and I hope you and everyone else who worked on that's really proud of it. Might have a different view on divestiture laws, but all the best for the future.
Thank you, Senator.
Thank you, Senator McKim. Senator McDonald, you've got some questions. I think you've got the last lot of questions we have for the ACCC. So
Terrific.
Over to you.
Thank you. Thanks, Mr. Sims, and thank you for your service. I'm a big fan of yours because you are proactive around issues that I care about. So Thank you for that.
Thank you, Senator.
And Chair Sims, you thought this was going to be difficult. Sorry, over to you, Senator McDonald.
It's always been very courteous and very interested in our issues, as I said, Senator, so I've always appreciated it.
Senator McDonald.
I understand that the ACCC is engaged with NBN Co and relevant industry stakeholders in considering the future regulatory framework for the NBN, which is currently set out in NBN Co's special access undertaking. I understand this process is considering the future of matters such as NBN products, pricing and cost recovery. This is obviously an important and complex process which has to navigate a range of factors, ensuring value for end users, reasonable cost recovery that will allow NBN Co to maintain and invest in the future of its network, as well as providing certainty to the retail sector. I was hoping to ask a few questions about how this process is proceeding, the major issues and themes that the ACCC has identified. What is the Commission's view when it comes to the demand for broadband speeds? The COVID pandemic has obviously emphasised and accelerated trends like working and studying remotely, all of which are underscored by good broadband speed. I'm interested in what types of speeds the ACCC expects consumers will need now and into the future.
Certainly, I think the role, and I'm going to warn the EGM responsible that I'll be passing to her to finish the rest of the question, but I mean, getting the NBN built, obviously there's a very wide range of views on the NBN, but getting it built just as the pandemic came along was obviously very, very helpful for a lot of people. There is an active debate about how much speed you need working from home. I think our view is that a 25/5 service is good. If you've got a hell of a lot of family members on things, working from home and watching Netflix at the same time, you may need 50/20, but that's been our advice. But I might just ask the Executive General Manager, Infrastructure, to see if she's got a quick comment she wants to add.
Thank you, Mr Sims. Sarah Proudfoot, Executive General Manager, Infrastructure Division. Would note we would agree with the 25/5 at this point, and that was also found by the recently reported Regional Telecommunication Independent Review Committee to be, for now, appropriate, but noting that as things change going forward, that may change also on higher speeds.
Thank you. What is the Commission's view on NBN Co's need to recover its costs through revenue? And how is the Commission seeking to balance any revenue constraints with the need for the government and therefore the taxpayer to recover its investment?
Oh, Senator, look, I have a slightly controversial view on this one. I've always taken the view that, I mean, obviously the NBN was built by the government, and now that it's built, I think it's appropriate to treat its costs as sunk, and therefore what matters for Australia is getting the best use out of the NBN. And so obviously NBN need enough cash to, going forward, to cover their investment. That would be absurd not to do that. But I wouldn't be personally hung up on getting a commercial return on every last dollar spent, because I think that's just bad economics. What's the best use we can make of the NBN should drive it, provided they've got enough money to do all the things they have to do. That would be my view.
To support the best interest of end users, communications networks need to be both maintained and upgraded over time. Does the ACCC consider that it is in the long-term interests of end users that NBN Co should be able to generate sufficient revenue to continue upgrading and investing into the network to meet the future demand?
Absolutely. I mean, that's the investment they need to make, and that's what judgment has to be formed. That could be a different sum to just, you know, I can't think of the right word, but almost blindly making sure they can get a commercial return on everything that was spent. That'll leave you one price. Doing what you've just described, which I completely agree, might leave you with a different price. And my guess is that the second one's better than the first.
In considering this complex process, to what extent does the ACCC take into account both its own and NBN Co's statement of expectations?
Oh, absolutely, Senator. We take all that into account. I should also say, I mean, there's been almost year-long process here, and we're obviously in this regulatory process. There's a whole range of procedures that have to be followed, and we're taking a very close interest in the views of the users as well, the RSPs, consumer groups, business groups. So there's a range of expectations that, but I mean, the statement of expectations give a framework, but we're following a good regulatory process, and that involves getting all stakeholder views.
And that would include local infrastructure providers like Field Solutions and Wiseguy. These are guys up in the Gulf who are taking the NBN fibre but then extending the connectivity using windmills and tank stands, and to be able to stretch it miles away. You'd be consulting with those as stakeholders?
I'm not sure. I might refer to Ms Proudfoot again.
I'm sorry, Mr Sims, I missed that question. My internet, unfortunately, is backing up.
Look, look. We are open to all views. I don't have a particular recollection of those players, but I'm aware of those types of players, and the names ring a bell. But we consult very widely. I mean, obviously, you've got city issues, you've got regional issues, and you've got rural issues that have to be taken into account.
Well, I might provide you with those organisations, given that they'll give you a Far North Queensland, Northern Territory.
We'd welcome that.
aspect.
We may already have it, but,
Yeah.
for the avoidance of doubt, please do.
Thank you. And then finally, Dr Kennedy yesterday morning said that inflation was rising unexpectedly quickly, but that he suspected were short-term disruptions. I'm aware that supermarkets have increased the price of milk by 10 cents per litre on the basis of the increased cost of AdBlue, which I know you've been doing some work on cost monitoring. Given that a tanker of fuel takes around 26,750 litres of milk, that would be a significant impost or significant revenue gain for the supermarkets, and they don't pass those prices back to producers. What role have you had? I know that you've been looking at AdBlue prices, but is your inquiry into inflationary pressures on prices extended as far as those sort of price increases?
I'll pass to my colleague on my left, but the comment I would make is that there are a lot of supply constraints in the system, as we all know. Our role, again, subject to contradiction on my left, is pretty well exclusively are companies explaining price rises based on misleading information. So the essence of consumer law is don't mislead. We have no generalised power if people are pricing excessively. So if someone, if Woolworths was to say to someone or whoever that this price rise is due to this, when that's not true, we would take action, and we are looking at that. But
yes, and there's a range of industries where those kind of explanations are given by suppliers to customers, either at the end user as a consumer or throughout the supply chain. The question, we are engaging through in a number of those industries, and we're asking for them to tell us what they've been told by their suppliers, so we can actually go and test those claims. It's certainly what we're doing with rapid antigen tests and a whole lot of other similar issues. So we're happy to hear from anyone who's had those representations made to them, and then we can follow those up.
Thank you very much. Thanks, Chair.
Okay, Senator Patrick, just in time.
Thank you.
Just in time, JIT.
Yeah, that's how I run these things.
Over to you, Senator
committees.
Patrick.
Thank you. I don't know if anyone's talked to you about rat tests at all.
no, strangely not.
Okay, so
But
can I get you to perhaps inform the committee as to where things are at in terms of the investigation that you're conducting into rat tests?
I will. Look, we've got a number of investigations underway, but my colleague on my left is the world expert on rat test investigations, so I'll pass to him.
So, Senator, I might just give you some context with complaint numbers and those things. So, to date, we've received around 5,000 contacts about rapid antigen tests. We, up until last Friday, were receiving around 35 contacts a day at its peak, around the 4th of January.
So a contact means someone
calling our
you.
info centre or submitting
Okay,
a form on
thank
our
you.
website. At the peak, around the 4th of January, we're receiving around 450 a day. So what we're doing with all of those is reviewing them to understand what the issues are. Most of them are around high prices. So we're categorising those and prioritising for further follow-up those businesses where they receive a number of complaints. So we've written out to around 60 suppliers throughout the chain of supplying rats, from the sponsors, TGA-approved sponsors, all the way through to the retailers. We're getting close to finalising a number of those inquiries. We're looking at a range of issues such as representations about price, so whether the prices are high because of certain reasons. So we're looking at that issue. We're looking at the non-provision of receipts, which is required under the law, and we're also looking at whether some of the pricing might raise unconscionable conduct issues. So that's the sort of broad work we've been doing on rats, but we're getting close to finalising some of those inquiries.
Okay,
So,
so
can I just say, so we're sort of running on a two-track process. One is the investigations. The other one was by looking at the data and frankly calling out some chains, we got them to look closely at their stores and make sure they weren't doing the wrong thing. And so we had complaints going like this with some chains, and once we named them, they went like that. So there was a bit of putting pressure on as well as the investigation. So it was a dual-track process.
Politics is about putting pressure on, so I understand that. So when you've say you've written to, I think, 60, about 60 entities, does that mean you've sought to inquire, or a particular prima facie concern exists and that's the trigger for writing?
So the trigger for writing was a combination of the nature of the representations they were making, but also the number of complaints we were getting about that particular business. So these are contacts that come to us directly from consumers and business. They're untested, so that's the purpose of us writing out, is to better understand what's happening in those businesses. So we're towards the end of that process, and hopefully in the next little while we'll be in a position to form a view.
Okay, and if you form a view that someone has behaved in a manner unconscionable, has abused the circumstances, what are the remedies?
So whether it's misleading conduct, failure to provide receipts, or unconscionable conduct, there's a whole range of options under our Act, all the way from administrative resolutions all the way through to court action. In between there, you have infringement notices, court enforceable undertakings, so all those things are available, and we tailor those in accordance to with our compliance and enforcement policy to fit the circumstances.
Sure, okay. Now, I'm just trying to recollect, as the issue arose in the media, the government acted to put in some sort of regulation, is that right?
Yeah, so under the Biosecurity Act, the government passed a very helpful law which said if you buy them retail and you on sell at more than 20%, then that is illegal and you can face a range of sanctions, including jail.
Sure.
So that helped deal with a lot of rogues, and the police are looking at a number of those.
Okay, so in those circumstances, because of the breach of the Biosecurity Act or a regulation, it becomes a police matter, is that right?
That's right, Senator. So those have been referred to the AFP.
Okay. And some of them may have come to you and you've referred them on, or is that
Yes.
that's how it's worked? How many have you referred on to the AFP?
It's around 70 so far.
Around 70. Okay, and how you say it was helpful? That can mean a number of different things. It could have been helpful to you. Was it effective in terms of causing a change in conduct?
But my view, yes. I think all of this helped a lot. I mean, you had, for example, I remember one television footage of someone who'd clearly got them retail standing outside a shopping centre. selling them at 50 or 70. It was an enormous price, and that person was challenged. I can't now remember whether the Biosecurity Act was mentioned by the person, but the guy just ran off. So I think he just did give us an extra, because you see, what we do is deal with, complaints, systemic behaviour. If you had a company with a number of stores that was doing something systematic, that I think would probably, in these circumstances, get them end up in court. If we find what we're doing with a very small outfit, maybe it's infringement notice, I don't know. But there is that sort of rogue behaviour of people doing that sort of thing, and I think having an ability, see that what the police could do, just taking that individual, they could go up and arrest the person. We can't do that. All we've got to do is go through an investigative process.
Sure.
So it was a very useful thing to send messages, and I think those messages were sent, and certainly the police have knocked on doors, and you only have to get knocked on the door once, and I think you change your behaviour as well.
Yeah, sure. No, so that's useful. Just turning to gas. We've had a history of conversations.
We have.
In relation to gas.
Shame not to finish without a gas conversation.
Yeah, well, exactly. Exactly. And I understand this is your last estimates, isn't it?
That's right. I mentioned at the start, thanking senators for the interest in our issues over time. So.
Yeah. I think we might have even engaged, not directly, but on radio, one after the other at various different times. So your release on gas sort of raises some concerns. You've said that gas went from $6 to $8 per gigalitre in late 2020 to $7 to $9.50 by mid-2021. Where's it sitting right now?
So we can easily see the spot prices almost daily.
Well, I guess that in some sense I want to know, it comes down to what those numbers were that you were giving us. Were they,
yeah, that's right. They're contract prices.
Contract
We
prices.
get those through issuing notices.
Yeah.
So our notices, we've probably got a bit of information up to about August, but that's so many months ago, 6 or so months ago. Anecdotally, we get the sense they've gone up just a little bit more.
Okay.
But interestingly, in an energy crisis worldwide, not much, not as much as there'd been in Asia and Europe over $35 a gigajoule, and
now what
we're
do
nowhere near that.
you put that down to? I'm on record as saying it's a gas cartel, and I know you can't say that, but has there been sort of some ethical injection somewhere that what's the cause of there not being what I might call gouging or
You mean why haven't they followed world prices up? Look, I think it's partly to do with when those contracts were put in place, so there's a bit of a lag effect. I seriously think, though, there's an element of concern over regulatory action.
Okay. So that's
sorry,
the AD...
government action, probably more.
So that's the ADGSM
It's that.
threat.
It's the head. It's a bit that. Well, it's yes that might be activated or enhanced, but the heads of agreement the government brought in requires the 3 LNG producers to go through a process before they sell the gas externally, and so I think that helps as well. But it's an interesting issue with our gas prices, Senator, because if you look at countries who don't produce much gas, their prices are way higher than ours. If you look at countries that are massive gas exporters as we are, probably our prices are a bit high. So I think that the companies have now realised that they just can't keep putting prices up to world levels. Otherwise, there might actually be government action to do things. So I think the threat of government action in any form is relevant here.
Okay. Now just in relation to the threat in respect of Russia invading the Ukraine and perhaps a diversion of gas from Russia to, the source of gas from Russia to other jurisdictions. People have been talking about the ADGSM, but my understanding is that's really quite it's not a highly reactive thing. It has a particular process where you examine gas prices, I think between June and December or something, and
Yes,
decision.
a lot of procedures to it, yes.
And the decision gets made in January of the next year. So it's not like you can pull the ADGSM trigger next week in response to something happening. That's correct, isn't it?
Look, that's right, but I have to say, when you've got prices of $35 a gigajoule in Asia and Europe, and you've got prices here that are around that $9, $10 or $11 or even $12, it's a bit... I think the combined impact of actual regulation and threat of regulation is probably doing its job, Senator, would be my guess. I mean, the world is facing extremely high gas prices, ridiculously high oil prices, and we are a bit insulated from that because of, I think, that threat of regulation.
But that's quite different to the situation we were after the LNG plants came online.
Yes.
So you've basically had this...
yes, they were then charging above world prices.
That's right. So we had this, what I would call cartel behaviour and in unreasonable behaviour. You're saying now you think that's sort of plateaued a bit and everyone's being a lot more reasonable, and we actually now have an advantage in some respect from a manufacturing perspective over other jurisdictions.
I think that's right. I mean, manufacturing in Britain has been whacked really hard because of gas prices. I suspect that's happened in Europe. I suspect it's happened in Asia. So I don't want to downplay the impact on our manufacturers. I mean, the LNG producers are paying $4 a gigajoule and now they're paying 10 or 11, and many of them can't handle that. So, this is a really complex issue, as you know better than I do. But I think
I wouldn't say that.
There was a time, when the gas prices went up to $20, that was outrageous because the international prices were nothing like that, and that was a lack of supply to the market and prices going up. Now, as I say, with international prices north of 30, it's a bit hard to be critical. I think indeed they're pulling their heads in response of the threats of what could happen to them.
Okay, and just a final line of questioning. It's my amateur observation that with the high prices, that actually caused a switch away from gas. So in some sense, the conduct by the companies themselves drove some of their market to a different place. They almost kicked themselves, put their foot in their own mouth. Is that a reasonable observation?
Yes and no, if I could. So yes, some people, I mean, when it goes from 4 to 10, you change your behaviour and you try and move away from it. So there has been much more a reduction in gas usage. I'd have to say 4 or 5 firms have closed down, which were big gas, so that's affected demand as well. So I think that has happened, but I think the real view is that I think the 3 LNG players, they are focused on the international market.
Yeah.
I don't think they are much concerned about domestic market. So I don't think they've done themselves any harm because their focus is overseas.
Sure.
Now,
Okay.
the other players, the non-LNG players, they do have an interest in gas demand being there.
All right, thank you. Thank you very much. I've always enjoyed our chats.
As have I.
And I bid you well.
Thank you
I
very
hope you have either a relaxing future, if that's what you want, or an exciting future.
It's exciting, not relaxing.
Okay.
Senator Chisholm? Yeah, just on behalf of Labor, Senator Sims, wanted to thank you for your long record of public service. I think a recollection recognised by an AO earlier in the year as well. So in the limited time I've been on this committee, we've always appreciated your efforts, and I'm sure I speak for all Labor senators who've been on this committee that they recognise your work as well. So all the best for what you do next.
Thank you very much, Senator. That's really good.
Thanks very much, Chair Sims. You go with our deepest respect and our kindest regards. Thank you very much. Thank you to all the witnesses from ACCC.
Thank you very much.
wasn't that coming. Yeah.
Oh.
Was it the ABS?
Yep.
Absolutely.
The only time I remember anyone getting angry with you was the others.
I've got a bit of a list.
That was a you, was that?
Possibly.
You would have been sitting over there.
Yes, okay, I
Yeah, well, perhaps we need to be sitting in community affairs. That happens or something. Lots of questions in there.
Can you give me?
They're scheduled for 50 minutes.
Yeah, they won't be 50. Can you come back in 25 minutes? Is that okay?
We're happy for you.
Oh, you are?
Very
Yeah.
well.
Oh, okay.
That would be
All right.
fantastic.
Okay, okay,
Yeah,
okay, Senator Ross.
Yes. We don't have to be.
Yeah.
Okay. Keep this. Right. You want to keep this as a memento?
It's triggering.
It's triggering, exactly.
Yeah. Okay, welcome Mr. Gruen and the team from ABS. Thank you for joining us today. Do you have an opening statement?
I don't, Chair.
You don't, okay. I'm going to, after discussions with the Deputy Chair, I was going to Senator Rice first, who has another commitment she needs to go to. Senator Rice.
Thanks, Chair, and lovely to see you here, Mr. Gruen. Given that ABS is usually on right at,
Indeed.
11:15, and they've decided not to stick around, or not on at all, getting, put off. So look, I just want to ask in particular, so with the last year's census, I mean, how far progressed are we with the processing of the census data now?
So the answer is that the processing is proceeding well. We are planning to have our first release at the end of June, and there have been some minor delays as a consequence of COVID, as a consequence of the fact that much of the work has to be done on site, and there have been some cases of people who have had to isolate because of COVID. So things are a little bit behind where we hoped they would be, but nothing too serious at this stage. And our plans are to release the first release at the end of June. I might ask Teresa Dickinson if there's anything she wants to add to that.
Teresa Dickinson, Deputy Australian Statistician, Census and Data Services Group. Not at the moment, but I'm happy to take more detailed questions if you...
Okay, look, I particularly want to go to the issues regarding sexuality and gender identity and the controversy over those questions at the time, and the fact that, the way that the census was framed, many people were not able to express their gender identity and sexuality or sexual orientation, were they? Do you have any indications of how many people, were not able to express their gender identity or sexuality because of the questions that were chosen by the Assistant Treasurer?
So just to be clear, the question that was asked in the census is a question about sex, not gender identity, and there were three potential options: male, female, or non-binary sex. The ABS gave advice to the government in 2019 about the pros and cons of seeking information about gender identity and sexual orientation in a census, and the judgment of the ABS at the time was that the arguments were finely balanced and that we did not make a recommendation one way or the other. The government chose to simply have the question on sex. So that's as the census was conducted. We don't have any information about what people would have answered to a question that wasn't there.
No. So we don't have the information we need on sexuality and gender identity.
Well, not from the...
Certainly that the peak bodies and people from the LGBTIQA+ community know that this is critical data so that they are being appropriately counted.
So not from the census, but we have substantial surveys where we do ask those questions.
Before I want to come to those, and before we do that, How many complaints did you receive about the problems with the fact that there wasn't a question there and that people were not able to express what, for many people is a really critical part, a fundamental part of their identity?
So I received a few letters and I have responded to those groups by saying I'm happy to meet with them. And one of the things that I've said is obviously there will be a process in the lead up to the 2026 census in which we have a look at what are the appropriate questions for that census, and I have encouraged those groups to make submissions when the time comes. But I'm also happy to meet with them.
So you received a few letters. I think there was an option for people to send feedback on the census in some way.
Yes.
Which I know I personally did, because I felt that, yes, my sexuality, which is an important part of my identity, was not, not something that was questions were being asked about. And having, my late wife having been transgender, knowing that her identity as a trans woman would not have been counted in the census. What happens, what's the processing of those comments, which I certainly haven't received a letter back from you asking to meet.
So when we received those comments, when people completed the census, we looked at them, but not attached to names. So we looked at the results that came in, we looked at the feedback, most of which was about how easy it was to complete the census or not. There was a very small proportion, and I can't tell you the proportion, that were about the questions themselves. And some were, there's too many questions, and some were about particular questions that people would have liked to have seen or were unhappy that were on the census. But they were very much a minority.
Given the controversy over the lack of questions about gender identity and sexuality, did you do any analysis of the comments that you got back about those questions, or the lack of those questions in particular?
We have done an analysis of the feedback that came in generally, yes.
Are you able to table that analysis?
I can certainly find what we've got on that and make it available.
Okay, thank you. So can you tell me, Mr. Gruen or Dr. Gruen?
Dr. Gruen.
Dr. Gruen.
I answer to both.
Thank you, Dr. Gruen. You talked about other surveys that are being done, the census not having those questions. Just quickly outline for us what they are.
So I might get Michael or Helen to talk to that. But certainly they're health surveys that ask questions about sexual orientation and gender identity. Do you want to?
Thanks, Dr. Gruen. Senator Helen Wilson. I'm the Deputy Australian Statistician of Statistical Services Group. Questions on gender identity and sexual orientation will be included in surveys that are being undertaken as part of the intergenerational health and mental health study, which is rolling out as we speak.
And what's the sample size in that?
Oh, that's a very good question. I think I do have that here. For our mental health study, which is part of the intergenerational health and mental health study, we're aiming for around 17,000 people over 2 cohorts over 2 years.
Okay, and so the sexuality and gender identities are included in that mental health study?
Yes, that's right.
Okay, and I presume you've consulted with peak LGBTI organisations in the construction of that survey, and that element of those surveys?
We consulted with a range of experts as we developed a new standard. We released a new standard on sex, gender, variations of sex characteristics and sexual orientation variables. Now that standard then underpins and guides the questions that we will be asking through the intergenerational health and mental health study.
I wanted to go to that standard, so it's being used in those questions. Is it being used in any other data collection?
Not at this point. I will triple check, but not at this point. But the aim of the new standard, as we roll out any new surveys into the future, if questions are going to be asked, we will be guided by the new standard.
Okay. But at this stage, it will just be the intergenerational study that's being used in. Thank you. Thanks very much. Thanks, Chair.
Thanks, Senator Rice. Senator Walsh, some questions?
Thank you very much, Chair. Just going back to the census and the fact that it was conducted almost entirely online last year, and taking note of the fact that you're not releasing any of the first reports or results, thank you, until June. Do you have any indication of any changes to the response rate from the methodology that was used last year?
So an online option has been available for the previous two censuses, and the proportion of people who have taken up the online option has been rising from one census to the next. And the online response for the 2021 census is just shy of 80%. So there's still 20% of people who filled it in on paper. I think as part of checking the results, one of the standard things is to make sure that you don't have serious effects that depend on which way people answer the census. I don't know whether you want any more detail about that.
Yeah, could I just go back a step? So,
yes.
So this may have already been made public, and
right.
Apologies if it has, but so you just said the response rate to the last census was 80%.
Sorry, no. I apologise. That's the proportion of people who filled it in online. The
right.
response rate, our target response rate was 95%.
Yeah.
And we are confident that we will do better than that.
Okay. And do you have any indication of any difference in ability to achieve that target response rate for the last census as compared with previous censuses because of COVID and the shift to predominantly online?
So I think the fact that with COVID, I think COVID meant that in lots of neighbourhoods it was just a lot easier to fill it in online. And we also encouraged people, if they knew where they were going to be on census night, which plenty of them did, to fill it in before the day. And we got a very substantial response. So I don't think COVID has had an impact on our ability to assess for households where there was no response, whether they were vacant or not, because in lockdown areas we have to find other ways of finding out whether a dwelling was unoccupied. But in terms of the actual response, I don't think COVID hurt the response rate.
Right, okay. And so would your thinking be that you would continue to embrace online methods for this major data collection in the future? So
one of the things that's front of mind for us is making it as easy for people to fill in our surveys as possible. So we will continue to have paper as an option, but we will encourage people to fill it in online, partly because that reduces the cost of processing it.
Okay. Of processing, not of collection?
Well, collection as well. Both.
Yeah.
Both. I mean, to the extent that the thing is electronic. No, both. You're right. Collection as well as processing.
Yeah. Just in a general sense, I guess when you look across the work of the ABS, are there sort of major areas where you're looking to expand existing data series or introduce new data series? And conversely, are there areas where you're looking at reducing or cutting existing data series?
So we've introduced some new data series as a consequence of COVID. So we introduced a couple of rapid surveys. Early in the pandemic, we introduced a small business survey and a small household survey, small being having a much smaller sample size than would be our normal practice, in order that we could publish the results quickly. And we ran those surveys for an extended period, and then the funding for them came to an end. But with the Omicron wave, we've had considerable interest in restarting those rapid surveys, and we've done that. So we've restarted the rapid business and household surveys. That only relatively recently, the first results from the business survey were published within the last 10 days. Those are new. Another area where we've been producing new statistics has been in taking advantage of what is called big data, and so we're in the process of introducing new statistics on a monthly frequency to track, first of all, business turnover, where we are using business activity statements from the tax office to prepare those, and we've been publishing those since late last year, and we're about to introduce a new household consumption measure, which will have significantly wider coverage than the retail trade survey, and we're going to be publishing that later this month for the first time, and that will use bank transactions data to de-identified bank transactions data to give us a better handle on household consumption than you can get from the retail trade survey. So those are a couple of areas of where we're doing new things. Single touch payroll was obviously a big addition to our labour force statistics, which we introduced from April of 2020, which relies on the single touch payroll data from the ATO and gives us a window into the employment experience of slightly more than 10 million people. So it's very big data. We're not, I don't think there are any significant areas where we're looking to not do things. There might be there may be circumstances where we reprioritise things, and therefore there might be some products that we stop doing because we think there's something that's a higher priority. And the other thing that is that has been an issue is that we've had an extended period of time where face-to-face interviewing has not been possible. We've gone back into the field now with face-to-face interviewing, but with COVID waves, that's something that we keep under constant review. And the fact that there've been extended period when we couldn't put our interviews in the field has meant that we have been unable to achieve response rates that we had previously thought we could achieve for some of our social surveys.
Thank you. With the sort of the emerging and new series that you've referred to there, so the payroll jobs series, which has been there for a while, based on single touch ATO data, and then you've referred to new or emerging series around BAS statements and bank transactions, and you've talked about those being new series based on, did you call it big data? That sort of other data sets, not
yes,
not
administrative
your
data sets of one sort or another.
Yeah. So why is that trend happening? Is it just because I did used to spend a lot of time in the actual ABS when there were big paper books of data collected by the ABS many years ago, and many things have changed since then. But is that a trend towards using these other data sets? Why is it happening? Is it happening because there's just this great invaluable data and you can develop protocols and get good insights? Or is it also related to changes in the overall capacity of the ABS to collect its own data?
So I think it's related to the digital revolution. So there are all sorts of digital platforms that produce data as a consequence of digital interactions with citizens, either with private entities or with the government. So single touch payroll is a an innovation that enables the tax office to interact electronically with businesses, and as a consequence of that, there's an extremely valuable source of data that's collected. So I think the short answer is that the digital revolution has in its wake created a data revolution and generated enormous amounts of data, whether we're talking private sector or the public sector, and we are keen to use that data to generate public value by publishing it, cognizant of the fact that it's important that we keep privacy front of mind to make sure that we're not breaching the privacy of the individuals or businesses who have supplied that data.
And how does that trend, given the availability of that data because of the digital revolution that you've described, how does that change the ABS? How does it change your organisational structure and what types of people you have working for you doing different tasks?
So it's still the case that there's a big role for surveys, because the data that you get from these alternative sources is not exactly representative of the population. So it's been collected for reasons other than for statistical reasons. So you can imagine a world where there's a hybrid. So you have information that you get from surveys, and you combine it in some way with big data, and that gives you a more powerful picture of whatever variable that you're interested in. But it would be wrong to suggest that the arrival of big data spells the end of surveys. It won't. But you're correct that it broadens the range of skills that people at the ABS have to work on things that are surveys on the one hand, but building the platforms that enable us to get big data and analyse it in a secure way. That's a whole set of skills that we are developing.
I think I could continue down that path for a while, but I see other senators, so I'll just ask a final smaller question, which is that I think the last census removed a question on internet connectivity, and so the question is just how do you now collect data on that, and how can we see that data reported?
So the question that was removed was about internet connection to the home, and it was a lot less relevant this time because people have internet connection to their phone, not necessarily to their home. So do you want to add anything more about how?
In terms of availability of data on that particular issue, it's now ACMA that do the publishing on that, so the Communications Media Authority.
And do you have, how does their collection and reporting of data compare to what you were able to do before? Is it comprehensive?
I don't know the details of their data. My colleagues in the Statistical Services Group might.
I might just ask that on notice, just in the interest of time, whether we could have a comparison of what questions were asked prior and how the data was collected and reported, and how it is even, albeit by
another agency.
By another agency, if that's appropriate. Thank
you.
you.
Of course, the question was on the census, so it was only asked every 5 years.
Yeah. Thank you very much.
Senator Walsh. Now, Senator Roberts, Senator McDonald has kindly ceded her position to you on the question order. So, collegiality amongst Queensland senators. So, away you go.
Thank you, Senator McDonald. Thank you, Chair. And thank you all for being here. My questions have to do with death data, particularly from COVID. Can I reference and information gathering? Can I reference your diagram entitled Data Flow for Doctor Certified Deaths? I think that's it there. It's off your website.
Do you need a copy of that, Mr. Gruen, or you...
It's a question of whether it's in this publication or not, but I know a copy would be helpful.
So, sorry, Mark.
Yeah. I'm not sure this is speeding things up.
Multitasking.
So, just in summary, it's a really simple workflow. So it's a data flow for doctor-certified deaths. The workflow is someone dies, death event, doctor certifies, or it goes to a funeral director, but that's only a small percentage, and then from there it continues to where the doctor then sends a certification sent to the state births, deaths and marriages, and then from there that is sent, the state officers send data weekly to the ABS. That's broad summary.
And of course, Senator, it doesn't include deaths that go to the coroner, so it's not all deaths.
Yes, correct. So, but that's a small number.
20%-ish, I think.
20, okay.
I believe so.
But they eventually get entered in later.
Later,
when
right.
the coroner's
That's
resolved.
Right. Pardon? Yes.
And we've also got the Queensland process here, but that just verifies what you're saying. Could I have a copy back, please?
Yes, certainly.
So is that correct?
This?
Yeah, that.
Yes, if it came from our website, it's correct.
Yeah, and my summary, which is backed up by
I
the
think
Queensland.
the summary, I think that I didn't hear anything in the summary that I would take exception to.
Thank you. When a doctor certifies a death, they certify a cause of death. Thank you.
Mm-hmm.
If the cause of death is unknown, the matter is referred to the coroner to decide. Between 86 and 89% of deaths are doctor certified, meaning we know the cause of death at the time we know of the death.
Mm-hmm.
So my question is, the transfer of doctor certified death data from the states to the ABS takes, how long does that take? And has this reporting time changed over the last 3 years?
We can take that on notice exactly how long it takes, but certainly what we have started to do, and we started doing this, I think in 2020, was to start publishing deaths data purely on the basis of deaths certified by doctors. So before that, we had an annual publication of all deaths, but it was very substantially delayed. So the annual publication would come out something like 10 months after the end of the year for which it was reporting. And one of the other things that we did as a consequence of COVID was to see whether we could provide useful information on mortality much faster. And so we instituted a new publication which is monthly, which is called Provisional Mortality Statistics. And what we do is report on doctor-certified deaths that we have collected up to that point in time.
Okay. And then if they come in later because the doctor was slow or whatever, you add them.
Exactly. Exactly. So in other words, if you look at the subsequent month's publication, it will have slightly more certified deaths in the previous month because new ones have been added. That's correct.
Okay. So referencing your website, the causes of death in Australia, the last data release, I think you may have explained this, was September 2021 for the period calendar 2020. That's what you said. It was about 9 or 10 months later. So that's the most recent. Is this the most recent data other than the COVID data released on the 15th of February, which, that's this one here. COVID mortality in Australia. Yep.
I've got it. So the answer is there's the annual data is the deaths from all, both doctor and coroner certified. That's the annual data. But we are, as well as that, doing a monthly publication of just doctor certified deaths. And those have come out those come out monthly.
So the annual is accurate in terms of it got the coroners and...
It's complete.
Complete, thank you. Yeah, they're all accurate, I hope. So let's continue. So referencing the COVID-19 mortality in Australia, which you have in front of you,
Yes.
issued 15th of February 2022,
Yes.
quote, it says, COVID-19 deaths that occurred by 31st of January 2022 that have been registered and received by the ABS, end of quote. So here we've got death data and cause of death data that's only 2 weeks old, not 3 months old for a single mortality figure or 10 months for the cause of death. This report, could you go through that report on the bottom of the first page, Mr. Gruen?
Mm-hmm.
2,639 deaths where people died with or from COVID. What do you mean by with or from specifically?
So that's explained later in the document.
Is that on?
The
that's
vast
on page
majority
3?
of them are from. A small number are with. So if you look at page 3, it explains. There were 83 deaths which were COVID-19 related. Sorry, I'm reading from a dot point in the middle of page 3.
No, I've got it. I've got it
Good.
circled. Yep.
83 deaths which were COVID-19 related. The person died with COVID-19, confirmed or suspected, but it was not the underlying cause of death.
Right. So COVID was not the underlying cause; it was something else.
That's right. So just to be clear, there were 2,704 deaths that were either with or from COVID.
Yes.
And of those, only 83 were with, the rest were from.
Right. Okay.
So the vast majority are from.
So that's the cause of death was COVID. Okay. So if we turn over to page 2, at the top of page 2, you have chronic cardiac symptoms were the most common pre-existing chronic condition for those who had COVID-19.
Yes.
Certified as the underlying cause of death.
Yes.
That goes back to the previous page, the second bullet point. The majority of deaths had an underlying cause. So where would that fit in? The 83?
No. So there were a substantial proportion of the people who died from COVID had pre-existing conditions.
Right. Okay.
Right? The pre-existing condition didn't kill them, but the COVID was the underlying cause of death.
Right.
But the fact that they had a pre-existing condition was material.
So is there any percentage of those who died with or from who had chronic cardiac conditions?
Yes. It's a good publication, Senator.
Yes, it is.
It's worth reading.
Yes, I haven't read it all.
No, that's okay. Associated causes conditions in the causal sequence, page 8. That will tell you about all the pre-existing conditions. Sorry, pre-existing conditions, page 9. And there's a chart on page 10 which shows you what the conditions were and the proportions.
So that's percentages, are they?
Yes.
Okay, so these are percent of the 83 or?
No, percent of the 2,000. No, we're talking about people who have, yes, so yes, that's it. Pre-existing conditions were reported on death certificates for nearly 70% of the 2,556 deaths due to COVID. That's a sentence at the bottom of page 9. And then the conditions are that chart.
On the graph.
The chart shows you the proportion of chronic conditions that were reported on the death certificate.
Okay.
And you can have more than one, cheerfully.
Cheerfully, right. Okay. So turning now to birth data.
Oh, that's not going to help.
The Australian Bureau of Statistics releases birth data at the end of the year following. Now, this data could influence the debate around the effect of vaccines on reproduction and may provide reassurance to vaccine customers. Why does it take so long to report on a simple metric like births? I understand the delay in the deaths for getting the accurate annual figure, but why does it take so long for births?
Yeah, so I don't know the answer to that question.
I will take that on notice, Senator.
Yeah, we
Thank
can
you.
certainly take that on notice.
So the Australian Bureau of Statistics budget has grown 18% in the last year from $497 million in 2019-20 to 588 million in 2021. Is that enough to get your data out in a timely fashion?
So, as you would be aware, the Bureau publishes data across a very wide range of topics: economic, social, environmental, demographic. And so, obviously, timeliness is one of the things that we care about. And in answer to Senator Walsh's questions, I was talking about some of the new products that we have produced that have been much more timely to help decision makers in the pandemic. But there's no question there's a limit, and the other thing that we care critically about is accuracy and making sure that what we produce is correct. So some of these things do take a substantial amount of time. That we are cognizant of that, and we do our best to publish them as quickly as we can. It ultimately is a function of the resources available to us.
Senator Roberts.
Last question. What you're saying, and I would agree if this is the case, is that it is better to have accurate data a little delayed than timely data that's not accurate.
It depends on the circumstances. In a situation where a pandemic has just broken out, we made the judgment that we were happy to produce data that was somewhat less accurate, fast.
Okay.
So there are circumstances where you make that, where you are willing to accept that trade-off.
Is there any way we can get the birth data more quickly?
So let's take that on notice.
Okay. Thank you. Thank you very much, Chair, and thank you again, Senator McDonald.
Thank you. Thanks, Chair. Dr. Gruen, I just wanted to give a shout out to the ABS's. I follow your LinkedIn page. I assume the Facebook page is equally fabulous. And for anybody who's listening, in the words of the rock great Molly Meldrum, do yourself a favour and follow it, because it's hysterical and you learn all sorts of useful, interesting things. So,
well, the team that puts that together will be delighted to hear that. I actually follow it on Twitter, and it's certainly the case that I learn things too.
And surprising things. I don't know if you heard last night, I was asking questions of the RBA about CPI construction. I've got a particular interest in regional Australia and the 30% of homes that are outside of capital cities. Mm-hmm. Inflation has moved quickly in North Queensland because of the cost of insurance. Rentals increased by 25% over the last 4 years as unit and homeowners pass the cost on if they're renting out. Mm-hmm. I'm sure there's positive metrics as well, but we have no way of measuring CPI in regional places. I understand about 10 years ago there was a campaign from a Townsville-based economist, Colin Dwyer, to see if we could get a regional CPI index, and at the time was told that there wasn't a budget for it. But I would like to get your thoughts, and specifically, we've just introduced legislation on the reinsurance pool for Northern Australia. I wonder if there'd been a suitable metric, we would have been alerted to this looming crisis earlier, and it would have been easier to convince the rest of Australia that this was something that was required using the data.
So you're correct that the CPI is a measure of consumer prices in capital cities. That's what it is. And ultimately, it is a question of available resources. I guess one of the things I often say to people in the ABS is we've got more good ideas about data to collect than we've got resources available. However, the resources are going to be limited in all feasible circumstances. It would be possible to calculate a regional a CPI for regional Australia. That would be possible, but it would take resources.
And as you're saying that, I'm thinking, well, regional, that's such a broad topic.
Indeed
but,
it is.
You know, major regional cities, perhaps, that would reduce it somewhat. But, okay, so what you're suggesting to me is that this is a resourcing issue and I should be taking it to, you know, the Treasurer or Minister and asking for additional resources to do that. I shall do so. Do you see a value in what I'm proposing, or do you think I'm being a little bit too granular?
No. I mean, as I say, I think there's value in collecting lots of things, and I think regional CPIs would be interesting, but it wouldn't be cost-free. Yeah. The other consideration for the CPI is frequency. We collect the CPI quarterly, and most countries do it monthly. So there's, I think us and New Zealand are the only advanced countries that do it quarterly. So there's more than one dimension on which you might expand the CPI.
Could I ask you, if you don't have the data here, what sort of resources it requires quarterly to collate?
Sure.
And prepare? Or, yeah, what sort of resourcing you need, and that'll give
we
me
can
a
certainly
starting
take that on
plate too.
notice. Yeah.
Thank you. Thanks, Chair.
Excellent. Thanks, Senator McDonald. Senator Rennick, thank you for your patience.
Yeah, no worries. Hi, guys. I noticed in your provisional mortality statistics from January to October 2021, you gave a set of numbers that had doctor certified deaths, but it excluded coroner referred deaths. Does the ABS actually have figures on coroner referred deaths now, or how does that work?
So you missed the answers that I gave to Senator Roberts.
Yeah.
So the answer is that we get doctor certified deaths much more quickly than we get coroner certified deaths. Yeah. And one of the judgments we made early in the pandemic was that it would be of considerable value to people to publish the provisional mortality statistics based solely on doctor certified deaths. We have an annual publication which includes both doctor certified and coroner certified deaths, and that's a long-standing publication.
Sure.
We have introduced this new publication, which we introduced in 2020, to look at the significant majority of deaths that are doctor certified. We think it's a bit over 80% that are doctor certified, but they don't include. But you have to wait for the annual publication to get the complete picture.
Okay, so how far away will that be? Do you know?
So I think actually Senator Roberts quoted the answer to that. So it's about September of the year following the year that you're publishing the results for.
Calendar year or
calendar year?
Calendar year.
Right. Okay. So that it takes about 9 months to get the data out, and you don't have any provisional coroner death figures.
No, we don't have provisional coroner deaths figures. We publish provisional doctor certified ones.
But just as a benchmark, it normally runs 80-20, does it?
I think it's a bit more than 80% are doctor certified.
86%. Okay then, cheers. Thanks very much.
That's all right.
Okay, excellent. I think that finishes questions for the ABS, so thank you very much for joining us. It's greatly appreciated. We're running a little bit over time, so we will take a 10-minute break, I think. Senator Walsh, I think we need that. So we will come back at... I'm not on a 5-minute, so it's... What is it? It's 12...
12:08 now, so 20 past 12.
About 20 past 12. We'll make it simple. 20 past 12, we'll come back. Farewell, Senator Hume. We just have some reorganisation. We're actually going to release, if that's the right word, the Office of Innovation and Science Australia. We're also releasing the Australian Nuclear Science and Technology Organisation, and we're also releasing Geoscience Australia. Not releasing you, Minister. or you, Mr Fredericks.
Good, Chair.
The committee's proceedings today will resume with the industry portfolio, beginning with the Department of Industry, Science, Energy and Resources cross-portfolio and corporate sections. The hearing will then follow the order as set out in the circulated program with the modifications I've just provided. The committee has set 25 February 2022 as the day by which senators are to submit written questions on notice, and 25 March 2022 as the date for return of answers to questions taken on notice. I now welcome Senator the Honourable Zed Seselja, representing the Minister for Industry and representing the Minister for Science and Technology. I also welcome the Secretary of the Department of Industry, Science, Energy and Resources, Mr David Fredericks, and officers of industry. Minister, Secretary or officers, would you like to make an opening statement?
No, thank you, Chair.
No, thank you, Chair.
Okay. I'll now give the call to
Yes.
Senator Walsh.
Yes, thank you very much, Chair. Thank you all for being here. I have some questions about rapid antigen test manufacturing.
If you just pause, we'll just bring the relevant officials to the table.
Just kick off as you get settled. We're obviously coming out of a period of serious supply challenges on rapid antigen tests. It's known now that industry approached government back in October 2020 to talk about support for manufacturing rapid antigen tests here in Australia. Are you aware of those representations of industry to government? The Industry Association, for example, Pathology Testing Australia, has reported that they approached government in October 2020 and also the company Lumos in October 2020. Are you aware of those representations, and were you engaged in a response towards the end of 2020 about opportunities for manufacturing these tests here in Australia?
Thank you for your question, Senator. Jane Urquhart, Acting Deputy Secretary. I'm not aware of the approaches as you describe them. It's certainly the case that the department has obviously taken an interest in manufacturing capability, including in respect of rapid antigen testing. And specifically in the period sort of August through to October, when Delta was the dominant variant, and in that particular context, we undertook some work at the request of the Department of Health looking at the use of rapid antigen tests in workplaces. And we have, particularly since December, with the emergence of Omicron, been looking at the utility of domestic manufacturing. But your mention of Pathology Testing Australia, I'll turn to my colleague just in case she's aware of that particular approach.
I might just mention that we have been, Donna Looney, Acting Head of Industry Growth Division. I might just mention that we've been engaging very closely with Pathology Technology Australia over the last couple of months, and been in very productive discussions with them to understand the current supply situation or the supply chain situation with regard to rapid antigen tests. We've also spoken with Lumos of Planet Innovation since we started looking at that supply chain work in December. We met with them in January. So we've been engaged with them, with industry more broadly, to understand that supply chain environment.
Yeah. And so just to get a bit of a time frame in my head, I've presented information about the end of 2020, which you're not familiar with. That's fine. I don't have any point to make about that.
So I would just say that in 2020 that there were approaches to government. We had our regional network, our Oz Industry Network, working with companies. I can't say that I'm aware of the two that you mentioned, but I do know that we had Oz Industry working with some companies in that space, looking at what support might be available at that time.
Okay. I'm glad you added that to the record. So you are aware that representations were made and government was working with industry about rapid antigen testing in late 2020.
In the context of seeing what there was available at that time, and in that context, to support business development in that space at the time.
Right. Can you just clarify what you mean by that? What were the objectives of those sorts of conversations?
So we have. I was going to say we have a network of business advisors through our EP network who work closely with firms in all sectors, and they worked alongside my division to make industry at that time, as we do, like I said, across all sectors and businesses who reach out for advice of the programs that may have been relevant and available to them at the time. It's then up to those firms to pursue any programs that they may have an interest in or that they may be eligible for.
Yeah, Senator, if I could just add to that, just to say, you know, we have a network of 100 business advisors and obviously a lot of interactions going on between the department on the policy side, as well as in through networks like the Entrepreneurs Program Network. And so, you know, without doubt there's been interactions with, you know, medical product manufacturers around programs available that the government is running, and, you know, we're sure that there has been interactions where information has been provided in that way. But I think I'm just struggling a little bit with the specifics of your question. Is there a particular approach that you're referring to?
I think I just have media reports of Lumos and Pathology Technology Australia approaching government in October 2020 or around late 2020 to talk about what support was needed specifically to deal with the demand that they foreshadowed for this equipment. And so I'm wondering if there was any sort of, if you're aware of any special representations outside of your network, and whether you had any special or specific response to approaches about the need for us to manufacture these things in Australia at that time.
Senator, I would say that, you know, it's entirely possible that Lumos approached the department sometime in 2020. I mean, you'll recall at that time PCR testing was the gold standard. Rapid antigen testing at that time was not recognised by the TGA for home use. But it's entirely possible that we were talking to entities like Lumos. You know, the National Manufacturing Priority on manufacturing of medical products means that we have a lot of interaction. The other thing I would note is that I think it is Lumos who's been engaged with Victorian Government, and there is Victorian Government support going to Lumos and its activities. And as Ms Looney said, we have more recently, this year, been talking to Lumos just in terms of looking at domestic manufacturing and, you know, sort of deepening our understanding of the supply chain and how it operates.
Thank you. So when did you, Ms Urquhart, you talked about starting to look into this more closely during the Delta outbreak. I've got COVID brain and can't remember which one was when. Being a Victorian, it's all the same. Don't say anything, Senator Seselja. But I
didn't.
Yeah, but so you started working on this in a more sort of concentrated way in the middle of last year?
So, Senator, you'll probably recall from previous exchanges with us that since about February, March 2020, this department's undertaken a range of activities on COVID, mostly in support of the Department of Health, and mostly on, the sources available of different types of PPE, the state of domestic manufacturing and that sort of thing. When I responded to you then, what I have in my mind is that, most recently, from about August through to October, this department was assisting the Department of Health on the utility of rapid antigen testing in workplaces. We were having, discussions with industry at that time about their views about the utility of those tests. That came before the Omicron variant was declared both as a variant in South Africa but also present in Australia. So we were in an environment where I think, the caseload in Australia was fairly low. PCR tests were doing very well. But nonetheless, I think industry was very interested in talking about, alongside the national plan, resuming their activities and the utility of different tools in that context. So we were doing some work with industry through various fora about that. More recently, though, and I think the date in my mind in terms of the declaring of the presence of Omicron is 24 November, 27 November in Australia. Since that time, obviously, we've seen massive rise in infections and a consequent impact on supply chains. Now, obviously, public health settings matter for the Department of Health, but we've continued to try to support health and home affairs. Just in, collecting information and so on from our stakeholders to support that effort.
Yes, and I appreciate the massive amount of work that you've been doing through through this crisis. I am trying to figure out whether at any point you sort of put a concerted effort into considering whether and how to support a domestic rat manufacturing sector in Australia. Was there ever anything sort of written down, a document, a plan about this is how we can support domestic rat manufacturing?
So I would say, Senator, that particularly in the last 6 months, because of that tasking around, the utility and workplace settings, we've been interested in, what exists in the way of domestic manufacturing, what are the international import sources, that entire picture.
So your role is has been, how do we look at all the sources of supply to get them out there? And I guess I'm sort of asking these questions in the context of your role as trying to rebuild Australian manufacturing, which we often talk to you about. So I think that's the disconnect here. I mean, was there a point in time where you thought, let's make these things here, how are we going to do that?
So, Senator, I guess what I'm trying to present is that we've undertaken work firstly and towards the end of last year around workplace settings, more recently in terms of the supply chains and the obvious problem around supply of rapid antigen tests. In that context, we have looked at manufacturing, and it warrants even further analysis. You'll appreciate when we look at the opportunity for manufacturing in Australia, we want to be satisfied on a number of criteria. We want to understand the longevity of public health settings, the likelihood of demand being of a sufficient quantity to warrant or be able to sustain a domestic manufacturing capability. We want to understand how the supply chain works in terms of international sources of rapid antigen tests, what that broader market looks like that an Australian capability would be competing into. We know that there is at least one assembler of rapid antigen tests in Australia, but that is also reliant on imports of the components of that. We're aware too of other manufacturers that don't have TGA approval for supply of their product in Australia, but exhibit the opportunity, I guess, to pursue that. And thirdly, I think, and most interestingly, through our modern manufacturing strategy and our engagement on the National Manufacturing Priority, and through some of the program opportunities, there are some exciting diagnostic technologies developing amongst Australian entities that we're very interested in and that are being supported through government programs that we think also potentially offer the prospect for manufacturing in Australia.
So I think Ms Looney said before that if you'd sort of been approached, you would have referred people to the existing programs in the modern manufacturing strategy. So you're nodding. So that's the general approach that you would have taken. And then Ms Urquhart, in the context of all of the work that you've been doing, which has been about supply, not just about manufacturing here, it sounds like you did analysis, you asked a lot of questions, which you've just presented here. So what was, I guess, the outcome of that reckoning? Was it that we don't need a dedicated strategy to make rats in Australia?
I would say, Senator, that that's an ongoing question that we're investigating, and that's a matter for government. But I would also say that, in the broad, our activities would not just be to point people towards existing opportunities, but to also ensure that capabilities or knowledge of capabilities in Australia, were brought to the attention of relevant parties in government. So that would include, our own ministers, but also, departments like the Department of Health, Department of Home Affairs running the National Coordination Mechanism.
Have any rapid antigen test manufacturers with plant in Australia successfully accessed any of the funds available within the modern manufacturing strategy?
So there are a number of companies offering interesting diagnostic technologies that have taken up opportunities and I think we have a few examples.
But specifically rapid antigen tests, I think is what we're after.
Well,
So we have various types. So I'll use one example, a WA-based firm, Alkalizer, who were funded through the Advanced Manufacturing Growth Centre run commercialisation fund to develop a mass market saliva-based antigen test to detect COVID-19 in asymptomatic and symptomatic patients within 10 minutes. So that work has been supported through that program and is progressing. So that's a specific one. I can also give another example of a New South Wales-based company to upscale their production capacity to produce 1 million COVID-19 or other pathogen tests per month, and that's an agreement between that company and the Department of Health. So there are things happening.
So, given that you've been involved not just in trying to foster manufacturing here, but you've also been involved in the broader supply issues throughout COVID. And, we've just had a period where both state and federal governments have put massive orders in for millions of these tests. Are you able to tell us roughly what the proportion is of those tests which we've imported over a recent period versus those that have been manufactured in Australia?
I would obviously need to refer you to the Department of Health on their procurement, but simply to say that I think you would find that the bulk would be coming from overseas.
Yeah.
Well, I think all of them are, aren't they?
I wouldn't be able to say, Senator. I'm not looking after the Department of Health's procurement of rapid antigen tests.
But you have been involved in, from all your previous answers, in trying to understand where supply could come from, and broadly, Senator Watt is right that the vast majority, or even all, not quite all, because you've referenced a WA facility there, the vast majority of these tests have been imported.
So the examples that we've given you are companies that have had support to develop those capabilities. The extent to which, Australian suppliers have been brought into the health procurement, you'd have to ask Health. I really can't say, but I would expect that the majority is sourced from overseas.
Right. So, Minister, I might get some of your thoughts on this because, essentially I think what we're hearing is that companies went to government towards the end of 2020 and said, we see that this is going to happen. We'd like to manufacture these things here. We're looking for some indication of government support about how to do that. I note that those representations were made at exactly the time that government launched the modern manufacturing strategy at the end of October 2020 and made medical manufacturing one of the priority areas. And then we get, we track forward to January, February 2022, and we've had to rely primarily on imports rather than our domestic manufacturing capability in order to meet this critical supply issue. Isn't it a tremendous failure of government strategy and policy that we have failed to make these things here? We've had to import them instead, and a tremendous lost opportunity to use this crisis to rebuild Australian manufacturing, given that you launched the strategy at the very same time that people were coming to you saying, we can make these things here if you will work with us.
Well, the answer to your question is no, and I don't accept your characterisation of it. And I'll address a couple of the different points you've put to me. You're suggesting, one, that you could you could foresee what we saw with Omicron and how much that changed the need for different types of testing. We'd been relying, of course, on PCR testing largely up until that point, and obviously we saw the Omicron variant, which saw much larger case numbers than had previously been experienced. So you're in 2020 hindsight suggesting that people knew, or that you knew, or someone else knew that we'd be facing what we faced with Omicron sometime out.
The world knew. I mean, the world knew.
No, I don't accept that. I don't accept that.
Order and make these tests at the start of
And if I could also finish, and then also your suggestion that somehow that the answer to that, once it became apparent that more rapid antigen tests were needed, that there would have been the ability to, in such a short space of time, that the best way to deal with that supply issue would be to develop a onshore manufacturing capability for it, I don't think is reasonable. So what we've seen is, in fact, in dealing with this crisis and dealing with what we saw at the back end of last year and over the summer period with Omicron, is we've seen the need to source significant amounts of rapid antigen tests, and the government secured more than 78 million of those. But your assertion that you knew somehow and that even if one had anticipated that you could easily just simply manufacture them all here, they have to go through a detailed approval process, as you know, with the TGA, and the TGA has approved many of these rapid antigen tests. But as you say, most of them being sourced from overseas. But the key priority is to make sure that those tests are available, and that's what we've been working on.
Thank you. Sure.
Just to that last thing, so the TGA approval process is important, obviously.
Yeah.
And it is worth noting that at the moment as we speak, my understanding is, it's a matter for health, but my understanding is that at this stage, one Australian company has that approval. There are 2 or 3, I think, that are looking to try to get that approval, that are Australian-based manufacturers. I understand TGA is working closely with them. But it's important to understand. It's important just to recognise that TGA approval is a crucial step in the capacity for to come into the Australian market.
Yeah, I'm absolutely aware of the TGA approvals and the time frames. Of course, if government had have acted around October 2020, TGA approval timeframes would probably be less of an issue than they are today. And I just want to go back to the Minister's comments. I mean, I thought I heard you say in your answer there that you're not convinced, even knowing what we know now, that these things should not have been imported. That you're okay for them to have been imported if that's the best way to do it. I mean,
No.
would you prefer that we had have built domestic manufacturing capacity and created Australian
that's
jobs
not what I said
through
at
this
all.
process?
That's a complete verbling of what I said. What I said was, one, I don't accept your premise that. I didn't hear you, a year ago or more, a year or more ago, suggesting that this was the answer, as we were dealing with a very different phase of COVID, and so you've applied 2020 hindsight, going back to an outbreak that came late last year. So that's the first thing.
What did other countries order?
And then in terms of the priority in the short term of dealing with that, the priority is to get those tests. Of course, if they can be manufactured here, we want to see them manufactured here. But you need to look at what are the most effective ways of getting those tests. And as I say, we've secured 78 million of them.
From overseas.
Well, the secretary's pointed out
When companies
the one
were begging to work with you.
approval that's there. There is a TGA approval process. It doesn't happen overnight because we need to have those kind of assurances. But I just don't accept the premise of your question. One, you say it from 2020 hindsight in terms of a very different situation that you refer to in 2020 versus what we saw from late last year, and then also in terms of the solution that you're suggesting.
I'll just say again that it's not in question whether industry approached government at the end of 2020 seeking to work with you on a plan to manufacture these things. So hindsight is not required. Industry approached you at the end of 2020. The rest of the world was already manufacturing these and moving on it. We could have had domestic manufacturing capability set up here. Why didn't we? Why did government not act to make these things here? And if we had, could we not have avoided the crisis that we've just endured over this summer?
Well, I can ask Ms Urquhart to go into more detail again, as she has for you.
No, you're the minister.
And I've answered the question.
Walsh has the call. And
well,
has
the
had
trying to flick Senator
Watt, sorry.
Well, I'm happy to share the call with Senator Watt. We're okay.
That's not your call, Senator Walsh. It comes through the chair. But Senator Walsh, how many more minutes do you need? You've had the call for nearly half an hour.
Seeking answers from the minister, and I think he was about to give an answer.
Okay, Minister.
And so, I'm sorry, you'll have to just remind me of the question. I mean, I think you were putting to me again that that somehow we were able to perfectly anticipate the number of tests that were needed.
The way that you could have known is listening to
that could have then
Order. If for the benefit of everyone in attendance, for the benefit of parliamentary broadcasting, we can just make sure there's a clear delineation between the question and the answer. So please give the Minister the opportunity to finish his answer. Minister.
Yeah, so I'm probably restating my earlier answer, Chair, but and that is that the government has focused on getting access to as many rapid antigen tests as we can, and as I say, we've secured more than 78 million of those. I think there are more approved for use in Australia than there are in many comparable countries, and I just don't accept the premise of your question with perfect hindsight that as we were dealing with different phases of the outbreak, as we faced a new situation where rapid antigen testing became more important, we've sought to source those as quickly as we can, and you can't simply overnight develop that capacity to produce all of that in Australia.
I just want to have one more sort of answer here for people who have heard over and over and over again that this government could not have seen things coming, and that's why they didn't put measures in place. You've claimed that you would have needed hindsight to put domestic rapid antigen test manufacturing in place. Industry came to you in late 2020 and said, this is going to happen, we're going to need this, we can make them here, and you sent them away.
That's your assertion, but and as I say, you are applying perfect 2020 hindsight, because I don't recall you saying at that time that the urgent priority was to develop that capacity and that could be developed in time for the outbreak that we faced.
Okay, thank you, Senator Walsh. Thank you, Minister. Senator McDonald has some follow-up questions in relation. Sorry, hang on. Has some follow-up questions in relation to this matter. Then I'm going to be giving the call to Senator Cox. And then I'll be giving the call to Senator Patrick, okay? Just to
Thanks, Chair.
put everyone on notice. Senator McDonald.
Could I just clarify, what date did the World Health Organisation identify the Omicron strain of COVID-19?
I don't have that in front of me.
I think, Senator, the first case of Omicron was identified on the 24th of November.
That's right.
I believe. And the first variant in Australia was the 28th of November, confirmed by the New South Wales Department of Health. I think that's right, Ms. Lennon.
I would just need to clarify that we would need to just check that. You asked specifically about the World Health Organisation, so we would just need to check that date.
Thank you. And so what I want to understand is, when did the TGA start accepting applications for rapid antigen self-tests?
Senator, I don't think we can answer that. I think you would need to put it to the health portfolio.
What I'm trying to get to is that we had a new variant appear in the world. It was a variant that needed to have a specific, a rat developed for it. And I want to understand, the sequence of events that would have legally and ethically allowed for Australia to start approving or supplying those products.
Senator, if I may just respond to that. As Ms Urquhart said, it would be a matter for health to confirm that. But my understanding is that there was a pilot started in August. There was an announcement in September that rapid antigen tests would be considered by the TGA for approval, and the TGA in September released some information regarding that and started to take applications in October, with 1 November being the date that they were approved for self-use.
That's right, for home use.
For home.
For home use, terrific. Thank you.
Okay.
Thank you. I'm just testing to see if I've got the right officials in the room to talk about the Beetaloo drilling program.
Is that appropriate
Energy?
under this?
So it strictly falls in the resources, Chair.
Yeah, so is it possible, Senator Cox, for you to come back when we're looking at resources?
Yeah, I can do that.
Okay.
That's in which, sorry?
That's in outcome...
Outcome 3.
1.3.
Outcome 3.
Yep.
That's fine.
Thanks, Senator
Can
Cox.
do that.
Thank you. And if perhaps Secretary can just give Senator Cox a heads up when we're about to...
Thank you.
Okay, thank you, Senator Cox. Senator Patrick.
Yeah, thank you. I'm hoping I don't run into the same problem, but we'll see how we go.
If it's the same issue, it'll be the
well,
same.
Oh no,
Go on, Senator Patrick.
Yeah, sure. So my line of questioning comes from questions I've already asked PM&C and Treasury about government response to high fuel prices. And you guys have been mentioned, so as having done some work on this, particularly, for example, in relation to what happens in respect of a conflict between Russia and the Ukraine, how might we respond to potential shortages, but perhaps more in general, looking at energy prices. So not about drilling per se. It's
So is that a corporate?
Yeah, so we are in a difficult position there, Senator, just because. So we're kind of in industry estimates, and that the relevant people for that is in Outcome 3 Resources.
Okay.
Is where we traditionally deal with that, and we'll be able to deal with it at length for you because it's a good discussion.
Yeah, sure.
But I think we'd be better off doing that in Outcome 3.
I'm happy to take advice on it, but I didn't want to press it.
That'd help us.
That's the line of questioning I have, and I guess you're now forewarned. Later on, I'll just ask what industry has been doing in respect of those issues.
Okay. Right. Thanks, Senator Patrick. Do we have any more cross-portfolio corporate questions? Senator Watt, you have the call.
Thank you, Chair. Can I just keep going on this point about the local production of rats? Minister, I mean, you've got to accept surely that it is an absurd situation that it is easier to get an Australian-made rapid antigen test in the United States than it is in Australia. That is just surely absurd.
Well, I mean, I'm not aware of exactly what you're saying, and I can ask officials to address. I can ask officials to address that detail, that point of detail, if you'd like.
Well, Illume is the manufacturer I'm talking about, which is producing about 500,000 rapid antigen tests a day. They're earning hundreds of millions of dollars exporting rats to the US, but we can't get a locally made one here. Supported by the government of the US, you're right. A government that believes in manufacturing. Lumos have been approved for sale in Canada. Antiotech sells to at least 14 countries, including the UK, New Zealand, Thailand, Malaysia, Indonesia, Vietnam, Singapore, Myanmar, even Myanmar, Philippines, Turkey, Greece, Cyprus and Romania. How is it that people in all sorts of other countries around the world can pop down to their chemist and buy an Australian-made rapid antigen test, but Aussies can't do it themselves?
Well, I'll ask officials to go to some of the detail of that.
Thank you for that question, Senator. So Jane Urquhart again, Acting Deputy Secretary. In the two examples that you've cited, it's my understanding that they don't have Therapeutic Goods Administration approval for their product. And so I do wonder if, the question might be helpfully answered by the TGA in terms of progress in that respect.
My understanding is that the TGA has approved at least some of the Australian-made rapid antigen tests. I'll get that detail for you.
So, Senator, our advice is that they've approved Innovation Scientific, which is an Australian assembler of rapid antigen test kits, and I think they are on the market. But my understanding is Illume is still in discussions with the TGA in order to secure approval.
Well, what was your department doing as the department that is supposed to be building up Australian manufacturing to work with these companies and the TGA to get approval so that we could buy Australian-made ones rather than having to rush out and probably pay well over the odds for overseas-made rapid antigen tests?
Yeah, so I'll ask Senator Ms Urquhart to provide that.
So we have had exchanges with the companies, and we have had exchanges with the Therapeutic Goods Administration, Home Affairs, through the National Coordination Mechanism, where this matter of TGA approval for products has been raised.
And what did you do to encourage the TGA and these manufacturers to get it together and ensure that we could have Australian-made ones?
So my feeling, Senator, was that I recall the TGA having quite extensive contact with at least Illume in respect of their interest in TGA approval for their product. But beyond that, I'm afraid I'm not party to the exchanges on, the requirements for TGA approval and so on.
Because, Minister, it's not just me who thinks it's absurd that we can't get locally made rapid antigen tests when they're being exported. Former Liberal Treasurer Joe Hockey has used exactly that word to describe the situation. The Morrison government's failure to back a locally made rapid antigen test has been slammed as absurd by former Liberal Treasurer Joe Hockey in an article January the 21st this year. Is Joe Hockey wrong?
Well, look, I don't accept the critique, and
So Joe Hockey's wrong?
Well, I'm saying I don't accept the critique. So, but what you seem to be suggesting is that that we should overrule the TGA, or if the Labor Party were in office, you would not have the TGA processes, and you would therefore just make the decision outside of those TGA approval processes. I mean, I'm just trying to understand. Well, I'm just trying to understand because they're going through a TGA process. It's up to the TGA to approve them for use. Are you suggesting that we should step into that process and overrule the TGA's approval processes?
Well, I haven't said anything of the sort.
Well, then what is your suggestion?
My suggestion is that
my suggestion is that perhaps if we can just keep the questions coming from the senators on the committee.
Well, I'm happy to pose a question.
And the answers just to keep it flowing. So, Senator Watt, do you have further questions?
I do. So my suggestion, Minister, and I'll pose a question at the end of it. My suggestion is that perhaps when other countries around the world were manufacturing rapid antigen tests for at least a year before Omicron came along, and when numerous Australian manufacturers were pleading with your government to work with them to get Australian-made rapid antigen tests, maybe you could have listened. That's my suggestion. Why didn't you listen? Why didn't you do anything?
Well, again,
sorry, Senator Vang. Minister, please opportunity to answer the question.
That's a political point you're making, and I don't accept it.
Well, what did you do, Minister?
Sorry, Senator Watt, can you please let the
I think
Minister
officials have been through what we've done, and in relation to the particular company you're talking about, Ellume, I think you mentioned, I understand they're going through a TGA process. So, as I say to you, if you're suggesting that we should shortcut those TGA processes or somehow overrule those TGA processes, well, you should say so. But otherwise, it's not clear how you would have them approved in Australia, independent of or separate from our TGA approval processes.
Well, there's only one problem with that argument, Minister, and that is that Joe Hockey went on to say in this article that it was the Department of Industry, not the Health Department or the TGA, who wasn't prepared to back the biotech company. So why wasn't this department prepared to back an Australian manufacturer of rapid antigen tests?
I really don't think I can do much more than repeat Ms Urquhart's evidence. I mean, we've given evidence that at the time there was engagement with Illume. We've given evidence that consideration over a range of months was given to available programs that could be available to support. So there was that level of engagement with them. There was always the understanding at the end of the day the responsibility would be on them to seek TGA approval, and so we understood that. And the thing I will ask Ms Urquhart to refer to is just, it is worth understanding through that October-November period that at that stage Omicron had not in fact been declared by the WHO. That didn't happen, as I understand, until November 26. And secondly, the health settings determined by the National Coordination Mechanism, by National Cabinet, were relevant to that issue as well. So I'll just get Ms Urquhart to remind us of how the relevance of the health settings through that October-November period to the question that the Senator is asking.
Thank you, Secretary. So it was late November when Omicron became known and emerged in Australia very quickly, and then there was a rapid surge in cases in Australia, as you're aware, and it was in that context that public settings changed. And I think that followed AHPPC consideration as well as discussion in National Cabinet. Prior to that, PCR testing was considered, the sort of main testing tool in public settings across jurisdictions. And I would just take the opportunity to note, Senator, that, it was in that period, I guess, August through till mid-November, that we were in an environment of declining case numbers and where PCR tests were, fine in availability for those issues. The only other point I would add is that
I did want to be clear that the government has given support to companies on manufacture of diagnostic testing. We gave a couple of examples earlier that relate to rapid antigen testing, and I think it's also important to note the support of the Queensland and Victorian governments, which we have monitored closely, and we've engaged with state jurisdictions about their activities. So we're aware of the Queensland Government providing support to Illume. We're also aware of the Victorian Government providing support to Lumos.
Exactly.
And kept a watching brief on that. As well as you noted, the US support for Illume and its activities. And indeed been in discussions through the National Coordination Mechanism on the TGA approval processes, and been absolutely aware of quite a high degree of engagement by the TGA with companies like Illume.
Yeah, so thank you for that, Ms Urquhart. So, Minister, we've heard that the Queensland Government was providing support to Illume. We've heard the Victorian Government was providing support to manufacturers. We've heard the US Government is providing support to Illume. Is there kind of someone missing in this picture? Is it possibly you?
Well, no, you've heard Ms Urquhart refer to the support we've been giving, so no, I don't accept that.
Why do you always wait for things to become a crisis before you do something?
Senator Watt, order. Senator Watt, you must give the witness an opportunity to finish the question. You have an opportunity to ask the question. The answer is for the benefit of all of us. And there must be a clear delineation between the asking of questions and the giving of answers. So, Minister, please conclude your answer.
Thank you. And so Ms Urquhart has given examples of the support that's been provided. But in relation to the point you are making in terms of Illume, you are the only conclusion that one could draw from your suggestions and what you are putting to me and putting to witnesses here is that somehow we should short-circuit the TGA's approval
I've said nothing of the
processes.
sort.
Well, there's no other way to read
stuff up.
what you are putting to me. And if that's your suggestion, well, then you should be more blunt about it. But if it's not your suggestion, then it's very unclear what it is. Well, you know,
I've suggested nothing of the sort.
Then what are you suggesting?
Minister and Senator Watt, as
Well,
I
am I
said,
supposed to just sit here and
I've been watching.
have
Don't
words
worry,
put in my
Senator
mouth?
Watt. I understand. How many do you have?
A couple more questions on this.
Questions? Okay, please proceed.
Now, I've heard over the course of the morning or the afternoon that this suggestion that Omicron changed everything, we couldn't have known, all good in hindsight. But this wasn't only an issue that emerged when Omicron came along. Again, there's an article in the Sydney Morning Herald, December the 31st, 2021, where Melbourne-based Lumos Diagnostics Executive Chairman Sam Lanyon said the company participated in discussions about the local manufacture of rats in Australia with government representatives in mid-2020 as part of a federal government initiative to improve sovereign manufacturing capabilities. However, the talks ultimately proved fruitless. Now, if this was about sovereign manufacturing capabilities, I'm guessing the Department of Industry was involved in those discussions.
So, Senator, I will take what I'm about to say on notice to make sure I can qualify myself. But my expectation of those discussions that would have been happening at that point in time of the year would have been that, especially your reference to sovereignty, would have been discussions in the context of the modern manufacturing strategy and the modern manufacturing initiative. So at that time, as Ms Urquhart and Ms Looney both gave evidence, this department generally and through AusIndustry in particular was engaging with a vast array of Australian industry in those 6 priority national manufacturing priorities. It includes medical products. And so, as Ms Urquhart said at the start, I can readily assume that those sorts of discussions would have been happening because there was a context in which they could happen, which was the government's modern manufacturing initiative. And Senator Ms Urquhart has given you the evidence about firms that have been beneficiaries of that modern manufacturing initiative. So I think that's why we keep raising that, Senator, the evidence is that a range of Australian firms in this area have benefited from funding from the modern manufacturing initiative.
So, Minister, this article goes on to say, Mr Lanyon says, I guarantee you we would have had manufacturing in Australia already if they'd had some assistance from the government. We would have been producing tests in Victoria and we would have been shipping them nationally. How many Australian manufacturing jobs have been lost as a result of your government not working with industry and the TGA and all of the other parties to get Australian manufacturing of rats?
Well, I don't accept the premise, but in terms of
I know that's what you say every time.
Well, but I don't accept the premise, so...
There you did it again.
Well, if I could
Well,
finish.
Senator Watt, the other thing that reoccurs is that you interrupt answers. So if you want to maintain the call, please, as I've raised a number of times, let the minister finish his answers.
So I
will give the call to another senator. Minister.
Thank you, Chair. So, no, I don't accept your premise, but in terms of the detail of it, the Secretary has taken that on notice and he'll no doubt come back to you with some more information.
So, Minister, we've got Illume begging to work with the government. We've got Lumos Diagnostics begging to work with the government. We've got other companies doing the same thing. Back to 2020. No interest, no support. They start manufacturing and offshore, send stuff offshore instead. Why does your government only ever swing into action, whether it's manufacturing, whether it's COVID, when we reach a crisis point? Because that's what's happened here, isn't it?
No.
All of a sudden we want Australian manufacturing, but it's all too late.
No. I don't accept that.
And Minister, if you permit me, I'm led to understand from my colleagues that Lumos has been supported through the Entrepreneurs Program, and that Illume also was a participant in the Accelerating Commercialisation Program. So in fact, if we take it on notice, I think you'll find that we do have information about support that's been provided to both companies.
For the production of rats?
I can't tell you, Senator. This is just the indication that I have that there is more information that we could provide.
I'd be
Senator
keen to
Watt,
get it.
I need
Yep.
to share the call. Are you...
Thanks.
Thanks. Okay. Okay, now, do we have any more questions in cross-portfolio and corporate? Is it cross-portfolio and corporate or
believe so.
outcome
It's fairly
1.1?
general or generic, so...
You can? Mr Frederick? Okay. So, Senator Venn, you've got the call.
Thank you. In previous estimates, I've raised questions or put questions towards industry about research and development grants in particular with a Victorian defence company, a very innovative defence company, and I just wanted to acknowledge on the record in estimates that I'm incredibly grateful for the work that Ms Wiley-Smith and Ms Greenwood have done in working with that company and resolving the issues that are raised at estimates. This company is incredibly innovative, produces some of the finest products that will protect our defence service people. The ability to get grants under or tax relief under the grant scheme is very important to its ongoing contribution to the defence of our nation and our sovereign capability and export capability. So I just want to put on the record my thanks for working with the company and myself to resolving those issues, and you should be congratulated. Thank you. Thank you, Secretary. Thank you.
There you go.
Senator Van,
Said I'd be a minute.
Senator Van, you've been a tireless advocate for that company as well, so that should be on the record as well.
Okay. Thank you. Thank you very much, Senator Venn. So I think we are now in outcome 1, and we
Some more cross-portfolio.
Oh, do you?
Yep.
Okay, so who's seeking the call?
We've got some questions about mRNA and also consultancies.
Okay. Senator Walsh?
Thank you. So some questions about the Moderna announcement with the Victorian government. How much has the Commonwealth committed for the Moderna facility, for the Moderna mRNA facility in Melbourne?
Senator David Wicketti, General Manager,
for the Vaccines Manufacturing Task Force. Could you repeat the question, please? I was just coming into the room.
Yeah, that's okay. How much has the Commonwealth committed for that facility? What is the Commonwealth's contribution for that facility?
So that's still being determined, Senator. We're currently in negotiations with Moderna and the Victorian Government to put into place the arrangements for the manufacturing facility to be up and running. At this stage, we're looking at a range of things. There's costs associated both with the drug substance facility, with fill and finish, and also potentially not potentially, but the purchase of vaccines, both for the treatment of COVID, but potentially future purchases of vaccines, whether they be for another pandemic or for the flu or some other vaccine. And that's yet to be determined, and we're working through that at the moment with the other two parties.
Thank you. What was the first thing you mentioned there before a proposed contribution to fill and finish?
Drug substance facility, so the actual facility that will make the product.
The plant.
Yeah, the plant.
Right.
That's right.
Okay. So you're in negotiations with Moderna and the Victorian State Government, is it?
Correct, yeah.
About what your contribution will be on all of those things.
That's right.
And one of those things, the last, was ensuring a level of government demand for the product in terms of sort of pre-purchase orders.
That's right. That's a discussion that's going on at the moment.
Right. And are you intending to make the result of those discussions public?
I don't believe so. That will be a matter for the Department of Health. But in the past the Department of Health hasn't made that information public.
But just in terms of the agreements, I mean, that would be a matter for government.
Yeah. Is there a figure on what government has sort of contributed to the process? Like how much has it cost to not just sort of do the proposal for market and all of that process, not so much the administrative process, but is there any other amounts that government has spent on the process?
So, Senator, I think we'll have to take that on notice. I suspect we don't have that information here, but also because I'd like to be able to come back to you with a response from Health as well, and possibly from Finance. So, this is an exercise that's being carried forward by ourselves, the Department of Health, Department of Finance. So, if you would, I'll come back to you on notice with that information as broadly as I can.
And sort of broadly up to this point, the Commonwealth's involvement has been in the sort of, my terminology is failing me, but the putting it out to market, engaging with the companies, assessing the approaches, engaging the consultants that we've talked about before. Is there anything else that Commonwealth has been engaged in up to this point in relation to the decision?
The only thing I would add to that is engaging with the Victorian State Government too.
Yeah. Okay. Right. I just have an awareness of the Victorian State Government putting up an amount of sort of $50 million or some such to get the process underway.
Senator, I think you might be thinking about their investment in mRNA Victoria.
Right, okay, yep.
And so that would be sort of one of the principal entities that we're engaged with.
Yes, got it, thank you.
And I mean, to Mr Lucchetti's set of activities that we've been undertaking, I mean, it would be important to also add that we've talked to entities like the Academy of Science around the ecosystem relevant to mRNA technology to inform the entire process.
Yeah. Can you just remind us of the sort of the final steps of the process that the Commonwealth engaged in that led to contracting Moderna? So you had a panel, didn't you?
That's right. Yeah. So I'm obviously limited because there was government consideration and it went to Cabinet. But just very broadly, that's right. There was a process of consideration with the support of an expert advisory panel that provided advice to government. There are iterations where we sought advice, additional advice or clarification from the respondents to the approach to market, and that advice was provided to government. And then in the background there were discussions with the preferred outcome. So Moderna, which then informed the final announcement on the 14th of December of last year.
And just to be really clear, because you used the term contract, so on the 14th of December, the Prime Minister announced an in-principle deal. That agreement had been reached on that with Victoria and Moderna. And so now you find us in, putting the meat on the bones, if you like, settling the commercial arrangements to underpin that in-principle deal.
Okay. And do you have a time frame now for when we expect these vaccines to, in effect, roll off the production line from this facility?
So, Senator, we're working to a timeframe collectively of 2024, and we're not necessarily being any
12 months in 2024.
There are, Senator, but this is a complex process. Moderna themselves have already been to Australia, visited a number of potential sites. So these kinds of things will influence just when in 2024 it will happen, because they could potentially use an existing site, or they could actually use a brand new site. And obviously there's additional time required if it's a greenfield site and they've got to take it from scratch and secure equipment and necessarily regulatory approvals. It's hard for us to be specific about exactly when we will be turning, the plant will turn on and start producing vaccines.
Minister, it was in October 2020 when one of the industry ministers of your government, Minister Andrews, said that we would be making mRNA locally within 12 months. And it was about 18 months later, in May 2021, that the approach to market was actually opened and government began the process of discussions that have been outlined. It's currently February 2022, and we've heard that vaccines will roll off the production line sometime in one of the months of 2024. How did your government get up to 4 years behind in the process of delivering mRNA manufacturing to this country?
Senator Walsh, just before the Minister answers that question, Minister, do you need, to answer the question, do you need the reference Senator Walsh is quoting from in terms of that statement from Minister Andrews?
I have the quote.
You do? Okay, over to you, Minister.
I assume so. And I'll ask officials to fill out the answer in terms of the time it's taken in other countries to go from scratch to an mRNA manufacturing capability, because I think Singapore, from memory, might be one of the ones that's sort of starting from scratch, and it's taking a few years. But the full quote, as I understand it from the Minister, was, whilst expressing hope that we could get there in that time frame that you reference, went on to say, but I think we really need to be conscious that with the vaccine there are a lot of variables in there. So we don't have the vaccine proven at this point in time. We don't know what the base for that vaccine is going to be. So we're trying to prepare across a wide range. So I think you're verbling the Minister in that.
Pfizer was approved by the TGA 2 months later.
I've given some context for the verbling for the benefit of the committee, but I might ask officials to talk about some of the experiences overseas in getting a mRNA manufacturing capability up.
Well, I respectfully haven't asked about experience overseas.
No, because you've
Sorry,
suggested...
Senator Walsh, you've asked a question. The minister's given an answer. Minister's also...
I've asked a question that I'd like to restate.
Sorry, Senator Walsh. The
I
minister...
think the minister needs your protection, Chair.
No, I'm not, Senator Walsh.
It appears that you're running protection for the
Well,
minister
I
from
think
these
that's
questions.
an unfair comment. The minister has asked an officer to provide some additional comment with respect to the answer.
To a question that I didn't ask.
No, it's not true.
To a question that I didn't ask.
If I could just ask, well, the officer's heard the question, so the officer will be in a position to add anything further that you think helps assist the answer.
Thank you. So, Senator, it is worth actually the reference to what's happening overseas, because it goes to my response about 2024 being the year that the vaccines will start rolling out. Our experience in seeing what's actually occurring in other countries, the Minister referenced Singapore, they're expected to have their facility, which isn't a Moderna facility, it's a BioNTech facility, to be up and running sometime in 2023. They haven't been specific about that time frame. There's also discussions I'm aware of with other countries about the location of facilities, and they're in a roughly similar kind of time frame. So at the moment, production, as far as I'm aware, is at the moment predominantly based in the US and Europe, and has been for the last 12 months. And sorry, Senator, just to respond to your question too about Minister Andrews and the comment that she made 9 to 12 months. As the Minister referenced, that was caveated with an acknowledgement that there are a number of variables, as I mentioned earlier, whether it's a brownfield or greenfield site, the ability to access equipment, whether the raw ingredients are available, going through the necessary regulatory approvals. They're all things that impact the time frame. And until you're actually up and running and underway, it's difficult to be any more specific at this point in time.
I would just seek a response from the Minister to the fact that you announced a modern manufacturing strategy in October 2020. You prioritised medical manufacturing. You haven't been able to manufacture vaccines in Australia since then, and we don't have apparently any hope of manufacturing them for another couple of years. And we haven't been able to manufacture rapid antigen tests in Australia during the same period. I mean, what a complete failure! What a complete failure is your manufacturing strategy when it comes to
one of the points you
products.
made in your political attack there is completely wrong. We have manufactured vaccines in Australia. You may or may not be aware that we have seen millions of AstraZeneca vaccines manufactured in Australia. So you're saying that hasn't happened? So that's not what you said.
Well,
you said we haven't been able to
say
manufacture, and that's
mRNA.
wrong. So another sort of political attack which doesn't even get the basic facts right. But to go to your more specific point, your suggestion that you can, in a very short space of time and in time to deal with the COVID outbreaks that we've been experiencing, that you would be able to develop from scratch mRNA manufacturing capability. Well, nowhere that I'm aware of has been able to do that from scratch in time since the vaccines were approved. So this doesn't happen overnight, and we've managed to, both through our onshore production of AstraZeneca and our overseas procurement, get sufficient vaccines for the Australian population to deal with this crisis. And now what we are developing is for the medium and the long term to have a mRNA manufacturing capability, something that very few countries have.
Well, it's just more promises not delivered, isn't it? I mean, the Minister did say in October 2020 that mRNA capacity could be built in a period of 9 to 12 months. You had manufacturers approach you about making rapid antigen tests here. You turned them away. I mean, what can you point to that this government has delivered when it comes to manufacturing the things that we need to deal with this virus here in Australia?
Tens of millions of doses of vaccines manufactured right here in Australia.
AstraZeneca.
So that's happened. That's happened here in Australia. I don't know if you've noticed, and millions of those doses have been used by Australians, and indeed millions have been shared in our region, as you would be aware. So you point to what's been done. We've developed manufacturing capability which has protected Australians during this period. We've procured doses from overseas, and we are now developing mRNA technology. And in order to make your case, you have to, one, say things that are simply not true, that we don't have manufacturing capability for vaccines when we clearly do. And then secondly, you have to completely verbal the minister in order to make your point. I mean, this is reflective of the way Labor has engaged in cheap political point scoring during this crisis, rather than actually engaging on the facts and dealing with them. I mean, you've had to completely verbal what the minister said there, and as I say, you've also had to completely ignore the fact that we are manufacturing vaccines in Australia.
So
apparently you didn't notice that.
So Minister and Senator Walsh, we're approaching lunchtime break. Are you nearly through those questions? I don't want to.
We've got one area of corporate that we still need to cover.
How long do you think it'll take, Senator Chisholm?
If we finally get straight answers, probably 10 minutes.
10 minutes? Okay. Let's try and knock that over, and then we can let the officers go. Okay.
Thanks, Chair. How many people does DISA directly employ today?
Senator, if you just bear with us, we'll just do a change of personnel for this one.
Just for a 50-minute lunch.
Chief Finance Officer. So in terms of employment, actual ASL as at 31 December was 3,107. Our current headcount at last pay is 3,214.
And how would that compare, say, to 2018?
So what's happened since 2018 is we had the machinery government change with environment and energy and small business coming in, so our numbers have increased. I think the better way to answer it, if we look at the current, so in the MyEFO process, our ASL cap increased by 149. That's probably the best comparison over the last 2 years.
Okay. So Senator, can I just assist on that one? It is difficult because of the MOG changes that happened, because it kind of fundamentally changed the numbers. We can give you. I appreciate what you like. We can get back to June 2020 as a figure of our headcount. So I think in December 2021 our headcount was 3,473, and in June 2020 our headcount 3,409. Is that right?
Yes, that's correct.
Is that the sort of closest you can get to an apples comparison?
I think so, because
before the changes.
Because the MOG changes happened in February of 2020. And as you recall, Senator, they're quite substantial because...
I don't think we want to start on how many ministers you've had.
Yeah, that was the MOG.
It's probably common.
That's the MOG that I'm referring to.
It's probably common. Since July last year, 2021, how much has DISA spent on external consultants?
So for the current financial year to 31 December, it's 21.2 million.
Okay. And I think based off AusTender, it's up to 24 million now. Does that sound about right?
So that'd be the contract value, not the actual expenditure. So contract value is approximately 34 million.
Okay. So that's contracts. So you've awarded contracts but haven't paid out.
Represents about 2% of our total appropriation.
Okay. So it's been reported that the Morrison government have contracted consultants who charge taxpayers between $1,800 and more than $5,800 per day to work for the APS, which public servants should be able to do for a fraction of the price. Is it defensible use of taxpayer money that could be better spent on utilising in-house capability?
So the majority of, or the consultancies that we do are open tender, and the reason that we go for consultancies is expertise, and generally that expertise is beyond the national. It's where we look at international expertise and where we can draw on that.
Just on the contractor issue, so I'll stand to be corrected by my colleagues, but I think almost the majority of our contractors are in the Chief Information Officer division, which is just a cultural issue. I mean, the ICT sector in this country basically is fundamentally a contractor-based industry, and in many ways, you know, that's our intersection with that industry impels us to rely on contractors in the ICT sector. I don't think we're Robinson Crusoe in that, but you know, by and large, our contractors a large number of them are in the ICT world.
In contractors, that's correct.
Yeah.
So what was the spend for the 2021 financial year?
On consultancies?
Yeah.
So in terms of actual expenditure last financial year, $38 million.
38. So I would assume, even though we've got a few months to go, you would be on track to spend more than that this year.
I would suggest that it would be, it looks like, let me just work out, I've got it split between the 2 years. So the expenditure would probably be around that 38 to 40 million. That's on an estimate though. The value of contracts is 63 million. What I don't have is how much of that would go into next financial year, but I could take that on notice.
Apart from, you mentioned the CIO issue, what other barriers are there, Mr. Fredericks, to undertaking this work in-house?
So I think in our case, Senator, we do our very best to make the best judgments we can about where a particular function or a particular job is best served by use of a contractor. And so I've given you the example of ICT. So I think a lot of our numbers have, as I said to you, are in the world of ICT. The other thing we use contractors for is for surge capacity. We're very upfront about that, and particularly in a department like ours, Senator, where we're responsible for the management of a lot of grants that tend to ebb and flow, and so we frequently find ourselves using contractors in order to be able to deal with a wave of work that's coming through the grants process, and most frequently that's work of a processing nature anyway. So to be really honest with you, we jealously guard our ASL and our public servants for policy work, for program development, all the sort of work that traditionally the public service is relied upon, and then we tend to use contractors where, in a sense, the market requires us to use them, or we're dealing with short-term surges where, it just to be frank, as the manager of the organisation, it makes sense to use an outsourced provider for a surge. But what that sits on top of is a contingent of public servants that are there on an enduring basis.
I was going to ask about that, because the DISA awarded a contract for PwC, a $1.9 million contract running from 12th of January to 30th June for surge capacity and capability uplift.
Yeah, so I'll get Ms. Wiley-Smith to talk to that, because that's one contract I had in mind when we were just having that discussion.
Senator Mary Wiley-Smith, Deputy Secretary.
What I might do is, I've got a specific question on this. I might put that, because that's probably easier to respond to. That sounds all right. So in response to an Innovation Oz article on 8th of February, a spokesperson for the department said this was to, in talking about the contract, support the delivery of grant programs and the government's priorities. What specific activities will PwC be undertaking? What does surge capability entail in this instance? And will PwC be assessing grant applications? And if so, which ones?
So I'm just double checking, Senator, did you want to put that on notice or would you like me to actually try and answer it now?
If you can. Yeah, if you could, yeah.
Okay. So look, I think as the Secretary said, sometimes we actually do have an unprecedented kind of surge, and that's what's happened in this instance in terms of AusIndustry. Just for context, what's happened is we've got increasing numbers of grants which need to be worked through and announced, and so I think the peak there is in around March this year. And at the same time, there's also a backlog of variations to existing contracts, which is quite significant, and it's happened during COVID, as a lot of the grants that have been awarded, the businesses are having trouble with their supply chain. They can't actually do the work that they were required to do under the contractual agreement that we've got with them. So we've got a bit of a peak for about 3 to 4 months. Before we went out to market, as usual practice, we have a look to see if we can surge people from within the department or across other departments in to actually assist us. In this instance, we were able to get some of the staff from other areas of the department to come in and also to assist, but we still needed to go out and actually get extra support from the market. So the 1.9 million that you've just mentioned, Senator, is the upper limit. What's happening at the moment is we're working kind of from fortnight to fortnight with PwC, and depending on the number of staff that are required, we will actually pay according to that number. So 1.9 is kind of the upper limit. I believe that the contract for the surge kind of finishes at the end of April because we think that we'll be back down into kind of normal operations. And I should mention, Senator, that just for extra context, as you were asking for information on kind of ISL and also FTE in the department earlier, in this particular instance, AusIndustry have significant ASL, but they're actually under ASL. So they've got continuous recruitment happening. We want to actually bring permanent officers on board as quickly as we can, but we are actually facing a fairly tight labour market. And while the Secretary said this is, quite concentrated really in our IT area, we are finding that it's actually more general at the moment. And I know that industry is also experiencing the same issue. So we plan to bring on extra staff, permanent staff, as quickly as we can. But just for these couple of months, we did need to go to the market because we couldn't get the surge from across other areas of the department.
So will those PwC workers be assessing grant applications? And if so, for which program?
So I will actually just have to take that on notice, Senator, or just might be able to get one of my colleagues to clarify that first part of your question. The second part, can you just repeat that, Senator?
So will they be assessing grant applications, and if so, for which program?
Okay. So we've got a significant number of programs within that area, Senator, and so I think they're actually doing surge across all of them. From memory, it's around 250 programs that are kind of sitting in that space within AusIndustry. In terms of the assessments, I am going to get my staff to just clarify for me, but I believe that most of the programs that we run actually have independent expert assessment panels, and so the departmental officers themselves aren't doing the main assessment against the program guidelines, if that makes sense. But I'll just check. I'm getting nodding, Senator.
I think if
yeah.
you would like to take that notice, give you a thorough answer to that as well.
Yeah.
So what are they doing then?
So this is actually in the lead up to the launch of a grant. So they're actually working out the kind of the governance. They're going through the program guidelines, helping to develop them. But my colleague is just coming up to assist, which is Miss Emma Greenwood, who actually manages AusIndustry. So I'm sure she's able to provide a little bit more clarity than I can.
Senator Emma Greenwood, Head of Division for AusIndustry. So the additional surge resource from PwC will be working across different teams, and we are embedded with the existing staff that we have. So they'll be doing processing for applications. I will check for you, but in some cases they may be involved in some eligibility checking or under supervision doing some forms of assessment for some grants. They're not doing specific granting programs, and they're being managed within those teams, is my understanding.
Okay. And so how many PwC staff are we talking about, and are they getting a daily rate?
So what we're doing is managing them on a fortnightly basis. So what we can do is look through our grant pipeline to understand over a fortnight where we might have some peaks. And then what we do is we actually kind of say, we need this number of staff for the next fortnight, whether it goes up or whether it goes down, and we only pay for those resources that we're using. So to go back to Ms Wiley-Smith's earlier comment, we've had about $105,000 in the last fortnight, which means that we had, I think I'll have to take this on notice or check with a colleague, but we probably had about half a dozen staff assisting at that point. And then we've also looking at around about $300,000 next fortnight. So it just varies, and one of the advantages we've got is we can actually really quickly scale up and scale down by using their resources. What we'll probably do is scale up over the next 6 to 8 weeks to 12 weeks, then we'll hit a peak and then we'll be able to stop.
So 6 staff earned $100,000 for,
I'd need to check,
for
Senator.
10 days' work.
It will depend on, I'm talking about headcount, I need to check. Sorry.
So all $9,000 each a week.
We need to take that on notice so that we give you the best possible number for you to use going forward.
Pretty extraordinary number, though.
But, Senator, I mean, you're working that out on the back of an envelope. It doesn't sound like we have that number. We'll make sure we give you...
In fairness,
quality numbers,
Ms
Senator.
Greenwood sounded pretty confident in that number. I think it was only when you worked out how much it is that you got a bit nervous about it.
No, Senator, I think I said I would have to check. But the other thing I think to remember is that at the same time they're also assisting us with continuous improvement and some systems and capability improvement, which I think was also in the article you're referring to. And in that regard, we're also paying for some additional support that comes with that. And that's about, whilst our staff are working in and on and managing all of these programs, we can benefit from some additional insights at the same time.
Senator Chisholm, we need to go to lunch. We've gone over 10 minutes. We do need an hour for lunch due to commitments people have. So
final question. How much would it cost for these activities if they were undertaken in-house by department officials?
We would need to take it on notice, Senator. We'll come back to you.
And on the 8th of February, Innovation Oz article mentioned the department handed PwC 3 contracts worth a total of nearly $3 million for a range of eternal work. Was that along a similar set of circumstances?
We'll just get our colleagues to come to the table, Senator. They might be able to assist you on that one.
Yes, I think those contracts, Senator, aren't in the grant space. I think they're in our corporate area.
we are finishing at 150.
Okay,
just to
I
let
can make
everyone
it-
know, and then we'll be coming back at 250.
Okay. Yep, so we approached the market for 2 procurements, which is 2 of the 3 that you're referring to. There were 2 separate engagements, and what we did, though, for efficiency, we went out as one, but we gave the option for people to come back and apply for either both or one or the other. So the first one was to do a review of some of our internal entities as part of the budget process. So we put to government an independent view of sustainability of some of our entities to have a look at what that was. That is part of MyEFO. We received some funding, but it's also part of a comeback in the 23-24 budget, so it's still before government at the moment. There's a second contract, which is a contract for the corporate area, and it was to look at what our benchmarking is, how do we compare to other departments, and were there any other opportunities that we could look at to improve what we do. So either streamline our processes, automate, or anything else that they could find. So they're the 2 separate engagements. Would you like any more detail on?
No, that's fine. I think what's pretty clear is that taxpayers are forking out millions of dollars to process election promises from the government. And it's pretty outrageous that we're paying tens of thousands of dollars to a consultancy firm all to get another pork barrel around for this government ready.
You need to have a question. So,
Mr.
Fredericks, do you want to respond?
So, Senator, I understand that perspective. From my perspective, I have an obligation when entering into these contracts to ensure that they represent value for money for the taxpayer. And in each of the instances we've described, I'm satisfied that they represent value for money for the taxpayer.
Okay, thank you, Mr. Fredericks. Thank you, Senator Chisholm. We'll adjourn for lunch. We'll come back at 2:50. Thank you, everyone. Okay, we'll reconvene. I do have a little bit of housekeeping. I just want to correct the record in one respect. There was a discussion yesterday in relation to a question on notice, SBT 003, in relation to ACT debt refinancing, and it was thought that the question on notice was outstanding. I just need to correct the record and advise that, in fact, an answer to that question was provided in December 2021. So I'll just put that on the record, if I could. And now I'll give the call to you, Senator Pratt.
Thank you very much.
Yes?
Just one piece of housekeeping.
Yeah.
Could I just confirm whether we've formally completed cross-portfolio and corporate? I only asked that because I got a lot of staff here from the corporate world that I'd like to excuse if I
My
could.
apologies for not making that clear.
No,
yes,
that's
we
100%
have.
fine.
We have.
Thank
we
you
have
very much for that. I
completed.
appreciate it.
So we're on outcome 1.1.
All good. Thank you for that.
Thank you. Thank you, Mr. Fredericks.
Thank
Senator
you. And
Pratt.
I've got some questions related to program 1.1. So can I ask, please, are you happy, Mr. Fredericks, with how the round 2 of the Boosting Female Founders program has gone?
Senator, I'll just bring the relevant officials to the table for you for that one. Thank you for that, Senator.
Thank you. I wanted to ask, please, I've heard some controversy and disappointment around the rollout of the Boosting Female Founders program. Can you tell us, I guess we can get into some questions about that, but can you tell us if you've been happy with the rollout of the program thus far?
So, Senator, there have been issues with the way in which Boosting Female Founders has been managed, and certainly there was a concern raised which you may well be aware of, where a large number of applicants who were ineligible or unsuccessful through the expression of interest first stage were incorrectly notified by the department that they were successful. That was about 1,800 applicants.
Sorry, is that applicants that happened to, or total applicants?
That was the applicants it happened to.
And what's the total number of applicants?
The total number of applicants for that program, sorry, I just need to find it for you.
If I can, take that, Senator.
Thank you.
Janine Richards, I'm the Head of Science and Commercialisation in the department, and we look after the policy for this program. Ms Greenwood's talking about round 2, which I think was the round that you asked about. The total number of applicants in that round at the initial stage were 2,500 roughly, who applied in April 2021 in response to the request for expression of interest.
And when they applied then, and when was this mistake in terms of post the assessment of their applications?
So this was it's a staged application process. So this happened actually in July, where the applicants who put in an expression of interest who were unsuccessful to go through to the next stage, and that's the stage at which they're considered for a grant, were notified that they had been successful when they weren't. The department responded very quickly. It contacted all of those applicants. It explained what had happened. It was apologetic. We've been apologetic through the whole process. We're very concerned about the impact on those applicants. We offered to provide them with feedback. We're clear about the issue that had happened. We've taken steps within the department to ensure the same problem doesn't happen again. And we've also wound that across all our programs to ensure that we've got correct probity and process and we don't have the same concerns. Similarly, we sent a well-intended but perhaps poorly worded email to those applicants, and we've also apologised for that and changed our internal processes.
Thank you. Can I ask in that context, if you had 1,808 that got that email, does that mean all of the other people, all of the other applications, therefore about 700 of them had progressed to the next stage, or was it that some got this incorrect email and others didn't?
So unfortunately everyone got the email. 156 applicants were successful for the next stage, and that was the competitive merit stage according to the information I have, but I can check that, Senator.
Okay, so there were 2,500 applicants. They all got this email, but only 156 of them should have got it.
Yes. And at that stage, none of them were successful for the grant, Senator, just to be clear.
No, I understand it was to the next stage.
Yep.
An invitation to progress. Do you have an estimation of, I guess, the amount of time it would take to put together one of these applications?
Senator, I don't have an estimation of the amount of time, but it does take them time. We're well aware of that.
4 or 5 hours, a couple of days? What would you, if you were doing one of these, how long do you think it would take?
Senator, it's difficult for me to answer that question. I think some of them have probably spent a couple of days on it. Some of them will have spent significantly longer on it. Some of the applications were more complicated than others. Some of the applicants have more experience than others.
Okay, so if it's 2,500 applications...
Sorry, can I just check my bill? I understood that the number of incorrect outcome notifications was 1,808.
Yes, it was.
Okay, thank you.
And Senator, if I could just...
But there are 2,500 applications, yet only 156 have gone on to the next stage. Is it that there were another 700 knocked out some other way?
We might just need to clarify the figure of the total number of applications received between myself and Ms Greenwood, Senator. If I can just explain the two-stage process, we're talking about the EOI, which is the first stage. We actually undertook a national consultation for the design of this program because we appreciate that women entrepreneurs don't have a lot of time to put into an application process.
Can I just, I'm still confused.
Yeah,
1,808 got the wrong email, or 2,500 minus the 156 that went to the...
Sorry, Senator.
Who should have got the email, got
I'm
the
just
wrong
clarifying that now, so I'll give that to you as soon as I have it.
Well, clearly you're trying to tidy up this and you've apologised, but I would have thought you would know the answer.
There were
to this.
550 applicants who were ineligible, Senator.
Okay.
So I think that's the missing number.
All right, and if they were ineligible, but they still got the same email?
No.
You mean even applications that were ineligible were told that they had made it to the next round?
No, Senator, if I can just clarify, the number of applicants who applied for the EOI process who received the incorrect email was 1,808.
Okay.
So they were the applicants who had applied, they were eligible.
No, I do understand. Ms Greenwood had said that everyone got the email, but it was everyone bar those who had been deemed ineligible. Can I ask how many, so that's about 550 that were ineligible. What was the most common reason for that ineligibility?
Senator, I'm just getting that information as well. I might need to come back to you on that, Senator. I don't have that information in my notes, but I've got someone looking at it now.
That would be terrific. I'm very grateful. How much funding has been spent on round 2? We've been told on our previous question on notice that it's 11.6. Is that still correct?
Sorry, Senator, can you repeat the question? I'm just trying to orientate myself to the 11.6.
We've been advised previously in question on notice S161 that the funding for round 2 is 11.6.
So
Senator, that's
my
correct.
advice is 11.6 million in grant funding has been awarded under round 2.
Great, cool. What's, if I can ask please for an overview of the assessment process?
So the applications are assessed for eligibility. Those that are eligible move to the next stage, which is the stage 1 EOI process. Those applications are then assessed and rated or ranked.
Yeah, okay, I understand that kind of process.
Yep.
What I'm looking for to try and gauge in your answer is this program has been promoted as support for female-led businesses and companies. Can I ask how that relates to the successful, to the criteria and, you know, the significance of that grounds in assessment of eligibility?
So they're assessed by a range of staff and who understand female entrepreneurship. That's that expression of interest stage. They will then take that information and it goes to an independent committee of experts, and that committee will look at those applications, each of those applications again, and then they'll make a decision as to which ones they are of the opinion
we're
match.
going. Sorry, I don't mean to interrupt,
that's
Ms.
okay.
Greenwood, but you're talking about the process. I want to get more of the detail of the criteria, not the process, and what those criteria were and the emphasis that the assessment placed on that criteria. Use the words, they should have an understanding of female entrepreneurship. If you can expand on those elements, please, in terms of what's important in female entrepreneurship and support for assessing the viability of the business model, I guess, and the importance of the grant to those female-led initiatives.
So, Senator, this is actually in the program guidelines, which I've got before me.
Yeah, I've seen those too.
Yep.
So in terms of that assessment, in the 550 odd that were knocked out, is it because they were let down in relation to they didn't have the right, they had too much, so there's criteria around shareholders, founders, decision makers. It's supposed to be a women's program. What was the bias, therefore, if there was leadership, for example, and shareholders and ownership coming from men, if this is supposed to be the program that gives women a leg up?
So, Senator, the committee looked across all of those criteria. I would need to take on notice to look at what kind of balance there may have been in the way in which different applications were assessed. We don't have that information in aggregate. I can say that what the committee will look for is things like what kind of experience they may have as a leadership team, what the actual project looks like, where they have addressed market, so what information they have in that sense. It's a competitive program, it's a highly competitive program. So in that sense, all of those elements would generally be considered by the assessors and the committee.
Senator, if I could just speak to just the eligibility criteria in terms of the way that the program is designed. Only applicants who can demonstrate that they have a startup that is female founded, that is a majority woman owned and led, applicant are eligible. And that was, amended after between the first and second round of the BFF program. That definition was amended. It was built on a pretty strong response to the initiative. This initiative's been really heavily oversubscribed.
So why was it amended so that you didn't have to have female majority owned?
Yeah, no, you do, Senator. So I'll just finish. It was heavily oversubscribed in both rounds. Like, we've had very significant numbers of applications for the round. Part of our review of the first round was, well, how do we make sure it's a bit more targeted? We consulted with the expert assessment panel, so the people Ms Greenwood were referring to who were involved in assessing the applications. And the grant guidelines were amended after round 1 to both streamline the application and assessment process, and the definition of female-founded startup was updated so that it needed to be a startup that is at least 51% owned and led by women.
Okay.
So that was up from 50% requirement in round 1.
Okay, and the requirement for round 2 is higher than that?
The requirement for round 2 was that the startup had to be at least 51% owned and led by women.
And who assessed the applications?
They were assessed within Oz Industry, and then we also used...
So departmental officials, or did they send them out to
There were
consultants?
also others, so we used some members of the Entrepreneurs Program Network with a background in startups and commercialisation.
Okay, and was each application reviewed by more than one person, or were they vetted?
My understanding, and I can check, is that the committee then looked at each of the applications that had been assessed by another assessor. So there was a validation process through the committee for those applications.
And was the truthfulness of those applications also assessed?
If you're asking, did we verify whether or not they were female owned and led, then yes, that was part of a check that was done.
Okay. So
Senator, there is a very rigorous assessment process around the expression of interest stage for that reason, which is what leads to something like 500 of those EOIs being declared not eligible. Applicants are required to provide a declaration that they meet eligibility around their ownership requirements. They are also assessed by our assessors and third-party providers. There's additional information that might be looked at from ASIC. Shareholdings and trust deeds are considered for the eligibility checks that are conducted by departmental officials. Any applicants whose information can't be verified at that stage, would receive notification that they've been considered ineligible.
Okay, can I quickly ask, are you aware, as far as I can tell, there are records that show that there are companies that would not meet your criteria, that there are 3 companies who are awarded grants that appear to have male CEOs or directors and are not female majority owned?
Senator, without knowing the businesses that you're talking about, it would be difficult for me to answer that. What we do is we look at a point in time at the applicant. We do go, as Ms Richards has said, we verify that information. And I know that there's been some general comment in the media and on social media about a number of companies where others have complained that they're not female owned.
And what have you done in terms of assessing that yourself?
Well, we've gone back and checked those that we were aware of, and we have established that the information that we had was correct,
and
to my knowledge.
We'd very happily do that for you, for those 3 companies that you've got there, if we'll take that on notice and do the same exercise for them, if that would suit you.
Okay, so as to be eligible, you have to be a startup that's 51% owned and led by women. Can I ask, where do you check those records to establish that? Because I'm assuming people check the same sources in terms of looking up ASIC websites, etc. Are we all verifying it and getting the same answer different answer from the same source?
Senator, with respect, it's hard for me to answer that. So they have declarations that are provided. We'll also generally ask for a range of other information that they provide, and then we check the veracity of that against the registers that we have available to us. And
do you check the sole trader registration, partnership agreements? Do you see the actual documentation for that, or do you just take it at face value when you've verified that?
Senator, I would need to check. I don't believe we take most information at face value, but at the same time, we won't spend, we need to make sure we're verifying things on information that we're providing that's given to us. We don't just take the word of a business, so we will look at it and try and establish the information that we have.
Okay, so you think you've satisfied yourself, but you haven't satisfied yourself using the actual business records?
No, Senator, that's not quite what I'm saying. I need to find out in more detail exactly, having not processed them, exactly what information and checks we use. But my understanding is that we take information that's provided by businesses, we verify that information, and at that stage we'll establish, at that point in time, the structure of that business.
Okay, so of the 550 that weren't eligible, because they didn't meet the eligibility criteria, was that because I'm assuming some of them also didn't meet that eligibility, but they'd talked about their company structure? How do you know the extent to which all of the applications are truthful in relation to those attributes?
As I described earlier, Senator, and as Ms Greenwood's been saying, the declarations that are made by applicants are assessed, but then there are additional ASIC shareholding and trustee checks that are conducted on eligible applications by departmental officials. If you'd like us to provide some further information about the nature of those checks,
yeah, that would be terrific.
We could take that on notice to be a bit more specific for you about how they're those shareholdings in particular are verified.
Yeah, and do you check director numbers or anything like that?
We'll take that on notice.
Okay. In answers provided at last estimates, we were told that there were 38 women-founded and owned start-up businesses. But based on the total grant amount, you're aware that there are allegations that 3 of the 5 largest grants were awarded to companies with a male CEO. You refute that that's the case, but you can't point to the evidence that that's the case other than what's in the application itself.
Senator, we are aware that there's some social media commentary. I don't know the businesses that you're talking about, so as the Secretary and Ms Richards have said, we can take that away and we're happy to do those checks and look at them.
Okay, so you haven't, your social media commentary, we know that there are 3 out of the 38 in question. Clearly someone else has come up with the conclusion that 35 of them are women-led. But have you done your own assessment based on those company records as a whole as to whether...
Well, that's the assessment that's conducted as part of the application process that we've described, Senator. So yes, there's been some suggestions.
I'm assuming that on paper they all met the application. I'm not accusing the department of approving someone where someone has explicitly lied on their application, but well, sorry, if someone has explicitly lied on their application and you've taken that at face value, is it possible that there are 3 of the very largest grants given in this program that have been awarded to companies with a male CEO?
So, Senator, I think on that, I think reasonable evidence has been given to you, but not sufficient on the process and on the assessment, and particularly on this issue of verification. So we will make sure we come back to you on that.
Okay.
And then secondly, in terms of the 3 that you've got, as I say, I feel I now have a responsibility to have those assessed for the reasons that you're describing. So if I could get that, I will take it on notice and come back to you.
Senator Pratt, are you coming to the end of your line of questioning, please?
Yes, I am. I just need to challenge the department in saying you've told us today quite explicitly that you're confident that they all meet the criteria, but only now you disclosed that the assessment of that criteria is based only on the information provided to you through the application process.
So to be fair, I don't think that was the evidence of Ms Richards.
Okay.
She provided evidence that there is a verification process. I accept that we haven't fully described it to you, and so we will do that on notice. I, on behalf of the department, remain confident in the outcome, but I'm always wary and very grateful to receive further advice from you, Senator, which we'll check.
Okay. I would be very disappointed if indeed we've got male-led companies trying to get their hands on this money, which has been promoted as to support women setting up businesses, particularly in, what is a very competitive economic environment where women's businesses deserve the support they've been promised.
So,
Thank you,
Senator, on that, we are with you on that, but we would be too, and we'll come back to you on that.
Okay. Thank you, Senator Pratt. Do we have any more questions on 1.1? Senator Chisholm?
Thanks, Chair. Just had some questions about industry more broadly, and including payment times. So I asked some questions last night of Treasury, particularly focused in the manufacturing industry, which offer some of the lengthiest payment times. So small business suppliers receiving average payment terms of 49 days. Were you aware of that?
Thanks very much, Senator. Narella Keddy, Head of Division of Manufacturing.
So,
could you just repeat the question? I was coming up to the table.
Just seeing if you're aware of the, according to the government's payment times register, big businesses in the manufacturing industry offer some of the lengthiest payment times, with small business suppliers receiving average payment terms of 49 days.
I wasn't aware of that. I did see the questioning last night and have reached out to my colleagues over in Treasury. We have a round table where we meet with manufacturers once a month, and this issue was raised by the Small Business Ombudsman probably middle of last year. We haven't heard since. Manufacturers haven't raised this issue with us, but based on your questioning last night, we will
Have you got the big ones there, though?
Sorry?
Have you got the big manufacturers there? They're probably not going to be the ones who are going to be raising it.
So to clarify that, Senator, we have the big manufacturers, and then we have the industry bodies who represent the smaller manufacturers as well. So it's quite a large round table. It consists of many, many manufacturers. And we have a meeting coming up in 2 weeks, so I will raise this with them.
Okay. So you're not aware of if that has an impact on supply chain issues at the moment, if there's sort of late payment is something that is a factor in that?
I think what I would think is happening at the moment, Senator, is that the supply chains are quite challenged at the moment for many of these manufacturers, and depending where they are in that supply chain, many of them are probably placing orders, and as we know, supply chains, whether it be shipping, transport issues, whatever it may be, they are probably seeing that they're placing those orders, then they're unable to, the orders are not arriving in time, but payments are being asked. That's what I assume is happening, but I'd have to clarify that.
Okay. What about in the construction industry? Is that something that you were aware of as well, around payment times having blown out through COVID-19, now at record highs, with 12% of building companies more than 60 days behind on debts owed to suppliers and contractors?
So, Senator, no, I wasn't aware of that either. And on this roundtable, we do have many of the construction industry bodies there, and so this is something that we will follow up.
Okay. So it's not something the industry itself tracks, sort of to get a sense of what market conditions are like?
It's not something that's been brought to our attention, Senator, so, but I'm happy to take it on notice and provide you a more detailed response.
But it's not something the department sort of tracks or is...
No, Senator, no. And the responsibility for payment time sits with the Treasury, and I know that the Small Business Ombudsman does track this.
Yeah.
And Senator Jane Urquhart, Acting Deputy Secretary. So just to highlight one of the comments Ms Lucchetti made, so we maintain this supply chain roundtable precisely to try to get visibility of these issues as they arise. So we really appreciate actually the question being asked, because at the next supply chain roundtable this will be something that we'll specifically seek to investigate.
Yeah. Do you think that late payment times across industry, manufacturing, construction, do you think it holds companies back? Do you think it stops companies' ability to grow, smaller businesses?
Senator, what I would say is that it's a challenging time for manufacturers and for business with COVID and the challenges and the supply chain issues that they're currently facing. So any barrier does make it difficult for those businesses.
Yeah. It just seems that the sort of register was set up, which has been supported. It just strikes me that I would have thought elements of the government would be paying more attention to it.
But, Senator, the responsibility for that register is, and the policy does sit with the Treasury. And like I said, and grateful for you for raising this, we will follow this up and look into it a little bit more detail.
Well, they did say you were the ones best placed to answer questions about it.
So this has not been raised with, as I said.
No, Treasury last night said that.
I understand. I did see their evidence, but as I said,
you need to switch the agenda and get on
it hasn't
before
been
them.
raised with us, Senator. But we've got a meeting in 2 weeks' time with the supplier working group, with the roundtable, and we will raise this issue.
And Senator, if I could just add, I mean, the Treasury probably thought we might have visibility of the issue through forums like the Supply Chain Roundtable. As it happens, we haven't.
Yeah.
But we do have the opportunity to, ask specific questions to draw that out.
Sure. So just finishing on manufacturing in particular, do you think that it has an impact on sovereign capability? The fact that these late payments are a problem for small business?
Without having more knowledge, Senator, I can't say one way or another, but we do know that supply chains are complex. At the moment, many businesses are operating in just-in-time supply chains, and it is creating problems for many of these manufacturers, but I really do need to know more.
Yeah. So I just wanted to ask about recovery and resilience plans. I think the Department of Industry had one securing our economic recovery from COVID-19, setting up Australia for the future. Was that something that the department were involved with?
Senator, I might just need a bit more specifics. I suspect that was a whole of government sort of overarching framework, and we probably sit under it along with some others with some initiatives, I guess.
Yeah. So that I'll sort of add to it. So on March 2020, the Prime Minister noted that, and I'm talking about the COVID-19 Coordination Commission, is about mobilising a whole of society, whole of economy effort to ensure all resources are marshalled to this vital task in a coordinated and effective manner. What role did the Department of Industry play in this, and did the Commission itself seek input from the department?
So, I think the principal outcome, I'll hold that question to manufacturing if that suits you, because it's probably the best way to explain it. So in manufacturing, I think what the manifestation for this department and for our ministers was, out of that work, was the modern manufacturing strategy and the $1.5 million commitment to modern manufacturing, which, as you know, Senator, we've been asked questions about that in the past, particularly from Senator Watt. So that was obviously a policy that went through the cabinet process. We, as the relevant department, led the development of that work. At that time, I do recall, that the commission was in place. It was a properly constituted agency, if you like, and so we certainly worked cooperatively with them, as we did with Treasury and other agencies in the development of that package. So it was really, a traditional process of developing a cabinet submission, and that policy that came out 2 budgets ago now, and it would definitely have been done cooperatively with the Commission and other Commonwealth agencies.
Okay.
Does that help?
No, I'll probe a bit more detail. So there were 5 points to the announcement. So there was keeping taxes low, red tape, drive investment, etc., etc. Investing in infrastructure skills development, growing our workforce. Thirdly, delivering the affordable, reliable energy, businesses, especially regional economies. Fourthly, making Australia a top 10 data digital economy by 2030. And fifthly, securing our sovereign manufacturing capability, unlocking new generation, high-wage, high-skilled jobs. So I would have thought there would have been more engagement from the Commission than just on that specific program that you mentioned, given the breadth of what was announced.
To be fair on that, Senator, I can't answer for their engagement across all the breadth of that. I was just using manufacturing as an example of the engagement that we as a department had with them. So I can't talk to the engagement that the Commission might have had in some of those other areas that aren't in our portfolio responsibility.
But did they have more engagement? Did you have more engagement with the Commission than just on the modern manufacturing strategy?
My recollection is we had engagement with them also on the energy priority as well. The reality is, Senator, there wasn't any sort of mystery to it. They existed They're an important source of advice to all in government, and we liaise with them and in the development of our policies across all of our portfolio, as we would have done with Treasury or Finance or PM&C and everybody else. So in many ways, they were just part of the establishment of government that we engage with, as we always do in cabinet processes.
So did you meet with Mr Power?
I certainly met with Mr Power a couple of times, I did.
And did the department provide work for the Commission? Advice to the Commission?
Well, again, I don't think you could describe it as providing work for the Commission or providing advice to the Commission. They are a source, they are a government agency, and we iterated with them as we did with Treasury, Finance and any other element of government as we develop proposals.
I'll try and be more specific. So, for instance, the gas-led recovery came out of this. Did you provide advice specifically about that?
Do you mean, did we provide advice to the Commission about that?
Yeah.
I think the way to describe it is the Commission, as well as us and other parts of government, collectively worked on the proposals that were about the gas led recovery that found their way through the cabinet process.
Okay. What about providing analysis on supply chain constraints and options to mitigate risks? Did you provide any advice on that?
Well, again, that one I probably know less about, but I'll just ask Ms Urquhart. I mean, I think the same philosophy applies. I mean, to be really honest with you, Sandra, like for us, there's no great mystery here. Like they were an agency, they had views to offer. It's our responsibility as a department developing proposals in everything that we do to consult broadly within government, and we consulted broadly within government, including with them. So that'd be my expectation that we would do that. But just on supply chains?
Yeah, but if I might first, Secretary, make a few comments. So I led different iterations of COVID task forces during 2020. And during that time, we did get questions for information from the NCCC. We also played a supporting role to the Home Affairs-led National Coordination Mechanism that prepared some advice for government at different times around relief and recovery. And, you know, so we obviously liaised with entities like Safe Work Australia and others in providing that advice into that sort of planning that then informed National Cabinet. And I think, you know, as the Secretary's indicated, out of that sort of work and advice from the NCCC to government, there then was tasking from government to different departments at different times to bring forward proposals in the Cabinet process that, you know, then progressed. But in terms of supply chains specifically, so our work on supply chains hasn't just been, you know, in, you know, that sort of conversation through the National Coordination Mechanism. We obviously are responsible for delivery of the Supply Chain Resilience Initiative. In that context, we've undertaken phases of analysis of supply chain vulnerabilities to inform successive rounds of the Supply Chain Resilience Initiative. We also continue to work with the Office of Supply Chain Resilience in Prime Minister and Cabinet up to today, and I've no doubt in, you know, coming months around, you know, supply chain issues. We mentioned before the Supply Chain Roundtable that our department runs at regular intervals to try to keep visibility of, you know, quickly emerging issues. And, you know, there's a number of issues that, you know, we've talked about already today, you know, where we've experienced some of the stresses and strains and needed to lean in and work with industry to assist them to address them. But my colleague, Ms Lucchetti, can paint a bit more detail around the Supply Chain Resilience Initiative for you.
So thanks very much, Senator. So the Supply Chain Resilience Initiative was part of the Modern Manufacturing Strategy, which was announced in October 2020. Predominantly the first tranche looked at medical products, PPE, and the other one's my mind, agricultural production chemicals. That was a grant round that was announced and closed middle of last year. And there's a second round out at the moment in relation to semiconductors, semiconductors, water treatment chemicals. And we also did analysis around telecommunications equipment, but we found that there was no need for us to open a grant round around that particular area. And that is currently under assessment.
Thanks. Just coming back to the Commission, So, Mr. Fredericks, you say you met with Mr. Power. Was that something you did frequently or one-on-one? Or I'm just trying to get a sense of your engagement. Was it you and other departmental secretaries around a table?
No, so I certainly met with Mr. Power a couple of times. It would have been in the context of preparation of budget proposals. And in my world, it was, I'd have to check, but I would have had some officials with me and he would have had some of his staff with him as well, because it's worth remembering that the NCCC was well staffed by public servants as well.
Yeah.
So they were basically, you know, at a departmental level, they were our interlocutors. And for me as a secretary and Mr. Power as the head of the agency, I have the same relationship I'd have in a policy development process as I'd have with any other secretary or agency head.
Okay. I just wanted to ask some questions about the Australian Space Agency.
Senator, I think we can take that now, if that helps.
They're more about funding.
Okay, well, we will need a change of personnel for that.
Okay. Senator Chisholm, do we have any more questions on 1.1?
Yes. Only like 5 minutes.
Okay.
Is there something we could do in the meantime? Probably not. There you go.
Good, Senator.
The 21-22 MyEFO notes that funding for the Space Agency will be partially met from within the existing resources. I just wanted to get a sense of how that works.
For Hansard, Enrico Palermo, head of the Australian Space Agency. Senator, you're referring to the statement in the MyEFO budget. I don't have a copy, unfortunately, of that statement in front of me.
I'm just wondering if we could get you a copy that might make it easier. Do we have a copy of the MyEFO? I've got, what page is it? Senator Chisholm?
The relevant.
What page?
Find out.
Senator Jane Urquhart, were you referencing a specific measure? Could you give us the name of the specific measure that you were referencing?
Well, that basically it was my understanding was it was the budget measure for the Space Agency will be partially met from within existing resources.
Senator, unfortunately, I'm not familiar with that language.
What I might do is I might clean that up and come back to it in the next session if you want, because I've got some questions.
Oh, I've got it. I'm making it today.
I heard the chair.
Thank you, Chair.
Thanks, Chair.
This measure of cost.
Does it correspond to
Oh,
that?
I've got it. He's got it. Okay.
262.
Over 5 years, and it talks about partially met within existing resources to support growth of the space industry and ongoing.
Senator, unfortunately, I need to take that question on notice. I don't have the answer to your question.
I
yet.
suppose my reading of it is, does that mean something is being cut to fund this program?
No, nothing has been cut within the agency's budget to fund these important initiatives which relate to our Inspire pillar, in particular for the operation of the Space Discovery Centre. The extension of the Moon to Mars initiative, I think, is a rephasing of the later years, if I'm not mistaken.
Okay, so there's more money in the budget?
There is, as part of MyEFO, there was additional money to support the operation of the Australian Space Discovery Centre.
Okay.
As well as other technical resources within the agency, so ASL within the agency.
Okay. And can you give us a sense if the level of funding allocated for the Australian Space Agency, how that would sit to other comparable nations? Do you think we'd be on par in terms of our funding, or do you think we'd be behind?
Certainly, Senator. So if you look at what the government has done since formation of the agency, there's been over $800 million invested by the government into the civil space sector. We're also a priority for government across modern manufacturing strategies, the critical blueprint technology, and the recently announced commercialisation realisation plan. We are delivering on an ambitious agenda, and certainly, gracious for the money we've received in our programs. And any self-respecting agency head will always tell you they could do with more resources, but it's really a matter for government to determine our level of funding. Comparisons have been made of our funding to other jurisdictions, but I think increasingly space is a priority for government across all of government.
Okay. Thanks for that. I just had some final questions, probably for the Chief Economist, if that's all right.
Thank you, Chair.
Thanks, Chair. Save me.
Yes, Senator Russ Campbell, Head of Division, Chief Economist.
Thanks, Mr Campbell. Have you modelled any impact of border closures on Australian industries?
No, not in the industry department, no.
Would you have done any work on what industries have been most impacted by border closures?
We haven't done specific independent research on that. I mean, we work very closely with Treasury and the central agencies as part of understanding the economic outlook. We sort of work very closely with them around the broader implications of the shutdowns in various states and territories, but we don't have specific work ourselves. No.
And any work on policy steps that could be taken to help mitigate these impacts?
We may have colleagues in our COVID division that would be working closely with Treasury on some of the steps that can be undertaken. If you're referring specifically to particular measures to support business, there is a body of work that's going on across the government.
That was sort of going to be my next step, is how that input has sort of had on policy making.
Yeah, so I think Ms Urquhart may correct me on this, but my understanding is that a lot of that work is now largely led from Treasury, and we feed into a lot of the business liaison processes as part of that work with Treasury to understand where some of the impacts are most pronounced, as do a number of other agencies across town for various responsibilities. So obviously we have something to say about manufacturing and the building sector in particular, but others will have something to say around the health and education portfolio as well.
Senator Jane Urquhart, sort of depends when we're talking about, the nature of border closures at different times. Obviously, border closures are not such a significant issue now, although, we still have, Western Australia with, its particular jurisdictional situation. But what I can say is that, throughout 2020 and into 2021, where jurisdictions were maintaining, closing borders, there was significant work undertaken in the department to raise up where there were industry activities that to be hindered in being able to cross borders would be problematic in the sense of essential services being delivered, through to the community. So, for example, I seem to recall that we had at different times maintenance technicians needing to move across borders to assist hospitals to have machinery running that was, imperative to the COVID response, just by way of an example. So our department certainly, again through the National Coordination Mechanism and through our constant engagement with industry through, the last 2.5 years, we played a pretty strong role in alerting our colleagues to intelligence about where those challenges are arising and seeking to follow through for industry with answers on where they're facing those sorts of barriers. Now, my colleague mentioned that, we have been doing a body of work with Treasury. Well, certainly, you would appreciate how much strain supply chains came under with the combination of the floods across road and rail over Christmas. And Treasury certainly led the whole sweep of departments in seeking to troubleshoot issues around that. And the result was, I think, particularly with help of colleagues in infrastructure, access of transport and so on was actually managed to get back online pretty quickly. But there was also a lot of engagement between departments to connect industry up to shipping opportunities, to be able to find other modes or routes. And I also recall, just over the Christmas period there being, for example, very swift adjustment of regulation to allow trucks to take alternate routes into the Northern Territory, for example, just to really shore up essential supply. But in terms of that all goes to the supply to the consumer. I think your question came from the point of view of what would be the impact on industry. Well, I can certainly say that border closures impacted industry. Any business that isn't operating in an immediate community but is seeking to, develop product for sale nationally or internationally has by definition been impacted by border closures within Australia and also by, the challenge of the global scene.
So can I just add one thing as well, just to assist? So everything that Ms Urquhart said about the role of the department in the industry, because we're here in industry estimates, so we played the same role in relation to the resources sector, the same role in relation to the energy sector. So we did see it as a real responsibility of ours for the various sectors that this department's responsible for, to engage, to understand the impact of border closures. In an operational sense, they would go off to the national coordination mechanism led by Home Affairs if there were tactical or operational issues that raised that they could fix. For the sort of medium to long-term policy, then that would go off into, Home Affairs in some instances. If you were talking about Home Affairs responsibilities like visas, it would go off to Treasury for some of those broader macroeconomic policies. So that's kind of how the system worked.
Yeah, I suppose what I was specifically chasing is how did that therefore impact on decisions on government support, so government support for businesses?
Yeah. So the answer to that is, as you know, Senator, those policies about government support for business were largely a Treasury responsibility, and so everything that Ms Urquhart and I have described as intelligence gathering on behalf of industries was all being fed into Treasury in order to ensure, and of course they had their own sources of intel as well because they had the business liaison unit, to ensure that government generally had the best possible understanding of what those real impacts were that you're describing as they develop those measures.
Very good. Just on a sort of separate but related, probably for Mr Campbell again to start with, did you assess the impact of skill shortages over the last year and what industries were most impacted by that?
Look, most of the work on skills and skills implications are usually addressed by the National Skills Commission and the Department of Employment Services. We obviously feed into cross-government work again on a lot of these sectors for which we have a lot of intel and insights, but we wouldn't have independently undertaken some skills analysis.
And anything on, what about specifically on skills shortages impacting the industry, sort of manufacturing?
Yes, so not in a formal modelling sense, but we certainly, through our intelligence networks, including in resources, including in energy, we have very good intelligence around some of the key areas of shortages, but also some of the implications from access to lack of skills and being able to transport across borders, both internationally and domestically.
Can I just add to that, Senator, to say that our employment colleagues have led whole of government work around workforce and, you know, the sorts of skills issues that you point to. In addition, we are working on a manufacturing workforce strategy to try to, you know, develop further analysis of where the challenges are in recovery for manufacturing.
Thanks, Chair.
Excellent. Any questions, Senator McDonald?
No, thank you.
No, Senator Walsh? Okay, so I think we're moving then on to outcome 1.2, if we could, if that assists. Okay. Do you have, Senator Chisholm, do you have questions on outcome 1.2? Senator Walsh?
Very quickly, as we await
That's
the
okay.
of our colleague, if that's okay.
Yeah, that's okay.
Which one's being asked?
Okay, Senator McDonald, do you have the call?
Oh, terrific. Thank you. I'd like to ask a question about the Australian Building Codes Board. Didn't you expect to get a question right out the back?
Okay. Okay.
Terrific, thank
Senator
you.
McDonald.
I would like to get an understanding of how you interact with the Queensland, Northern Territory and Western Australian building codes authorities.
Sure, thank you. Gary Rake, Chief Executive, Australian Building Codes Board. We have a role coordinating a national position that tries to influence construction standards across the country. And so in preparing our National Construction Code, we look to jurisdictions, including each of those that you named, to reflect that in their own legislative base. They then have a responsibility to implement that in their own jurisdiction, so they have the compliance role, if you wish. We have a representative from each of those jurisdictions on our board, and I personally would liaise with those representatives and then any other of their industry members that might be useful to help in our consultation role.
One of the elements that the Australian Insurance Council has raised with me about the reason for higher insurance premiums in Northern Australia is building codes, particularly in Queensland, but you know, I guess across Northern Australia. Is that something that comes up in your board meetings? Has that been something that you've discussed particularly, is how building codes intersect with insurance premiums?
Senator, I would have to say, so week 5 for me, I haven't yet been through a board meeting.
Sure.
But when we look at the extent of our regulation, cost-benefit analysis is a really important part of our work. All of our regulation, we're looking to make sure that the regulation addresses a key problem, particularly for the community and for the sector, and where the regulation has the ability to produce a net benefit, we would look to make changes in that direction. The cost of insurance and all of those flow-on costs are elements that we consider when we do our regulatory impact assessments.
All right, well, perhaps if I could put a question on notice, that you let me know if that's been a topic of board meetings or consideration recently, and if not, I hope it would go on to board meetings in the future, because certainly if the Insurance Council is saying it's a reason why their premiums are, they perceive the risk as being higher in the north, and it would be good to understand what could be done differently in that space.
Thank you. Will do.
Thank you. And Mr Fredericks, while the Chair has not noticed that I'm still asking questions, I just want to ask one on growing innovative and competitive businesses, industries and regions. The end of last year, we had an inquiry into the government's drought response, and the Public Service Union came and gave evidence about how we could pin jobs that were currently working remotely or were working remotely during COVID, particularly those ones that were in the regions. And I was really interested in that concept because, you know, a white-collar job in the regions brings a lot more multipliers than it does, I believe, in cities. What does your department have a policy on allowing a continuation of remote working, or how do you see the department engaging specifically in growing the regions?
So, Senator, thank you for that. So, yes, I mean, the lived experience of how departments like mine and across the public service have managed lockdowns has been that, we as a department, both collectively and all the individuals within it, now have a much stronger capacity to work and to manage the business of the department where staff are working remotely. I'm very proud of our IT system, allows us to be able to facilitate that remote work. The reality is that, I as the leader of this organisation believe that remote work will remain a feature of the employment landscape, not just for the public sector but for the private sector as well. And we'll make sure that, of course, we bring to that a sensible balance between allowing people an opportunity to work remotely, whilst, of course, at all times ensuring that the productivity of the organisation is maintained. So that's going to be a feature for the future. It does mean that there are potential regional benefits. I mean, this department, as you know, Senator, already has a very strong external to Canberra footprint because we have AusIndustry offices in a range of capital cities and regional centres. So we already have a physical footprint, if you like. The reality is, for us as a department, the fact that we now have a capacity to allow remote working and understand how it works means that we will have a capacity going forward to have more of our workforce outside of Canberra and living in other parts of Australia, including in regional and remote Australia. And can I be really honest with you? I think that's a really good thing, because from my perspective, my desire is that this department draws from all of Australia and can sustain employment opportunities for all Australians. Traditionally that's meant packing up and coming to Canberra. Over time, we're going to be able to develop working models where we're going to be able to employ people in Brisbane in a regional area because we now have a more mature capacity to manage the department with staff working remotely. So my own view is that this represents an opportunity for the department to draw from all of the strength of Australia and the market that the workforce market presents, bring more views into public policy making from all of Australia, and essentially have more capacity to influence out in other parts of Australia as well. So for me, as you can probably hear from my tone, I think it creates real opportunities for the public service to really have a stronger footprint in the rest of Australia, and we need it.
Joe Palmer, who was the 2019 AgriFutures winner, calculates that if we were able to mobilise or harness the regional workforce, generally the partners, the one who's gone into the region. So in my hometown, that we've had an engineer, a doctor, a couple of nurses, an accountant, all move into the region recently, but unable to find work in their professions because they're living remotely. Joe estimates that it's worth $1 billion a year to Australia to harness those latent skills. So that's terrific.
So that wouldn't surprise me. And it's interesting you raise that, because we know those examples exist in real life, i.e. For various reasons, one party to the marriage moves to a regional area. If that person is a tremendous asset to the department, then I probably don't want to lose the partner. And so, we're open to looking at ways of making that work. As I say, we're always going to have to keep in balance the capacity to facilitate remote work for all of the reasons that you and I agree, while simultaneously ensuring that we can maintain the productivity of the department. Can I say my lived experience during COVID including at times where large parts of my organisation were working remotely, is we didn't skip a beat. And so I'm quietly confident that we need to push in and push out to all of Australia and do that by maximising remote working.
A terrific answer. Thank you.
So,
Thanks, Chair.
Mr. Fredericks, I just want to explore that a bit further, and to be frank, I'm really impressed by your passion in that regard. And we talk about diversity of workforces, regional diversity is potentially an element of that. How do you convert that concept, that idea, that vision into reality? Are you going to develop some sort of a plan with key performance indicators to try and track how successful that is? What's your concept? Obviously, you've given this a lot of thought and reflection. I'm just interested in your view in terms of how we get from here to wherever you think is the optimal potential outcome.
Yeah. So Sarah, I'm genuinely glad you asked that question. Everyone behind you.
You're genuinely glad.
Everyone behind me is cringing because I could speak for the next 2 hours. Can I take Brisbane as the example?
Take it on notice.
And come back with a 1,500-word essay. Can I take Brisbane as an example? So our Brisbane office is growing. That's a good thing. We should have a decent sized office in Brisbane. And what we've discovered is Brisbane office originally was an office of AusIndustry, which is, as you know, is the division within this department that has responsibility to be out in the community engaging with business. They're very strongly important in the Australian government. But that was by and large the office of AusIndustry that sat there in order to facilitate that work. The Brisbane office of my department now pretty well has some people from every other division of my department. So if I go and visit, in fact I come back and tell the crew here, when I go and visit the Brisbane office, and if I do a walk around the floor, then essentially I'm talking to a bunch of people from AusIndustry. Then at the next couple of tables, it'll be someone from the energy group. Next, I'll be talking to someone from the National Measurement Institute. Then I'll be on to a climate change couple. Then I'll walk around the corner, there'll be people working for resources. And so that has extraordinary benefits. The benefits are, in a sense, I end up getting a microcosm of the department sitting in an important city and drawing all the relevant information that we need to know from that city. I'm also able to draw good people from Brisbane to work there who might not otherwise work for the Commonwealth Government. They'll work for the Queensland Government. I need them working in the Commonwealth Government. Then, of course, they maintain very strong connections back to their home division. So they get the staff in Brisbane get a great advantage, right? Because they sit there and they're working remotely with their energy colleagues. So they're part of a defined division. They're in a reporting chain. So they get the strength of being in a division. Simultaneously,
and they're living in the best state in Australia.
Best Senate representation.
Oh, absolutely.
and too hot for my liking. And they also get the benefit then of sitting next to colleagues in other parts of the department, and drawing from them as well.
Yeah.
So they kind of have two homes, and so you get great strength from that.
So how do you translate that into? How do you set KPIs in that regard? How do you go on the journey?
So it's interesting, Sarah, because essentially they get managed these days as surely as the person who's sitting next door in a Canberra office gets managed, because they're part of a small work group. They'll have a manager whose responsibility is going to be to look after and manage 3 people in Canberra, 1 in Brisbane and 1 in Melbourne. But the connectivity now is so strong that, of course, we keep an eye on productivity issues. We have to. But the connectivity is so strong that the Canberra-based manager can understand and understands the work value, contribution and productivity of that person in Brisbane. But also there's a Brisbane management structure, and so we have a senior person in Brisbane who also can keep an eye on that as well. So, it's something we've got to keep an eye on.
Well, I was thinking, just to be clear, I was thinking more about doing more of that and setting goals to achieve more of that regional diversity because you're therefore tapping into
Yes.
a larger employment pool,
So-
talent pool.
so
So
I-
that's the side of it I'm coming
So
from.
I can give you the understanding, of course, we're going to sensibly plan for that.
Yeah.
But in many ways, I'm the secretary of the organisation and I'm giving a very strong signal that I want to make sure that we look for opportunities to increase our footprint and to draw remotely.
Okay.
And so that will start to influence for example, our advertisements. I want to be pushing and finding opportunities to advertise outside of Canberra,
Yep.
advertise in South Australia,
Yep.
advertise in Queensland.
Yep.
That's what we should be doing.
Yep.
And so in many ways, of course, we've got to strategically plan it. We have to think about things like floor space. Of course, we have to think about some additional costs for working remotely, etc. So we need to plan it and think about it. But what matters most is not the plan. What matters most is the commitment to try to do it and to understand that there's benefit for all from it.
Okay, excellent. Thank you, Secretary. Senator Patrick, now you've got two areas of questions. One in relation to Australian building codes.
Yes, so I was going to do the Space Agency first, if that's okay.
You can do the Space Agency first. We do have the building codes people here as well. But
I'm just
if you
waiting
want-
for a piece of paper to come from my office.
Oh, are you?
Yes.
Okay, that's interesting. So if we could ask the Space Agency to come back.
Plus, they're South Australian, the Space Agency, so we've got to give them priority.
Right.
Yeah.
Well, there's another opportunity for remote movement. North Queensland's close to the equator.
Very
and
partisan.
Fantastic.
Can
for
I just say
taking
North Queensland actually has some really good launch sites, and we have been trying to support some people from North Queensland in relation to launch as well.
That's kind of you, Senator Patrick.
I think that might be the Prime Minister's want.
Right, okay. You have the call, Senator Patrick.
Thank you very much. Welcome again to estimates. You're getting used to it by now. I just want to talk to you very briefly about an inquiry that was run in the other place. We're not allowed to say the name of the other place. It's like Baltimore. We avoid the name. Now it tabled a report which contained 38 recommendations. So you're familiar with that, are you?
Yes, Enrico Plumer, head of the Space Agency.
Sorry, can you just speak up a bit?
Just for Hansard, Enrico Palermo, head of the Australian Space Agency. Senator, I am aware of the report and the recommendations.
Okay, so in relation to those recommendations, are you assisting government in any way in responding to those recommendations?
Yes, the agency is currently reviewing the report and preparing advice to government to inform a formal response.
Okay, so when might you expect your advice to go to government?
That analysis is ongoing right now. There's obviously a lot of recommendations. What I would say is, I think in practice the agency is actually executing on a lot of the recommendations, which is great, and it was a well-considered report with, I think, as you know, 89 responses. I don't have a date to confirm to you right now. It's really, we have to work with the Minister to agree a date that they want to provide the formal response.
Sure, but in some sense it's driven by you, and you know how we've worked this in the past. Not an exact date, just are we talking 3 months, 6 months, 12 months?
Within 3 months.
Within 3 months, thank you. That's all I was after. Now, that report stated that, and I'll just quote from it, launch service providers could contribute up to $2 billion of direct, indirect and induced value in the coming decade and beyond. Growth in this part of the sector is considered likely to contribute between 10 and 20% of the 20,000 new jobs by 2030. So it would seem to me that's a pretty obvious area to look for some gains. Are you in some way raising the priority on that particular work?
Yes, Senator, probably in 3 areas. Obviously, as you know, we're the regulator, and we've recently this year added more resources so we can support the industry to get through applications, get
I think I might have helped with that actually, before you arrived in complaining about things, but I'm glad to see that's working out.
A second area I'd mention is access to space, of which launch as part is one of the 7 key priority areas in the civil space strategy. So it is prioritised into our mandate, and our CTO team is working across government and research and industry right now on that roadmap. That roadmap will inform the 10-year aspirational vision for launch. The third thing I'd summarise that signal the importance we're placing on launch is the Technology Safeguards Agreement with the United States. So much of that, there's certainly domestic suppliers looking to develop technologies, but from our colleagues at Austrade, there is potentially opportunity for Australia for inbound investment from US launches, and as a result, we're also prioritising negotiating the Technology Safeguards Agreement. So there's at least 3 areas, I think, that demonstrate we are pursuing that economic opportunity and also, prosperity opportunity. Launches one part of space that really opens up the full value chain of space activities.
Okay, now, I think it was in the last estimates I might have accused you of not answering a quant, and it turned out I was wrong. It had been answered, and it was about market comparisons. Have you done anything beyond those market comparisons, perhaps in more detailed, more formal?
No additional work. I think we've done the formal work. We understand how we compare internationally on our regulations front, for example, and as a result, we are actually looking at. Actually, I will elaborate a little bit here, Senator, on work we're doing. We're looking at areas where we can reduce the burden on applicants, but maintain the rigour we want in approving facility launch licenses and permits. And I can bring up a few examples or ask one of my colleagues to walk you through that. Let me find my notes on this. So we have commenced a set of activities, as I said, removing unnecessary regulatory barriers. And that came through the House of Reps inquiry aforementioned. But let me introduce Mr. Christopher DeLewis. Mr. DeLewis started with the agency as the new General Manager for the Office Space Regulator in October, and he's really looking at and has done some good work already on how we can really move our operating model for the Regulator Office into the future. So if I can, Senator, ask Mr. DeLewis to walk you through some of that.
Thank you. Good afternoon. For the benefit of Hansard, Christopher DeLewis, General Manager, Office of the Space Regulator. Can
you tell me a bit about yourself, what you've come from, where?
Where I've come from. I'm an aerospace engineer, worked in CASA the last 6 or 7 years, and defence prior to that. Okay. Mostly in safety assurance, safety regulatory roles. Thank you. So as Mr. Palermo just highlighted, we're really pushing forward in some areas from the regulatory space for improvements. I guess I'd like to acknowledge the work that the Office of the Space Regulator team has done to date. Since July 2018, we've issued 22 authorisations under the legislation, including 2 launch facility permits. There's currently another 13 in progress.
So launch facility, there's 2 licenses, a launch facility and there's a launch
there's actually
activity.
5, but yes, there's those 2 plus 3 more. Yep.
Okay, so which when you said there's 17...
no, there's 22 have been issued in total.
Yeah.
And there's 13 currently underway of all the things that we do effectively.
And sorry, of the 13, sorry.
Yep.
Which are launch activities and which are launch facilities? Just to get a feel for
So in progress, there's 6 launch facility licences.
Yeah.
3 Australian launch permits and 1 high-powered rocket.
Okay.
And 3 overseas payload permits.
Were the launch permits, were they all the ones for South Australia, for Southern Launch?
The ones that are in progress, no, not all. The 3.
No, I'm talking about the ones that have actually been issued.
Correct.
Yes,
the
that's
launch
correct.
permit is in South Australia.
The South Australian ones, okay. Yeah. Okay, thank you.
Just to answer your question specifically about the sort of the improvements we're looking at, we're in a very good space now to I guess, learn from the past 4 years. There's plenty of really good feedback through the House of Representatives report and other feedback that we are now packaging up in a number of activities that over the next sort of 12 months that I think will really improve the regulatory environment.
Okay, now it's been reported to me, and I do talk to lots of the Space Agency people. Turns out if you question the Space Agency, a lot of space people call you. They've indicated that and this is not a fault directed at you, but when they're actually conducting, you know, a launch, they've got to deal with 6 or 7 different government entities. And I wonder if there's any way in which that can be streamlined, because, you know, you could imagine the difficulties that can place on people trying to operate commercially.
Yeah, I'm happy to take. Yeah, Senator, we're definitely aware of that feedback. Maybe Mr. Lewis can expand on the new operating model for the agency.
Yes, so Mr. Palermo mentioned the operating model for the Office of the Space Regulator. One new feature of that is really an regulatory engagement team, which we haven't had, which really will push out to us, I suppose, won't change the regulations per se, but do as much as it can within the regulatory environment to assist applicants, particularly prior to the assessment process.
Yeah.
So one thing we're looking at is sort of the concept of a case manager that could push out into various state and other Commonwealth regulatory authorities to see if there's ability to streamline some of the work there. So we've heard that feedback.
Okay.
We're looking to act on it.
All right, so that's good news. Thank you for that. The inquiry recommended considering separating the agency industry engagement and the regulatory function. Is that something you're considering?
We are aware of that recommendation. It said give careful consideration to that matter. Our view is today, obviously, we're in the process, as we talked about earlier, giving advice to government reviewing that. What I'd say is in the establishment of the agency, which was really founded in the expert reference group study in March 2018, concluded that if we want to really provide certainty for industry, minimise regulatory burdens and assist in growth of the agency should be responsible for regulating Australian space activities, which is the setup we have today. We appropriately have the necessary firewalls within the agencies. Mr. Lewis has a separate branch that has its own independent reporting line through me, and you know, the structure is working. What we need to also monitor is this is a nascent industry. We're not dealing with thousands of regulatory approvals per year. And so right now, it's certainly my submission, it's fit for purpose, but we treat the segregation of duties very seriously, and we've boosted the regulatory expertise in the team recently to help with that as well.
So I know they've done it I think they've done it in the UK, haven't they? They've split the functions in the UK just recently, is that right?
That's right. The UK Space Agency started out like the Australian Space Agency, having them together, but they decided after a longer period than we have existed to segregate those duties. We've had calls with the UK Space Agency about that, and what's interesting is we've actually had more activity than them, and it was certainly a decision of the UK government to do that.
Now, I won't get any pushback from the committee members here. You're a new agency. If I look and if I look to your former role, and it's not a reflection on you, but if we look at CASA, for example, most people external to CASA would view them as an agency that has sought to kill industry. And if they haven't sought to kill industry, they've managed to do it very effectively without that being their goal. I say that as a contrast. I just wonder how you, as you're moving forward, how you might avoid the circumstance where we end up being highly, sort of overly regulated.
Well, one of the advantages we have is by having the regulatory function in the office, we have very open and transparent communication, so we can have feedback amongst our teams, and I think that makes us a stronger regulator as a result. Our mandate is to triple the size of the sector, but it's also to do it responsibly, and I think those things need to go hand in hand if we're going to develop this sector.
Okay, just moving then quickly on to roadmaps before I finish. You've got 3 of 7 roadmaps have been issued. You've got 4 roadmaps to go, and I think they're supposed to be finished by the end of this year. Will you hit that target?
We will, Senator. The last 2 were the Earth Observation Roadmap was released in November, and the Robotics and Automation in Space Roadmap was released in January. So we do have the 4 to go. We anticipate 2 more will be released before the middle of the year, and the remaining 2 by the end of the year. And the reason I'm confident in that is, the first one always takes you the longest. Going through the process.
I get it. Yep.
Patrick, I need to share the call shortly.
Sure, no, I'm really just at the last couple of questions.
Thank you.
So, thank you. You had the Australia's robotic roadmap was issued.
Mm-hmm.
Can you just tell me what departments, other than the Space Agency, were involved in that roadmap?
We consult across government. The CSIRO played an integral role in development of that roadmap. We worked with colleagues in CSIRO was the main one. Also, Department of Defence as well. We have liaison officers in our team. I can certainly take that notice and get you the full list.
Yep, if you wouldn't mind.
Yep.
I think Defence identified the need for a similar onshore sovereign capability, focusing on autonomy. Is that something you're going to collaborate in?
Absolutely, across all our priority areas. In particular, 4 of them, there's a strong tie between ourselves and Defence. We have embedded Defence liaison members in our team, and in fact, 2 of the 3 roadmaps published were led by Defence secondees, so that extends through all business areas. The autonomy as we look at autonomy in robotics and automation in space, what we're really looking at is how do we spin Australia's world-class expertise in operating remote mine sites, remote oil platforms, to operating remote space stations and things at the moon. And that's sort of our focus on autonomy, and we have real strengths in interoperability of humans with machines and interoperability of different machines by different vendors. So how do we, and that's what our premise behind Moon to Mars and the roadmap.
You've just fueled the conspiracy people who think that the landing of the moon took place on a mine site. But finally, do you have a map of in terms of the robotic roadmap? Have you mapped out the onshore capability in this area, so you know what we have?
Yeah. So the roadmap process, we follow a process established by Cambridge University, and one of the tasks in the roadmap process is to evaluate state of the art. So evaluating the state of the art is what is the state of the art in the Australian economy across businesses, across research and academia. Yes.
All right, that's it. Thank you. Thank you very much, Chair. And thank you very much for the job,
Senator.
Yes, you can, and then I've got a supplementary. Supplementary, go on.
So when I think of the Space Agency, for ages I assumed that it was something to do with looking at space, getting AMSAR to decide who's going to collect any things that fall to Earth, and building rockets. But I've been reading about Asteria, an Australian woman who went to the same university as me, University of Queensland. She's in America building shelters for the first astronauts to go to Mars, and they're doing them in... But anyway, what other sort of technology? Is there a range of kind of space-related technology you're trying to encourage, or, how big's the funnel?
Thank you for the question, Senator. Absolutely, there is a very diverse industry forming in Australia. Launch is one of the priority areas we discussed, but it's only one of the 7 priority areas. So I'll quickly touch on the other 6 areas and how they apply to Australia and the benefits we see from them. So Earth observation is not looking out to space, it's looking from satellites down to Earth. That is essential to agriculture, weather forecasting, many of our industries across mining and others are sort of remote sensing Earth observation, so you're probably very familiar with that one. Communications, so using satellites to communicate. We have a wide geography in Australia and remote communities, and actually the availability of satellite communications is very important to regions and as backups. And in fact, with the Tonga earthquake recently, that was the only way to communicate with Tonga, right? It was using communication satellites and satellite phones. Third area we mentioned is robotics and automation, and that's about how we spin our expertise in. The fourth is precision navigation and timing. It's a bit of a jargon, but this is using satellite technology really to enhance the precision at which you can show where something is, and that's going to have very important applications in agriculture. So you can do precision agriculture, but also autonomous cars and other technologies.
Working with Geosciences Australia on that.
With the SBAS program, exactly. Yep. And then The last one is, we call it Leapfrog R&D, but we're focused on, actually there's two more, space medicine, life sciences. And this one was very surprising coming into Australia. We actually have great strengths in the medicine that applies to space travel. If you look at what we do to support Antarctica or remote communities with remote medicine, as well as other technologies, dosimetry and others, that's also a strength. And then the final one is space situational awareness. So this is really about protecting our critical assets in space. So you've probably heard about space debris and other things. Space weather events have been in the news recently. So we're also, that is an opportunity, sort of crisis brings opportunity for Australian businesses to do things in that space. So it's a really diverse, really interesting industry that really touches every portfolio of government.
Terrific. You can invite us to the Discovery Centre in Adelaide.
Yeah.
It's true.
You're very welcome to come.
And just my supplementary very quickly, Mr. Palermo, is there's a great Queensland company called PFI, which I don't know if you've heard of. What they produce is hybrid all-inclusive learning instruments, and basically it's a mini rocket that they can actually provide to high school students, and they can learn all about the different sciences which are incorporated in terms of launching a rocket, builds critical thinking, problem solving, teamwork, but also really promotes the STEM disciplines to both male and female students, and has been extraordinarily successful, and I've seen it firsthand. Have you come across that project? Are you interested in coming to Queensland and learning more about it, Mr. Palermo?
I'm very interested. I think I'm not 80% sure I've met the company virtually. It's a little hybrid rocket motor, and the beauty about rocket science, in many respects, it covers all technical disciplines. You've got thermodynamics, structural engineering, avionics and programming, and so we have an incredible opportunity to inspire the youth of the nation with space.
Absolutely, thank you. I'm going to Senator Watt, and Senator Watt's got a bracket of questions at hopefully about 15 minutes, and then we'll be taking a break at 4:35 if we could. Thank you, Senator Watt.
Thanks, Chair. I think this is the right section to do modern manufacturing initiative.
Yep.
Thanks. Is there anyone else we need to?
Yeah, we'll just do a personal.
Sure. Okay, this is something we tend to talk about each estimate session, so I'm just keen to get a bit of an update on the Modern Manufacturing Initiative. Just to recap, this was announced on the 1st of October 2020. It was a $1.5 billion modern manufacturing strategy that includes a few different components, which we've talked about each time. I think I'm gradually understanding them. So, out of that $1.5 billion modern manufacturing strategy, are you able to give us an update on how much has been spent from that to date, broken down by initiative?
Yes, certainly. So, Narella Keddy, Head of Division Manufacturing. So, Senator, as of the 14th of February, we have committed through executed agreements $292.4 million.
292.4?
That's right. So under that is 186.6 million under the translation integration round one.
So 186.6 for translation integration round one?
That's correct. 24.4 million under supply chain resilience initiative round one.
24.4?
Yep, that's correct.
Yep.
53 million under the Modern Manufacturing Fund round two.
Yep.
And 28.4 million under the Advanced Manufacturing Growth Centre Commercialisation Fund.
Advanced Manufacturing
Growth Centre Commercialisation Fund.
Thanks. And if I add them all together, that gets me to 292.4, does it?
That's correct, Senator. Yep.
Thanks. Sorry, Advanced Manufacturing Growth Centre Collaboration Fund?
Commercialisation Fund.
Yep. Thanks. And I think we've discussed before that MMF round one preceded the modern manufacturing strategy, didn't it?
That's right, Senator. Yep.
Did you have the figure for how much was spent for that?
Ooh, I do.
That's all right. That's all
I
right.
think the value of executed grants is 40.2 million
There you go.
For round one.
for round one, yep.
Okay. But
Yeah,
that, again,
that's
that was
right.
not part of the modern manufacturing strategy.
That's right.
Thanks. So just going back to what you have, the 292.4
Yep.
that's been committed, how much of that has been released?
So that's executed grant agreement, Senator. So what I've just given you, that is when we have entered into the grant agreement with
Yep.
those companies.
Yep.
In terms of money actually paid to business,
Yep.
so for round one, translation integration is 60.5 million.
60.5?
That's right.
Yep.
The supply chain resilience initiative round one is 3.2 million.
Yep.
For the the MMF round two, 16.4 million.
16.4.
Yep. And the 5.1 million under the Advanced Manufacturing Growth Centre Commercialisation Fund.
So that's 85.2 all up.
Yep.
I make it.
And would it help, Senator, too, if I actually give you the number of recipients for each of those?
Sure.
So for translation integration, 34 recipients. For supply chain...
sorry, when you say recipients, this is the people with whom you've
Number.
signed an agreement?
That's right, that's correct.
So not
yep.
this isn't the number who've necessarily received funds yet, but they've got an agreement with the department.
That's exactly right.
Okay, could you give me that figure again, sorry?
So 34 recipients.
For translation and integration?
Yeah, so that's, yep,
round
that's
one?
right. Yep.
Yep.
27 for supply chain.
Yep.
86 for modern manufacturing fund.
Round two, yep.
Round two, and 55 under the Advanced Manufacturing Growth Centre Commercialisation Fund.
Okay. So at this point in time, from the 1.5 million committed for the strategy in October 2020, there's 84.2, which has got to companies.
So that is the amount of money that has actually been paid to business, and
Yep.
remembering their milestones for business.
Yep.
The grants that have been executed, really, Senator, is the figure, because that is actually us working, my colleagues in Oz Industry working with those companies to finalise and execute those grants. So we're entering in. So that figure is the 292.4 million.
Yep. Can you just remind me, in terms of what was budgeted in portfolio budget statements for the 1.5 billion, obviously a lot of that was going to be outside the forward estimates, I think, or am I wrong about that?
No, it's within the forward estimates.
Within the forwards,
yep.
okay. So what was budgeted to be spent in 2020-21?
I'll just ask my colleague, Ms Mulder, to assist you there.
Hello, Joanne Mulder, General Manager, Strategy Implementation in the Manufacturing Division. So the current budget at the moment, as represented in pays, is there's $420 million for this financial year.
For 21-22?
21-22, that's correct.
420?
$420 million. That's for the Modern Manufacturing Initiative specifically.
Which is only part of the overall strategy, isn't it?
That's right. It's 1.3 billion of the 1.5 billion.
Okay, what about the other component? But, sorry, just before you give me the others, the figures that Ms Lucchetti, you gave me are across the whole strategy, aren't they? They're not just MMI?
That's right. So the supply chain resilience is across the modern manufacturing strategy.
Yep.
It's not part of the MMI.
Yeah.
That's right.
Okay. So, Ms Mulder, sorry, it was for 21-22, 420 million was budgeted for MMI?
That's correct.
And what about the other components of the strategy?
So there's 10 million in the supply chain resilience. I'm still talking about 21-22.
Yep.
There's 37.07 million for the the Manufacturing Modernisation Fund, round two. Yes.
Right.
Yes. There's 30 million for the Commercialisation Fund, which is delivered through AMGC.
Sorry, is that 35?
Sorry, 30.
30 million for the...
Commercialisation Fund, delivered through the Advanced Manufacturing Growth Centre.
Yep.
Yep. And then, again, just still talking 21-22. Sorry, that's all of... that covers now.
Okay, and all of those things are under the umbrella of the modern manufacturing strategy?
Strategy, that's
okay.
correct. Yes.
Did you have any figures for 2020-21 for what was budgeted for that financial year?
So if we recall, I think it was $72 million that was originally budgeted in 2021, 40 million of which was for the Modern Manufacturing Initiative. Do you want me to
Sorry,
say?
what did you
Yep.
say in the 40 million for the Modern Manufacturing Initiative in 2020-21?
That's correct,
What did
yes.
you say in the lead up to
There's
that?
72, there was 72 million for all of the initiatives under the Modern Manufacturing Strategy
Yep.
for 2021. So that was
Okay.
the, yeah.
Okay, so across 2021 and 21-22, it was expected that we would see about 570 million spent on the
what's-
Modern Manufacturing Strategy.
That's what's budgeted in the profile.
Yep.
I think that's right. You've done the addition. Apologies. So.
But on the 17th of February, with 4 months to go, it's been 85.2.
So Senator, it's good to recognise that there are two, we've still got rounds open. So the collaboration stream, which is the centrepiece of the Modern Manufacturing Initiative, is an $800 million stream that is currently under assessment. There is also round 2 of the translation integration stream. That's $280 million. That's currently under assessment. And there is a supply chain resilience initiative, round 2, which is $50 million. That's currently under assessment.
Yep. But if they're still under assessment and decisions haven't been taken, we're hardly going to see funds provided to industry by the end of this financial year. I mean, they've still got to sign an agreement with the you've still got to make a decision, then sign an agreement before and then they've got to hit milestones before they receive any money. So we're not going to get anywhere near the 570 or whatever it was that I said was budgeted by the end of this financial year, are we?
As far as we're concerned, Senator, we're still on track to deliver that, and we intend to work very closely with businesses once those decisions and announcements are made.
Do you really think you're going to get there?
We'll do everything we can,
I hope you
Senator.
can. I mean, it obviously that does sound like there's quite a few steps before any of these businesses will receive funding. Like, for starters, a decision's got to be made and announced. And it's close to 500 million short compared to what was budgeted for the 2 financial years at this point in time.
So the only other comment, I guess, Senator, that I would make to that is for the collaboration stream, grants were from $20 million to $200 million. So we are talking significant number of grants and potentially only a small number of grants for a large volume.
Yeah, I recognise that there's a lot of money out there and been announced and, applications called, but the question is is when that money actually hits the ground. That is a theme that I tend to pursue across a range of committees because this government has a habit of making big announcements and making big promises, but you have to wait a long time before you actually see the money. I'm not having a crack at officials, I'm having a crack at the government.
Just on that, so I should endorse what Ms Lucchetti said. So, from this department's point of view, we will drive to ensure that as much of that funding that's been committed in the forward estimates is out the door this year.
Yep.
And the thing I know, and you're always very good about this, to be fair, the importance of milestone payments and understanding that, of course, it's not in government's interest, it's not in taxpayers' interest to push all this money out without having a properly considered milestone process to make sure that there's accountability in what the businesses are delivering. And so, of course, that necessarily means that the funding is expended across years. But you've always accepted that, haven't you?
No, I do. And as I say, I understand you can only work within the constraints that you're set by ministers, who often determine the timing of these things. So just on, you've made the point that I think the collaboration stream, there's about $800 million available for that.
That's correct.
And you've called for applications for $800 million.
Yes.
Am I right that, I think in answer to a question on notice, you advised that the department had received 86 applications under the MMI collaboration stream?
Yes, that's right.
How many applications were successful?
So that's currently under assessment. So 81 are eligible, and that is currently under assessment, Senator.
Yeah. So no decision's been made
No
yet?
decisions have been made yet.
And when did applications close for that?
Application, sorry.
I think it's the 9th of December?
Yeah, 9th of December,
Senator.
9th of September last year?
Correct.
9th of December, yep.
But no decision's been made?
Not at this stage, no.
So my information is that applications opened on the 11th of August last year and closed on the 9th of September last year, which meant that industry was only given 29 days to make their applications, but the department has had these applications since the 9th of September and we're still waiting for a decision to be made. Is there any reason it's taking so long?
I would just clarify, the program was actually launched on the 30th of June 2021 with the guidelines being released. Applications, yes, then did open, we opened for applications on the 11th of August, and as you said, we closed on the 9th of August.
It's a pretty short window for people to put together a complicated application, but that's by the by, nothing can be done about that. But I think those businesses who went to the trouble of putting in an application in such a short window might have expected they would have heard something and be able to create some jobs. So what's the hold-up?
I would suspect, though, that for a grant size of $20 to $200 million, you're right, these are significant, complex projects, and it is reasonable for the department to ensure that there's a robust assessment process, which there is currently ongoing.
So no businesses have yet received funding under the collaboration stream?
That's correct, because yes, it hasn't been finalised.
Yeah. Could I just have 2 minutes before I wrap up and go to a break? Thanks. That earlier explanation of the figures took a bit longer than I expected, so I apologise for that. And so can you tell me then, very briefly, the assessment process for these applications? There's an independent panel?
That's correct.
We've gone over this before, I think. So there's an independent panel of experts who've been tasked with making recommendations. So they've reviewed the applications.
Yes, that's right.
That has happened.
Yes.
They have done that. Did they sort of score each application, or have they sort of rank ordered them or something like that?
So the assessment process involved obviously around 40 committee members, 40 independent experts across 40. Sorry, 40.
Yep.
Yes, sorry. Of independent experts across the national manufacturing priorities and across the expertise that's required around manufacturing. Sorry, what was your question again?
Before I remind you, would you be able to just on notice tell us who the independent panel of experts was?
Certainly happy to do that, preferably once the decision's been made, just for probity reasons.
Okay.
If that's okay.
But there was no departmental representation on the panel of
collaboration
experts?
committee? No, there wasn't.
And no representation from any department of government?
There was a non-voting member, which was the program delegate.
From which department?
This department.
This department, okay.
Yes.
Who's that?
That would be myself.
That would be you?
Yes.
So you're across what's happened even though you didn't have a vote on them? And so the independent panel, my question was, have they sort of rank ordered them or scored them or something like that?
Right. Yeah, sorry. They did. They gave scores in terms of the assessment, more to determine where they felt that the applications rated.
And very briefly, what were the criteria for determining a score?
So the merit criteria is outlined in the guidelines.
Okay.
There is 4 criteria there. I recall they are of equal ranking.
Mm-hmm.
And so
I can refer to them if they're publicly available.
They are
they?
publicly available.
But and they were the only criteria applied.
Yes.
Okay. And so the panel has now scored all of those applications.
Assessed the applications.
And have they provided that information to the department formally?
That part of the process is effectively closed. Yes, and that's with the department.
Okay. And has the department? My understanding is the next step, the decisions on this are being made by the Prime Minister?
That's correct.
He's the only minister who's making decisions on this?
He's the decision maker, yes.
Okay. And has any advice been provided to the Prime Minister at this point about who the successful application should be?
It's still going through the assessment process.
And I'll just jump in there, Senator, too. With this particular, and like everything in the modern manufacturing strategy, the Industry, Innovation and Science Australia has a role and provides strategic oversight for the modern manufacturing initiative. So once the assessment committee went through their process, the IISA provided its strategic advice, and that we've gone through that process too. So that was another layer, another area of due diligence that we were doing, and really trying to make sure that they are transformational, trying to meet the objectives of the modern manufacturing strategy.
So just finally, what I'm trying to get to, I suppose, is where are we up to in this process? So the panel have effectively made their decisions or where they think the order should be. That's been provided to the department, that we've had that external advice that you just talked about.
Yep.
And so is it sitting with the department at the moment, or is it being provided to a minister or another department like PM&C?
So part of the process which is outlined in the guidelines is additional advice from relevant portfolios. And prior to that, there was also a step around a cross-portfolio review as part of the assessment process by the committee.
And who's leading that? PM&C?
No, this department.
Okay,
is coordinating that.
so whose desk is this on? I suppose is one simple way of putting it.
I think it's fair to say that it's still with the department bringing all those channels of advice together before the next steps occur.
And have there been any discussions with ministers or ministers' offices about the recommendations of the independent panel at this point?
So, if it helps, Ms Boulder can talk about that cross-portfolio review that we've been undertaking.
Yeah.
So-
what I'm
sorry.
particularly interested in is any interaction with ministers' offices at this point.
So look, going back a step, the cross-portfolio review was actually a review that took place across relevant Commonwealth agencies in order to get views on the policy alignment of the particular projects. So that has occurred as well, and is one form of advice as well that will be taken on board by the decision maker.
Yep.
In terms of the next stages of the process, as I said, one of those steps is to receive advice from relevant portfolio ministers, and we're still in the midst of bringing that all together.
So have those sort of discussions with portfolio ministers begun?
The interaction has begun, yes.
Right. So I guess what I'm really trying to understand is why it is, and I acknowledge these in some cases are big grants, but what I'm really trying to understand is why grants which closed on the, was it 9th of September last year, still haven't been decided or announced, because obviously it's not until they are announced that you can then go and sign an agreement, and we're not going to see any jobs come from this for quite some time. So the longer that this process goes on, the more delay there is in seeing these jobs that we were promised would happen.
So, I think the fair answer to that question is, I think we've tried to strike a balance between speed and thoroughness of process and diligence of process.
Have any ministers or ministers' officers indicated that they would like to slow this process down or hold off decisions for any period of time?
Not to my knowledge.
Because I'm conscious that, we're getting pretty close to an election and governments like to have things to announce during election campaigns, but there's been no suggestion from ministers' offices that can be put on the back burner so they've got some nice announcements to make through a campaign?
We have a schedule that we have been working through and that we are still working towards.
Okay, thanks.
Oh, excellent. So we're going to break for 10 minutes now. And when we come back, Senator Patrick has some questions on the building code issue. So if we could just be ready for that. And then, do you have more questions under this outcome?
I think we might only have 5 minutes or so.
Okay, so we'll be able to tidy it up and then move on to CSIRO. On this outcome, yeah.
I think we'll have a bit more than that.
Okay, well, let's talk about that offline, but we'll have a break for 10 minutes and then come back with you, Senator Patrick. If I can drag out the commencement for a minute. So Senator Patrick has, I did say before the close that Senator Patrick was going to commence with the questionings in relation to building codes. However, Senator Patrick has had to go to the Defence Committee where he needs to ask a tranche of questions. So we have some further questions in relation to the modern manufacturing initiatives, as I understand it, Senator Chisholm.
Senator Watt's going to start.
And Senator Watt is going to continue with those questions until Senator Patrick comes back to ask his questions in relation to the building code. So with that, and as I'm speaking very slowly, I think we will just about be ready, Senator Watt, to give you the call.
Sure. Thank you, Chair. Ms Mulder, can I just come back to something you said before the break? I was asking about what interaction ministers or ministers' officers have had in this process so far, and I can't remember your exact words, but you were sort of saying that there's been some engagement or interaction, whatever the words were. Can you just talk to us about exactly what role ministers' officers or ministers have played so far?
So as per the guidelines, the decision maker takes into consideration advice from relevant portfolio ministers. Therefore, as part of the process, relevant portfolio ministers will be interacted with, and their advice will be sought based on the, the outcomes of the assessment committee, and all of that information will come together to support Minister Taylor to make recommendations to the Prime Minister, who, as you mentioned before, is the decision maker.
Okay, and so again, so the process so far, applications closed,
Yes.
independent panel established to assess the applications.
The merit of the application.
The merit of the applications.
Eligibility assessment was a step prior.
Sure. So determine who's eligible, 81 left. Independent panel assesses them.
Yes.
I've forgotten the organisation, Ms Lucchetti.
RSA.
RSA. They have their say.
Provide strategic advice.
Provide strategic advice. All of that is kind of jumbled together to essentially establish a rank order
To provide
or scores,
advice.
however.
The assessment committee is the only kind of part of that process that does actually give a score
Yep.
against the 4 merit criteria that are in the
Okay.
guidelines.
And then at what point did ministers' officers get involved, or ministers?
So, as per the guidelines, and there's a flow chart in the guidelines, the advice from relevant portfolio ministers is one of the kind of last steps, I guess, in terms of the final piece of advice that comes together
Yep.
to make the whole bundle of advice
Yeah.
that is considered.
Senator, it just might be useful clarifying what we're looking for in terms of that advice is an extra layer of due diligence. So seeing with those portfolio ministers whether they have had companies who are making their way through, whether they've had similar grants for similar projects, or it's just an extra layer of it's probating due diligence that we
Yep.
do on those companies.
Yes,
And-
so there's not a reassessment
No.
by any of them. No.
And which ministers are consulted in that way? Obviously, Minister Taylor.
Yes, as Minister Taylor and relevant portfolio ministers. So I'm happy to take that on notice.
So if it's, I've forgotten the streams, but if it's in the sort of health and medical manufacturing, it'd be Minister Hunt.
Exactly.
And so forth.
That's exactly. Right. That's yes.
And I just want to come back, Ms Mulder, to what interaction or whatever the word was that you used with ministers' officers has occurred to date. I understand that they sort of come in late at the process, but it
Yes.
sounded like there had been some discussion with ministers' officers about the assessment process and where it got to.
So as per the guidelines, so we are obviously sticking to the process in the guidelines, relevant portfolio ministers have been asked, as Ms Lucchetti said, more around due diligence. Questions such as does it align with their portfolio objectives or any strategies, government strategies that they have responsibility for. So it's an additional piece of
Yep.
advice.
And has that started?
It has commenced, yes.
Okay, so and is it ministers' officers or ministers?
Ministers,
Ministers, okay.
as per the guidelines.
Okay, so that engagement has begun with ministers?
Yes.
So does that mean that ministers are now aware of what the assessment panel has had to say about the applications?
I think it's fair to say that that's the case, yes.
Okay. And
but we are still partway through that process, so...
Sure. So it's begun?
I can't talk for others, I guess.
Yeah.
It's begun.
And does that mean that has written advice been provided to ministers about that?
Yes, that's correct, Senator. So the way that advice is packaged up, Minister Taylor writes to his portfolio colleagues to package that information around those who are involved in the collaboration stream. Yes.
And Minister Taylor has done that?
Yes, correct.
Okay, so he is aware of what the assessment panel had to say.
He is aware.
Obviously,
yes,
and
right.
he has communicated that to other relevant ministers.
To relevant ministers, correct.
And some of them have replied, some of them haven't.
We're partway through that process.
Okay,
That's right.
so if there are any businesses out there who are still waiting for a decision to be made here, like ministers do know what applications have been recommended. So ministers could expedite that process if they want to.
If it's okay, I might just clarify that. Ministers know which applications were supported for funding from through their assessment process.
Right.
Yeah.
So,
Not necessarily what will be recommended.
Sorry, and it's worth clarifying, ministers only know what is relevant to their portfolios.
Yeah.
They don't know the whole, it's what is relevant to them.
But Minister Taylor knows about all of them.
Correct.
And Minister Taylor provides that advice to the Prime Minister, remembering the Prime
Yes.
Minister is the decision maker, not Minister Taylor.
Yes. So has Minister Taylor written to the Prime Minister or communicated with the Prime Minister about
That's
this?
a further step.
That comes later. Okay. So, Minister, what are you going to do to get these applications decided and get the money out the door so people can start creating the jobs that you promised Australians we would see?
Well, the process that's been outlined is being followed. And so what we're going to do is make sure that process is thorough and complete. And for an $800 million program, it is important that we get it right. So, I'm sure that once it's been through those relevant processes, once they're completed, then a decision will be made.
Are ministers holding on to this so that they can make announcements through the election campaign?
Not to my knowledge, no.
Because that would be a pretty terrible thing, wouldn't it, if Australian businesses are having to wait for election campaigns and election commitments before they find out what money they're going to get. That would be a pretty terrible thing to do, wouldn't it?
Well, what's important is that we get the process right, and that's what everyone is endeavouring to do.
Can we just come to the jobs that have been created so far? And again, I know this is something that we talk about each time. And this is where we get Mr. Campbell. So, I'm sure you know what I'm going to ask. What's my first question? my first question is what's my first... No, my first question is what's my second question?
I wouldn't hesitate to guess.
Good answer, Mr. Campbell.
So, can you please tell me, and I know when we've done this before, you've also given me round one job numbers, which I probably don't need because I'm focusing on the modern manufacturing strategy. Can you tell, what we know is that $85.2 million has been paid out to businesses under the modern manufacturing strategy to date, and we also know that $292.4 million has been executed in contracts. What I'd like to know, Mr. Campbell, is how many jobs you say directly attributable to the modern manufacturing strategy have been created so far?
So, Senator, as I think we've said on many occasions, that there's a number of elements to the modern manufacturing strategy. The first pillar is probably the most significant in terms of its funding, which is the broader economic support provided from the government during the pandemic, as well as the continuing funding. As I've said at the last estimates, it's very hard to unpack from general figures in the manufacturing data that comes out. So what I've been able to do in previous estimates is take you to completed jobs reports.
Yep. Yes, that's right.
That's right. And we only have completed jobs reports for round one, and that's still not complete either, because basically we get the updates on the jobs figures.
Yep.
When the completion reports are submitted.
That's right.
So I can give you an update.
So why don't you give me the round one figures, job figures?
Yep. So we are now at, of the 172 successful projects, we now have 99 project complete reports.
Yep.
And that has now moved the jobs number for that particular package up to 997 jobs.
Mm-hmm.
And obviously that means there's still another further 73 projects to submit completion reports, and obviously as they come in, be able to update for those. But because the other packages have only just commenced, we don't have any, obviously, job completion reports at this stage. So I can't give you a number from the specific spending line item.
So from the modern manufacturing strategy so far, we can't say that any jobs have been created because we haven't yet got the completed project reports.
No. If I take you back again to the start of my testimony, so the modern manufacturing strategy includes the first pillar, which is lifting all of manufacturing
Yep.
by providing taxation support. Now, I say we can't give you a specific estimated number from that, but we know it's significant as part of the overall trend in
Yep.
manufacturing figure.
I understand that, and again, we've had this conversation
Yeah.
before.
Yeah.
And I acknowledge there probably are some indirect jobs that have come out of this, but I really want to focus in on the direct jobs that we say are attributable to the modern manufacturing strategy. And at this point in time, it's not possible to give a number for how many direct jobs have been created.
Not a specific figure at this stage. I mean, as you know, there was an estimate provided for a 10-year projection, and that was the 80,000 figure.
Yep.
And we'll be making progress over the 10 years towards that estimate
Yep.
as each of the packages are rolled out. But as I say, the most substantial amount of support is coming through the first pillar, which is the improved tax regime, the job support provided through expenditure more broadly.
Yep.
That goes to manufacturing as well as to other industries, obviously, but manufacturing sector benefits, and we'll get jobs from that.
And you're right. So, Minister, again, I know we've talked about this before, but when this strategy was announced in October 2020, the Prime Minister claimed that it would create 80,000 direct jobs and 300,000 jobs in total. How many jobs do you say have been created so far?
Well, Mr Campbell, I think, has pointed out the fact that when you look at the entire strategy, which includes getting the economic conditions right for business, you can't link exactly those jobs. But what we see is at a whole of economy level, and we saw the jobs figures out today, jobs being created across the economy, and what we intend to continue to do is to pursue those strategies. So whether it's getting the economic conditions right for business, that includes things like tax cuts and tax incentives, whether it's making science and technology work for industry and for jobs, focusing on the areas of advantage, building the national resilience, those policies are about supporting jobs. Now, Mr Campbell has, in previous estimates and at this estimate's pointed out that over time we expect there will be direct jobs that will be attributable. As
when?
Well,
because we can't point to any yet.
Well, but that's a 10-year strategy. But again, what we've put in place is the conditions that see large manufacturers making large investments on the back of it. When you've got BlueScope and others saying the conditions for manufacturing are the best they've seen in relation to the policies of this government, then those investments are being made. And so Mr Campbell can take you through some of those indicators in relation to the response of manufacturing businesses to those policies. But what we're seeing at a whole of economy level, as I say, is unemployment down to 4.2%. And that is something that I think is very positive. It is something that stands in stark contrast to your record when you were in government, and those are the kind of policies we'll continue to pursue. But in terms of the specific elements of each part of the strategy and the Modern Manufacturing Initiative, well, Mr Campbell can talk you through in more detail, as he has already.
What I would like to know, Mr Campbell, is whether the department has updated modelling on the anticipated direct job creation to come from the modern manufacturing strategy.
We haven't updated an estimate for that. I guess the only thing I would point to, though, and I guess as the Minister said, on the strength of the economy and the growth that we saw coming out of the base of the recession was stronger than I think most people had expected. Now, there's been some temporary factors more recently around the Delta shutdowns in New South Wales and Victoria, and to some degree some of the impacts from the Omicron. But as we look through some of those temporary factors, that strong growth path is projected to continue, and manufacturing will follow with that. We've seen very strong forecasts from both the Reserve Bank and the government themselves in the update in the MyEFO. So the outlook is strong. We do have some headwinds just at the moment from the new variants, but I guess as everyone in this committee would be expecting, we'd hope to see that end fairly shortly.
Are you aware that according to the latest single touch payroll data, manufacturing jobs have decreased by 3.6% since the announcement of the modern manufacturing strategy in October 2020?
I don't have those figures in front of me. Sorry, what was this? Sorry?
So single touch payroll data.
Single touch payroll.
Manufacturing jobs have decreased by 3.6% since this strategy was announced in October 2020.
Look, I don't have those figures in front of me. I can talk to the ABS figures where we've seen 3 quarters of incredibly positive growth in February, in May and in August. That was prior to some of the most recent lockdowns, but there was a very strong return to growth in employment in manufacturing, which has been a very positive outcome for the sector. And we've starting to see some of the positive sentiment in the National Australia Bank survey around confidence. Some of the conditions are still a bit patchy, but on confidence levels, and again, it's, as some of the restrictions unwind, you'd expect that confidence to build in coming months.
This is probably one for you, Ms Lucchetti. When do you expect the $800 million that's been set aside for the collaboration stream to be spent in full?
So, as I said to you, Senator, it's currently under assessment process and we're expecting a decision from government very shortly. And we're working on it as quickly as we can.
Sure, but, sorry, my question wasn't when will a decision be made. When do you expect that the funds will be spent, as in given to, all gone to business?
Well, so Senator, I mean, the money, the way it is profiled, we intend to spend it, the way it has been profiled. But naturally, these things come down to conversations with those businesses too, in terms of, as we found with translation integration, some businesses deciding they didn't want to start, they didn't want to take up the money until 1st of July this year, as opposed to, as in 1st of July this financial year, rather than last financial year. So it just depends on our negotiations with each of those businesses and their circumstances.
You talked about the spending profile for this. Is that across the forward estimates?
Yes, that's right.
So it'll be 4 years since the strategy was announced before the money will be fully spent?
So it all depends on the milestone payments, Senator, in terms of what actually goes into those contracts when we're negotiating with those businesses.
It could be later in some
Senator,
cases?
the profile is the profile, and in the grant guidelines it explains when the funding streams finish in terms of like 2023, 24, those types of things. I'd have to go back to the guidelines to double check.
Sorry to interrupt. We have Senator Mirabella's got some questions in relation to hydrogen. Mr. Fredericks, I'm just trying to get a guide as to whether or not your officers who deal with that subject matter are available during this block. I just thought I might raise it with you.
Unfortunately, Senator, they're not available at all because hydrogen is the responsibility of Minister Taylor. That's where the work around the hydrogen hubs, etc., is being done. And so we always deal with that in energy and emissions reduction estimates on Monday in the Environment Committee.
Okay.
But to be fair to the Senator, though, we can at least have a listen and perhaps take questions on notice or see what we can do.
Well, let's do that. But I'll send her what I just wanted to flush that out.
Yep. I won't be much longer.
Okay.
So we'll do. The DISA portfolio additional estimate statement shows that MMI was underspent to the tune of $35 million. I'm presuming that was last financial year. Why was that money not provided to Australian businesses as it was budgeted to do?
So, Senator, I think that's just a profiling in terms of the conversations and the negotiations that we're having with business, but Ms Mulder will be able to assist.
Thank you. So, sorry, Senator, you're referring to...
The additional estimate statement for the portfolio shows that MMI was underspent to the tune of $35 million.
That's correct.
Why did that money not get out the door to business as was budgeted for?
So the original budget for 2021 was $40 million for the Modern Manufacturing Initiative. And as you can see, $5.91 million was the actual expense for 2021. And last estimates we spoke about the amount that had been accrued for the last financial year, which was 5.91. So that 5.91 represents the 3 contracts that had been executed at that point in time and their first milestone payments. Other businesses had been successful in receiving grants at that point, but were in negotiations with the department. And of course, as you can appreciate, with the environment that was on at that time, including COVID, we worked with businesses to suit their timeframes rather than our timeframes. The remainder of that $40 million funding was, there was a movement of funds, so that's been moved over to further financial years.
The same statement projects that $420 million in MMI expenditure this financial year. You've given me some figures so far about the strategy as a whole, the money that's been spent. Can you just remind me which of those are for MMI as opposed to the overall MMS?
So the 420 million was for the Modern Manufacturing Initiative, so the MMI.
And the figures you gave me before were for Translation Integration Round 1, that's MMI?
That's right.
That is MMI, yes.
Supply Chain Resilience is not?
No, that's no.
MMF Round 2 is not?
No.
And Advanced Manufacturing Growth Centre Commercialisation?
Is not.
Is not.
It's
so,
the collaboration stream, that's the addition, like...
Yes.
Yeah.
So far of the 420 allocated for MMI this financial year, 60 has been spent, 60.5, being Translation and Integration Round 1.
Certainly the funds that have been spent to this point in time is from Integration Translation Round 1, that is correct.
Okay, thanks, Chair.
Okay, thank you, Senator Watt. Now, Senator Mirabella just has some questions on in relation to hydrogen. So, thank you, Mr. Fredericks, for trying to accommodate.
No, I understand you'll be taking these on notice.
Yeah, if that suits you.
But I'm moved to ask these questions because I did in fact question Snowy Hydro the other day on this, and the CEO was very upfront that they are not experts in hydrogen. And this is in relation to the Kurri Kurri.
All right. Well, if you're comfortable, Senator, we will take them on notice because I do want to help, and we'll get back to you as quickly as we can.
Okay. All right. Well, I'm moved to ask these questions and raise this issue in light of today's announcement about the closure, Origin's announcement of another coal plant being closed a number of years early. That's obviously of great concern going forward to the stability of generation, stability of the grid. It is proposed that the Kurri Kurri plant will eventually be hydrogen capable. And what my questions relate to the reality, the feasibility and the cost of that. The head of Snowy Hydro told us that, for example, the decision being made on some of the equipment, Mitsubishi turbines, has been made because those turbines are hydrogen capable, although I also understand they are potentially hydrogen capable. So I'd like to know what's that going to cost over what time period, but more importantly, there's a whole bunch of infrastructure would have to come with that eventually, and the start of that has got to be some hydrogen production. So I'm curious as to what what sort of feasibility is being done on that, because by my reckoning, the hydrogen will be produced from coal gasification in the Hunter as one option. Steam methane reforming, that's going to require a carbon capture and storage system. What's all that going to cost? The existing gas pipeline is not capable of taking more than, I think, about 10% hydrogen. If they're going to run at 30% hydrogen mix or something, there's a new pipeline. What's that going to cost?
Yep.
And in the alternative, or as well as, I know there's a lot of talk about very large-scale hydrogen production from electrolysis. Well, I'm really interested to see the feasibility of that anywhere near the Hunter Valley, what that would look like, what the footprint of that would be, and ultimately what the cost of the gas would be. So there's a whole lot of questions. So I guess coming down to it, what I'd like to see is some broad modelling on some of those options. So the cost of upgrading the eventual plant to run on a certain mix of hydrogen. And I know that in theory, those Mitsubishi turbines are supposed to be able to run on 100% hydrogen. Okay, but what sort of conversion cost is that going to be, and the cost of all those other options, the cost of the hydrogen, as best as we can estimate it now, because I think these are, very important sums to do today.
So, Senator, can I just say this? They are very valid questions, and we will be in a position to be able to give you quite a deal of detail on that. Just a couple of things for you to note. When it comes to the sort of questions that are about the costings to Snowy Hydro for the project itself, we would most likely go to Snowy Hydro to ask that for that information. We'd work with them on that because it's their responsibility and their accountability. All the questions you've got around connection, the hydrogen issues, is our responsibility, and we'll be able to come back to you on a bit of detail, with a bit of detail on that.
Thank you.
Thanks for that.
Okay, thank you.
Thank you, Senator.
Thank you, Mr. Fredericks. Appreciate that. Now, Senator Patrick, you've got some additional questions in relation to building codes. I hope you had a successful period in your previous committee before you joined us just then.
Defence, yes, I did.
Good.
I'll try and expedite this if I can.
Good on you. Thank you, Senator Patrick. You have the call.
I don't know if you want to just state your name for the Hansard and the...
Gary Rake, Chief Executive Officer, Australian Building Codes Board.
Thank you, and I think you're new to the job, aren't you?
I am. This is week 5.
Okay. First estimates?
In this capacity, yes, but no, I've appeared at other committees over the years.
Okay, all right. So
Nobody answered questions today, Senator Patrick. You should have been here earlier.
Well, there you go. Does that mean I can be hard on you then? Is that how it works?
I don't think
I've spent the last 4 weeks and 3 days studying very hard.
Okay. All right, well, that's good. I just want to go to the issue of cladding, and you may have seen my past interactions with the former CEO and concerns that I had raised. And some of that centred around a product called K15, which was a Cooltherm, a product that was found to have been not compliant in the Grenfell fires. And we did some tracing back through to look at how that was being handled here. Now, another example's come across my desk, and I don't know how we want to handle this, Chair and Mr. Rake. I've got a report from the East Maitland, on the East Maitland aged care facility. It's a fire engineering report.
Where's it located, Senator Patrick?
It's in Maitland, in New South Wales.
New South Wales.
New South Wales. But it's an example of my concern.
Yep.
What this report says, and this is a report that's dated May 2020, and I'm happy to. I don't know how to do this, Chair. Maybe I'll just give it to the witness. I'm just a little bit reluctant to table it because I don't know whether it's commercially sensitive or not.
Oh, okay. Well, let's reflect on that.
Yeah.
Why don't you ask does
Ask
the witness
the question and
does the witness need to refer to
if he wants to see it, maybe there's a way we can just.
Okay.
So I don't want to put him at disadvantage, but I don't necessarily.
No. Well, let's see how we go.
Okay. Well, I'll maybe take this at face value. So, in this fire report for this residential aged care facility, it talks about a BCA Type A fire-resisting construction is applied to this development in line with specification C1.1 of the Building Code of Australia 2019, Amendment 1. And then it refers later into the document to the cladding, and the cladding relies on Cooltherm K15, and it relies on a certificate, a test certificate. It says this BS 84142 report from Cooltherm K15, a product made of the same phenol foam core as part of the rain screen system, proves that Cooltherm does not pose an additional flame spread risk. So the engineer has done their job. They've looked up the certificate. Now, a short time later, what's happened is Cooltherm have then withdrawn the certificate. Okay, and I'm happy to table this letter, if I may, and put it before the witness. But basically, this says, in October 2020, Kingspan Installation withdrew the following 3 BS 8414 cladding system tests as the K15 they incorporated did not sufficiently represent the product currently on sale. So there was a difference between what was tested and what was actually being sold. This leaves us in a dilemma where you've got an aged care facility that now has cladding, and everyone's tried to do the right thing, but a certificate is withdrawn because of concerns relating back to the Grenfell fire. How do we handle this? And I know there's state jurisdictional issues in here, but how do we handle this?
So Senator Patrick, just before the witness response, I just want to make, have you got all the information you need to give a fulsome answer?
I'm comfortable to
Are you
answer
comfortable
in,
you can
with
respond?
a reasonable level of specific, and I'm happy to take some extras.
Senator, can I say one thing, which we've had these discussions before, so I think it's right for Mr. Ray to do his best to answer that at a high level, but I just think given the detail around this, I think it's incumbent on us to outside of estimates, work with you to understand the issue. And I'm just conscious of sensitivities around these sorts of issues. So if you're comfortable with a sort of a general answer, and that's fair, the Senator deserves that, but I think really what you need is a bit of work.
I'm using this as an example of what could be a systematic issue,
Understood.
and trying to understand how you address this sort of issue.
Understood. So, but if you're comfortable with that, so
and I'm happy to assist
generic answer,
offline.
but then I think we chuff out of here and look at it in detail.
Thanks, Senator. And as you identified, I think you already understand that at the very building compliance level, that would fall back to the certifying jurisdiction, whether that's state or local government authority. But in terms of dealing with a certificate that's been withdrawn, I think as this matter has progressed over the last couple of years, there have been some improvements to the way the Code Mark Register deals with these. Previously, the register showed active and suspended certificates. I understand the register, through our efforts negotiating with JASANZ, the register now includes withdrawn and expired certificates available for members of the public to review. So in terms of the information available to the certifiers, to the operators of the facility, they would have access to that information now that might not have been as easily obtained previously.
Okay, so I might reflect. So this report is dated after it was withdrawn. So which makes me think maybe the engineer went to the database, looked to the certificate, and went everything's good, and then certified it as compliant. And
So did you say that report is dated after the withdrawal?
Yes, this was dated the 10th of the 5th, 2021, and the certificate, Kingspan has said in October 2020, Kingspan Installation withdrew the following 3 BS 8414 cladding tests. So, sorry, I perhaps mischaracterised at the start. I mistakenly went off the date of the letter.
I think that, with your permission, Senator, that would be a good one for us to take and just work through the order of those dates, the information that was available at the time of each of those assessments, and we could come back to you with some.
Okay. So I think there's 2 things out of that, which is one is we'll take on notice the systemic issue, if there is one. So that's the basis on which you've raised the issue, so then that's sensible. I think also, given Mr. Rake's comment about the certifying jurisdiction's responsibilities, we'd want to make sure that on specifics, we engage with the certifying jurisdiction as well. So we'll take it on notice on both those bases,
problems.
if that's all right.
So I'll lead to my next line of questioning, which I think you've sort of touched on in the past. So I've had a real issue, and I think Senator McLaughlin joined me at one stage, had a real issue with the idea that the database only contained current certificates. And of course, if you wanted to go back a few years and look to see whether the product that your house was actually built with several years ago was compliant, you couldn't do that. Now, the rules of the scheme say, and I'll just refer to 22B of the Codemark Australia Scheme Rules. I've got a version 2016.2. It talks about the scheme administrator is responsible for creating and maintaining the register of certification bodies and the register of certificates of conformity, which must be accessible by scheme participants and the general public through the scheme administrator's website. So that's presumably the database. Now, the way I read that, and the way anyone who looked at this from a common sense perspective, who said, the public want to go and check their product is certified, would be that all of the certificates would be there. The current, as you said, the suspended, the withdrawn, and you could go back through the history of those. Now, I've had a private briefing from your organisation, and I haven't breached that private briefing, so I know there's progress here, and I'd like you to put on the record what you're doing in that space, or what has been done and what you are doing.
Certainly. So, in consultation with JASANS, we have now extended they have extended the register to make expired and withdrawn certificates also available. So, active certificates, suspended certificates, expired certificates and withdrawn certificates are all available on the register.
And so that's online. If I went and wanted to search this particular product, I could trace the history of this product over time.
The advice I have from the manager of the certifying scheme is that all of those 4 categories are there, and so if that certificate falls into one of those 4 categories, it should be on the register.
All right.
One thing I'd add, Senator, and I'll let the limits of my knowledge here, but just in the using common sense, I suspect there'll be a question about how far back we've been able to reach. The system's been able to reach for now expired. So I don't know anything about it, but I have a suspicion that'd be an outcome moving forward, and I don't know what
my
is
role
going
in
backward.
life is to make life better.
Yeah, exactly.
Day by day. So, if we make it better, we've achieved an outcome.
Yep. So we'll look at that particular issue and take that on notice.
Yeah. Okay. And I'll actually go and do the same. Okay.
Yeah.
And we can meet again in May. Thank you.
Well, thank you for making our committee better hour by hour, Senator Patrick. We do appreciate it. Now, Senator McLaughlin, I think, as you foreshadowed, obviously South Australians travel in pairs, perhaps. I think, Senator McLaughlin, do you have some questions on this issue?
I do, Chair. I'd like to. A constituent's given me some correspondence from the ABCB, which I will table, which means I don't really expect you to answer the questions on this letter today.
Is it the same letter?
So I'd just like them taken on notice. It's a letter to Mr A. Bullock of Cowell Clark. It concerns a response to a client complaint regards Codemark certificate CM 20029, and it's signed Neil Slavering, Chief Executive Officer, on the 26th of June 2020. And like my colleague Senator Patrick, I'm just interested in the processes associated following on a response to a complaint, because in this complaint, in effect, many aspects are upheld. I'm not speaking to challenge, but I'm interested in, it concludes that some of the claims in a particular certificate of conformity were not clear, and goes through the arrangements of a new certificate being issued. And I'm interested, if you're in the industry, how you would know, or your building had that cladding or whatever, how you would be informed that a certificate had been withdrawn and a new one issued.
Thanks, Senator. I've received the correspondence, and I'm happy to take that and come back to you.
Okay,
Yes.
thank you.
So I don't even necessarily a complete breakdown of the complaint itself, but more the processes around how the parties all move forward. In particular, I'm interested in the section regarding the thermal break, because that's where there's quite a bit of scientific analysis. And in effect, it indicates that there was not effective guidance in relation to the previous certificate, and therefore allowed the issuing of a new certificate. I'm just struggling with the utility of all that. If in fact there are some deficiencies or the lack of clarity around issuing a certificate, then you issue a new one, it sort of undermines sort of the validity of the scheme, which is to inform architects and builders that a product can do a certain thing. So similar to my theme of questioning on the last occasion. And like Senator Patrick, I'm interested in really whether the past history of certificates, the sort of information that's provided in response to the complaint, how does another member of the public get access to this? And not necessarily the complaint itself, the structure of the complaint, but the technical aspects coming out of the complaint. So the complaint has findings relevant to the individual who's made the complaint, but there are also a series of implications for those in the industry and how they're communicated. Whether they are communicated around the issuing of the new certificate or a narrative around that. So there's complaints made, to summarise, certain aspects are upheld, a new certificate is issued. Why? I'm just interested in how a certificate of non-conformity could have occurred. It's a little technical for me. And the process going forward with the information that's been delivered to that one individual, that's fine for the individual, but how does that get communicated to a broader public audience and therefore ensure building safety? Is that clear?
Yes, Senator, thank you. I understand the question you're asking and more than happy to go through and come back to you and describe that in that process sense, yes.
All right, and then if there's more to inquire about, I'll do so in the next estimates.
Of course.
Okay, thank you, Senator McLaughlin, and good to see you working hand in glove with Senator Patrick for the good people of South Australia.
And for the nation. Really.
And for the nation, absolutely. Thank you very much, Senator McLaughlin.
South Australia first.
Okay, now Senator Chisholm has got some questions in relation to dumping reforms.
More precisely, anti-dumping reforms?
Depending upon your perspective.
So the additional $5 million that was in the 21-22 budget, so that was $5 million over the forward estimates. It included $800,000 for this financial year. I just wanted to get a sense of what was the purpose of that $800,000 being provided for this financial year.
Okay, thank you, Senator. Helen Bennett, Head of Strategic Policy Division. Let me just look through my notes to see if I can find that for you. We'll have to take that on notice, Senator.
A college.
Apologies, Senator, I'm new in this particular role and I just don't have that level of detail in my notes, so very happy to take it on notice.
Okay. So, do these reforms include a legislative component?
Yes, they will, Senator.
Okay. And is that component essentially the reforms that the Department of Industry have been consulting on since 2017?
Yes, that's correct.
Okay, so that includes proposals which come out of the International Trade Remedy Forum Subcommittee, I think in 2016?
Yes, that's correct, Senator.
Okay. When did these reforms first go to Cabinet? I understand from previous responses to questions and estimates that it was when Minister Cash was the Minister responsible?
Senator, I think you're fine to take that on notice. I mean, I'll do the right thing and take it on notice, but I think I think we're going to have to not be able to answer that as Cabinet in confidence, but we'll take it on notice.
Okay. According to the ITR Forum's published minutes from 5 July last year, the Department advised that it is drafting legislation to implement the reforms as soon as possible and that DISA will seek stakeholder feedback around October 2021 if it obtains approval to release an exposure draft. I take it that, well, who provides approval to release an exposure draft?
Senator Louise McCulloch, Deputy Secretary. So exposure draft is matter for government when they actually release it.
Okay, so the Minister, effectively, would that be?
It's the Minister, but there's actually a process through Office of Parliamentary Counsel and with Prime Minister and Cabinet around legislation and availability of drafting resources.
So is there a timetable on when we can expect the exposure draft to be released?
So, Senator, it hasn't yet been listed on the parliamentary calendar, and at this stage we don't have a timetable.
There was a change in ministerial arrangements in September when Mr Porter ceased to be the Minister and Minister Taylor subsequently appointed. Has this been part of the delay for the exposure draft being released?
Senator, I'd have to take the detail on notice, but in general, as I said, it's actually the drafting of legislation is dependent on parliamentary availability of drafters, and that's been a significant part of the delay.
Okay. The published ITRF minutes from December last year state that the department advised that the department was working closely with the Commission, the Office of Parliamentary Counsel and other government departments to implement the reforms. Ms Drury, which I think Ms Drury is the General Manager of Trade, advised that drafting has been delayed due to several factors, including complexities that had arisen in drafting legislation for some of the reforms. Is that correct?
That's right.
Okay. Should approval for an exposure draft be obtained, the department would be seeking feedback from stakeholders, including ITRF members, in January 2022. It was expected that members would be given 2 weeks to review the proposed legislation before it was introduced in the autumn sitting of Parliament. So that was what that contained. So I take it that's not likely to be the case?
That was the expectation at that time, Senator, but the bill is not ready.
Okay. So no exposure drafts been provided to industry, nor has any legislation been foreshadowed for the autumn sittings. There's no proposed introduction on the horizon at all.
I'd have to just double check my facts, but it is not listed for the autumn sittings.
Okay. Thanks, Chair.
Thank you very much. I think we've now finished outcome 1.2. So I think we're in a position to move to CSIRO. We are in a position to move to CSIRO. So thank you very much for officers in attendance for outcome 1.2. Okay. Ames has only got one question. No, okay, all right. Yeah, okay, all right, okay. All right. Welcome. Do you have does CSIRO have an opening statement you'd like to make, or would we go straight to questions?
Dr. Larry Marshall, Chief Executive, CSIRO. I do chair if there's time.
I'm not sure how long it is, but there is time if it's not too long. Dr. Marshall.
Thank you, Chair. Just quickly then, Chair, since we last met, Team CSIRO has been busy collaborating across the system to turn Australian science into solutions that benefit all Australians. We're going to be creating Australia's most advanced model for predicting and beating bushfires in collaboration with the Rural Fire Service, or collaborating across the agricultural system to deliver new strains of drought-resistant wheat, or releasing a landmark study in partnership with the Centre for Invasive Species on preserving Australia's biodiversity. We're working broadly across sectors to catalyse innovation and deliver impact. Our vision is to create a better future for all Australians by helping all parts of our world-class research sector to better connect with industry so they can get more brilliant inventions out of the lab and into our lives. We're proud to work with every major Australian university and to manage national labs to help supercharge Australia's research. We recently added a new lunar testbed to help researchers and businesses preparing to head to the moon, and we look forward to working with universities to access our test lab facilities as part of the Trailblazer program. We also work with thousands of businesses across every sector to drive sustainable innovation and growth. For example, together with Commonwealth Bank, we're combining climate and financial data to help boost resilience to climate risk in the financial sector. And under a new 5-year arrangement with Boeing, we're collaborating to create a more sustainable aviation industry. Our purpose is to solve Australia's greatest challenges, and so we're always looking ahead to capture opportunities for the nation. With the establishment of the National AI Centre, we're laying the foundations for an Australian AI and digital ecosystem. Thank you, Chair.
Thank you very much. Senator Chisholm?
I'm happy for Senator Cox to start.
Senator Cox.
Thank you. My first questions are for, in relation to GM cotton and the Fitzroy River catchment. How long has CSIRO been working on the developing of GM cotton?
Senator, I think that's one for Kirsten Rose, actually.
So, excuse me, Kirsten Rose, Executive Director, Future Industries. Senator, I don't have that data at hand. If you can give me a little bit more detail about what you're looking for, perhaps I can take it on notice.
How long have they been working on the development of genetically modified cotton? That was the question.
Right.
Senator, sorry, I didn't realise you were talking about GMO.
Yeah.
I think we can answer our breeding programs for cotton, which we've been doing cotton breeding for probably more than 50 years. But I'm not aware of, because our breeding is, we breed different strains of cotton, but I'm not sure that is what you're asking. You're asking about genetic modification, which...
Has there been a time frame that you've been working on it? Like, is there...
I'm not able to answer. I'm not aware of that, Senator, so I have to take that on notice. But I probably would know if it was significant.
All right. And how many variants of GM cotton are there that have been developed by CSIRO?
Senator, if you're going to ask me about genetic modification, again, I'll have to take it on notice. But there are many varieties of cotton that we breed, and wheat, and many crops, and basically we breed them to reduce the impact of drought. Or, for example, wheat today has a 30% higher yield than it would otherwise due to the effects of climate change because we bred new strains, but that wheat is not genetically modified, it's genetically bred, if that makes sense. So I just want to be clear, you're talking about actually changing the genetics of the material through breeding. You're talking about interfering with the genetics. You're talking about changing them through some mechanism other than breeding. Is that what you're saying?
Yes.
Okay. I'd have to take those questions on notice.
Yeah, if you could provide that, that'd be great. And also, if CSIRO actually gets a royalty from GM cotton, that would be great if you're able to give me on that on notice as well. My next questions are in relation to the Gas Industry Social and Environmental Research Alliance.
It's a GZERA, Senator, and Dr Mayfield is in the best position to answer that.
So, Senator, Peter Mayfield, Executive Director for Environment, Energy and Resources. Happy to answer your questions.
Yeah, thank you. I just want to note that in relation to the progress report on groundwater baseline study for the Canning Basin, can you tell me which oil and gas companies are currently part of the alliance?
This is for GZERA you're asking for?
Yes, that's right.
Yep. So we have Origin, Santos, Queensland Gas Corporation, and APA are there. I think that's everyone.
Okay. How much money does each oil and gas company invest in the alliance over the past 5 years?
I'd have to, in terms of the past 5 years, I'd have to take that on notice. But in terms of the whole GESERA program, it's been going for some time now, and it's about $54 million worth of investment to date. Majority of that comes from governments, whether they're federal or state governments, and a smaller proportion of that comes from companies.
Okay. I understand that the Research Alliance recently published the groundwater baseline study of the Canning Basin, which CSIRO undertook. Do they believe the involvement of oil and gas companies, particularly ones like Thea Energy, is a conflict of interest in developing scientific research on groundwater?
So if it's done through GESERA, so I just want to make sure we're talking about the same study, because there's also work that's been done under the Geological Bioregional Assessments Program as well, and that work is fully government funded.
No, I'm talking about the scientific framework that's been developed in relation to determining, and the baseline study for groundwater in the Canning Basin. So within this report, there's, Thea Energy are part of your actual development group of that framework. And I think I have a significant concern when we've got a fracking company like Thea Energy who will operate in the Edgar Ranges in the Kimberley, who will determine the cultural places, talk about the aquifers and the scientific research that formulates that in order for them to go in and frack country.
So, Senator, in terms of the research that gets done through GESERA, so the projects that are put forward, they're put forward by researchers and by community members and other relevant stakeholders, and there are regional advisory committees, so the governance structure is quite clear around how those projects are selected. And those advisory committees all have independent members on them who have the balance of the vote. So the selection of the projects, that's independent. The actual execution of the research is also done independently by CSIRO. So companies don't participate in the research. They get to see the outcomes of the research, but it's done independently with the right level of scientific rigour.
Yeah, I'm not talking about the independent research, I'm talking about the development of the framework. So the framework that actually governs the data collection and the task outputs and deliverables of that framework. In your progress report on this, you actually highlight the different areas of baseline characterisations of those, which continue to be an issue when we're talking about water resources in regional development, because they become open slather for energy and fracking companies like Thea Energy. So they're sitting at the table developing all the scientific basis in which to do this, all the while crafting it along the way to be able to get access to it.
So, Senator, I can only talk about the work that gets done by CSIRO, and that's done to ensure that we do the right scientific rigour and approach to baselining and whatever research gets done.
Thank you for your answer. My only other set of questions are in relation to the Murujuga rock art and the report around has CSIRO done any, undertaken any independent assessments of the impact of the industrial emissions from industry on the Murujuga rock art?
So can you just say that name again for the rock art?
Murujuga, which is at the Burrup Peninsula
On the
in the
Burrup.
Pilbara region.
Yes, okay.
Yep.
Yes, thank you. So there's some work being done on that some time ago. It would probably be around about 2015 or 16, I believe.
Okay. Can you provide any details in relation to the findings and recommendations of that work?
I'd have to take that on notice, Senator. It's something that I haven't looked at for a long time.
Okay. I note that there's the 2017 Senate inquiry which uncovered some evidence regarding the incorrect use of flawed studies on the impact of industrial emissions that actually are still up on the WA Government Department's website. Do you have any concerns with those?
So the work that was done at the time, it was peer reviewed. We've gone through a long exercise around that, around the quality of the work, and we're very comfortable with the position that we ended up in terms of what work was done to, I guess, understand the scientific rigor behind it. So that was done back then. We're quite comfortable for it to stay there.
Okay. Will there be any further work?
There hasn't been any activity in that space for a number of years, so at this point in time, I'm not aware of any intention to do any more work.
Okay. Given the changes of legislation in the WA state, particularly around protections of cultural heritage, but also the Juukan Gorge inquiry, the Way Forward report, I thought there might be. But that's it, Chair, for me. Thank you.
Okay, thank you. Thank you, Senator. Now, Senator Rennick has to catch a plane and has asked, just for some indulgence, to ask a quick question. Senator Rennick.
Hi guys, how are you going?
Is that the question?
No, that's not a question. Larry, I was just going to ask you, last time in estimates you said there were 40 different climate models. I'm just curious as to which model the government will be using to determine net zero emissions.
Oh, sorry, Senator. Are you talking about the model to actually predict the climate, or are you talking about the model to map the pathway to net zero?
Well, I mean, presumably you'd have to use some of those climate models to come up with a set of rules to map the pathway to net zero, wouldn't you? I mean, they depend on each other. The model to map the way to net zero would also have to link to one of those 40 models.
Yeah, Senator, I might be missing your question exactly, but the pathway to get to net zero for us at least has been about what scientific interventions do we need to make. You know, things like future feed to reduce the emissions in the cattle industry or hydrogen to reduce the emissions in energy. What kind of things do we need to create so that Australia...
So clearly there's got to be a correlation between a reduction in carbon dioxide and a reduction in temperature, because the whole idea of reducing carbon dioxide emissions is to reduce the temperature. So at some point you've got to take the model that's used, to calculate reducing carbon emissions and apply that to the model that says, this is how the temperature and this is how carbon dioxide fits into the climate model for the temperature.
Right. So Senator, in that case, if you're asking, will it take to see an impact from reducing carbon emissions? We have.
Well, that's part of the argument, isn't it? That we've got to keep carbon emissions, at certain levels to reduce or at least limit the temperature increase. So.
Yeah, that's right, Senator. Yep. So that model, then, Peter, you have, I think.
Sorry, what was that?
I think Dr. Mayfield has that information.
Oh, right, okay, sorry.
Yeah, so, Senator, so there are the two different types of models, and so through the IPCC work, that's where they're using the ensemble of the 40 plus models and looking at trying to get the right sort of understand what the climate trajectories are. You'd be aware of there's the RCP pathways that they look at, and that sort of sets a range of, I guess, different pathways between CO2 and temperature rise that are understood through the IPCC work. And that's then driving the net zero to 2050 sort of targets that we're seeing across through the COP process. So to do the net zero work in Australia, it requires a different sort of modelling, because it's all about which technologies are available to us to produce energy or to do industrial activity that have lower emissions, the uptake of those, the relative advantages and disadvantages of them for those various businesses. So it's a different sort of model that you use to then work out what are the steps you take to get to net zero in the Australian context. But the IPCC work provides that guidance as to if we get these emissions to these levels globally, this is what we will expect to see in the climate temperature-wise.
And you'll be able to map that. Yeah.
Well, they're already mapped. They're already mapped, and I guess one of the things with what the models show us is that there's a lot of carbon already in the atmosphere and in the oceans, for that matter. which locks us into a trajectory where, you know, we're heading for 1.5 to 2 degrees already. That's assuming that there's some sort of level of reduction in emissions.
So can you send me that model, that sort of algorithm or the model, so I can have a look at it myself?
I don't think it's something that you could look at yourself. It's very complex. But
Well, I'm quite capable of solving complex problems. I'd be fascinated by it. I must admit, though, I'm intrigued. I would have thought if the science was settled, there would have been only one model, not 40. But anyway, I'll leave that as a comment. Okay, cheers. Thanks,
the
guys.
models are produced by different countries.
Now, Senator Walsh has a thank you, Senator Roberts, for being patient. I do need to give Senator Walsh the call, and then Senator Roberts. We do have to break for dinner at 6:30. I am keen, to the extent we can, to try and get through the next little session as quickly as possible. So if everyone could assist us on that basis. Senator Walsh, you have the call.
Thank you very much. Thank you, Dr Marshall, and all your colleagues that are there for us today. Just a couple of questions on trends in your staffing levels, so your direct CSIRO employees. Are you able to tell me how many actual full-time equivalent staff you had at June 30, 2021, and what that equivalent figure would be as close as at today as possible?
And Senator, Mr Maynard will give you that information. Just want to make sure I give you the right answer. So you're not looking at all of the people CSIRO employ, you're just looking at the ones that are direct employment on our payroll and in FTE, full-time equivalent?
Yeah, that's right. Your actual direct employees. Yep.
Right.
Senator Tom Maynard, Acting
g'day.
Chief Operations Officer. So our full-time equivalent as at 30th of June 2021 was 4,949.
And what is it? 4,499?
4,949.
4,949. And as at today?
Let me just check that figure. So our data as at 31st of December 2021 is 5,032.
5,032. And was there a change to your ASL cap? Was your cap lifted during the pandemic or something?
So our ASL
similar?
estimate in 2021 was 5,351, and for 21,
Sorry.
5,351.
Yep.
And for the 21-22 year, it is 5,414.
5,414.
Yeah.
So as at today, you're about 400 below your ASL cap.
That's correct,
for your
Senator.
direct CSIRO employees. Dr Marshall, can you just give us some insights into why that would be the case, that you'd be reasonably significantly under your cap in terms of direct employment?
Well, Senator, I can. There's a number of modes of employment at CSIRO, and not all of them are direct and on payroll. We have affiliates and other mechanisms. But we tend to shape the organisation with the skills that we need to suit whatever challenges we think Australia is going to face, and get the scientific expertise that we need. So we've been going through a number of shifts, for example, around the modern manufacturing strategy or around AI, and you may have seen with a number of recruiting campaigns going on at the moment to recruit talent. But of course, recruiting has been incredibly difficult during COVID, and so we're probably a little bit behind where we would otherwise want to be. But we don't try to get to the max of our ASL cap. We try to choose the talent that we need for the problems that we solve.
Okay. And when I asked the question about your direct actual FTE employees, you mentioned the concept of another number, which might include sort of all the people that you would describe to be working for you in various modes. I assume that includes independent contractors and labour hire and so on. Is that where you were going with that?
Well, actually, a little bit broader, Senator. We also have a lot of students and postdocs,
Yeah.
some of whom are employed through the university, but they work on our site with us. And we can do postdocs. We can do either way. We can employ them directly, or we can employ them through a university. It really just depends what's best for them and for us and for the university. So when you add those numbers, it gets a little bit larger, depending on how you define it.
And so without taking our time to go through all of that, what's the sort of headline number that you have in mind when you're including all of those people?
Oh, gee. Tom, you might have to help me out here.
So, Senator, if you're talking about all of our affiliates, you can talk somewhere between 2,000 and 3,000 people.
An additional 3,000
2 to 3,000 people that are...
Okay. No problems. We may come back with some questions on notice based on that, but I won't go through it now. But your answer to why you might be about 400 under the ASL cap is partly in relation to recruiting challenges in the current environment, and partly in relation to you may choose to do it a different way depending on what your priorities are.
That's correct, Senator.
Yes, Senator.
Okay. Just another question around the number of projects that you've done in COVID. You've had a special sort of role in relation to providing advice during the pandemic. Do you have a number of reports that you've published in that special role that you've had during COVID?
There's a range of them, Senator. That's why I'm hesitating, because we did reports on economic recovery. We did reports on, I think we even did a hydrogen report for aviation during that time. So there's a number of them that relate to recovery from the pandemic, but that's probably not answering the question you're asking.
That's okay, because that just gives us a little bit more insight into how you sort of view things that we could put on notice. So would you normally expect that government would sort of formally respond to those sorts of reports that you've done, for example, on economic recovery? And did they respond?
Senator, we generally engage with our department on these things if they relate to things that the government would be needing or wanting to look at.
So just on a sort of informal basis, you might be in a meeting about something and engaging rather than sort of getting a formal response.
Yeah, it depends on what it is, Senator, but our engagement it's far more frequent for us to engage with the department directly.
Yep.
Since we're in that department.
Okay, no problems. That gives us a little bit to go on in terms of some possible further questions on notice. I just wanted to ask you, Dr. Marshall, you've got the 150 million for the CSIRO Innovation Fund, which is managed by the Main Sequence Ventures as part of your sort of broader commercialisation program there. And CSIRO is also sort of, renowned for having done sort of very pure research as well, which has led to different sorts of inventions that you proudly have on your website, starting with the technology underpinning, for example, Wi-Fi, which I take to have come out of a more pure research model rather than a sort of industry-linked applied model. How important is foundational discovery research to driving ongoing innovation and commercialisation in the long term?
Well, it's very important, Senator, and one of the things that we do to start inside CSIRO is two things really. we've increased our collaboration with the university sector because there's 39 great unis and they do terrific Horizon 3 Blue Sky foundational research. So we've deepened the collaboration there. And in our Act, Senator, it does specify that our purpose is to help ensure translation of all Australian science, not just what CSIRO does. So that's a reason for that. And then the second one, we've invested a lot recently in what we call our future science platform. So these are the deep discovery research, the Blue Sky research. And I think, Tom will correct me if I'm wrong, but I think it's 150 million over the forwards, isn't it, Tom?
I think so. That sounds in the ballpark, yeah.
For what you just described as the Blue Sky research?
Yeah, we call them our future science platforms, Senator, and hydrogen in part came out of a future science platform, our hydrogen tracker. We're looking at carbon locking, a way to lock in carbon for better sequestration. We're looking at quantum. So these are kind of right on the cutting edge, and I should say they're all done in collaboration with a pretty big cohort of students and postdocs. Often whom work in universities, and we're all partnered up with many of the unis on this work again to deepen that collaboration.
So, Senator, just to correct that figure, it's slightly above 150. It's about just over $40 million per annum for the 4 years.
Right.
Yeah.
Okay. And how does that compare then to the 150 million for the CSIRO Innovation Fund? Is that over the same sort of period? Is it? Or was that just a one-off?
So the fund is a 10-year fund, Senator, and that fund is not for investing in CSIRO research, although it can, but it's investing in
commercialisation of broader
research across the whole system.
Yeah. I mean, can I just get your sort of general perspective, Dr. Marshall, on what the appropriate balance is for our country in investing in blue sky research, as you described it, versus investing in research that is linked to industry partners, even before the commercialisation phase. What do you think the sort of the appropriate balance is, and are we striking it?
Well, Senator, I probably can't answer for the system, but I can tell you how we think about it for CSIRO. And that 40 million is ballpark rough number about 10% of what we invest. I'm just pulling that number out of the air. Tom might need to check me later. But I think that would be fairly close to the right percentage. And that's, if you look, we're an industrial research agency, so our purpose is, of course, to translate and assist industry with Australian science. If you look at a company, they might invest 4% or even only 2% in cutting edge research. So based on that projection, you might say, so a university would probably be something more than what we are, given we're kind of in the middle between industry and academia. If that helps you.
Senator Walsh.
Yeah, I'll just wrap up quickly, Chair.
Okay, thank you.
Late last year, the government issued new directions for the awarding of research grants by the Australian Research Council, aligning those grants with the Modern Manufacturing Initiative. Do you have a perspective on what the implications of that sort of shift are for the scientific community?
Senator, just insofar as the priority areas in the modern manufacturing strategy, we shared a lot of our information with the department on what we were seeing in terms of areas of strength in Australia and areas that Australia might need. So those priority areas do align fairly well with what we think the priority will be for the need of industry. And given that, then universities should find it a bit easier to commercialise their discoveries in those spaces because have a bit more interest, a bit more pull from industry to support.
Okay.
Okay.
The
thank
chair
you.
is winding me up. Thank you.
Thank you, Senator Walsh. And look, I just want to do some quick housekeeping before I go to you, Senator Roberts. I don't have any questions for the Office of the Chief Scientist or the Australian Institute of Marine Science. Senator Walsh, did you have any questions for them? Because ideally I'd like us to be able to complete...
Got a few questions for the Office of the Chief Scientist, but not the Institute of Marine Science.
Okay, all right. So ideally we have to finish at 6:30. It's a hard marker. So Senator Roberts, I'll go with you, and if you can be as... You've been terribly patient, as you always are. If you could be as quick as you could.
Thank you, and thank you all for attending. My questions are going to be initially to the Minister, and then, if there's time, to the Chief Executive of CSIRO. Minister, referring to the government's change in its 2050 net zero policy, in the 2019 election, the government's opposition to the UN's 2050 net zero carbon dioxide policy gained you many votes and a lot of political traction, and used the policy to Labor's adoption of the policy to really smash the opposition leader Bill Shorten. Just 2 years later, after emphatically, repeatedly and thoroughly criticising Labor and the Greens, there was an unexplained reversal last year, and the government adopted the UN's 2050 net zero carbon dioxide policy. What is the specific change in climate science on which the government's change of policy is based?
Well, thank you. I think to answer that question in detail, I think it'd probably be best for the Environment Minister, but I would simply say that I don't accept the premise of all of what you've said.
What do you disagree with?
Well, you said unexplained. I mean, obviously we went through quite a detailed process. The Prime Minister spoke on a number of occasions about his desire to get to a net zero position if it can be done in a way that protects Australian jobs and continues to see industries thrive, and that's what Minister Taylor worked on. Now, we're not obviously in the space where we have the detail in terms of those portfolios, but it was explained over a period of time. The government made the decision. Obviously, it played out publicly. There was a conversation, I think, with the Australian people, and obviously there was a live debate that you were aware of that the coalition went through, and the government came to a conclusion.
Okay. It wasn't explained in terms of some change in science. There's no references, there's no document, no publications referred to, no specific page numbers of the change in the data or the cause. So there was nothing to change the policy.
Well, as I say, the government was not prepared to commit to such a policy without being able to do the work as to how we would get there and how we would do so in a responsible way. And that was the job that Minister Taylor in particular was tasked with, and that was the work that fed into the government decision. Now, in terms of, the detail of the various portfolio parts of that, I think that's probably for another part of estimates, but I think that I think that summarises the government's position.
Well, let's go back a step further. What's the basis of the government's climate policy and ensuing consequent policies on energy, agriculture, manufacturing, social policy, and other aspects that the UN's climate and associated policies impact? What's the overall basis?
Sorry, I might just get you to repeat that question. Sorry.
What is the basis of the government's climate policy and the consequent policies that stumble on from that on energy, agriculture, manufacturing, social policy, and other aspects that the UN's climate and associated policies impact?
Well, look, it's a fairly broad question. I might ask officials if they can assist.
Yeah, so
Ms. Evans.
Very quickly, Jo Evans, Deputy Secretary in the Department, and Senator, the basis is really the globally agreed science on climate change, which is articulated through the International Panel on Climate Change reports.
Intergovernmental Panel on Climate Change?
That's the one, yeah.
Okay, thank you. That was nice and quick. Back to the Minister. Cutting human carbon dioxide has had huge costly impacts. Cutting human carbon dioxide output has had huge costly impacts across our society especially on fundamentals for productivity and prosperity, for example, energy. Surely the only sound basis for policy with such economic consequences is the specific effect of changing human carbon dioxide output. The impact, for example, of a specified change in human output of carbon dioxide, what specific impact would it have on climate factors such as temperature, rainfall, droughts, wind? Then when that is the specific impact, then when the effect is quantified, only then can we do a cost-benefit analysis of the costs of doing that and the benefits that come from that. And significantly, we can't do any measurement of progress as we implement the policy unless we've got that specific impact of carbon dioxide. What is that specific impact of carbon dioxide on various climate factors?
Well, I'm happy for officials to elaborate, but I mean, in terms of what the government's approach has been, it has been to be part of the Paris Agreement, so part of collective action across the world, where we are doing our part, and we've been doing that obviously with our emissions reductions to date, which have been tracking in fact ahead of many comparable OECD nations and many sort of comparable resource-rich nations such as Canada.
So what would be the extra impact of tracking ahead?
But if I can also go to your question, and in the preamble to your question around, you talked about other economic impacts or impacts in relation to higher energy prices and the like. What we've seen under our government in the last few years is actually energy prices coming down year on year and coming down quarter on quarter. So we as a government never look at these issues in isolation. We look at it as part of that collective response and taking our responsibilities to the environment seriously, but never taking our eye off the ball in terms of the need for affordable and reliable energy, for instance, and that's something that we've been delivering, and that's been our track record.
Senator Roberts, we've got to go to the Office of the Chief Scientist at 6:25. So I know you did want to ask some questions to the Chief Executive Officer of CSIRO, so I just wanted to give you that chance.
Thank you. So essentially what you're saying, Senator Segelja, is that your answer is the same as the one Senator Cormann gave me repeatedly when I asked questions in the Senate and wrote him letters. That was, we've got to do our part of global agreements.
Well, I mean, I don't know if... I'm not aware of exactly what former Minister Cormann...
That's the gist.
Well, as I say, I'll take your word for that.
I can show you his letters.
Sure, I'm not disputing. All I'm saying is I'm not aware of exactly what Minister Cormann told you, but you know, my evidence is the evidence I've just given.
Assuming what I've said to you, Senator Cormann's responses, you're agreeing with it.
Well, look, it's a difficult question to answer without seeing all the detail of what you've said, but I think my evidence speaks for itself.
Okay. Bob Hawke's Labor government first introduced the climate topic in the 80s. Then in 1996, the Howard Anderson Liberal Nationals government first made it policy. On what specific quantified effect did they base that policy? Do you know?
Well, look, I think you're talking about history of before I was in this place, and so I would prefer, without having been involved in those discussions, I'd prefer not to. I don't feel qualified to give you a detailed answer on that.
Are you aware that the Howard Anderson Liberal Nationals government implemented the renewable energy target, that is gutting electricity and industry generally, that they stole farmers' property rights to use their land, and they did that deceitfully going around the Constitution, Section 51, Clause 31, and that John Howard was the first leader of a large party to adopt an emissions trading scheme, which Tony Abbott rightly called a carbon dioxide tax. Are you aware of those major policies that are now still in play? And John Howard actually said that the renewable energy target has gone too far now.
Well, but I certainly wouldn't accept your characterisation of some of those policies in the way you framed them, and certainly in relation to those fine leaders of our nation that you've sort of characterised their policies in a certain way. So no, I wouldn't agree with that.
Okay, thank you.
Sorry, Senator Roberts.
I'm sorry. Just got one thing to follow up.
Well, it's got to be very quick.
It will be very quick. Are you aware that 6 years after being booted from office in 2007, in 2013, John Howard admitted at a global warming skeptics annual address in London that on climate science he was agnostic, yet he introduced these policies?
No, I wasn't aware of that. But,
I can show you that.
But I am
Thank you very much, Chair.
Thank you, Senator Roberts. Thank
Next
you.
time, Dr. Marshall.
Thank you for our representatives from CSIRO. Thank you for joining us today. I should also say the Australian Institute of Marine Science won't be required, so you are released. Thank you very much for your patience. We'll go to the Office of the Chief...
Stay safe, everyone.
Thank you, Dr. Marshall. So we'll go quickly to the Office of the Chief Scientist. It's a long wait for 5 minutes, Ms Foley, but we'll make it it's Senator Walsh, so we know it's going to be a quality 5 minutes. Senator Walsh.
I was referring to the answers. We'll see that.
I was referring to both. Senator Walsh.
Thank you so much for being here, Dr. Foley, and it's going to be really difficult to ask what I would like to ask in 5 minutes, so we certainly might put some things on notice. Last time you were in front of the committee, we were talking about the exciting opportunities for mRNA manufacturing in Australia and some of the things that need to be in place to support links between science and advanced manufacturing. And so I'm wondering, in a couple of minutes, given that at the end of 2021, Moderna was announced as the successful bid for delivering mRNA in Australia, if you could give us your reflections on how significant it is that Victoria had invested for some time in R&D, in manufacturing, in creating sort of an ecosystem to support that bid, and broadly, how important it is that we continue nationally to support our higher education sector to make these linkages with industry as well.
Okay, it's quite complex, and I've got 2 minutes. So, look, the first thing you've got to remember is mRNA is a very new way of making therapeutics or vaccines, and it's something which the pandemic gave it a chance to really rise and shine. We've also got to remember that Australia at this stage has not got its own developed mRNA vaccines of any sort that have actually got to a point where it's reaching the market. And so one of the complexities of the whole process of seeing the adoption of manufacturing in Australia of mRNA vaccines has actually been because getting IP has been difficult. And the fact that we've been able to attract a company like Moderna, which is a startup, it came out of Harvard University, and they've been, although many people have got Moderna vaccinations, I think my booster is a Moderna one as well, that's shown an example of research that's come out of a university, in this case the USA, startup company, and then gone gangbusters, and now going to have global manufacture around the world, which is a good business model to operate. When you look at the Australian context, it's nothing like bringing a company in to be able to set up manufacturing here. It actually is a little bit like a honey pot to bees, and you actually start creating that ecosystem which allows path to market, because mRNA is not just for COVID vaccines, but it's got the potential for a range of different vaccines and therapeutics for different medical conditions. We've got a lot of fantastic research, and around, we know that Victoria, particularly around the Parkville region and also around the Monash region, we've got very extensive biomedical research. It's absolutely super duper world class. We should be very proud of that. We also have that in, we know in New South Wales, there's through the New South Wales government's Westmead focus of having a precinct there, that's really growing, and they're looking to also set up mRNA manufacture of some sort, which is more of I think a plan to have a sort of pilot place where you can go and sort of do that first scaling up, so you can go through the steps to be able to have what's needed to be able to deliver the clinical trials, because manufacturing of anything to do with human health products requires you to go through these rigorous trials, which means you've got to have different stages of volume until you get to a point where you have mass use. And then in Queensland, of course, we've also got amazing medical research. That's where Gardasil came from, University of Queensland being a good example. So, Australia's invested a lot in health and medical research, and what we're seeing now is, I think, that maturity. So we're going away from just the discovery side, which we've absolutely nailed it, to seeing that translation. And what we're also seeing is the need to have industry and both startups and multinationals, and also governments, both state and Commonwealth, coming together, as well as the publicly funded agencies such as the TGA, CSIRO and other places like that, Animal Health Laboratory, or it's called the Australian Centre for Disease Preparedness, all coming together so that it's able to work together. And it's what I'm seeing is a real spearheading of that during the pandemic. It can be frustrating. I know that there's a lot of desire to see us be able to set up manufacturing of mRNA vaccine locally. I won't say a stopgap, because at the time AstraZeneca was seen as being the way forward, and setting that up and manufacturing it was absolutely critical to delivery of the first round of vaccines. And I know I had AstraZeneca for the first 2 vaccinations I received, and that's life-saving for many, many Australians, and then overseas as well, where we've taken that product internationally. We've now got to a point where a pandemic such as the coronavirus is something which is changing, and we don't even know what the next variants are like. The current, I don't want to scare people, but we don't know, will they be variants that are of concern and that the current vaccines are not able to manage. So there's a whole range of unknowns, and so when you're looking at what to prepare for the future, you've got to sort of marshal lots of troops and be able to make sure we're prepared for anything, and that's the challenge.
And I think I'm allowed to sneak in one quick
Yeah,
follow-up
I think you
question.
can very quickly.
So there's a lot of, you've expressed quite a lot of excitement there and last time about translation of research, all of the infrastructure that's required for that. You talked last time as well about opportunities for scientists to have a different way of how success is measured, not just in papers,
the metrics and things like that.
All of that stuff is, and there's a lot of interest and excitement around that, which I share. At the same time, I was wondering if you had any comments about how important it is to also maintain the ability for researchers to do curiosity-driven research, and how important that is to achieving actually the same goal of ultimately fueling our own innovation pipeline.
Yeah, and if you could be very quick.
I'll be very quick. Well, Senator, this is. I thank you for asking that question, because it's one which I think is really important. Look, research is humanity's superpower. We wouldn't be here today with everything we've got without fundamental research, from whether it's been radio astronomy that led to us understanding the electronics that led to Wi-Fi, which thank goodness we had for the pandemic, through to, believe it or not, fundamental particle physics that led to the World Wide Web. So, as well as understanding the human genome that's go to health and wellbeing in many ways. So it's absolutely critical to have a curiosity-driven fundamental research. We've also got to remember that what is the definition of fundamental research is very much dependent in the eye of the beholder. It's not like it's sort of in 2 buckets. And so for one person's fundamental research is another person's applied research. And so that makes it very hard to sort of say this is in A or B bucket. But one of the things we do have to recognise is that it is a judgment call, and it's a judgment call of those, just making the decisions of where we're going to place our dollars. And of course, you would always want to have as much, because it's so, research is so important to the world and to all of us. Of course, you want to have the investment that you as much as possible, but you've also got to work within the budget that you've got. And so I think from my perspective, we have to look at making sure that we do a couple of things. One is that we incite the curiosity of people so that that they do want to be researchers, that we feed that as a, something that young people aspire to, and so that they, work hard. It's not easy to become a researcher. There's a lot of work involved, and it's probably not as financially rewarding as other careers. And so you've got to sort of make sure we support them and also support them in their careers. And I think we've got work to do there. So that's one thing, is the supply chain of people to do the work. But the other is also making sure that we get that balance right. And it's something which is really for for our society and for our decision makers to make that judgment call.
Okay.
Thank you.
Thank you so much for all of those insights in such a short period
time,
of
big
time.
impact. Thank you, Dr. Foley.
That's my pleasure.
And thank you for joining us today and all the great work you do.
Sorry, a bit late for dinner.
Yeah, no, that's okay. Thank you, Minister, for joining us today. And so that concludes Office of the Chief Scientist. So when we return, it'll be Department of Industry, Science, Energy and Resources, Outcome 1, Continued Program 1.3. Okay, thank you very much.
Chair, can I just confirm that it's not required to appear?
Correct.
That's right, thank you.
Correct. Welcome, Minister Colbeck. And we're moving on to item 1.3, program 1.3, supporting a strong resources sector. So good to see you, Mr. Sullivan. So Senator Walsh, you have...
Pleasantries that you were very skilled at
I do
doing.
have some homework I've got to catch up on. There was a document referred to by Senator McLaughlin earlier today when we were having our discussion in relation to the building codes, and I just want to make sure it's clear for the record that that document has been formally tabled, and it's the letter which is addressed to Mr. Bullock, dated 26 June 2020 from the ABCB. So we'll take that as formally tabled. Senator Walsh, you have the call.
Thank you, Chair. Thank you for being there. I have some questions about initially iron ore prices.
G. Karunaratne, General Manager of the Resources and Energy Insights Branch.
Resource and Energy Insights Branch.
Within the Office of the Chief Economist.
Okie doke. Insights are what I am looking for.
Okay.
Come to the right place. In my EFO, there were some assumptions about iron ore prices which have proven to be fairly drastically off. I think my EFO in December assumed that iron ore prices would be back to $55 a tonne by the end of the financial year. And as at December, it was around $110 a tonne, and since then it's risen to around $150 a tonne, I understand. I think you may also have given us some estimates on some projections on iron ore prices as well, which were that they would stabilise in the previous estimates round. I think may not have been you, but I think that's what we had from DISA. Can you give us any insight into the different assumptions of iron ore pricing from Treasury in my EFO and from DISA?
Sure. So it wouldn't surprise you, Senator, that both DISA and Treasury consult with each other on their assumptions about what's going on in the iron ore market. And we both, in our December Resources and Energy Quarterly, we both were expecting iron ore prices to come down. So as you alluded to, Treasury's forecast in MyEFO was to get to $55 a tonne by the end of the June quarter.
Could I just pause you for a second there and just ask if anyone knows what the
Sorry, what?
the bipping is?
The what?
The beeping.
Right.
Just
Right.
We're trying to fix it, Senator Walsh.
We
Just-
should
I'm sort of
ignore.
imagining it as a clock ticking. I'm imagining it as a clock ticking.
right.
We're working on it.
That's all we can hear now. Is
I know. Now we're all fucking.
I didn't get the memo that we were pretending that it wasn't there.
No,
as it
I
went
was
on,
watching
so-
people's facial expressions. I was going to say something about it, but you beat me to the punch. We are working on it. Sorry.
Please continue.
Sure. So as I was saying, so Treasury's forecast is for the purpose of constructing
We're trying to fix it.
for MyEFO,
Yeah.
is for the iron ore price to get to $55 per tonne by the end of the June quarter. We also forecast that the iron ore price would fall from their high levels, and our forecast was $81 per tonne by the June quarter. And we both had similar views on what the drivers were, which was that we expected some moderation in Chinese steel production. And we also expected some recovery in Brazilian iron ore supply. Now, in the past couple of months, we've seen iron ore prices actually a bit higher. So I think most recently iron ore prices are around about $120. They rose to about $137 before and have come down a little bit. And that's because the Chinese market has been a bit stronger than we expected, fundamentally. And that despite the fact that there was additional output coming from us. In our December rec, we forecast that volumes would grow from 867 megatons in 2020 to 2021 to 920 megatons in 22-23 as some new mines in WA opened.
Thank you. Is there a way that you could explain why you think, first of all, there was such a reasonably significant difference between your assumptions and Treasury's assumptions?
Our assumptions were actually
Sorry, the
similar.
projections. I'm looking for the right word. Your projections and
Yeah.
Treasury's projections.
So our assumptions were very similar. It's not unusual for forecasters to take assumptions and have a different view on what the what the output of that assumptions would be in terms of a price. We compare our forecasts to work done by Consensus Economics, which compares the a range of different forecasts, including our own, versus what is in the market. We tend to be in the middle. We are on the conservative side, but whether we Treasury and ourselves forecasted prices to come off. Now, Treasury's was a bit more conservative than ours, but that reflects Treasury's prudent approach to their forecasting for the purpose of budget.
What level of confidence do you have in the forecasts up to the end of this financial year?
Let me see if I can answer it this way. When we did our forecasts in December, we were looking at a weaker demand from the Chinese market. That demand we expect, we've seen has been a bit better, and that's because there's signs from China that they're willing to use both fiscal and monetary policy measures to support their infrastructure and property sectors. The infrastructure and property sector account for about 50 to 60% of Chinese steel demand. So they're big drivers, Senator, of what might be a future price. So on the infrastructure side, we're seeing the Chinese government willing to front load a lot of infrastructure investments, 102 infrastructure mega projects in 2022. They've cut the bank reserve ratio requirement, and they've also cut the benchmark mortgage rate, both of which will provide more ability to borrow, to undertake investment. But on the sort of on the other side of that, we do still expect risks in the Chinese property market. So we saw major developers like Evergrande and Shimao default on some of their offshore debt, and they've been offloading some stock, housing stock, to meet interest payments. The Chinese government appears to be taking some steps to stabilise the property sector. So they've had state-owned businesses being willing to purchase distressed assets and purchasing lands, and they've loosened their 3 red line policy, which will also help with make the property more willing to borrow, make the property sector more willing to borrow.
And so what does that analysis of that stimulus in the Chinese economy and the sort of ongoing stable demand do to your forecasts for sort of the next 6 to sort of 12 months from the very high watermark that we're at now?
Yeah, so we go through this process, Senator. It's a very involved process to produce our 3-monthly forecasts, our quarterly projections. We're right now analysing all the different resource sector markets. And we're seeing how we're gathering a lot of data on how these factors are playing out. We go through this process and we consult quite widely throughout government, and then ultimately we produce our next quarterly results in April.
Mm-hmm.
So we're in between those. I can't offer you a view.
Preempt the
I can't offer you a view of what that
would be meaningless for you to try to do so. I've got similar questions on coal price forecasting, so that sounds like that would be you as well. And then just got a couple of questions on sort of markets and efforts to expand markets. I'm not sure whether that's also you or whether that would be someone else. Okay, so I'll go to the coal questions, which are essentially the same.
Can I just ask a question about iron ore before you move on to coal?
Yeah.
It's also true, isn't it, that there's just incredible volatility in the iron ore price at the moment. It seems to be a hallmark of the market over the last 12 months. Is that a fair comment?
Yeah, we've had. I've outlined what I think are the biggest factors, but there are other factors which have meant that some volumes just recently have not been able to be exported. Like for example, in Australia, when you have a COVID case and workers can't turn up to mines, and that can impact output, which the mining companies have talked about.
Yeah. And my only, just one more follow-up question on iron ore. In
fine.
terms of the cost curve, right, you talk about where producers are on the cost curve, and you want to be in the first quartile in terms of the producers, in terms of having the lowest costs. So that means you're insulated more if there's a fall in the iron ore price. Where are Australia's major iron ore producers in terms of the cost curve, do you know?
I could talk about this in the generalities. We do have cost curves internally, but the big majors, like the established mines, they're fairly low down on the cost curve, and they were producing when iron ore prices were at their 60s and 80s, quite reasonably. The new entrants that saw prices that saw the very attractive prices and got in, their cost curve, they would be sitting higher on those cost curves, and they're a bit more exposed.
Yeah. Okay. Thank you. Sorry, Cole, Senator Walsh.
No, that's okay. Thank you, Chair. So I really just have the same questions with a different set of numbers, really, on coal, as you could imagine. So at MyEFO, the forecast was for coal to drop, I think, from $170 a tonne to 130, but instead we've had this significant improvement in the price, especially beyond the Treasury forecasts, to almost $200 a tonne. Why do you think those forecasts were so far off? Is it for similar reasons, but different sorts of sectors?
So both Treasury and ourselves expected the price to fall. So they assumed that the price would decline to 130 by the June quarter and then hold. We assumed the price would decline to...
This is met coal.
Met coal, I should say, yeah. And then we forecast that the price would fall down to 183 by the 2023 year, so a less steep decline, but still a decline. Similarly, on thermal coal, we also expected prices to come off their highs. The assumption that we had, and it was quite reasonable, our numbers were again within the range of consensus economics forecasts, were that the disruptions that we saw, the weather events that caused first of all, the high demand for coal in the Northern Hemisphere to dissipate a little bit, but more importantly in Australia, some of the weather events that have disrupted supply, that they would dissipate. Now, what's happened in the recent months is that prices have sustained themselves, as you've rightly pointed out. We have seen demand be sustained much higher than we thought would be the case. China has sought to maintain their inventories during the Winter Olympics to really make sure that they don't have blackouts during that time. We did see a ban from Indonesia on its coal exports, but that was just a month, and it seems like the market did factor that in. So effectively, look at the prices; they just continued on their upward trend over the month of January. But then on the supply side, we had COVID cases disrupting supply in Australia. People being able to turn up at mine sites, and the market's still thinking about the potential for rainfalls in the second quarter of this year.
I guess just to sort of follow up with you on both of those issues, and of course there's lots of factors and the chair used the word volatility, and you need to be reviewing your data all the time, as you do. I mean, these forecasts have such a sort of a huge impact on our on the government's financial position, and so I guess I wonder how you work with Treasury to try to improve those forecasts so that we do have more accurate budgets and accounts.
Yeah, I mean, as I explained, we do work really closely with Treasury, and we both had similar views of the direction of the prices. It's a matter of opinion about the speed at which prices change. And we were our forecasts were within the sort of range, slightly erring to the conservative side, but we prefer to slightly to the conservative side when we forecast what Australia's revenue could be from the resources sector. Just as a government publication, we think that that's the right tenor to take.
Mm-hmm. Thank you. Chair, I've got quite a lot of questions in 1.3 in general, but I'm happy to share the call and come back around.
All right. I'd just like to ask some follow-up questions in terms of prices.
Sharing the call.
I will be sharing the call, but I'll just ask some follow-up questions first, which are conveniently located immediately following up from you. We should emphasise, shouldn't we, that it's a bit of a rhetorical question, I guess, but that this upside risk, if I can put it that way, is of huge benefit in terms of the budgetary outcomes for Australia in terms of GDP. The MyEFO, for example, in table 5.1 refers to for every US $10 tonne FOB increase, there's a positive
impact
in nominal GDP of around $3.9 billion. It's a huge positive. That's correct, isn't it?
That's their that's the sensitivity analysis that Treasury referred to in my.
So the upside in terms of the upside risk occurring in terms of the iron ore price, in terms of the met coal price, thermal coal price, gold, copper. Copper's at $4 something a pound. I mean, all of those upside risks, which are being eventuated, are a positive thing in terms of GDP and the budgetary outcomes. Is that correct?
Well, yeah, I outlined the prudential approach that Treasury take. That effectively speaks to you'd rather skew to upside risk than downside risk with your forecast.
Okay. They use $50 a tonne for iron ore, don't they? In the budget?
Pardon? 55.
55.
By the June quarter.
So I'm now, well, thank you for asking those very short supplementary questions before I share the call to Senator Cox. I think you've got...
Sorry, Senator, it's really important that I think that upside risk is really in terms of the conservative view that Treasury takes, and we're still on the conservative side with that. But that upside is much better than trying to forecast.
It's better when the price goes up than goes
potential
down.
downside risks.
And it's prudent to take a conservative view with respect to assumptions in terms of revenue.
And particularly given the importance of the resources sector, and the particular importance the resources sector has played through the pandemic in terms of its contribution and ongoing contribution.
But I guess put it in a sober way, the Australian people are going to benefit from the tidal wave of cash generated by our wonderful resources industry. Is that right, Mr. Sullivan? Okay. Well, your opportunity will come. Your opportunity will come, Senator Patrick. So, Senator Cox, you have the call.
Sorry, are you up to 1.3 still, Chair?
Yes. No. It's perfect timing for you.
Perfect timing. I love that. I think this falls under that. But correct me if I'm wrong. Can I ask about the Beetaloo drilling program?
Certainly.
Right place?
Third time lucky.
Third time lucky. Thank you so much. So my questions pertain to the cancelling of the Empire Energy contract and the Beetaloo drilling program. So firstly, was it someone within the department or Minister Pitt or Minister Taylor that was responsible for the very hasty decision into entering into contracts with Imperial?
So at the end of the day, the court found that it was the department's responsibility and we were the one that made the legal error. So just to give you a little bit of background, so as you say, these were proceedings that the Northern Territory Environmental Centre ought to declare invalid ultimately the grant that was made by the Commonwealth to Imperial Oil and Gas under the Beetaloo program. The Environmental Centre asked for three things. So they asked to have set aside the power that the Minister exercised under a regulation to do the grant. The court found in favour of the government on that one, that that reg is valid. The applicants asked to set aside the Minister's decision to approve the grant. The court found in favour of the Minister on that. The applicants also asked to set aside the department's execution of the contract to provide the funding, and they asked for that to be declared on the basis that we, the department, had entered into that contract unreasonably, legally unreasonably, and the court found in favour of the applicant on that one. And the short explanation, if you like, is that we, the department, had the responsibility for executing that contract. At the time we executed, there were legal proceedings on foot. What the court found was when we executed a contract, we didn't give sufficient notice to the applicant that we're going to do that, and thereby we deprived them of a reasonable opportunity to bring an injunction against our actions. The judge's legal conclusion was we had acted unreasonably, and as a consequence the contract should be voided. To give you the explanation of why we acted unreasonably, and we're obviously very apologetic of this, we said this to the court that we regretted it, and we certainly didn't mean any disrespect to the court or to the applicants. It was just one of those situations where we had a process flaw within the department, and it arose because in our department, AusIndustry, that you've heard about, is a separate division within the department. It's responsible for managing the implementation of all of our contracts. At the same time, we had in a different part of the department, the policy group that were responsible for the policy, and they were effectively the instructors on this. And what did not happen was at a time when the policy area were working with our legal branch to decide whether it was the right thing to do to enter into this contract. So we were seeking legal advice as to whether we could sign the contract. At the same time that was happening, AusIndustry were in the process of getting the contract executed. And the two parts of the department, so AusIndustry entered into the contract without realising that another part of the department was saying to itself, we better see whether we're allowed to enter into this contract, and was seeking legal advice. By the time, and the legal advice was with AGS, by the time AGS came back with the legal advice, the contract had already been executed. So, I mean, it's very unfortunate, but the department was at fault here.
Right. Just to be clear, there was no direction from the Minister?
There just wasn't. So the Minister had made a decision, knowing that the legal proceedings were on foot, that the process should continue. We were the ones that made the mistake, that as the court found, that we didn't give sufficient notice to the applicants of our action in entering into the contract. And as I say, we're very frank about that in the court proceedings. Our counsel apologised for it. We reported the breach. We voluntarily identified it as a breach of the Legal Services Direction. So we reported that to the Office of Legal Services Coordination at AGD to say that we believe we'd breached the Legal Services Direction. And of course, it's been a good learning for us because, we exposed a want of communication between two important parts of the department. I think most importantly for all is we've now instituted some training from AGS to make sure that all the department is aware or alive to the necessity to think about giving proper notice in a situation like this again.
Thank you for that explanation, Mr. Fredericks. Have Imperial Empire reapplied under the program, or did they receive any special fast track now in the reapproval process?
So, Senator, because the court positively affirmed the minister's power, and because the court positively affirmed the minister's approval of the grant, we, the department, are now in the process of executing the contract with Imperial Oil and doing this legally now. And we're able to do that because the appeal period for the proceedings have now finished. So the legal proceedings are completely finished. There are no legal proceedings left. So we're back in a world where, as a department, we need to get on with the business of implementing a minister's decision.
Right, okay. Thank you for clarifying that. Has the federal government made any commitments or undertakings similar to the Northern Territory government that they would honour and implement all the recommendations of the Pepper inquiry into fracking in the Northern Territory?
I'd better get one of my colleagues to come to the table for that one. Or Michelle.
Michelle Croker, Head of Division Onshore Resources. So the department is currently working with the Northern Territory on considering those recommendations that have come out of the inquiry.
In their entirety, so all of the recommendations, or only part of those recommendations? Sorry, Ms. Croker, just to clarify that.
So my understanding is it's all of the recommendations.
Right, okay, thank you. Have there been any more applicants other than Imperial, Sweetpea, Tamboran, Santos or Origin under the Beetaloo drilling program?
Yes, there have been other applications made. I'll just find that information. So under the Beetaloo Cooperative Drilling Program, we have had 10 applications made, of which the 3 that we've spoken about, Imperial Oil and Gas, have been approved.
Okay. Is that process now closed to new applicants?
I'll just check with my colleague Dan Quinn, who is online, with that answer.
Dan, you're on mute. That's it's the call sign of the last 2 years.
Oh, still no sound.
You still can't hear me?
Oh, yeah.
We can hear you now, Dan.
I'm sorry, I had to come in on my phone. The program, Senator, is open until the 30th of June for new applications, and the work has to be completed in this calendar year.
Okay, thank you. And just to note, Empire Energy was fined $37,000 for significant oil spills in Kansas in 2019. Was the department aware of this as part of their track record at any point through the implementation, and the application process?
Senator, I guess relating to that one, the department relies on regulatory processes that are conducted by other governments as well. So in terms of the environmental permitting of activities in the Beetaloo, that's a Northern Territory government responsibility.
Okay.
So we accept that they have done those checks.
Okay, thank you. What is the kind of information that the department uses to determine allocating public money to frack on First Nations land in the Northern Territory, and what's the process?
Senator, the process for doing that is outlined in the Cooperative Drilling Program guidelines. Essentially, there are a range of eligibility criteria for the activities, and there are essentially 3 assessment criteria that look at: is the activity being brought forward? Is the activity going to increase our understanding of the Beetaloo Basin? And is the company in a financial position to carry out those activities and to provide its 75% share of funding of those grants?
Okay, great, thank you. Thanks, Chair.
Thank you. Senator Patrick.
Thank you very much. So I'm going to ask some questions about energy and energy prices and remedies. I did foreshadow this, so not sure who the right person to ask is. So this follows, these questions follow similar questions I've asked of PM&C and Treasury, who've indicated that your department is involved in some of the work the government's been doing. Some of this line of questioning is invoked because of the potential conflict between Russia and the Ukraine, but also more generally noting that fuel prices have been steadily rising over the last, I think, about year or so. I think it's probably accurate to say. So first question is, what assessment has industry undertaken in regard to the current sharp rise in energy prices, petroleum and gas, that is being exacerbated by the international crisis over the Ukraine and the low value of the Australian dollar?
So Michelle Croker, Head of Onshore Resources Division. So the department, as a matter of course, does a lot of analysis on the energy market, both domestically and globally, and what's going on, and we provide regular briefings on that, both internally and to ministers.
Yes, so I'm trying to understand what... okay, so I've asked what assessments are done. I guess you've answered that question. So what has that assessment been?
So, Senator, I suppose what we look at is basically the supply and demand within the markets, what's going on globally, what the potential impact might be on our domestic prices. So, I mean, it's kind of very generic kind of economic kind of market analysis that we're doing, looking at the gas and energy sector as a whole.
Okay, so let's go to the detail of the Ukraine. If Russia were to go to war with the Ukraine, and we hope that doesn't happen, but if they were, there will be disruption of gas from Russia into Europe, and I think some of that may have started already. And obviously we're the largest exporter of gas in the world. What effect do you think a conflict would have on Australian gas supplies and prices?
So that kind of tension would likely contribute possibly to upward pressure on global oil and gas prices, and which is already experiencing high prices across Europe and Asia. And my colleagues from the Office of Chief Economist can talk about that situation. But while we're seeing those high global prices, that we're not experiencing those same prices in Australia, and certainly at the moment the domestic East Coast spot price, the gas spot price is around $9 a gigajoule, so significantly lower than some of the prices that we're seeing in Europe, around 70% below those benchmarks. And the ACCC's gas market inquiry report, which was released on Wednesday, noted that the East Coast contract prices are between $6.70 and $9.60 a gigajoule. Yeah,
we talked with Mr Sims today, and he indicated that without any conflict it might go to, over the next year or two, go to 10, maybe just slightly north of 10.
Coming back to your question, Senator, around what does a potential conflict do in terms of prices outlook? So obviously Europe, and I think we traversed this at last estimates, there's been enormous tightening with respect to supply, and we've had demand issues across Europe, and that's had a domino effect not only in Europe, but that has spread eastward. So that price issue was not due just to the sort of Russian supply, but that was part of it, but it was also due with COVID maintenance, and we've all, across the energy sector across the world, we've had to deal with that, and because of the pandemic, some maintenance has been put off and put down, and so scheduling that, I think we had a tightening of the electricity market in our autumn, and that was in part because of those maintenance issues being part of that issue. the same time, there were weather events in Europe. And so what you had was not necessarily the perfect storm, because that's simplifying a bit too much, but you had multiple factors affecting price. Now, if there's continuing pressure on with respect to supply, particularly coming through Russian gas pipelines, then we're sure to have that price issue flowing through. That has onward price impacts with respect to gas products as well. And we're seeing that with respect to the price of urea and a whole range of other products. So I think we're monitoring that really carefully, but in terms of the Australian price outcome and how we're travelling a whole lot better.
Yeah, look, I understand that, and Mr Sims made that pretty clear today in his evidence. But again, this line of questioning comes from initially a discussion with PM&C, who said that DFAT had set up an intergovernmental group that were looking at what happens in the event that there is that Russia does invade the Ukraine, and they mentioned that you guys were involved in that group. So what sort of, I mean, so have you done any analysis to look at what might happen in terms of, and I might indicate that US President Biden has indicated publicly that he was seeking to ensure adequate gas supply to Europe, and he mentioned Australia as a possible remedy. So
we're working really closely with the US, and part of that is in the lead up, has been through the process of the International Energy Agency Ministerial, and that will take place in Paris in late March, 22nd, 23rd March.
Mm-hmm. So you're saying there's conversations going on in the lead up to that meeting? Is that right?
That ministerial is being chaired by the US Secretary Granholm, and Australia is a vice chair of that with Minister Taylor.
Yep.
So and with his Belgian and Danish colleagues. So that group has been looking at energy security more broadly, and the possibility then of where I think President Biden was going there was in part the outreach from Secretary Granholm in the US, reaching out to us or to Minister Taylor to say, let's actually use the IEA ministerial to actually bring the countries together who are members of the IEA as well as association countries to look at energy security, which is the role of the International Energy Agency, but it's also an opportunity to look at gas security, which has been an issue that the IEA has pushed around the plate a little bit in terms of the vegetables rather than eating them, and this is a chance to actually to look at gas security as just as important as oil security, and
Sure.
You understand the origins of the IEA was very much in oil security.
So have we made any undertakings to the US government about how we might support supplies in Europe in the event that there is a conflict?
No, there hasn't been undertakings, but as you said, quite rightly, that Australia and Qatar and the US are the three largest gas exporters. But as the ACCC report showed, there's also, we've got a tightening in our own market, and we've also got to think about not only our friends and allies, but also our significant contracts and honouring those contracts and long-term contracts particularly in North Asia.
Yeah, well, I have a view about whether, in the circumstances where it's against the national interest, whether we, whether we support commercial interests above the national interest. But I think, look, I'm not going to get into a debate about that. But
yeah, look, I understand why you don't want to get into a debate, but it's important to recognise that the stockpiling of gas in particular is not something that a lot of our North Asian trading colleagues do. And so 2 to 3 weeks is their margin. And so really it's about where does the export potential of combined Qatar, the US and Australia, how can that actually influence world trade?
Okay, and I just want to check, because I was actually fundamentally involved in the ADGSM being brought into existence when I was an advisor to Nick Xenophon. Some people have been saying we've got to pull the trigger on that. I just want to confirm my understanding on the ADGSM is that that is a very rigid process where you start at the midway through the year, examining future supply estimates, and the trigger gets pulled in January. Is that right? There's no flexibility
I was
over
going
that.
to be corrected, but my recollection is, someone will correct this one, but my recollection is you're basically right. The process starts in the middle of the year ahead of the following calendar year. My recollection is that the intention to pull the trigger, to use your language, needs to be done by the end of October, I think. That then gives a month's worth of consultation, consideration, etc. And then the deadline for making the decision is the end of November. Sorry, I got my beginnings and ends. The intention needs to be done by the 1st of October. The decision needs to be by the 1st of November.
Okay, thank you. All right, I'll just depart from gas for the moment. So thank you very much for helping out there. Just in general, the price at the Bowser is now, getting close to $2 a litre, and that's harmful to most workers, most Australians, and indeed a lot of businesses. One part of the price of fuel is, of course, the fuel excise. I think it's at 40 cents or something like 45 cents of the current petrol prices is excise. Is that right?
Senator Shane Gaddis, head of the Offshore Resources and Liquid Fuels Division. It's roughly 44 cents. It's indexed, so it changes each year. Okay.
So has there been any consideration noting the current situation, which I can't see abating, and you might say I'm wrong, but I've just been watching the fuel price just steadily climbing. Has there been any discussion, consideration, brainstorming within the department with a view to looking at John Howard's policy back in, I think it was 2001, of putting a pause on the indexing and indeed maybe in some way reducing that excess to give relief to Australian businesses and consumers. Has there been any discussion around that?
So, to be really honest with you, that is absolutely a matter for Treasury.
Sure.
Because, Treasury and excise, it's about revenue. So at the end of the day, I'd be much more comfortable with that.
Well, I did ask them actually, so I asked them the same question.
I can guarantee you they didn't say it was a matter for us.
Well, no, they didn't. They didn't say it was a matter for you, but as I said, you got roped into the discussion.
Yeah.
And because you're experts in this field, they may like the revenue, but you understand the things that drive the price. They indicated that they hadn't. They indicated that that they wouldn't go to budget measures, but the sense was that they weren't talking about taking that to the budget as a proposition. But that doesn't mean I can't ask you whether you're talking about that, whether you're, someone's walked around the department and said, "Gee whiz, we're getting to a point where petrol prices are affecting people. Let's prepare some options in case government might ask us for some options."
Senator, if I could add some context, the Secretary quite rightly pointed out it's not our responsibility.
Sure.
Australia already enjoys some of the lowest taxation in terms of fuels in the OECD. So our fuels are roughly 25% lower than the OECD average, and most of that is because we pay lower tax than most OECD countries. So we're already at the lower end of the taxation threshold.
Sure.
Another way of looking at that is Bowser prices are largely determined by the level of government taxation because of the oil price being pretty persuasive in terms of price setting, and particularly with Australia as a net importer, then we're much more subject to world oil prices.
Well, I'll just finish up, Chair, thank you, by, as I often do, just making a statement, and that is I am concerned about fuel prices and the effect that's having on families and businesses.
Okay, thank you, Senator Patrick. Who's seeking the call? Senator Walsh.
Chair. We've got some questions about PEP 11 for Nocta.
So I'm happy to take questions with respect to PEP 11.
Or I can do 5 minutes of something else before that, if you'd like.
No, Nopta's on the line, but,
Oh, okay.
but in terms of some of the process issues for PEP 11...
Yeah, that's both of you.
Probably,
Okay.
yeah.
Yeah,
We'll
sorry,
work it out
Mr
as we go.
Sullivan. Yep, sure. Sorry, you made a face then. What did you say?
I said we'll work it out as we go.
Okay,
I was apologising to you
It is the last
in
night.
advance.
It is the last night of estimates.
Not for everyone.
Oh,
we're
whoops.
back
Okay, then,
tomorrow.
Senator Walsh.
Last night. I said last night. Yeah, that's right.
Okay. Oh, well done, Senator Walsh. Well done. Well done.
We're all getting along
Senator Walsh, you've
so
had the
well.
call.
Thank you, Chair. So the Prime Minister announced that he had advised NOPTA of the Commonwealth's intention to refuse the PEP 11 exploration permit application. He did that in a media release of 16 December. Has that decision now formally been made and concluded?
So, Senator, the addition to that story is that the Prime Minister made an additional media release today, which is the next step to formally reject the application for PEP 11. And as a result of that, this is coming at the very end of the process, and I'm happy to go back and walk through the chronology. But at the end of that, the Prime Minister has written to the other member of the Joint Authority in New South Wales, who's the Deputy Premier, and that now matter rests with the other member of the Joint Authority, and I think they have 30 days in which to respond. And at that time, the decision will be finalised.
Yep. So I might just go over that again, and partly I couldn't hear all of it, I have to say as well. But so the Prime Minister made the announcement on the 16th of December, but that announcement sort of didn't have the appropriate effect at the time. He's made another announcement today on the...
So I'll walk through the chronology.
Yeah.
So this goes back to an application by Asset Energy, and with respect to the permit conditions with respect to PEP 11. So the state member of the Joint Authority made an initial decision in February of last year. On 16th of December, which is the press release you're referring to, Senator, the Commonwealth member of the Joint Authority then made a decision to refuse the applications. And then NOPTA, which Mr Waters is online as the titles administrator, issued a notice of intention to refuse the applications. That then was given to...
When was that, sorry?
Sorry?
When did NOPTA
So that was
issue their notice?
that was made on the 16th of December.
Okay.
And so Asset Energy, the permit holder, had 30 days in which to respond.
Yep.
So that's just a basic procedural fairness step. Asset was then provided some additional time to respond. In part, that was because of the time of the year. And after that, the titles administrator provided advice to the Joint Authority on the 31st of January. Based on that, the Prime Minister, as the Commonwealth member of the Joint Authority, then has issued a media release today stating that he had written to the Deputy Premier advising of his intended decision to refuse the application. So that's where we're up to in terms of that now rests with the New South Wales member of the Joint Authority, and they have 30 days in which to come back.
Right, okay. What's the Joint Authority called?
It's called the Joint Authority.
Okay.
Good answer.
It's just called the Joint Authority.
Senator Murray, or General Manager of the Offshore
If I'm wrong, I don't know.
It's got a full proper name, the Commonwealth New South Wales Offshore Petroleum Joint Authority.
Okay.
Joint Authority for short.
Yeah. Okay. And the Prime Minister is on that.
The Prime Minister was the Commonwealth decision maker for the purpose of this decision.
Right. And so the joint authority is the relevant state decision maker and the relevant Commonwealth decision maker, and that's it.
Correct.
Yeah.
Yes.
Okay. So there's just this sort of process tracking through where NOPTA put into effect the decision of the Commonwealth decision maker at the time. The Commonwealth announced the decision on the 16th of December, and then there was a 30-day period for ASIT to respond. And then I've sort of lost track, but we're now in it. But we'll review the transcript, and there's a further 30-day period that is required where the New South Wales decision maker
I think it's up to
to
30 days.
Yes.
So
To respond.
So you're waiting on the New South Wales decision maker to say we're okay with this.
Correct.
That's correct.
And have they made any public statements about their position?
not that I'm aware of, Senator.
And what happens if they're not okay with it?
There's a provision in the legislation for the Commonwealth Minister to decide the matter.
Okay, right. And the Commonwealth, so the Prime Minister is the designated Commonwealth person on the joint authority, and the person who can decide it in the end, is that the Minister, or is that the Minister Pitt, or is that the Prime Minister as the person on the authority?
Is the Prime Minister on this matter?
It's the Prime Minister, okay, right. So he made an announcement, there's a long decision, and ultimately at the end he can decide it.
That's correct.
Correct. That's correct, okay. All right. What was Minister Pitt's role in this decision?
When you talk about this decision, so with respect to the decisions taken by the Prime Minister as advised on the 16th of December and today in terms of 17th of February, the Prime Minister was the decision maker and Minister Pitt didn't have a role with respect to those decisions.
Right, okay. When we spoke about this in the October estimates, I remember a little bit of confusion because there was a second application that we were talking about. And I think NOPTA said at the time that they were awaiting a decision on the first application before it could provide advice on the second application. So now we're in this process around the first application being refused. What is the status of the second application?
Senator Graham Waters, Titles Administrator. That situation has not altered. I am still waiting for the decision of the Joint Authority, and once I've had that, we will then submit our advice on the second application.
And is the second who has made the second application?
The title holder.
Asset Energy.
Right. So it's basically the same sort of it's the same application again to do this seismic testing, is it?
It's an application for a suspension and extension. The first application we're talking about is a suspension, extension and variation of the permit conditions. So very similar. And so in sort of
I might be just asking you to speculate, and I guess you'll tell me that, but in sort of layperson's terms, would it be understood that this second application there's not a lot of point in continuing with the second application if a similar first application has been refused?
We probably have to be a little bit careful in giving any view on that, just for fear that it might preempt a decision that's going to be made by the joint authority. I understand why you're asking this.
Is it alive? Is this issue still alive?
I suppose the way to help it is are you able to just, in layman's terms, explain the nature of the difference between the two applications?
Certainly, Secretary. The second application is a request for suspension of the work program conditions and an extension of the permit term, very similar to the first one. The first application, however, was to remove the seismic survey obligation. The second one has been made in order to essentially provide more time to complete the work program, which the applicant is still waiting on the resolution of the first decision, i.e. the decision to remove the seismic obligation, but they have made a second application just in case they need additional time to continue the work.
The work that's been
So just following on from
refused
from where Mr. Fredericks was headed, I'd prefer to take it on notice when we've got resolution of the first matter. I think I'd be much more comfortable to then provide advice on notice.
Just to add to that, Senator, we're just nervous given that the first application is still live because it's still waiting for a decision from the New South Wales member of the joint authority. So just got to be careful there. And then the second one, the application is in, so it's technically alive. So that's why we're being hesitant.
I understand. I understand how you're trying to assist. And is it not possible for the Prime Minister, as the decision maker on the joint authority, to make a decision about the second application until the first one is finalised, or would it be possible?
That's a complete hypothetical in terms of, I think what we need to do is cross the bridge with the first application, and once that's resolved, I think we can then try and bring the second to some sort of finalisation.
That's right. Yeah. Just to explain why that is, the first application sought to change the timeframe in which the permit obligations or the work program was to be delivered in. If it were approved, that would change the dates of the timeframe for commitments to be done by, and so that is why the second application is contingent on the first one being resolved. If, of course, it is refused, those dates are then a matter for the applicant to consider whether they do wish to amend that second application.
So it's not easy in the explaining, but I think the gist, Senator, is I think our advice is that the second application is contingent on the outcomes of the first. And I think that's the proper answer to your question.
Okay. Okay, I think I've probably taken that line of questioning as far as I practically can, so thank you very much. Shall I just keep the call for a bit longer? I've just got a few short ones, or what would you like to do?
5 minutes in terms of short ones, and then Senator Patrick has some questions on Northern. How long do you think you'll be, Senator Patrick?
Depends on the department's answers. Maybe 10 minutes tops.
How much?
10 tops.
Tops.
On,
maybe 5.
Senator Walsh.
On Northern Australia, was
Northern
it?
Endeavour.
Oh,
Northern
okay,
Endeavour.
right. Mr. Sullivan will be really pleased to know that I have questions on the Extractive Industries Transparency Initiative. However, I have reviewed the transcript of our interactions on this last time, which I do understand repeated a similar line of questioning on a previous occasion. And I think I understand that in general, the government's position has been that it doesn't wish to enter into this transparency initiative because of concerns about being able to influence what the requirements may be as they may change in the future. That was the last piece of advice that you gave us, and so I thought I might try to preempt a lot of back and forward by just asking whether anything's changed since last we spoke on our interest in making good on the commitment of 5 years ago to join this transparency initiative.
The short answer is no, nothing has changed. I mean, we're still waiting in terms of a response to the Board of Taxation review of the Tax Transparency Code, which is, again, we haven't changed that since we last gave evidence.
You haven't changed, the government hasn't changed
No.
its concerns about signing up to that and still wishes to follow domestic rules.
And as I think we've traversed before, Senator, that matter for the Board of Taxation review of the broader tax transparency code is a matter for Treasury, and so
Right.
And that hasn't changed unless my colleagues know.
No, you still have people in the department sort of broadly assigned and working monitoring.
That's right.
Yeah. Okay. That was pretty quick, wasn't it, Chair?
I thought that was a great example for all of us to follow. Has anything changed since last time we spoke?
Fortunately, it doesn't appear that Senator Patrick
No,
was
well,
watching, but-
did you hear that, Senator Patrick?
No, I didn't.
Sorry, Senator Walsh, go on.
I might just, I think I have a similar sort of frame on the Critical Minerals Facilitation Office. Might perhaps a bit longer.
That's fine.
Yeah. Thank you. Would you mind introducing yourselves?
I'm Senator
Good
Andrew Atkinson, General Manager of the Critical Minerals Facilitation Office.
Anthea Long, Head of the Critical Minerals and Major Projects Division.
Okay, thank you. This office was established in January 2020. So I'm really just sort of after some updates that I'll ask you about on sort of progress since then. How many people are working in the office now, both headcount and FTE?
So the CMFO is comprised of 12.6 staff.
Sorry?
12.6 staff,
Yep.
FTE.
Yep.
So that's, it's 13 in headcount.
Yes. And what's the nature of the employment? Are they permanent roles? You're referring to sort of permanent direct employees?
That's correct.
Yeah. Are there any unfilled roles at the moment? Any vacancies at the
No,
moment?
Senator.
Yeah. Thank you. Do you, can you tell me a bit about what you do, which will help me with my next question? What are you really working on at the moment?
Certainly, Senator. I'd make some comments about that, but in addition, the department reports against our activities in its annual report, which is a good source of information.
Yes, thank you.
So effectively, we're a small policy unit that sits at the centre of government and works across a range of agencies to help grow the sector. Our objectives align with the Critical Minerals Strategy of 2019 and with the Resources, Technology and Critical Minerals Processing Roadmap of 2021. In shorthand, we're trying to grow the sector, so create more jobs and more investment, stand up more mines and processing. We're trying to capture more of the value chain for each of these critical minerals, so move further downstream rather than just a dig and ship model We want to see more of that value and job creation happen onshore. And we want Australia to realise its position underpinning supply chains that are crucial for new and emerging markets, particularly for allies and like-mindeds. I think from an economic perspective, Senator, critical minerals are absolutely crucial to a range of technologies that are becoming increasingly important, particularly around electronics and electrification. And so we want to see Australia maximise its position and leverage its natural asset base.
Thank you. You provide loans to industry participants.
The Australian government does, Senator. The Critical Minerals Facilitation Office does not provide loans. We provide policy advice across government.
Okay.
And so we work closely with agencies like Export Finance Australia, the Northern Australia Infrastructure Facility, Clean Energy Finance Corporation, in lockstep with them to help them determine loan notice.
And are you involved in the assessment of applications?
Each of those agencies has their own particular process, Senator. And I believe we covered a little bit of this last time, but whether it's a hard requirement or a matter of practice, we work very closely with each of those agencies to provide policy advice to them in considering their loans and in helping government to consider the loans. But we're not technically responsible for deciding who gets the loans.
Sorry, you're not responsible, and you don't.
No.
You don't put out sort of requests for proposals. You don't assess them, and you don't give out money. Other agencies do that.
We have no authority or responsibility for administering loans, Senator, but to the agencies that do, we certainly work closely with them to provide them with advice.
Right. So the term sort of facilitation in your title is referring to the work that you do with industry, with government, with stakeholders to try to create opportunities to grow the industry in general.
Absolutely,
there's
Senator.
some confusion about the title.
Oh, sorry about absolutely. Happy to expand on that if you'd like. I can give you some examples perhaps of the types of work we do that cover the range a little bit, might be useful.
Sure, yeah.
We work closely firstly with the industry. There are 60 or more companies that we're in regular contact with, helping to understand their projects, what status is the project at, where are they going next, how can we help. That can be both by connecting them to, as you've already mentioned, financing and loan opportunities or with grant programs. It can be more run-of-the-mill stuff as well in terms of connecting them with good scientific expertise through CSIRO, Australian Nuclear Science and Technology Organisation, or Geoscience Australia. We liaise closely with the states and territories as well, and work closely with our Major Projects Facilitation Office to help those companies put their best foot forward and achieve things like environmental and planning approvals. We also work really closely with Department of Foreign Affairs and Trade and with Austrade and our embassies overseas to assist with trade facilitation. So we talk to a lot of domestic and international companies who are interested in Australian projects. We try and link them up. Where there's a project with some really interesting aspects, we like to highlight those, while of course being appropriate and ensuring that that facilitation service is available to all companies. So we really cover the field, Senator, but we also then provide, as I said, policy development and policy advice services within government using that industry expertise.
And just a final question, I think, from me, and I've got a couple more. You obviously do stakeholder work, and a lot of it. Do you have a formal stakeholder advisory group?
It's an excellent question, Senator. We don't have a standing stakeholder advisory group. By that you would mean like a group of kind of industry representatives to advise us on our work?
Yeah.
No, that's a really good question. We don't have such a thing. What I would note, for example, though, in pulling together the critical minerals, it's the Resources Technology and Critical Minerals Processing Roadmap, there was an industry advisory panel, although I may have the technical name of that panel slightly incorrect, happy to clarify. But there was a group that consisted of several high-profile critical minerals industry leaders that were brought in to provide specific advice to government on that particular task. And so we would, of course, look to do similar things if there are future policy development opportunities. We find the most appropriate way of working with and contacting industry, in addition to our existing formal and informal networks.
Okay. So following on from that theme, your annual report says that you work closely with state and territory governments on ethical certification of minerals. What do you mean by ethical in relation to critical minerals? Are you talking about sort of environmental responsibility? Are you talking about sort of the working conditions of people? Are you talking about sort of First Nations ownership of land and those matters? What do you mean about ethical certification?
Sure, happy to expand on that, Senator. Thank you for your question. It's really all of those things. I guess the common term within the industry, domestically and globally, is ESG, environmental, social and governance. So thinking about it from those kind of three parameters, environmental, obviously, as you've said, covers off things like, is there a rigorous legislative regime in place to ensure that the impacts have been assessed and any kind of considerations taken into account? What happens with the waste product? What sort of technology is used? How is that treated? Those sorts of things. The social goes to some of the labour issues that you mentioned, Senator. Are people being employed under fair conditions? Again, is there transparency and oversight of those arrangements? All those sorts of things. And governance goes really to corruption or lack of. Again, is there accountability and transparency? Is this a clear and open regime? Australia is incredibly fortunate here, Senator, in that we both hold these minerals, but we can leverage our existing systems around environmental protection, around labour protection, around governance and transparency to provide a really strong offering to the market that our competitors in many of these just can't do, whether that's lack of transparency or, for example, I'll pick cobalt, which is a really important mineral for producing lithium-ion batteries. Most of that is produced in the Democratic Republic of Congo. It is well documented that there are a range of labour and governance concerns as well as environmental ones there that can go to quite harrowing issues around child labour and sex trafficking, just dispossession of entire communities. It's really quite challenging. Australia is very fortunate in that we have quite large cobalt reserves, both as primary reserves and also co-occurring with nickel. We would really like to produce those and bring them online, and then in doing so we can offer the market a higher environmental credibility option. So the work we're doing with states and territories, particularly with the Future Batteries Industries Cooperative Research Centre, is really around pulling that market offering together and explaining why countries like Australia are a better bet than some of the less transparent countries and supply chains. Thank you.
And just finally from me, we talked about the stakeholders that you liaise with and what the structures are around that. Do you liaise with First Nations representatives about cultural heritage and sacred sites issues and how that interacts with critical minerals mining?
Senator, I'll be completely honest, about the 1 year that I've had this job, I personally have not, and I would quite like to do a lot more of that. I think if I was to sort of explain why that's not been a major focus of my office in the last 12 months, it's largely because that interaction often happens under the rubric of a state-managed environmental or cultural land use planning process, and the companies do a lot of that interaction as to the state regulators, whereas we kind of float atop and look at the settings more generally. However, I think it's a good point and we should definitely consider those perspectives more.
Thank you very much.
Senator Patrick, you have the call.
Thank you very much. So I was after the Northern Endeavour Task Force.
This is the short answer. The long one is for an explanation.
Mr. Geddes, I thought you must have taken on an extra job as well, have you?
No rest of the business.
Okay, there you go. All right. I just wanted to. I've kind of asked this question in the past, but I'm not satisfied I got an answer. Just wondering how many industry, and I'm talking about commercial proposals, did the department receive to take on the tenement and continue extraction? So I'm not talking about decommissioning, but this goes back a little bit.
It does go back a little bit, Senator. Off the top of my head, and I'll come back to you on notice if I got it wrong,
Yeah.
my understanding was that there was two.
Two, okay, thank you.
That commercial restart proposals.
Yes, thank you.
Unsolicited.
Now, have you received any commercial proposals re the decommissioning? And this sort of goes to, obviously we've passed legislation now that allows you to move forward and decommission. I presume you'll either go to contract for that, but I'm wondering if someone's come in with a proposition.
Yep. So, Senator, as you're aware, we've run both an expression of interest and then we've down selected through a request for a proposal as a part of a tender process, a global open procurement process for the decommissioning. On the 29th of July, the government received an unsolicited proposal from a consortium of industry companies with another proposal outside of that process to decommission.
So an unsolicited proposal. How does that interact in the circumstances where you have like a request for proposal? Did you say RFT?
So we did an expression of interest. We then down selected to a preferred subset of those tenderers, and we went out with and they put in a request for a proposal. They sent those back in. I think that was on the 9th of November. We've now gone through that process, and we're at offer definition and improvement activities with those down selected proponents.
Yeah. Okay.
And we're hoping in the next month or so to enter contract negs and then enter an agreement. Coming to the unsolicited proposal.
How do you treat the other proposal?
The other proposal was treated as an unsolicited proposal.
Yep.
We sought, so they wrote to the Minister. The Minister asked the department to investigate the merits of the proposal.
Yep.
We provided advice to the Minister on how we would do that if there was policy authority. So the Minister wrote to the Prime Minister to seek policy authority for us to investigate the proposal.
Okay.
We then established, do you want me to keep going? I can go through the process.
No, that's good. So you I presume we got some approval to do this?
Yep.
And then what happened?
Then we set up a separate team. So sought probity advice.
Chinese wall, yep.
Chinese wall, separate team to make sure that we could assess the two side by side and then come back to government at a point in the future to determine which was the best approach to take for the Commonwealth.
Okay, and that will come, the answer to that will come at some point in time?
The answer has already been...
Okay.
We've already reached a conclusion to the unsolicited proposal.
Yep.
We've reached a determination that doesn't meet the Commonwealth procurement requirements or the government's policy requirements.
Okay.
And it
so you're now back to
won't proceed any further.
The shortlisted group. Okay, that's very helpful. Next question I've got is, I've got two questions here, and I think they're kind of interrelated. I've written down, what's the current status of the legal action in relation to the Northern Endeavour, and also has there been an agreement reached with respect to the rights? So I think you're sort of at the point where there'd been a pause in the litigation, everyone had backed off, everyone was chatting. Have you reached some sort of consent position?
So, Senator, last time we spoke, we had reached the terms of settlement, and we were going through and we were looking to agree the more finite details of the terms of deed of release and settlement. We're still in that process.
So it's unlikely that you'll get a judgment from the court. It's going to be something hopefully by consent, by way of...
I couldn't give you a probability, but we are working towards that outcome.
Sure. Okay, no, that's all I needed to know. Do you have, as the task force, have any role regarding the title and the tenement, or is it just disconnecting and that's your...
This part of my division looks after just the decommissioning of the FPSO.
Yeah.
The title aspects would sit with NOPTA.
Okay, thank you. My last question on this. No, in fact, I'm not going to ask that question. I'll move on to NOPSEMA if they're around.
Senator, I think the chair might need to make an assessment about whether this program 1.3 is finished and you're moving to NOPSEMA. Senator, I'm co-chairing.
You're doing a very good job, Mr. Fredericks.
Senator Patrick.
So what are you doing? As I was distracted, Senator Patrick.
Very efficiently
Got
asked.
some aspirations, Rex.
I very efficiently. You don't want to be on the side of the desk. The pay's not very good.
Malcolm's not here to contest
that. I've just asked about 5 minutes worth of questions on Northern Endeavour.
Right.
I've got some on NOPSEMA. I think that requires a jump to the next.
It would require the chair to decide that we're ready to go to NOPSEMA.
That's what the secretary was just.
So I might. Do we have any more questions on 1.3?
I could put them on notice.
Okay, thank you, Senator Wash, and Senator Cox. You could put them on notice as well. Okay, so we'll now move to NOPSEMA.
Thank you, Chair.
And we'll thank all the officers who've provided evidence in relation to program 1.3. Thank you, Mr. Sullivan.
Thank you very much, Chair.
All your colleagues, thank you very much. NOPSEMA, do we have you with us? Can you hear us? Oh, there you are.
Yes, we can hear you. Hopefully you can hear us.
We can hear you. Now, do you have an opening statement or are you ready to go straight to questions?
No, happy to go straight to questions.
Okay, very good answer. We appreciate that. Okay, so Senator Cox, you have the call.
Trying to get an update on the Scarborough Pluto project. So can you provide an update on the approvals process for the Scarborough Pluto gas project?
Yeah. I'll get Mr. Grebe to answer that.
Thank you for the question, Senator. Cameron Grebe, Head of Division for Environment, Decommissioning and Renewables at NOPSEMA. Currently, we have an environment plan under assessment for the Scarborough project. It relates to the development billing activity. Currently, the environment plan has been returned to the proponent NOPSEMA to be modified and resubmitted. And we expect them to resubmit the environment plan this month, where we'll continue the assessment.
Excellent, thank you. Now, I understand that Woodside have not disclosed the amount of money that it'll cost to decommission the Scarborough and Pluto Train 2 project. As the regulator, I'm interested to know why you're allowing projects to go ahead when the company can't tell you how much it's going to cost to undertake the decommissioning.
Senator, the Pluto project actually doesn't fall within NOPSEMA's jurisdiction. That part of the project is on state land and falls in the jurisdiction of Western Australia. We're responsible for the offshore petroleum activity components, so that's the facilities and pipelines that relate to Scarborough and Pluto, but offshore.
Okay, so what's required then from a legislative or regulatory perspective so that NOPSEMA can assure that the company, basically that on the parts that you govern, what assurances or what processes are in place to make sure that they do decommission or do have the appropriate money to cover the costs of decommissioning that component?
NOPSEMA has responsibility for the decommissioning planning and compliance with the requirements to plan and manage activities towards full removal at the end of operations when property equipment is not in use, and also to make decisions under regulations regarding deviating from that requirement, which the Act provides for. That doesn't extend to matters that I think you mentioned there in relation to the financial capacity to be able to carry out that. It's not NOPSEMA's responsibility currently.
Thank you. I'm interested more in understanding more about the risks of leaving offshore infrastructure in situ from a research perspective. So I'm not sure if you can answer this, but how are you currently assessing requests from oil and gas companies to leave offshore infrastructure in situ as part of that decommissioning process?
So the requirements under the law that the title holder has to demonstrate under the environment regulations like other stages of the petroleum activity, that the impact will be at acceptable levels, that includes and extends to justifying leaving property equipment in situ. NOPSEMA has to have regard to a range of other factors, including for facilities, the safety of people under the safety regulations, in relation to wells, that wells are properly plugged and abandoned. There's also obviously other guidelines and principles and legislation that applies to leaving of property equipment, which we don't necessarily administer but ensure are covered through the environmental approval process. And so obviously the Sea Dumping Act, but also we have regard to relevant EPBC requirements, so Environmental Protection Biodiversity Conservation Act requirements, and also the international conventions that Australia is signatory to and apply.
So do you believe that we have enough information to make some evidence-based decisions around the environmental risks of leaving some of that offshore infrastructure in situ?
Well, that's a case-by-case decision-making process. So where there is sufficient evidence, we would make a decision, but where there isn't sufficient information and there's substantial uncertainty as to whether it can be demonstrated to be an acceptable outcome, then we wouldn't. The regulations actually prevent us from making an approval decision to allow that. The obligation to make that demonstration and provide the evidence falls to the title holder in the legislative arrangements for offshore petroleum. So it's really a matter for an individual case for a proponent to carry out research should there be gaps regarding evidence on whether the impacts and risks are acceptable.
Okay. Do you believe that there could be done, there more to be done to improve the quality and quantity of research that we have around environmental impact for offshore oil and gas infrastructure?
Certainly, Senator, and I think, all researchers would identify more research is needed. And I think NOPSEMA has been very active in this space in engaging with the industry and encouraging research and, in fact, identifying areas where there is a greater need, and particularly the implications of leaving property equipment in situ in perpetuity and the fate and effects of materials that are left. And we've been doing that engagement through not just the industry association bodies, but there's also a national decommissioning research initiative that's been established under the National Energy Research Australia, NERA, which is funded by the federal government, and they are carrying out a range of research programs on topics such as those that I mentioned, as well as other decommissioning research priority. I think I'd also point out that we do look to Australia's relatively new to decommissioning at a larger scale. And so we are aware of and engaged on research that's already been carried out and is relevant here, particularly in the Gulf of Mexico, in the United States and offshore California, as well as in the North Sea.
That's great. Thank you very much for that. Thank you, Chair. That's it.
Thank you.
I've just got one supplementary, or maybe two questions on this. Presumably, just thinking this through, if it were possible to leave some of the subsea infrastructure there without causing environmental damage, that could result in quite substantial cost savings, which could lead to extra revenue for the government because it takes away decommissioning costs. But it really is dependent upon it being able to be done in an environmentally appropriate way. Is that a fair comment?
Correct. Senator, I think also the term environment's quite broad actually under the regulations. So impact on mother marine users is a key consideration and comes also from international conventions. So hazards to other marine users is a factor. So your suggestion there is entirely the case, and we see that happening in other jurisdictions in Europe with steel pipelines that are decontaminated, for example, or on the seabed. But in the case of steel jacket platforms that obviously protrude through the water column, that's something that international conventions essentially don't permit.
Sure. Okay. All right.
Yeah.
Understood.
Senator, just to explain a little further, so the legislation requires full removal and restoration of the site back to its original state, but the regulations provide for NOPSEMA to be able to approve circumstances
which might deviate from that, where the impact on the environment is acceptable and the risks are reduced to as low as reasonably practical.
So the burden of proof reflects the precautionary principle. Is that a fair comment?
Correct.
Correct.
Yeah, okay. Senator Patrick, you have the call. That was all, Senator Cox?
Yes, thank you, Chair.
Senator Patrick, you have the call.
Okay, thank you. I'm not sure whether you might have tuned in last night when I was talking to AMSA about solar certificates.
Well, what else would you be doing last night?
Well, no, you know.
So,
Give us a synopsis now.
and in West Australia, it would have been early. You would have been, it wouldn't have been tired or anything.
Come on, Rex.
But okay, all right. So I want to ask you, because that just would have helped. That was all. Information you've provided the committee about the warrant that was executed and the reports that have flowed from that, and I thank you for them, indicated, and I'm not sure if I've got the reports with me here, I had them last night with AMSA, indicated that there were some real issues on board of Nungara. Is that how we say that vessel's name? Yep. Yes.
That's close enough, Senator.
Okay. It had a number of SOLAS-related issues. So there were fire system cylinders that were rusted and so forth. And the documentation showed that you initially emailed AMSA, and then both you, Mr. Smith, and the CEO of AMSA met at some stage. AMSA basically said that on an FPSO, the SOLAS requirements sort of fall outside the Navigation Act. So if it's in your control, then they don't look to it. Only were it disconnected would they then have some authority about that. Now, that leaves us in he called it a legal lacuna, in that you have safety of life at sea equipment that is not covered by you guys, and AMSA doesn't look at it. Now, one of the reasons I understand a SOLAS certification is needed is because you may have to disconnect an FPSO, with a cyclone coming or whatever. And so you really do need to have a SOLAS certificate in place. Can you talk to me about that lacuna and tell me about that from your perspective?
Senator, I might get Mr. O'Keefe to elaborate because I didn't hear you last night. Unfortunately, I was doing other things and
well, next estimates you'll know to do differently.
Anything else you possibly could do? Sorry to interrupt.
I'm not quite sure of the angle that you're coming from on this, and so I'm not quite sure of what the lacuna is that is being
a lacuna,
to,
it's not a common word. It means hole, like a gap.
No, I appreciate that. I'm just not sure of what the issue was that was being raised last night. So Mr. O'Keefe may be able to explain a bit more about what we do in regard to SOLAS requirements, which might help answer that question.
Thank you.
Thank you, Mr. Smith, and thank you, Senator. The specific issue there related to an inspection that we did on the Nungara PSO in 2018, and the fire protection system at Brant Lane, the Inogen system, clearly had defects. The operator had failed to maintain it. It got a number of defects associated with it. They were intending to be supported by external certification as a means of demonstrating the equipment was fit for purpose. And it was evident to us that the equipment was not fit for purpose. We issued an enforcement because of the risk presented by the equipment not being working. They could use any type of certification that they wish, but in this particular case, the equipment was defective. and they need to go and address that problem.
So what I hear you saying is, and the audio is a bit scratchy, but you're indicating that when it's at sea under NOPSEMA's control, you have a requirement for the fire safety equipment, or fire retardant in this case, to be properly certified in some way, but it's not a SOLAS certification.
Senator, we require, under the safety case, all of the risks to be managed to risk as low as reasonably practicable. And the operator can choose the way that they demonstrate that that has been done. And in this particular case, there were certain requirements they're going to adhere to. But in any case, the equipment was defective and could not function as intended. So again, we raised an improvement notice for that.
Yeah, okay, but it's still, I'm still trying to get to the point. The moment that the vessel detaches from its anchors, so it detaches from its site to maybe go to a port in an emergency, at that point the SOLAS requirement kicks in. But we seem to have a situation where AMSA, who are responsible for the SOLAS requirement and require a certification, basically, if they're looking in at the vessel whilst it's under your charge, they have no jurisdiction, and indeed, I would suggest if there's not a SOLAS certificate, it creates a huge problem if they do disconnect, because now they're in breach. I would have thought the Act would have had a requirement in there for SOLAS, such that if they do have to disconnect in an emergency, that's covered off.
Senator, again, the standard that the operator was intending to operate to was against particular certification. That was clearly not conforming according to the certification, and the equipment did not function as intended. So we looked at it from a risk perspective. Now, if the equipment had met that requirement and had been functional, when it passed into the other jurisdiction under AMSA, under that, my guess is that that would have met their expectation. But that's the matter when it moves from our jurisdiction to theirs. We looked at it from the risks presented at the time, and irrespective of what to do next, it was adequate at the time.
All right, maybe I need to lift this up a little bit in terms of saying, let's forget about the specific vessel. What I'm concerned about is that it's clear that once the vessel disconnects, it has to have a SOLAS certification. That would tell me that a vessel that is under your charge that is disconnectable, it would be proper that there be a SOLAS requirement placed upon the vessel itself. And what I understood from the evidence last night with AMSA is that you don't place that requirement. You might have a certification requirement, but it's not SOLAS certified.
Senator, I think it should be quite clear to the owner or the operator of the vessel that if they're operating under the NOPSEMA regime, that they need to meet the requirements of that. And if they change that to move into the AMSA regime, they need to meet the requirements of that. They may choose to do that by using the same level of certification to demonstrate that they've met the minimum requirements of both cases, and therefore, by maintaining that certification in place, as they presented to us that they were going to do, they would have made it. So I think it's actually one and the same thing, but they need to manage the risks at all times. They're fully aware of what it's like to be under NOPSEMA, aware of what it's like to be under AMSA. They've got an obligation to meet the expectations for whichever point in time they're at.
Yep. So just to help tease this out, if I could, Senator Patrick, you're saying that there should be a way for the operator to manage this issue so that they're compliant at all times when they're connected and when they're disconnected, and they should be able to manage the cutover, if you like, between one safety regime, legislative regime, to another safety regime, which is triggered by the disconnection. Is that your general evidence, the general view you have? That's the
nub of the problem.
Yeah.
And I understand you can have a regime where when it's connected, it's covered off by a certain certification. But noting the need might come in an emergency, it would seem to me that you would always have to have a SOLAS certification in order to, the point with the emergency calls, you can't ring up AMSA and say, geez, I need one of these certifications.
So that particular scenario, let's assume that it's connected, it's got all its certifications.
It's NOPSEMA
certifications, right? An emergency occurs, they need to disconnect. At that point in time, they move to the other jurisdiction.
SOLAS,
How do they ensure that they meet that those safety requirements under AMSA at that point in time when they've disconnected in an emergency?
And in essence, I'm saying I think the answer is you have to place the SOLAS requirement on the vessel when it's at anchor or when it's anchored. Otherwise, you have these two regimes. AMSA can't look in to see if it's okay, if the system's okay from their perspective, because they have no jurisdiction, even though they might be meeting NOPS's regime.
So the jurisdiction changes at a moment in time. That moment in time could be in the context of an emergency. So how does that work in practice to make sure there's no period where there's a gap, maybe as a practical result of the circumstances where you disconnect an emergency? How do they manage that transition from the NOPSEMA regime to the AMSA regime? Do you understand the conundrum Senator Patrick's raising?
Well, Senator, could I maybe suggest it's maybe more fundamental than that? The operator had a performance standard that said the equipment will be tested, certified and maintained according to a certain standard, which happened to be the AMSA MO Part 15 and so on. They've clearly failed to do that. So they failed to meet our expectations.
Well, I think, sorry to interrupt. I think Senator Patrick's trying to lift the discussion to a general policy perspective.
Yeah.
So it's not even the particulars. It's from a general policy perspective. How do you manage this transition between the two regulatory safety regimes where disconnection could occur in an emergency, and at the point in time when disconnection occurs, the NOPSEMA jurisdiction ends and you move to the AMSA safety jurisdiction? How do you deal with that?
And one of the problems being that AMSA can't look into the vessel until such time as it's disconnected, so it can't impose the SOLAS requirement. It just would seem to me that you ought to be having that SOLAS requirement embedded in on your side of the fence, so that there's a continuum.
But it could be a legislative regime issue as well. So
Well, AMSA indicated it was. They thought it was a legislative problem.
Okay, so
The danger, Senator, you don't want a situation where you have two overlapping safety regimes. That creates its own issues. So at the moment, they aren't overlapping. When the facility is under our jurisdiction, we're responsible for it. When it goes to AMSA, they're responsible. I think I understand the issue that Senator Patrick's raising. If AMSA had concerns that a facility wasn't compliant with SOLAS and they thought they should be, there's no reason why we can't be working with them through measures such as we can do as part of our inspections. We can authorise AMSA officers as NOPSEMA inspectors and so on. So rather than trying to have a duplication of regulatory regimes that could create problems because they may not be identical, you're better to work with the current arrangements where there is no gap between the two legislative regimes and have the two agencies working together if there are any concerns from either regulator.
So why would a SOLAS requirement not meet a NOPSA requirement? Well, I'm saying that the effectively you could still have the same jurisdictions, but the different jurisdictions, but the same standard.
That is what happens, Senator. I think that's the confusion here. That is the situation. I think there's two different things at play. One is about who has the jurisdictional authority, and they are separate. The other is the requirements under the two different jurisdictions, and all disconnectable FPSOs maintain the ability to be vessels and comply under the requirements for vessels under the Navigation Act. So that's not there's no gap there.
So Patrick, I need to I need to share the call to Senator.
I'm actually okay with that because AMSA are going to come back with a question on notice, and I'll just compare the two just to see I'm satisfied.
Do you want NOPSEMA to take anything on notice?
Well,
to flesh out the details.
No, I'm happy with what you provided with me with. Last night I was less happy because AMSA just said, well, whilst it's tied up, we have no jurisdiction, and that left me completely concerned. But let me just see what their answer is, and I reserve my right to come back and ask you next time.
Well, it certainly made sense to me what NOPSEMA was saying in terms of how there are practical ways to deal with this.
Chair, I think, because this is a policy issue as well, and I think it's a legitimate issue that you've raised, so we'll work with AMSA as well with that to make sure that we're joined up, because I think that the issue you're pointing out is one we should make sure that we don't have that gap and an unintended consequence. But I think, as Mr. Smith said, there are ways and means within the current regulatory setup that we can actually deal with this. It's making sure that we've got that sense of protocol in place.
Which would be ideal to do it under the current regime. Senator Watt, you've got questions for NOPSEMA?
I do, thanks, Chair. Not too many. You might recall at the last estimates I asked NOPSEMA some questions about whether you'd received complaints about sexual harassment, sexual assault, what sort of policies you had in place, that kind of thing. And I just wanted to follow up on that. I think you came back on notice and said that you had not received any reports of sexual harassment or sexual assault on regulated sites in the last 5 years. That's correct?
That's correct, Senator.
Thanks. And no complaints since the time you answered that question?
That's correct, Senator.
Thank you. The reason I suppose I wanted to follow up on this is that you've probably seen, since those questions, there have been some pretty disturbing reports, reviews, inquiries around bullying, harassment and sexual assault in Parliament, in mining sites, and obviously there was the recent release of Rio Tinto's pretty damning report into its workplace culture and other incidents of sexual harassment and sexual assault at mining camps. So what I think you said to us last time was that NOPSEMA didn't see any need to issue a guidance note or advice to regulated entities on dealing with these forms of workplace harm. Have any of the events of the last few months made you reconsider that position?
Senator, I don't think that was quite what we said. I think the position was that we haven't issued any guidance, rather than we don't see value in it, if that's what you're suggesting. Can I say, since your questions, we have pursued this matter further anyway. So I've had discussions myself with some of the CEOs from companies in the industry that work in both offshore and onshore, and asked them, some of the companies, in fact, that appeared before the inquiry and reported that they have dismissed staff over sexual harassment situations. And the advice I received from those companies was that although they have onshore and offshore interests, none of the incidents have occurred offshore. They have all been onshore. Typically, they have occurred outside of ours, and typically alcohol has been involved. I note that in offshore facilities, there is no alcohol permitted. So that's one factor. But nonetheless, we have been looking at whether or not it's appropriate for us to issue a guidance note anyway. We've also pursued things like the opportunity for training for our inspectors with the state government department that has the onshore responsibilities. We've also published information in the Regulator magazine, which goes to industry workers. And we also meet with the HSRs when we have inspections. We've been raising this issue on occasions as well. So your questions of us last time prompted us to actually act, Senator. We think we've made some substantial progress. We remain interested and concerned about any possibility of sexual harassment or assault offshore. We'd like to think we're vigilant to that. I can still say we have not yet received any complaints or allegations of such activities in offshore facilities.
Thank you. That's really pleasing to hear that about those actions that you've taken. So congratulations for doing that. I take it then that you sort of acknowledge that one of the reasons that you might not be receiving reports of sexual harassment or assault is because people don't know that they can report that kind of thing to NOPSEMA. In the sort of guidance notes and other measures you've taken, has one of the priorities been to make sure that people know that they can report these kind of things to NOPSEMA?
Yeah, Senator, that's certainly a consideration, and some of the forums we have, like the meetings with the HSRs, they're conducted without management present. We also have the opportunity for people to make anonymous tip-offs to us, referrals and so on. And I would note, Senator, that whilst we haven't had any complaints in regard to sexual assault or harassment or bullying, we have had some allegations in regard to harassment and bullying that aren't of a sexual nature over the years, and we have investigated those and taken action where appropriate. So people are willing to refer matters to us of a bullying and harassment nature, but we just haven't received any in regard to sexual assault or harassment.
Okay. How many of the general bullying and harassment type complaints has NOPSEMA received over, say, the last 5 years?
I don't know the numbers off the top of my head, but I can tell you that we have taken enforcement action in the last few years.
You have taken
in regard to bullying,
Matt?
Yes, we have.
What kind of enforcement action have you taken?
Well, one example that's public is against TK, and I'll get Mr. O'Keefe to give you a quick rundown on that if you'd like.
Sure.
Thank you. Related to an individual who had been subject to bullying offshore, they came back onshore for recover their health, and when they went back offshore again, it would appear that the circumstances hadn't changed. We investigated. We found out the company did not have appropriate return to work mechanisms in place, which would have addressed the cause or the potential for bullying. They didn't have systems in place, and we required them to put those systems in place. So we looked at their overall system, not just for that individual, but overall as a company, as how they could maintain a safe place of work. And one of those was to ensure that their people were free to go about their business unharassed.
Okay, and you were satisfied with the action the company took in response?
We were, yes, and we closed out that. We reviewed the work they'd done. I think actually they felt better for it. Actually, sometimes things turn out that way, that they recognise they can improve their systems, and I think they're appreciative of it.
Okay, well that's good to hear. Can I just encourage you to keep up that work? It's obviously really important from a workplace safety perspective. I'll put our remaining questions on notice for NOPSEMA.
Sorry to cut Mr. O'Keefe, you had one final comment you want to add?
Only to say that the measure of the workplace is actually critical for every time we go to offshore facilities. We meet with the health and safety representatives. That's one of the key things we're looking for, particularly at this time of pressures from COVID, is what's the temperature of the workforce in relation to how they can then live their lives and do their work.
Excellent. Well, I agree with Senator Watt. This is an extremely important area, and I commend you all for all the great work you're doing. So thank you, Mr. Smith and your team. Thank you for joining us this evening. I know it's a late hour, and we really do appreciate the input you've provided during this estimates hearing. Very, very useful, and thank you, Mr. Sullivan. And we will now move on to the Northern Australia Infrastructure Fund. Thanks, Mr. Sullivan.
You're back there.
Happy to be here, mate.
You look like it.
Thank you, Mr Fredericks. Thank you. And welcome back, Minister.
Thank you.
We're just getting started.
Right.
No one else saw the humour in that.
I smiled. There was a smile twitched the corners of my
Groaned.
mouth, Senator Watt.
Groaned.
I should say it's good that Senator Chisholm got you to substitute for him. The only substitute for a Queenslander is another Queenslander, as we know.
Absolutely. Did he actually sub me?
Yeah, he did. I checked. Okay.
Otherwise you could have pulled quorum or something.
Thought never occurred to me.
You wouldn't do that for Northern Australia, Susan, would you?
Absolutely not.
No, she talked me out of it. Okay, so I've got to read another blurb. I'll do it very quickly. If I need to.
Not a long one.
Well, I've got to find it first. Okay, I now welcome the Senator. No, I don't welcome the Senator Honourable Bridget McKenzie. I welcome back the Honourable Zed Seselja. Representing the Minister for Agriculture in Northern Australia. Also welcome Acting Deputy Secretary. I do.
Now Deputy Secretary, Chair.
Thank you. Welcome. And officers from the Department of Infrastructure, Transport, Regional Development and Communications. Minister, Acting Deputy Secretary, officers, would you like to make an opening statement?
No, thank you, Chair.
Thank you. Okay, and I also welcome our friends from the Northern Australia Infrastructure Fund. Would you like to make an opening statement at this stage, or just go straight to questions?
Thanks, Senator Amanda Copping here. I'm the Acting Chief Executive Officer here at NAIF. And so, yes, I would like the opportunity to provide an update on the activities of the NAIF.
Certainly. Over to you.
Great. Thank you, Senator. Total value of NAIF's investment commitments currently stands at $3.4 billion. Importantly, these projects are forecast to generate $25 billion of public benefit to the Northern Australian economy, and that's a multiplier of 7.3 for every NAIF dollar that's committed, and generate 12,500 jobs. By jurisdiction, the investment decisions have been split. So $1.25 billion committed for Queensland, $760 million for the Territory, and $1.4 billion for West Australian projects. We now have reached contractual close on $2.2 billion of financing. So thank you, Senator. I'm happy to take questions.
Thank you very much, Ms Copping, and I hope it's been going well for you since we gave you our best wishes in your acting role when you last appeared before us at Estimates. I'll now give the call to Senator Watt.
Thanks, Chair. I will definitely have some questions for the NAIF, but I might actually just start with the Northern Australia Development Program with the department. I suppose I'm just after a bit of a brief update on the Northern Australia Development Program and the Business and Community Growth Program. Maybe if we start with the Northern Australia Development Program. Now, you have opened applications for these grants, but they haven't yet closed.
So we can, how about we give you a bit of an overview and we can cover off opening and closing and where everything is up to. Does that
that'd
work,
be great.
Senator? I might ask my colleague, Ms Lee, to provide you with that.
Thanks. And will you cover off both those programs, Ms Lee?
Yes, I can.
Great.
Yep.
Thanks.
So Linda Lee, Assistant Secretary of the Office of Northern Australia. So the Northern Australia Development Program offers an opportunity for matched grants for businesses to grow and diversify. So the objective of the program is really about creating new jobs and strengthening business capability and resilience. There are two streams to the development program, or the NADP. The first stream is business development grants, and they're open to small to medium businesses up to 199 employees. and they offer $50,000 to $2 million for a range of activities, as I said, focused on scaling up and diversifying business. So to be eligible for that program, you need to have an ABN, be a trading business, and your project needs to be located in Northern Australia or benefit Northern Australia. So the activities that are eligible under that grant program are quite broad ranging, including buying, constructing and installing plant and equipment, constructing or refitting infrastructure, skills and training, feasibility studies, marketing activities. As I said, they're quite broad. The second stream in that program is the industry transformation grants. These are larger grants open to medium to large businesses. The grants range from $3 million to $10 million, and they're really about establishing a new industry or significantly growing an existing industry. So the Business and Community Growth Program extends the eligibility of the NADP to a broader range of organisations, and that includes sole traders, community organisations, Aboriginal and Torres Strait Islander corporations and other entities. And the BCGP supports the provision of economic and social infrastructure where it has benefits for community livability and social amenity. So those grants are available, as I said, matched again. They range from $50,000 to $2 million. So that's the basis of the program. Yep. I'm happy to give a bit more detail. We're required.
I've just forgotten, there's so many different grants programs. So have applications opened for both Stream 1 and 2?
That's correct. So for the NADP, which has the two streams, they opened on the 4th of November and the first round closed on the 10th of December.
Okay.
And then for the Business and Community Growth Program, that opened on the 6th of December and the first round closed on the 13th of January.
13th of January?
That's correct.
Okay. So how many applications were received through each of those programs?
So I'll start with the totals perhaps, Senator.
Yep.
So for both programs, for NADP 2 streams and the Business and Community Growth Program, total of 196 applications, and that's broken down 187 for the Northern Australia Development Program and 9 for the Business and Community Growth Program.
And 187 for the Northern Australia Development Program?
Yep, and within that, the two streams, the Business Development Stream is 143 and the Industry Transformation Grant's 44.
Okay. Were you sort of a little surprised by how few applications you got for the Business and Community Growth Program?
There weren't as many applications, obviously, as the Northern Australia Development Program, yes.
And just remind me, what's the major difference between those? Like, why would someone choose to apply for the Northern Australia Development Program and not the Business and Community Growth Program?
Yeah, so the major difference is who they're targeted at. So the NADP is largely targeted at trading corporations, so businesses, whereas the BCGP is targeted at other entities that aren't trading corporations, so to speak.
Right. More like NGOs.
Correct, yeah.
But there would be some private sector people
sole
eligible?
Traders, for example.
Sole traders and partnerships?
Yep.
Okay. Do you think it just reflected that they maybe, and given that they have to chip in 50% of the funding as well, maybe that was beyond sole traders and partnerships in a way that trading corporations could do?
Yeah, I'm not really sure, Senator. I'm not sure how to answer the aspirations of each potential applicant, but you are correct that it wasn't as well serviced as the NADP.
Yep. And have you got figures on the total funding that's been sought under each of those programs?
Yes. I'll start perhaps with the NADP, the first stream for the Business Development Program, 127.5 million.
Yep.
For the Industry Transformation Grant, 341.3 million.
Mm-hmm.
And for the BCGP, 7.7 million.
Okay. Where are we up to then with the assessment process if the application's closed in December or January?
So the applications are being assessed by the Business Grants Hub, and they're testing applications for eligibility.
Right, and it'll only be, once they assess the eligibility, they'll then make a decision about who's successful.
No, then it will go to an independent assessment committee, and they'll assess the applications against the criteria for the respective programs.
Okay, so as we sit here today, it's the Grants Hub that's assessing eligibility.
Yep.
Those who are eligible will go through to the next stage, which is the independent panel.
That's correct.
And who's on the independent panel?
So there are 6 members of the assessment committee. It's chaired by Glenys Schuttner, and the other members are Scott Anderson, Jeff Gooding, Chris Rees, Angela Tomasis, and Emma White.
Thanks. But they haven't begun their work yet.
They've started considering eligible applications.
Okay. And what there are criteria that they're going to assess those grants against?
That's right, yeah. So the criteria relate to the program objectives. So I guess in the order of the 2 streams and then the BCGP, it's about the ability to create new jobs and to scale up and diversify. For industry transformation, it's about the ability to grow new industries or significantly change the existing industries. And for the BCGP, the ability to improve social and economic infrastructure. In addition, the capacity, capability and resources to undertake the work.
Okay. If it's convenient, perhaps you could table what the criteria are if you've got them there.
Of course, yeah.
And so the independent panel will assess all of the eligible applications against those criteria. The panel will make recommendations to the minister.
Minister, correct.
Minister. And what role will the department have in all of that?
The department will package the recommendations, the eligibility assessment from the BGH, the recommendations from the assessment committee, and provide that to the minister.
Okay, but the department won't really have any role in assessing the merits of the applications?
No.
Right. What's the approximate time frame for providing a list to the minister?
We are expecting it to be with the minister in February. Because of the volume of applications, that's likely to be later in February, given the date.
So February, March?
Yes.
Yeah, we're well into February, aren't we? Yeah. Okay, and the Minister for Northern Australia is the sole decision maker?
That's correct.
Right. Has the Indigenous Reference Group for the Northern Australia agenda been consulted about the list of applications or any of the projects? Have they had any role at all in this?
No, not as yet. The IAG, as you know, has been refreshed, and they're yet to meet formally. That will be next week.
Yep. I know that there was work going on about refreshing it, but I've missed this. Have new members been appointed?
That's correct.
Okay,
yes.
I've missed that, sorry. Can you just tell us who that is?
Sure. So there are 8 members. It's chaired by Mr. Colin Saltmere.
Yep.
And the other members are Miss Gina Castellane, Miss Tara Craigie, Mr. Jerome Kubelo, Mr. Troy Fraser, Mr. Peter Jeffries, Ms. Gillian Mailman, and Ms. Cara Peake.
Okay. Was that announced by the Minister? That must have slipped by me.
Yes, it was. So there were 2 separate announcements. The first 6 members were announced on the 13th of December and an additional 2 members on the 24th of December.
I'll go back and have a look. But they're not playing any role in looking at these applications?
No, that's
okay.
right.
The reason I asked, I suppose, is that I noticed that Indigenous businesses are a group that's sort of named as being eligible for the Northern Australia Development Program grants. Indigenous organisations are named as potential applicants for the Business and Community Growth Program, and given there have been some issues about engagement of First Nations people with the Northern Australia agenda, would it not be a good idea to involve the reference group in helping select projects as well?
The terms of reference for the IRG are being formulated and are yet to be agreed, but certainly one of the things that we think the IRG could provide advice on is the application process from an Indigenous perspective and helping us to improve the process rather than looking at the grants themselves.
Okay. And were you referring to the grants that are underway as round one?
That's correct, yeah.
For both the Northern Australia Development Program and the Business and Community Growth Program?
That's correct.
Okay.
Yes.
And have you any idea when round two will be opened?
So round two will be subject to the funding available following the completion of the assessment of grants through round one.
Right. Can you remind me how much is available or budgeted?
So both programs share an envelope of $80 million.
80?
Yeah.
And you've had, what about 450, 500 million worth of applications?
476, yes.
Yep. So it's conceivable that all 80 million could be spent in round one?
That's correct, yes.
In which case there wouldn't be a round two? Unless if government decided to provide more funding?
Yeah, government would need to make that decision, yes.
Okay. Has there been any coordination or any interaction with the NAIF about these grants?
Only in talking about how the grants could support proponents get into the NAIF pipeline.
Mm-hmm.
So feasibilities, for example, feasibility studies are one way that we can assist smaller proponents into a NAIF pipeline. So we've had officer-level conversations about that.
Okay. I suppose the reason I ask is that, I don't think I'm telling any secrets to say that one of the criticisms of the NAIF has been, two criticisms, that it hasn't provided grants and that it hasn't focused sufficiently on smaller projects. And these grants seem to be geared towards, they're grants for starters, and they're geared towards smaller projects. So I wondered if in some way this might be filling the gap that's been identified in the NAIF.
Yes, and I guess that will be in the assessment of the program to look at whether it is being used as the bridge into NAIF and if that is the core of the challenge for those smaller businesses.
Okay. I think the remainder of my questions are for the NAIF.
Okay.
Anyone else want to have a go before I...
Senator Cox.
Happy to do NAIF, yes. Thank you. My focus is on the Herdeman Processing Plant Karratha, and so I'm wondering if you can tell me who first approached NAIF in regarding to supporting finance for this project.
Financing, NAIF is financing the two key components of the critical infrastructure. So the NAIF financing is going to Pilbara Ports Authority for the development of the critical infrastructure to support the urea plant, a multi-user port at Dampier. And then the other component is a $95 million loan to Watercorp to expand the Burrup seawater supply and mine disposal scheme. Both of those pieces of infrastructure will then be used by the Herdeman plant itself.
Okay, so just for clarity, because you dropped out there at the start, they're both on behalf of the West Australian Government, is that right?
They're both to the government trading enterprises, yes, that are owned by the West Australian Government. One to Pilbara Ports Authority and the other one to Watercorp.
Right. Was the Minister for Northern Australia or the Minister's Office aware of the request and provided support for the finance?
I think that's a question best answered by the department, Senator.
Senator Marisa Purvis-Smith, Deputy Secretary, Water Infrastructure in Northern Australia. I'd have to take the detail of that on notice for you. Mm-hmm. The process around NAIF approvals is that the NAIF go through the due diligence and get through to investment decision stage, and then it is subject to the department is involved in terms of making sure that there's no gathering information in relation to from other Commonwealth departments, mm-hmm. To make sure that there's nothing that the NAIF need to be aware of in terms of making their decisions. The Minister has rather than, for example, ticking off every proposal, the minister has a veto right, and so proposals, once the NAIF has made its decision, then go to the minister for whether the minister would like to use the veto right, and there are particular reasons and processes about how that is used.
Can you expand on that at all?
Let me see whether I've got any more. I can probably get some more detail for you on notice if you would like.
You're happy to provide
I
that?
can,
That would be
yes.
great.
There are particular processes by which the minister can use the veto right.
Yes.
It does have to be tabled in Parliament with a list of reasons, so if a veto right is used, then it's quite transparent.
Okay.
I might have something here for you, actually. It's quite detailed, actually, so it might be worthwhile that I can provide it to you quickly at a later stage, just afterwards, if you like.
Provide it on notice if you like. Yeah. I'm also keen to know whether there are other ministerial officers such as Science and Technology that might have provided support as well. That's probably a question for the minister. Science and Technology, supporting that application for Perdaman?
Sorry, my apologies, sorry, the question was?
So was there a request for support for the NAIF application for Perdaman through the Minister's Office for Science and Technology?
Okay, I'd have to take that question on notice.
Okay. Thank you. Did Woodside ever contact NAIF in relation to requesting support for Perdaman?
I'd have to take that question on notice, Senator.
Okay.
I'm not aware myself, but I will check.
So, great, thank you. Were there any government ministers, members of staff that were ever urged for NAIF to meet with representatives of Woodside to discuss Perdaman?
NAIF continued to talk to a number of proponents in Western Australia, including Woodside, to talk about a number of opportunities.
Right, okay. When did the NAIF board actually formally endorse supporting finance for Perdaman?
I'll come to the depot, but my understanding is that investment decision was made at the December board meeting.
So you are just noting your opening statement that it was after the 28th of October last year?
Yes, that
was the formal
my
endorsement?
understanding, yes.
Yeah.
Correct.
Great. Has Woodside ever requested support from NAIF, particularly for this project?
I will take that on notice, Senator and Chair. But to be clear, but obviously the NAIF loan is to the NAIF 2 loans are to Pilbara Ports Authority and to Watercorp.
Yeah. And did NAIF ever consider that if the Perdaman project didn't go ahead, that Woodside Scarborough project wouldn't proceed as well without finance? Was that a deciding factor?
We consider each project on a case-by-case basis, and so looking at the loans for Pilbara Ports and Watercorp focused on the Perdaman transaction itself.
Great. Minister, I'll direct my other questions to you if I can and come back to Ms Copping. Is it fair to say that extending this facility at Perdaman, as per Minister of Northern Australia's statement, it supports Aussie farmers?
Sorry, I'm just trying to understand your question. Sorry.
Do you?
So in the
sorry, Senator Cox. Do you have, Minister? Do you have a copy of the media statement that Senator Cox is referring to?
I'm sure I may have one, which I might be
just
able to
might
provide.
make it easier for
That
the
might
Minister,
help.
Senator Cox.
Let me have a quick look. Yes, there it is. There you go. Thank you.
Feel free to give it straight to the Minister in the first instance. Thank you.
So, just quoting the area that I'm obviously inquiring about is that the NAIF investment will provide farmers access to locally manufactured fertiliser, securing our agricultural production. Yet Perdaman is on the record, including on their website, clearly stating that this product is actually for export. 2.3 million tonnes per year is going to be exported. It's not going to be for local production. It's not going to be for Aussie farmers. It's actually going to go straight to the Pilbara port and out for export, according to the Minister.
Sorry, are you suggesting that it's a bad thing that things are produced for export?
Sorry?
Are you suggesting that it's a negative to be exporting Australian-produced goods?
That's exactly what it says. It actually states that the NAIF investment will provide this access to locally manufactured fertiliser for the benefit and to support Australian farmers. So how does it benefit Australian farmers if it's all going onto a ship and being exported overseas? It's not actually going to Australian farmers for its production.
I mean, the level of detail there, I'd probably just have to take that on notice.
So I'm not sure how, the Minister can make a statement like that and basically misleading the Australian public and Australian farmers to say that the Perdaman investment in the Pilbara will actually benefit our Australian farmers by locally produced fertiliser that will benefit our economy, but in fact it's actually for export and trade.
Again, I'd have to probably just take the detail of that on notice.
Happy for you to take that on notice. My other questions are to Ms Copping. Is NAIF aware that Perdaman's chemical processing plant will be built right next to millions of Aboriginal rock carvings, some of which are more than 40,000 years old?
So, obviously, yes, we're aware of the location of the plant itself, but for every transaction investment that we consider, we undertake detailed due diligence in relation to the project, and that includes environmental due diligence and ensuring strong Indigenous outcomes. Senator?
So in addition to this, Ms Copping, that rock art is also the subject of a World Heritage Listing application due next year, which the federal government and the West Australian government are providing funding towards that submission. And yet NAIF are providing funding to destroy it. An application on a significant piece of rock art on country in Murujuga, which essentially will destroy that, and has been objected by the traditional owners and elders who don't want this project to go ahead. Has NAIF even spoken to those traditional owners?
Yes, Senator, they have. As I mentioned, for every project that NAIF does, we do require an Indigenous engagement strategy from the proponents, but as part of undertaking the due diligence on those Indigenous engagement strategies, the NAIF team do go and speak to the traditional owners of the country where the project sits. Correct.
So, Ms Copping, in part of that Indigenous engagement strategy, can you point me to the section where it says in the policy that it deals with the destruction of Aboriginal sacred sites? Because I can't find it.
Sorry, Senator, in terms of the proponent's Indigenous engagement strategy?
That's your Indigenous engagement strategy, and in that process it says it's all about Indigenous employment opportunities for First Nations peoples near this project, and yet the section of the policy I can't find that talks about the destruction of sacred sites, because that's exactly what's happening in real time from industrial emissions to the Murujuga rock art at the Perdaman site. So I'm just curious.
A couple of points to make there, Senator. So, as I said, the Indigenous engagement strategy is the strategy of the proponent. NAIF undertakes due diligence and reviews that strategy. And secondly, every project that we finance has to have in place all the necessary approvals that are required for that project to proceed, and that includes environmental approvals.
So I just want to
and-
clarify this, Ms Copping. The NAIF isn't formally concerned as an Australian government agency in protecting Aboriginal sacred sites and history in this country. Is that right?
No, Senator. What I said is that NAIF undertakes due diligence on both Indigenous engagement strategy that for every project, and in particular for this project, but also we don't provide funding unless the project has achieved its environmental approval.
Right. So it's also accurate to say that NAIF's more concerned with trying to find ways to buy off Aboriginal people with jobs and contracts, and because they're the real jobs on country that NAIF are concerned with, and the economic filter here. And you talk about the environmental factor, but it's actually not being considered when we talk about cultural tourism of the oldest rock art in the world. Murujuga contains rock art that's not found anywhere else in the world.
Senator, achieving strong Indigenous outcomes is a key part of what NAIF does. And that includes, yes, it includes jobs, it includes procurement, it also includes cultural awareness and understanding. So it is a key part of every investment that we make.
Okay. So hypothetically, if NAIF had provided a financial facility to Rio Tinto for work that supported the destruction of Juukan Gorge, how would NAIF have prevented the sacred sites of the 40,000-year-old rock caves in that location?
Senator, I can't comment on a hypothetical.
What's a comparison of the same? Basically, it's the same thing.
I think it is a hypothetical, Senator Cox, to be fair.
Fine for Ms Copping not to answer that. So I just want to make sure that I've understood, just to wrap up this conversation, but what you've said is that NAIF doesn't understand the significance of Murujuga and the rock art and hasn't listened to the traditional owners and actually doesn't care about the impact of this project and is willing to finance...
Sorry, Senator Cox. Sorry, Senator Cox. Sorry, Senator Cox.
That's exactly what's happening.
Sorry, Senator Cox. Point of order, Senator McDonald.
This is a departmental official, a NAIF official. Senator Cox is putting words, is extrapolating words that Ms Copping has not said. Yeah. This is unreasonable and unfair.
Senator Cox, I understand, Senator Cox, you're passionate about this issue. I do. And I recognise that. Senator Cox, I recognise that. But if
and also spoken to the traditional owners. So, I'm trying to understand why a government department is trying to destroy something which is sacred to Aboriginal people. I know you don't understand that, Senator McDonald.
I don't think that's...
And I don't think that's fair, order, but we are
Senator
passionate
Cox.
about protecting country.
I don't think that's fair, Senator Cox. Do you have a final question in relation to this?
No, I don't. That's it. Thank you very much.
Thank you, Senator Cox. Can I just place on notice for you, Minister, just to check this issue about the export, the percentage that's going on export. I'm not sure if I located the particular media release. I was just looking on my phone. There is a question, I think, about whether or not this is a major export project, but also providing domestic supply. So if you could just clarify in terms of, perhaps in the answer to the question on notice that you took on notice from Senator Cox, if we could just make sure that it deals with any domestic supply.
So thank you for clarifying
Okay, thanks. I'm happy to be of service, Senator Cox.
I'm advised that they'll be supplying both domestic and international supplies.
Okay. Senator Watt, you have the call.
Thank you, Chair.
Thank you.
Ms Copping, again, I'm sure you're glad you had a bit more time to prepare for this hearing than you did for the last one. Again, thank you for stepping in at the last minute.
And I should say, Ms Copping, we've tabled your entire opening statement. You were very kind to read only part of it, but we have tabled all of it, and I have read it all, and it was very useful. So thank you very much, Senator Watt.
Ms Copping, hopefully you got my letter from a couple of days ago, just flagging some of the information I was going to be seeking. Have you? And the reason I sent that was that I knew we'd be doing this at 10 o'clock at night, and I thought it might save us some time. Do you have that information that I sought?
Yes, Senator, and we had also, we were going to table it as well.
Okay, I think that's just going to be tabled now.
Thank you.
While that's happening, I might just get the headline figure from you. What is the total amount of funding that has now been drawn down by the NAIF, from the NAIF?
Yeah, Senator, so as at the 31st of January, the total amount drawn down was $585.2 million. And that is split across the 3 jurisdictions, so $263.6 million in Queensland, $216.8 million in Western Australia, and $104.9 million in the Territory.
Okay, so we've just cracked the 10% mark of the $5 billion that the NAIF has at its disposal, and it's now 7 years since the NAIF was created. What's your rough timeline for when you expect the $5 billion that the NAIF already had prior to the recent announcement, that $5 billion will be fully drawn down?
So thanks for your question, Senator. So firstly, NAIF has made $3.4 billion of investment decisions, and $2.2 billion of that have reached contractual close. The timing of drawdown is at the borrower's request. They draw on the loans as they need the funds. And as the funds are for construction, they're not drawn in one tranche, but rather as required by the project's design and construction timetable. And it's that determines when those committed funds, those $2.2 billion of contractual closed funds, are drawn.
I'm just going through this information that you provided. So you've given the total amount drawn down, broken down by state. Are you able to, do you have, one of the things I asked for was the amount of funding drawn down by project. Do you have that information at all?
So, Senator, yes, we do track that. Absolutely, we do. But given its commercial in confidence, the relationship with the proponent there, and their overall financing package, that's not just NAIF, it includes other financing, we're not able to disclose drawdowns by individual proponents over time.
Okay, I might be wrong about this, but I thought that previously we'd been able to get a project by project breakdown of funds drawn down. Would you mind just taking this on notice?
I'll take that on notice, Senator.
Yeah, I
Yes,
might be
happy
wrong
to.
about that, but if that information has been provided before, if I could just ask you to reconsider and provide it to us this time as well. The next thing I asked you for was the total number of projects that have had loans approved by the NAIF broken down by state, and we've got 9 for the NT, 14 for Queensland, 16 for WA, and I see that you've got a note here. The number of projects includes 8 projects approved by the NAIF board but are not proceeding, such as AgriPower.
Yes.
Yes. Can you just quickly list me the 8 projects that that were approved but aren't proceeding?
Yeah, Senator, I'll have to come back to you on that one and take that one on notice. But you know, a couple of examples of loans that are not proceeding. So, for example, we provided a loan to a proponent who was subsequently taken over and advised they didn't require the NAIF financing. The AgriPower loan, similarly, they advised after the NAIF investment decision that they weren't able to secure private sector financing, Senator, and we're very conscious of not crowding out the private sector, and so they went with the private sector financing.
I didn't catch the name of that project.
That was AgriPower, Senator, where the proponent advised that subsequent to the NAIF investment decision, they'd been able to secure private sector financing.
Okay, sorry, I thought you gave us a second example, but it was just AgriPower, was it?
No, so no, the first one I didn't provide the name, but that organisation has been taken over, was acquired, and as a result, they advised they didn't require the NAIF financing. They're 2 examples, Senator.
Is there any reason you can't give us that name?
My understanding is that name remained commercial in confidence, but I'm happy to take that on notice, Senator.
Okay. I've just had a look at the NAIF website and the case studies, and I see AgriPower Australia is still up there. Are there other projects that are listed on the NAIF website as having been approved for loans that are actually not proceeding?
Senator, I'd have to check the NAIF website and go through case by case. Again, happy to take that on notice and confirm to you.
Okay. And the do you have a state-by-state breakdown of the 8 projects that aren't proceeding?
Yeah, not to hand, Senator, but again, happy to take that on notice and provide that.
And just so we're clear about our language, what I asked for was the number of projects that have had loans approved by the NAIF, and that totals 39 minus the 8 that are not proceeding, so 31.
That's correct.
Now, when are we meaning the same thing about loans approved? Is that are they the $3.4 million in commitments that you've made? Are those 31 loans?
31 in the investment decision commitments, yes, Senator.
Okay, so there've been 39 investment decisions, of which 8 aren't proceeding, and the remaining 31, the total value of them is 3.4 billion.
Yes, Senator.
Right, and what was the contractual close figure again?
2.2 billion.
Okay, so for those 31 projects, it's $2.2 billion worth of them have reached contractual close, and 585.2 million of those funds have been drawn down.
Yes, Senator.
Okay. So the $3.4 billion figure and the $2.2 billion contractual close figure, those don't include any of those 8 projects that are not proceeding.
That's correct, Senator.
Okay, thank you. Obviously, some of the amendments that were made to the NAIF legislation last year in a bipartisan manner approved a change to allow the NAIF to provide equity finance. Have any projects now been approved for equity finance?
Senator, we're very mindful of our role and investing taxpayer money. So as a first step, we have been looking to put in place the corporate governance and processes that will govern any investment that we make. We have not made any investment decisions to date for equity investments. However, a number of projects have proceeded through the strategic assessment phase and are now in due diligence. And we hope to be able to make some investment decisions in the not too distant future.
Okay. And there were other financial tools approved, such as derivatives and other things that the NAIF previously couldn't provide. Are there applications now before the NAIF for those other forms beyond equity finance?
Senator, we haven't made any decisions in relation to derivatives. Other changes that we've done, we've announced the first of our financing partnerships, our on-lending partnerships. That's a $50 million loan to the Northern Territory Local Jobs Fund, and that was made possible by the NAIF reforms, and that is designed to expand support for small and medium businesses. In addition, another one of the reforms, Senator, was the ability for NAIF to provide financing directly to proponents and not via the jurisdiction. And to date, NAIF has made investment decisions for 3 projects for direct financing, one in Queensland, one in WA and one in the NT. So the ALPA transaction, the Indigenous food storage and warehousing facility in the NT is direct. Alliance Airline, their maintenance facility in Rockhampton, that will be a direct financing, and the Kimberley Cotton in WA.
Kimberley Cotton was the last one, was it?
Yes, that's correct.
I might come back to that point, but just before I leave the equity finance and derivatives. So no equity finance has been provided at this point, but there are assessments underway.
Correct.
How many projects have formally applied for equity finance?
There are a number of projects in the preliminary stages, Senator, and in the pre-strategic assessment phase. And as you're aware, given that some of those discussions are still, relatively preliminary, and unlike a grant process, it's not a formal lodge a form at a particular date, it would be too premature for me to talk about those opportunities, Senator.
Okay. And is it? I'm just curious. Is it without revealing any of the applicants? Is it possible to sort of describe the types of organisations or the types of activities that are seeking equity funding as opposed to loan funding?
Sure, Senator. So under the terms of the mandate, NAIF can consider making equity investments of between $15 to $50 million. And so that influences and impacts the type of potential investments that NAIF can make. And so typically for equity investment, it is the case that it is further along the risk spectrum than debt, and so an equity investment involves a higher risk than at providing a loan, but also a higher return. And so obviously that's true for all the applicants that approach NAIF, Senator.
And is it possible to generalise and explain what it is that makes these projects riskier? And either therefore looking for equity finance rather than loans?
There are a number of reasons that mean that they would look for equity, and they're not ready for debt. So for a lot of them, it's the stage of development that they are, Senator, where they're ready for equity, they're not quite ready for debt. If I had to generalise, Senator, I'd say it's around revenue certainty. As you know, just when you take out a mortgage to buy a house, you have to have a level of comfort around the ability to service that loan, and that's no different to a NAIF loan.
Okay.
And so, well, that's it.
And just while I think of it, I mean, you've been in the acting CEO role for a few months now. Is there anything that you've observed that identifies, real gaps that the NAIF is increasingly being asked to fill from a financing perspective, and that might be particular industries, particular regions, particular types of organisations? Where are you finding that the NAIF is particularly getting interest?
Look, it's fair to say, Senator, that we are seeing interest across sectors and across the regions. We have identified five sectors within the investment team, and we're seeing interest and appetite across each of those sectors, be it resources projects, transport, social infrastructure, energy, and agri and water. Opportunities in looking for NAIF financing across each of those sectors.
Okay, and just back to the point about projects where finance will be provided directly to the proponents rather than through a state or territory. You gave us the three where that's occurring.
Yes.
Are there any applicants who are still seeking for funding to be provided via states and territories, or?
Senator, it's fair to say that going forward, we expect that there will be a mix of projects where some go directly to the proponent and others where we work with our jurisdictional partners to provide the finance. So obviously earlier this evening we spoke of the 2 loans to Watercorp and to Pilbara Ports Authority. Given the nature of those entities, for both of those it makes sense for us to provide the financing through West Australia.
Is that because they're owned by the state government?
Yes, in that, and so because of the critical role of the West Australian government in those projects, it makes sense to go through. But for other projects, we'll go direct. It really depends on the nature of the project as we determine whether it will go direct.
Okay,
Senator.
Could you table for us a current organisational chart of the NAIF?
Yes.
Or arrange to have that tabled?
Yes, Senator, I can do that.
And that leads me to where we're up to with the search for a new CEO. Can you just give us a quick update on that?
Sure, Senator. Obviously, from my perspective, the CEO recruitment is a matter for the board and perhaps best answered by the department. But before I hand over to them, I will say that the chair advised NAIF staff on the 4th of February that the search for the CEO is well progressed. They advertised in December and January, and the chair advised that they have got an excellent field of candidates.
Okay.
But best hand it over to the department.
Sure. Could I ask the department to give you a quick update, please?
Yes, Senator. The NAIF has engaged a recruitment firm to assist them with the search. They have shortlisted and interviews are being undertaken.
Have they started?
Yes, they have started interviews and they're in the middle of the assessment process.
And the recruitment agency is doing those interviews?
No, that is being led by the chair.
So who's on the selection panel?
Can I get the detail for you?
Yep.
Of that?
That would be great, thanks. Is there a rough time frame for when it's expected there'll be an announcement or a decision on this?
I think the chair is keen to fill the position as soon as she can, so she's going through the relevant processes to do so, and also it will need to go through cabinet, so it'll be a cabinet appointment.
Okay. Do you have some figures there about the cost of the recruitment agency?
No, I don't, but I'm sure I can get that for you.
Yeah, so the cost, when they were engaged, who they are, how long they've been engaged for, those sort of basic details will be good, thanks.
Yes.
What role has the Minister's office played in the recruitment process?
I'm not aware, Senator. I would have to take that on notice. I'm not aware that they have played any role, but I can check and get back to you.
Yeah, if you could on notice advise whether the Minister or his office have discussed the recruitment process with the chair of the NAIF, and if so, what the nature of those discussions has been, and specifically, has the Minister or his office made any suggestions as to possible CEOs to the chair or to the recruitment agency?
I'd have to take that on notice.
Thanks. And also, if you could take on notice whether the chair made any suggestions about possible CEOs to the recruitment firm.
Yes, I can take that on notice as well.
Yep. So you said that there's a short list. Has that short list been provided to the Minister or his office?
I'm not aware, Senator. I'd have to take that on notice.
Okay, but I assume the list has been provided to the chair if she's on the selection panel.
Yes, indeed.
Thanks. Has any decision been made about whether the new CEO will be required to live in Northern Australia?
I think that's a matter for the chair, and it depends on the candidates that they get. So I can take anything that the chair may wish to say on notice. If you like.
Okay, and Ms. Copping, I don't want to dwell on this, but you didn't receive any sort of handover from your predecessor when you suddenly became the CEO, did you?
No, Senator. as you're aware, there was an email advising the NAIF team that the former CEO had resigned.
Yep, okay. I'll just try and whip through my remaining questions as quickly as I possibly can.
Yeah, you don't need to seek my consent to do that.
I know, but all of us have had a long week. You came back to us after the last estimates with some answers on notice about staffing in the NAIF, and I think one of the questions on notice informed us that as of the 31st of October 2021, the NAIF had 35 staff members and 13 unfilled positions. Can you give us the same sort of breakdown either now or for a recent 31st of January or something like that?
Sure, Senator. So NAIF currently has 37.2 FTEs or 38 employees in total.
And how many?
I'll have to.
Yeah, how many unfilled positions?
Sorry, I was going to say. Yeah, I'll have to get back to you and confirm the number of unfilled at the moment.
Okay. And how many? Can you give us an update on the number of staff, NAIF staff, including management, who are based in Northern Australia? Because we talked about this last time and talked about the fact that there are more NAIF staff in Sydney than in all of Northern Australia. Has that changed?
Sure, Senator. So we can say that there are 17.6 FTEs in Northern Australia, split between Cairns, Darwin, Townsville. That also does include Perth.
Did you say 17? Sorry, 17?
Yes, that's correct.
Yep.
And that is an increase from 18 months ago of when we had 6 in the north, and we have 2 in Brisbane and 17.6 in Sydney.
So 17 in Northern Australia. That was split across Darwin, Cairns,
Townsville, and that does include Perth, which I understand is not but that's in WA.
How many are in Perth?
2.8, Senator.
Okay. I might just get, again, on notice, if you could just give us the breakdown of number of staff for each of those locations. And when were those figures as of?
They are as at end of January, Senator.
End of January, okay. I know you don't know the number of unfilled positions, but last time round there were about 13. Based on your knowledge of the organisation, do you believe that it's significantly less than that now, or about the same, or do you not really know?
Oh, look, I mean, Senator, we have had, 30 new employees since January 2020. Split between, new roles and 21 new roles and 9 new hires due to resignations. So, we continue to see strong appetite and interest in working at the NAIF.
And one of the other questions on notice from last time revealed pretty high turnover levels in the NAIF prior to your appointment. For instance, there were 18 staff who left between January 2020 and October 2021, pretty high proportion of the staff. Have you done any work to identify reasons for high levels of turnover and trying to turn that around?
Yeah. Firstly, Senator, people's reasons for resignations, really depend on each individual. We have seen that it differs between individuals, but obviously, we are focused on ensuring that we have the staff that we need to implement the mandate.
And exit interviews that were undertaken with those staff, were there any common themes about why so many people were leaving?
I'd say so, Senator. I haven't seen the exit interviews for most of those members, given that they resigned before I was in the acting CEO role. So I wouldn't be in a position to comment on those. Okay,
and I've talked before at estimates with NAIF about bullying allegations and investigations that were underway into that. Are there any bullying allegations still being investigated within the NAIF?
I'm not aware of any, Senator.
Okay. Again, if you could take that on notice for me, please. And I think that brings it to an end.
Excellent. Thank you, Senator Watt. Can I just say, Ms Copping, how impressed, I'm sure I can say this for all of us, how impressed we've been with you as being put in the position of acting CEO in very difficult circumstances. I think we've all been very impressed with how you've gotten across your brief and the service you've provided. And wherever you go, you will take with you the great experiences of having participated in the Senate estimates process. So I do wish you all the very best.
I think that she could consider herself an honorary North Australian.
Absolutely.
All right, thank you. Thank you very much, Ms Copping. There being no further questions at this time, the committee's consideration of the 2021-22 additional budget estimates will conclude. I thank Minister Seselja and officers of the Department of Infrastructure, Transport, Regional Development and Communications portfolio who have given evidence to the committee today. Thank you also to Hansard Broadcasting, the committee secretariat, also the cleaners who have assisted to keep us safe. Thank you to all of them. I now declare the hearing adjourned. Thank you very much.
Thank you, Chair.
Thank you.